Britishers came to India in 1608 as traders in the form of the East India Company, which had the exclusive right of trading in India under a charter granted by Queen Elizabeth I in 1600. In 1765, the company, which till then had purely trading functions, obtained the Diwani, i.e., rights over revenue and civil justice, of Bengal, Bihar, and Orissa. This started its career as a territorial power. In 1858, in the wake of the Sepoy Mutiny, the British Crown assumed direct responsibility for the governance of India. This rule continued until India was granted independence on August 15, 1947. The Mughal Emperor, Shah Alam, granted Diwani to the company after its victory in the Battle of Buxar, 1764. With independence came the need for a constitution. Hence, a constituent assembly was formed for this purpose in 1946, and on January 26, 1950, the constitution came into being. However, various features of the Indian constitution and polity have their roots in the British rule. There were certain events in the British rule that laid down the legal framework for the organization and functioning of government and administration in British India. These events have greatly influenced our constitution and polity. They are explained here in a chronological order under two major headings. 1. The Company Rule, 1773 to 1858. 2. The Crown Rule, 1858 to 1947. F. The Company Rule, 1773 to 1858. Regulating Act of 1773. This act was of great constitutional importance as a. It was the first step taken by the British government to control and regulate the affairs of the East India Company in India. B. It recognized, for the first time, the political and administrative functions of the company. And C. It laid the foundations of central administration in India. The features of this act were as follows. 1. It designated the Governor of Bengal as the Governor-General of Bengal and created an executive council of 4 members to assist him. The first such Governor-General was Lord Warren Hastings. 2. It made the governors of Bombay and Madras presidencies subordinate to the Governor-General of Bengal, unlike 2W Indian Polity earlier, when the 3 presidencies were independent of one another. 3. It provided for the establishment of a Supreme Court at Calcutta, 1774, comprising 1 Chief Justice and 3 other judges. 4. It prohibited the servants of the company from engaging in any private trade or accepting presents or bribes from the natives. 5. It strengthened the control of the British government over the company by requiring the Court of Directors, governing body of the company, to report on its revenue, civil, and military affairs in India. Amending Act of 1781. In a bid to rectify the defects of the Regulating Act of 1773, the British Parliament passed the Amending Act of 1781, also known as the Act of Settlement. The features of this act were as follows. 1. It exempted the Governor-General and the Council from the jurisdiction of the Supreme Court for the acts carried out by them in their official capacity. Similarly, it also exempted the servants of the company from the jurisdiction of the Supreme Court for their official actions. 2. It excluded the revenue matters and the matters arising in the collection of revenue from the jurisdiction of the Supreme Court. 3. It provided that the Supreme Court was to have jurisdiction over all the inhabitants of Calcutta. It also required the court to administer the personal law of the defendants, i.e., Hindus were to be tried according to the Hindu law and Muslims were to be tried according to the Mohammedan law. 4. It laid down that the appeals from the provincial courts could be taken to the Governor-General in Council and not to the Supreme Court. 5. It empowered the Governor-General in Council to frame regulations for the provincial courts and councils. Pitt's India Act of 1784. The next important act was the Pitt's India Act 2 of 1784. 2. It was introduced in the British Parliament by the then Prime Minister, William Pitt. The features of this act were as follows. 1. It distinguished between the commercial and political functions of the company. 2. It allowed the Court of Directors to manage the commercial affairs, but created a new body called the Board of Control to manage the political affairs. Thus, it established a system of double government. 3. It empowered the Board of Control to supervise and direct all operations of the civil and military government or revenues of the British possessions in India. Thus, the act was significant for 2 reasons. First, the company's territories in India were for the first time called the British possessions in India. And second, the British government was given the supreme control over companies' affairs and its administration in India. Act of 1786. In 1786, Lord Cornwallis was appointed as the Governor-General of Bengal. He placed 2 demands to accept that post, viz. 1. He should be given power to override the decision of his council in special cases. 2. He would also be the commander-in-chief. Accordingly, the Act of 1786 was enacted to make both the provisions. Charter Act of 1793. The features of this act were as follows. 1. It extended the overriding power given to Lord Cornwallis over his council to all future Governor-Generals and Governors of Presidencies. Historical background. 3. 2. It gave the Governor-General more powers and control over the governments of the subordinate presidencies of Bombay and Madras. 3. It extended the trade monopoly of the company in India for a period of another 20 years. 4. It provided that the Commander-in-Chief was not to be a member of the Governor-General's Council unless he was so appointed. 5. It laid down that the members of the Board of Control and their staff were, henceforth, to be paid out of the Indian revenues. Charter Act of 1813. The features of this act were as follows. 1. It abolished the trade monopoly of the company in India, i.e., the Indian trade was thrown open to all British merchants. However, it continued the monopoly of the company over trade in tea and trade with China. 2. It asserted the sovereignty of the British Crown over the company's territories in India. 3. It allowed the Christian missionaries to come to India for the purpose of enlightening the people. 4. It provided for the spread of Western education among the inhabitants of the British territories in India. 5. It authorized the local governments in India to impose taxes on persons. They could also punish the persons for not paying taxes. Charter Act of 1833. This act was the final step towards centralization in British India. The features of this act were as follows. 1. It made the Governor-General of Bengal as the Governor-General of India and vested in him all civil and military powers. Thus, the act vested, for the first time, the Government of India with authority over the entire territorial area possessed by the British in India. Lord William Bentinck was the first Governor-General of India. 2. It deprived the Governor of Bombay and Madras of their legislative powers. The Governor-General of India was given exclusive legislative powers for the entirety of British India. The laws made under the previous acts were called as regulations, while laws made under this act were called as acts. 3. It ended the activities of the East India Company as a commercial body, which became a purely administrative body. It provided that the company's territories in India were held by it, in trust for His Majesty, his heirs and successors. 4. The Charter Act of 1833 attempted to introduce a system of open competition for selection of civil servants and stated that the Indians should not be debarred from holding any place, office, and employment under the company. However, this provision was negated after opposition from the Court of Directors. Charter Act of 1853. This was the last of the series of Charter Acts passed by the British Parliament between 1793 and 1853. It was a significant constitutional landmark. The features of this act were as follows. 1. It separated, for the first time, the legislative and executive functions of the Governor-General's Council. It provided for the addition of 6 new members called legislative councillors to the council. In other words, it established a separate Governor-General's Legislative Council which came to be known as the Indian Central Legislative Council. This legislative wing of the council functioned as a mini-parliament, adopting the same procedures as the British Parliament. Thus, legislation, for the first time, was treated as a special for Indian polity function of the government, requiring special machinery and special process. 2. It introduced an open competition system of selection and recruitment of civil servants. The covenanted civil service was, thus, thrown open to the Indians also. Accordingly, the Macaulay Committee, the Committee on the Indian Civil Service, was appointed in 1854. 34. 3. It extended the company's rule and allowed it to retain the possession of Indian territories on trust for the British Crown. But it did not specify any particular period, unlike the previous charters. This was a clear indication that the company's rule could be terminated at any time the Parliament liked. 4. It introduced, for the first time, local representation in the Indian Central Legislative Council. Of the 6 new legislative members of the Governor-General's Council, 4 members were appointed by the local provincial governments of Madras, Bombay, Bengal, and Agra. 3 at that time, the civil services of the company were classified into covenanted civil services, higher civil services, and uncovenanted civil services, lower civil services. The former was created by a law of the company, while the later was created otherwise. For Subhash C. Kashyap, Our Constitution, National Book Test, 3rd edition, 2001, p. 14. T. The Crown Rule, 1858 to 1947. Government of India Act of 1858. This significant act was enacted in the wake of the Revolt of 1857, also known as the First War of Independence or the Sepoy Mutiny. The act known as the Act for the Good Government of India abolished the East India Company and transferred the powers of government, territories, and revenues to the British Crown. The features of this act were as follows. I. It provided that India, henceforth, was to be governed by, and in the name of, Her Majesty. It changed the designation of the Governor-General of India to that of Viceroy of India. He, Viceroy, was the direct representative of the British Crown in India. Lord Canning, thus, became the first Viceroy of India. 2. It ended the system of double government by abolishing the Board of Control and Court of Directors. 3. It created a new office, Secretary of State for India, vested with complete authority and control over Indian administration. The Secretary of State was a member of the British Cabinet and was responsible ultimately to the British Parliament. 4. It established a 15-member Council of India to assist the Secretary of State for India. The Council was an advisory body. The Secretary of State was made the chairman of the Council. 5. It constituted the Secretary of State and Council as a body corporate, capable of suing and being sued in India and in England. The Act of 1858 was, however, largely confined to the improvement of the administrative machinery by which the Indian government was to be supervised and controlled in England. It did not alter in any substantial way the system of government that prevailed in India. Indian Councils Act of 1861. After the Great Revolt of 1857, the British government felt the necessity of seeking cooperation of the Indians in the administration of their country. In pursuance of this policy of association, 3 acts were enacted by the British Parliament in 1861, 1892, and 1909. The Indian Councils Act of 1861 is an important landmark in the constitutional and political history of India. The features of this act were as follows. It made a beginning of the representative institutions by associating Indians with the lawmaking process. It, thus, provided that the Viceroy should nominate some Indians as non-official members of his expanded council. In 1862, Lord Canning, the then Viceroy, nominated 3 Indians to his legislative council, the Raja of Benares, the Maharaja of Patiala, and Sir Dinkar Rao. 2. It initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies. It, thus, reversed the centralizing tendency that started from the Regulating Act of 1773 and reached its climax under the Charter Act of 1833. This policy of legislative devolution resulted in the grant of almost complete internal autonomy to the provinces in 1937. 3. It also provided for the establishment of new legislative councils for Bengal, northwestern provinces, and Punjab, which were established in 1862, 1886, and 1897, respectively. 4. It empowered the Viceroy to make rules and orders for the more convenient transaction of business in the council. It also gave a recognition to the portfolio system, introduced by Lord Canning in 1859. Under this, a member of the Viceroy's council was made in charge of one or more departments of the government and was authorized to issue final orders on behalf of the council on matters of his departments. 5. It empowered the Viceroy to issue ordinances, without the concurrence of the Legislative Council, during an emergency. The life of such an ordinance was 6 months. Indian Councils Act of 1892. The features of this act were as follows. 1. It increased the number of additional, non-official, members in the central and provincial legislative councils, but maintained the official majority in them. 2. It increased the functions of legislative councils and gave them the power of historical background. Z. Discussing the budget. 5. And addressing questions to the executive. 5. The system of budget was introduced in British India in I 860. 6. V. N. Shukla, The Constitution of India, Eastern Book Company, 8th edition, 2001, p. A. 10. 3. It provided for the nomination of some non-official members of the A. Central Legislative Council by the Viceroy on the recommendation of the Provincial Legislative Councils in the Bengal Chamber of Commerce, and b. that of the Provincial Legislative Councils by the governors on the recommendation of the district boards, municipalities, universities, trade associations, zamindars, and chambers. The Act made a limited and indirect provision for the use of election in filling up some of the non-official seats both in the central and provincial legislative councils. The word election was, however, not used in the Act. The process was described as nomination made on the recommendation of certain bodies. 6. Indian Councils Act of 1909. This act is also known as Morley-Minto Reforms. Lord Morley was the then Secretary of State for India and Lord Minto was the then Viceroy of India. The features of this act were as follows. 1. It considerably increased the size of the legislative councils, both central and provincial. The number of members in the Central Legislative Council was raised from 16 to 60. The number of members in the provincial legislative councils was not uniform. 2. It retained official majority in the Central Legislative Council, but allowed the provincial legislative councils to have non-official majority. 3. It enlarged the deliberative functions of the legislative councils at both levels. For example, members were allowed to ask supplementary questions, move resolutions on the budget, and so on. 6. Indian Polity. 4. It provided, for the first time, for the association of Indians with the executive councils of the Viceroy and governors. Satyendra Prasad Sinha became the first Indian to join the Viceroy's executive council. He was appointed as the law member. 5. It introduced a system of communal representation for Muslims by accepting the concept of separate electorate. Under this, the Muslim members were to be elected only by Muslim voters. Thus, the Act legalized communalism, and Lord Minto came to be known as the father of communal electorate. 6. It also provided for the separate representation of presidency corporations, chambers of commerce, universities, and zamindars. Government of India Act of 1919. On August 20, 1917, the British government declared, for the first time, that its objective was the gradual introduction of responsible government in India. 7. The declaration thus stated, the policy of His Majesty's government is that of the increasing association of Indians in every branch of the administration, and the gradual development of self-government institutions, with a view to the progressive realization of responsible government in India as an integral part of the British Empire. The Government of India Act of 1919 was thus enacted, which came into force in 1921. This act is also known as Montagu-Chelmsford Reforms. Montagu was the Secretary of State for India and Lord Chelmsford was the Viceroy of India. The features of this act were as follows. 1. It provided for the classification of all the subjects of administration into two categories, namely, the central subjects and the provincial subjects. This classification was done by the devolution rules framed under the Act. These rules facilitated the delegation of authority from the center to the provinces. In this way, the Act relaxed the central control over the provinces. The central and provincial legislatures were authorized to make laws on their respective list of subjects. However, the structure of government continued to be centralized and unitary. 2. It further divided the provincial subjects into two parts: transferred and reserved. The transferred subjects included public health, education, local self-government, agriculture, etc., while the reserved subjects included police, administration of justice, prisons, land revenue, finance, etc. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the Legislative Council. The reserved subjects, on the other hand, were to be administered by the governor and his executive council without being responsible to the Legislative Council. This dual scheme of governance was known as diarchy, a term derived from the Greek word diarchy, which means double rule. However, this experiment was largely unsuccessful. 3. It introduced, for the first time, bicameralism in direct elections in the country. Thus, the Indian Legislative Council was replaced by a bicameral legislature consisting of an upper house Council of State and a lower house Legislative Assembly. The majority of members of both the houses were chosen by direct election. 4. It required that the 3 of the 6 members of the Viceroy's Executive Council, other than the Commander-in-Chief, were to be Indian. 5. It extended the principle of communal representation by providing separate electorates for Sikhs, Indian Christians, Anglo-Indians, and Europeans. 6. It granted franchise to a limited number of people on the basis of property, tax, or other qualifications. 7. It created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. 8. It provided for the establishment of a Public Service Commission. Hence, a Central Public Service Commission was set up in 1926 for recruiting civil servants. 8. 9. It separated, for the first time, provincial budgets from the central budget and authorized the provincial legislatures to enact their budgets. 10. It provided for the appointment of a statutory commission to inquire into and report on its working after 10 years of its coming into force. 11. It proposed the establishment of a Chamber of Princes, also known as Narendra Mandal. The chamber was inaugurated in 1921. It consisted of 120 members, i.e., princes of 108 states and 12 representatives of other states. It was headed by the Viceroy, Governor-General. It facilitated the consultation and discussion on the matters of common interest. This was done on the recommendation of the Lee Commission on Superior Civil Services in India, 1923-24. Simon Commission in November 1927, i.e., 2 years before the schedule. The British government announced the appointment of a 7-member statutory commission under the chairmanship of Sir John Simon to report on the condition of India under its new constitution. All the members of the commission were British and hence, all the parties boycotted the commission. The commission submitted its report in 1930 and recommended the abolition of diarchy, extension of responsible government in the provinces, establishment of a federation of British India and princely states, continuation of communal electorate, and so on. Consider the proposals of the commission. The British government convened 3 round-table conferences of the representatives of the British government, British India, and Indian princely states. On the basis of these discussions, a white paper on constitutional historical background, M7. Reforms was prepared and submitted for the consideration of the Joint Select Committee of the British Parliament. The recommendations of this committee were incorporated, with certain changes, in the next Government of India Act of 1935. Communal Award in August 1932, Ramsay MacDonald, the British Prime Minister, announced a scheme of representation of the minorities, which came to be known as the Communal Award. The award not only continued separate electorates for the Muslims, Sikhs, Indian Christians, Anglo-Indians, and Europeans, but also extended it to the depressed classes, scheduled castes. Gandhiji was distressed over this extension of the principle of communal representation to the depressed classes and undertook a fast unto death in Yerwada jail, Pune, to get the award modified. At last, there was an agreement between the Congress and Dr. B.R. Ambedkar, the leader of the depressed classes. The agreement, known as the Pune Pact, retained the Hindu joint electorate and gave reserved seats to the depressed classes. The British government accepted the Pune Pact and modified the communal award in respect to the depressed classes, scheduled castes. This means that the provisions of separate electorates for the depressed classes were dropped from the scheme of representation contained in the communal award. Subsequently, the provisions of the Pune Pact were incorporated in the next Government of India Act of 1935. In other words, the The composition of the central and provincial legislatures under the 1935 Act was based on this modified communal award. Government of India Act of 1935. The Act marked a second milestone towards a completely responsible government in India. It was a lengthy and detailed document having 321 sections and 10 schedules. The features of this Act were as follows. 1. It provided for the establishment of an all-India federation consisting of provinces, 8 Indian Polity, and princely states as units. The Act divided the powers between the centre and units in terms of 3 lists: federal list, for centre, with 59 items, provincial list, for provinces, with 54 items, and the concurrent list, for both, with 36 items. Residuary powers were given to the Viceroy, Governor-General. However, the federation never came into being as the princely states did not join it. 2. It abolished diarchy in the provinces and introduced provincial autonomy in its place. The provinces were allowed to act as autonomous units of administration in their defined spheres. Moreover, the Act introduced responsible governments in provinces, that is, the governor was required to act with the advice of ministers responsible to the provincial legislature. This came into effect in 1937 and was discontinued in 1939. 3. It provided for the adoption of diarchy at the center. Consequently, the federal subjects were divided into reserved subjects and transferred subjects. However, this provision of the Act did not come into operation at all. 4. It introduced bicameralism in 6 out of 11 provinces. Thus, the legislatures of Bengal, Bombay, Madras, Bihar, Assam, and the United Provinces were made bicameral, consisting of a legislative council, upper house, and a legislative assembly, lower house. However, many restrictions were placed on them. 5. It reserved a certain number of general seats for the depressed classes, scheduled castes. It also extended the special representation to women and labor workers. 6. It abolished the Council of India, established by the Government of India Act of 1858. The Secretary of State for India was provided with a team of advisors. 7. It extended franchise. About 14% of the total population got the voting right. 8. It provided for the establishment of a Reserve Bank of India to control the currency and credit of the country. 9. It provided for the establishment of not only a Federal Public Service Commission, but also a Provincial Public Service Commission and Joint Public Service Commission for 2 or more provinces. 10. It provided for the establishment of a federal court, which was set up in 1937. 11. It separated Burma, now Myanmar, from India. 12. It created 2 new provinces of Orissa and Sindh. 13. It provided for safeguards to protect the interests of minorities. 14. It provided for the establishment of a Federal Railway Authority to look after the administration of railways. 15. It provided for the appointment of an Auditor General of India to audit the accounts of the Federation and the provinces. Indian Independence Act of 1947. On February 20, 1947, the British Prime Minister Clement Attlee declared that the British rule in India would end by June 30, 1948, after which the power would be transferred to responsible Indian hands. This announcement was followed by the agitation by the Muslim League demanding partition of the country. Again on June 3, 1947, the British government made it clear that any constitution framed by the Constituent Assembly of India, formed in 1946, cannot apply to those parts of the country which were unwilling to accept it. On the same day, June 3, 1947, Lord Mountbatten, the Viceroy of India, put forth the partition plan, known as the Mountbatten Plan. The plan was accepted by the Congress and the Muslim League. Immediate effect was given to the plan by enacting the Indian Independence Act 9, 1947. 9. The Indian Independence Bill was introduced in the British Parliament on July 4, 1947, and received the royal assent on July 18, 1947. The Act came into force on August 15, 1947. The features of this Act were as follows. 1. It ended the British rule in India and declared India as an independent and sovereign state from August 15, 1947. 2. It provided for the partition of India and creation of 2 independent dominions of India and Pakistan with the right to secede from the British Commonwealth. 3. It abolished the office of Viceroy and provided, for each dominion, a Governor-General who was to be appointed by the British King on the advice of the Dominion Cabinet. His Majesty's government in Britain was to have no responsibility with respect to the government of India or Pakistan. 4. It empowered the constituent assemblies of the 2 dominions to frame and adopt any constitution for their respective nations and to repeal any act of the British Parliament, including the Independence Act itself. 5. It empowered the constituent assemblies of both the dominions to legislate for their respective territories till the new constitutions were drafted and enforced. No act of the British Parliament passed after August 15, 1947 was to extend to either of the new dominions unless it was extended thereto by a law of the legislature of the dominion. 6. It abolished the office of the Secretary of State for India and transferred his functions to the Secretary of State for Commonwealth Affairs. 7. It proclaimed the lapse of British paramountcy over the Indian princely states and treaty relations with tribal areas from August 15, 1947. 8. It granted freedom to the Indian princely states either to join the Dominion of India or Dominion of Pakistan or to remain independent. 9. It provided for the governance of each of the dominions and the provinces by the Government of India Act of 1935 till the new constitutions were framed. The historical background. Dominions were, however, authorized to make modifications in the Act. 10. It deprived the British monarch of his right to veto bills or ask for reservation of certain bills for his approval. But this right was reserved for the Governor-General. The Governor-General would have full power to assent to any bill in the name of His Majesty. 11. It designated the Governor-General of India and the provincial governors as constitutional nominal heads of the states. They were made to act on the advice of the respective Council of Ministers in all matters. 12. It dropped the title of Emperor of India from the royal titles of the King of England. 13. It discontinued the appointment to civil services and reservation of posts by the Secretary of State for India. The members of the civil services appointed before August 15, 1947 would continue to enjoy all benefits that they were entitled to till that time. At the stroke of midnight of 14 to 15 August 1947, the British rule came to an end and power was transferred to the two new independent dominions of India and Pakistan. 10. Lord Mountbatten became the first Governor-General of the new Dominion of India. He swore in Jawaharlal Nehru as the first Prime Minister of independent India. The Constituent Assembly of India, formed in 1946, became the Parliament of the Indian Dominion. 10. The boundaries between the two dominions were determined by a boundary commission headed by Radcliffe. Pakistan included the provinces of West Punjab, Sindh, Baluchistan, East Bengal, Northwestern Frontier Province, and the district of Sylhet in Assam. The referendum in the Northwestern Frontier Province in Sylhet was in favor of Pakistan. The members of both the Interim Government, 1946, and the First Cabinet of Independent India, 1947, are mentioned in IBLs 1.1 and 1.2 respectively. Note: the members of the Interim Government were members of the Viceroy's Executive Council. The Viceroy continued to be the head of the Council. But Jawaharlal Nehru was designated as the Vice President of the Council. Table 1.1 Interim Government, 1946. As I know. Members' portfolios held underscore 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 1. Jawaharlal Nehru, Vice President of the Council. External Affairs and Commonwealth Relations. 2. Sardar Vallabhbhai Patel, Home, Information and Broadcasting. 3. Dr. Rajendra Prasad, Food and Agriculture. 4. Dr. John Matai, Industries and Supplies. 5. Jajivan Ram, Labor. 6. Sardar Baldev Singh, Defense. 7. C.H. Babha, Works, Mines and Power. 8. Liaquat Ali Khan, Finance. 9. Abdur Rab Nishtar, Posts and Air. 10. Asaf Ali, Railways and Transport. 11. C. Rajagopal Akari, Education and Arts. 12. L.L. Chandragar, Commerce. 13. Ghaznafar Ali Khan, Health. 14. Jojendra Nath Mundal, Law. Table 1.2 First Cabinet of Independent India, 1947. 51. No members' portfolios held underscore 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 1. Jawaharlal Nehru, Prime Minister. External Affairs and Commonwealth Relations. Scientific Research. 2. Sardar Vallabhbhai Patel, Home, Information and Broadcasting. States. 3. Dr. Rajendra Prasad, Food and Agriculture. 4. Maulana Abul Kalam Azad, Education. 5. Dr. John Matai, Railways and Transport. 6. R.K. Shanmugam Chetty, Finance. 7. Dr. B.R. Ambedkar, Law. 8. Jajivan Ram, Labor. 9. Sardar Baldev Singh, Defense. 10. Rajkumari Amrit Kaur, Health. 11. C.H. Babha, Commerce. 12. Rafi Ahmed Kidwai, Communication. 13. Dr. Shyama Prasad Mukherjee, Industries and Supplies. 14. V.N. Godgil, Works, Mines and Power. Chapter Making of the Constitution. Demand for a Constituent Assembly. It was in 1934 that the idea of a Constituent Assembly for India was put forward for the first time by M.N. Roy, a pioneer of the communist movement in India. In 1935, the Indian National Congress, Inc., for the first time, officially demanded a Constituent Assembly to frame the Constitution of India. In 1938, Jawaharlal Nehru, on behalf of the Inc., declared that the Constitution of Free India must be framed, without outside interference, by a Constituent Assembly elected on the basis of adult franchise. This view was endorsed and reiterated by the Inc. by passing a resolution in 1939. The demand was finally accepted in principle by the British government in what is known as the August Offer of 1940. In 1942, Sir Stafford Cripps, a member of the cabinet, came to India with a draft proposal of the British government on the framing of an independent constitution to be adopted after World War II. The Cripps proposals were rejected by the Muslim League, which wanted India to be divided into two autonomous states with two separate constituent assemblies. Finally, a cabinet mission was sent to India. While it rejected the idea of 12 constituent assemblies, it put forth a scheme for the constituent assembly which more or less satisfied the Muslim League. Two of these include Madras, Bombay, Up, Bihar, Central Provinces, Orissa, Punjab, NWP, Sindh, Bengal, and Assam. Three of these include Delhi, Ajmer Marwara, Coorg, and British Baluchistan. The cabinet mission, consisting of 3 members, Lord Pethick Lawrence, Sir Stafford Cripps, and A.V. Alexander, arrived in India on March 24, 1946. The cabinet mission published its plan on May 16, 1946. Composition of the Constituent Assembly. The Constituent Assembly was constituted in November 1946 under the scheme formulated by the cabinet mission plan. The features of the scheme were: 1. The total strength of the Constituent Assembly was to be 389. Of these, 296 seats were to be allotted to British India and 93 seats to the princely states. Out of 296 seats allotted to British India, 292 members were to be drawn from the 11 governors' provinces and 4 from the 4 chief commissioners' provinces, 1 from each. 2. 3-2. Each province and princely state, or group of states in case of small states, were to be allotted seats in proportion to their respective population. Roughly, 1 seat was to be allotted for every million population. 3. Seats allocated to each British province were to be divided among the 3 principal communities, Muslims, Sikhs, and general, all except Muslims and Sikhs, in proportion to their population. 4. The representatives of each community were to be elected by members of that community in the provincial legislative assembly, and voting was to be by the (2) Indian Polity method of proportional representation by means of single transferable vote. 5. The representatives of the princely states were to be nominated by the heads of the princely states. It is, thus, clear that the Constituent Assembly was to be a partly elected and partly nominated body. Moreover, the members were to be indirectly elected by the members of the provincial assemblies, who themselves were elected on a limited franchise for. The Government of India Act of 1935 granted limited franchise on the basis of tax, property, and other qualifications. The elections to the Constituent Assembly for 296 seats allotted to the British Indian provinces were held in July-August 1946. The Indian National Congress won 208 seats, the Muslim League 73 seats, and the small groups and independents got the remaining 15 seats. However, the 93 seats allotted to the princely states were not filled, as they decided to stay away from the Constituent Assembly. Although the Constituent Assembly was not directly elected by the people of India on the basis of adult franchise, the Assembly comprised representatives of all sections of Indian society: Hindus, Muslims, Sikhs, Parsis, Anglo-Indians, Indian Christians, SCs, ST, including women of all these sections. The Assembly included all important personalities of India at that time, with the exception of Mahatma Gandhi. The allocation of seats in the Constituent Assembly, the results of the elections to the Constituent Assembly, the community-wise representation in the Constituent Assembly, and the women members of the Constituent Assembly are mentioned in Tables 2.1, 2.2, 2.3, and 2.4 respectively. Working of the Constituent Assembly. The Constituent Assembly held its first meeting on December 9, 1946. The Muslim League boycotted the meeting and insisted on a separate state of Pakistan. The meeting was, thus, attended by only 207 members. Dr. Sachidananda Sinha, the oldest member, was elected as the temporary chairman of the Assembly, following the French practice. On December 11, 1946, Dr. Rajendra Prasad was elected as the permanent chairman, president, of the Assembly. Similarly, on January 25, 1947, H.C. Mukherjee was elected as the vice president of the Assembly. Later on, the Assembly resolved to have 2 vice presidents. Accordingly, on July 16, 1947, V.T. Krishnamachari was elected as the second vice president of the Assembly. Objectives Resolution. On December 13, 1946, Jawaharlal Nehru moved the historic Objectives Resolution in the Assembly. It laid down the fundamentals and philosophy of the constitutional structure. It read: 1. This Constituent Assembly declares its firm and solemn resolve to proclaim India as an independent sovereign republic and to draw up for her future governance a constitution. 2. Wherein the territories that now comprise British India, the territories that now form the Indian states, and such other parts of India as are outside India, and the states, as well as other territories as are willing to be constituted into the independent sovereign India, shall be a union of them all. And 3. Wherein the said territories, whether with their present boundaries or with such others as may be determined by the Constituent Assembly and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units together with residuary powers and exercise all powers and functions of government and administration save and except such powers and functions as are vested in or assigned to the Union or as are inherent or implied in the Union or resulting therefrom. And 4. Wherein all power and authority of the sovereign independent India, its constituent parts and organs of government are derived from the people, and 5. Wherein shall be guaranteed and secured to all the people of India justice, social, economic, and political, equality of status of opportunity and before the law, freedom of thought, expression, belief, faith, worship, vocation, association, and action, subject to law and public morality. And 6. Wherein adequate safeguards shall be provided for minorities, backward and tribal areas, and depressed and other backward classes. And 7. Whereby shall be maintained the integrity of the territory of the Republic and its sovereign rights on land, sea, and air according to justice and the law of civilized nations. And 8. This ancient land attains its rightful and honored place in the world and makes its full and willing contribution to the promotion of world peace and the welfare of mankind. This resolution was unanimously adopted by the Assembly on January 22, 1947. It influenced the eventual shaping of the Constitution through all its subsequent stages. Its modified version forms the preamble of the present Constitution. Changes by the Independence Act, the representatives of the princely states, who had stayed away from the Constituent Assembly, gradually joined it. On April 28, 1947, representatives of the 6 states 5 were part of the Assembly. After the acceptance of the Mountbatten Plan of June 3, 1947, for the partition of the country, the representatives of most of the other princely states took their seats in the Assembly. The members of the Muslim League from the Indian Dominion also entered the Assembly. 5 these include Baroda, Bikaner, Jaipur, Patiala, Rewa, and Udaipur. 6 For the first time, the Constituent Assembly met as Dominion Legislature on November 17, 1947 and elected G.V. Mavalankar as its Speaker. 7 These are West Punjab, East Bengal, NWP, Sindh, Baluchistan, and Sylhet District of Assam. A separate Constituent Assembly was set up for Pakistan. The Indian Independence Act of 1947 made the following 3 changes in the position of the Assembly. 1. The Assembly was made a fully sovereign body, which could frame any constitution it pleased. The Act, making of the Constitution for 13, empowered the Assembly to abrogate or alter any law made by the British Parliament in relation to India. 2. The Assembly also became a legislative body. In other words, 2 separate functions were assigned to the Assembly, that is, making of the Constitution for free India and enacting of ordinary laws for the country. These 2 tasks were to be performed on separate days. Thus, the Assembly became the first Parliament of Free India, Dominion Legislature. Whenever the Assembly met as the constituent body, it was chaired by Dr. Rajendra Prasad, and when it met as the legislative body, it was chaired by G.V. Mavalankar. These 2 functions continued till November 26, 1949, when the task of making the Constitution was over. 6. 3. The Muslim League members, hailing from the areas included in the Pakistan, withdrew from the Constituent Assembly for India. Consequently, the total strength of the Assembly came down to 299 as against 389 originally fixed in 1946 under the Cabinet Mission Plan. The strength of the Indian provinces, formerly British provinces, was reduced from 296 to 229, and those of the princely states from 93 to 70. The statewise membership of the Assembly as on December 31, 1947, is shown in Table 2.5. 7. Other functions performed. In addition to the making of the Constitution and enacting of ordinary laws, the Constituent Assembly also performed the following functions. 1. It ratified India's membership of the Commonwealth in May 1949. Indian Polity. 2. It adopted the national flag on July 22, 1947. 3. It adopted the national anthem on January 24, 1950. 4. It adopted the national song on January 24, 1950. 5. It elected Dr. Rajendra Prasad as the first President of India on January 24, 1950. In all, the Constituent Assembly had 11 sessions over 2 years, 11 months, and 18 days. The constitution makers had gone through the constitutions of about 60 countries, and the draft constitution was considered for 114 days. The total expenditure incurred on making the constitution amounted to 64 lakh. On January 24, 1950, the Constituent Assembly held its final session. It, however, did not end, and continued as the Provisional Parliament of India from January 26, 1950, till the formation of new Parliament 8 after the first general elections in 1951-52. 9. One of the political consequences of the British government's statement of June 1947, was that following a referendum, the Northwest Frontier Province and Baluchistan became part of the territory of the Dominion of Pakistan, and as a result the tribal areas in this region became a concern of that Dominion. The subcommittee on the Tibal areas in the Northwest Frontier Province and Baluchistan was not therefore called upon to function on behalf of the Constituent Assembly of India. B. Shiva Rao, The Framing of India's Constitution, Select Documents, Volume 3, p. 681. The members of this subcommittee were Khan Abdul Ghaffar Khan, Khan Abdul Samad Khan, and Mirchand Khanna. The information about the chairman is not found. The complete list of the sessions of the Constituent Assembly is given in Table 2.6. Committees of the Constituent Assembly. The Constituent Assembly appointed a number of committees to deal with different tasks of constitution making. Out of these, 8 were major committees and the others were minor committees. The names of these committees and their chairmen are given below. Major committees: 1. Union Powers Committee, Jawaharlal Nehru. 2. Union Constitution Committee, Jawaharlal Nehru. 3. Provincial Constitution Committee, Sardar Patel. 4. Drafting Committee, Dr. B.R. Ambedkar. The Provisional Parliament ceased to exist on April 17, 1952. The first elected parliament with the 2 houses came into being in May 1952. 5. Advisory Committee on Fundamental Rights, Minorities and Tribal and Excluded Areas, Sardar Patel. This committee had the following 5 subcommittees: A. Fundamental Rights Subcommittee, J.B. Kripalani. B. Minorities Subcommittee, H.C. Mukherjee. C. Northeast Frontier Tribal Areas and Assam Excluded and Partially Excluded Areas Subcommittee, Gopinath Bardaloy. D. Excluded and Partially Excluded Areas, other than those in Assam, Subcommittee, A.V. Thackeray. Northwest Frontier Tribal Areas Sub, Committee 9-6. Rules of Procedure Committee, Dr. Rajendra Prasad. 7. States Committee, Committee for Negotiating with States, Jawaharlal Nehru. 8. Steering Committee, Dr. Rajendra Prasad. Minor Committees: 1. Finance and Staff Committee, Dr. Rajendra Prasad. 2. Credentials Committee, Aladi Krishnaswamy Iyer. 3. Allows Committee, B. Pattabhi Sitaramaiah. 4. Order of Business Committee, Dr. K.M. Munshi. Making of the Constitution. F. 5. Ad Hoc Committee on the National Flag, Dr. Rajendra Prasad. 6. Committee on the Functions of the Constituent Assembly, G.V. Mavalankar. 7. Ad Hoc Committee on the Supreme Court, S. Varadikari, not an Assembly member. 8. Committee on Chief Commissioners Provinces. 8. Pattabhi Sitaramaiah. 9. Expert Committee on the Financial Provisions of the Union Constitution, Nalini Ranjan Sarikar, not an Assembly member. 10. Linguistic Provinces Commission, S.K. Dar, not an Assembly member. 11. Special Committee to Examine the Draft Constitution, Jawaharlal Nehru. 12. Press Gallery Committee, Ushanathan. 13. Ad Hoc Committee on Citizenship, S. Varadikari, not an Assembly member. Drafting Committee. Among all the committees of the Constituent Assembly, the most important committee was the Drafting Committee, set up on August 29, 1947. It was this committee that was entrusted with the task of preparing a draft of the new Constitution. It consisted of 7 members. They were: 1. Dr. B.R. Ambedkar, Chairman. 2. N. Gopal Subramanian Iyengar. 3. Aladi Krishnaswamy Iyer. 4. Dr. K. Munshi. 5. Syed Muhammad Sadullah. 6. N. Madhava Rao. He replaced B.L. Mitter, who resigned due to ill health. 7. T.E. Krishnamachari. He replaced D.P. Khaitan, who died in 1948. The Drafting Committee, after taking into consideration the proposals of the various committees, prepared the first draft of the Constitution of India, which was published in February 1948. The people of India were given 8 months to discuss the draft and propose amendments. In light of the public comments, criticisms, and suggestions, the Drafting Committee prepared a second draft, which was published in October 1948. The Drafting Committee took less than 6 months to prepare its draft. In all, it sat only for 141 days. Enactment of the Constitution. Dr. B.R. Ambedkar introduced the final draft of the Constitution in the Assembly on November 4, 1948, first reading. The Assembly had a general discussion on it for 5 days, till November 9, 1948. The second reading, clause-by-clause consideration, started on November 15, 1948, and ended on October 17, 1949. During this stage, as many as 7,653 amendments were proposed, and 2,473 were actually discussed in the Assembly. The third reading of the draft started on November 14, 1949. Dr. B.R. Ambedkar moved a motion, the Constitution as settled by the Assembly be passed. The motion on draft Constitution was declared as passed on November 26, 1949, and received the signatures of the members and the President. Out of a total 299 members of the Assembly, only 284 were actually present on that day and signed the Constitution. This is also the date mentioned in the Preamble as the date on which the people of India in the Constituent Assembly adopted, enacted, and gave to themselves this Constitution. The Constitution, as adopted on November 26, 1949, contained a preamble, 395 articles, and 8 schedules. The preamble was enacted after the entire Constitution was already enacted. Dr. B.R. Ambedkar, the then Law Minister, piloted the draft Constitution in the Assembly. He took a very prominent part in the deliberations of the Assembly. He was known for his logical, forceful, and persuasive arguments on the floor of the Assembly. He is recognized as the father of the Constitution of India. This brilliant writer, constitutional expert, and undisputed leader of the scheduled castes is 16 Indian Polity, also known as the chief architect of the Constitution of India. On November 19, 2015, the Government of India has decided to celebrate the November 26th of every year as the Constitution Day Sambitan Divas, to promote constitutional values among citizens. T. Enforcement of the Constitution. Some provisions of the Constitution pertaining to citizenship, elections, provisional parliament, temporary and transitional provisions, and short title contained in Articles 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392, and 393 came into force on November 26, 1949, itself. The remaining provisions, the major part of the Constitution, came into force on January 26, 1950. This day is referred to in the Constitution as the date of its commencement and celebrated as the Republic Day. January 26th was specifically chosen as the date of commencement of the Constitution because of its historical importance. It was on this day in 1930 that Puma Swaraj Day was celebrated, following the resolution of the Lahore Session, December 1929, of the Inc. With the commencement of the Constitution, the Indian Independence Act of 1947 and the Government of India Act of 1935, with all enactments amending or supplementing the latter act, were repealed. The abolition of Privy Council Jurisdiction Act, 1949, was however continued. Experts Committee of the Congress underscore 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 while elections to the Constituent Assembly were still in progress, on July 8, 1946, the Congress Party, Indian National Congress, appointed an experts committee for the purpose of preparing material for the Constituent Assembly. This committee consisted of the following members: 1. Jawaharlal Nehru, Chairman. 2. M. Asaf Ali. 3. K. M. Munshi. 4. N. Gopalaswamy, Iyengar. 5. K.T. Shah. 6. D.R. Godgil. 7. Humayun Kabir. 8. K. Santhanam. Later, on the chairman's proposal, it was resolved that Krishna Kripalani be co-opted as member and convener of the committee. The committee had 2 sittings, the first at New Delhi from July 20th to 22nd, 1946, and the second at Bombay from August 15th to 17th, 1946. Apart from a number of notes prepared by its members, the committee discussed the procedure to be adopted by the Constituent Assembly, the question of the appointment of various committees, and the draft of a resolution on the objectives of the Constitution to be moved during the first session of the Constituent Assembly. On the role played by this committee in the making of the Constitution, Granville Austin, an American constitutional expert, observed, "It was the Congress Experts Committee that set India on the road to her present constitution." The committee members, working within the framework of the Cabinet Mission Scheme, made general suggestions about autonomous areas, the powers of provincial governments and the center, and about such issues as the princely states and the amending power. They also drafted a resolution, closely resembling the Objectives Resolution. Criticism of the Constituent Assembly. The critics have criticized the Constituent Assembly on various grounds. These are as follows: 1. Not a representative body. The critics have argued that the Constituent Assembly was not a representative body as its members were not directly elected by the people of India on the basis of universal adult franchise. 2. Not a sovereign body. The critics maintained that the Constituent Assembly was not a sovereign body as it was created by the proposals of the British government. Further, they said that the making of the Constitution M17 Assembly held its sessions with the permission of the British government. 3. Time-consuming. According to the critics, the Constituent Assembly took an unduly long time to make the Constitution. They stated that the framers of the American Constitution took only 4 months to complete their work. In this context, Nazaruddin Ahmed, a member of the Constituent Assembly, coined a new name for the drafting committee to show his contempt for it. He called it a drifting committee. The time taken by the framers of other constitutions is given in Table 2.7. 4. Dominated by Congress. The critics charged that the Constituent Assembly was dominated by the Congress Party. In this context, Granville Austin, an American constitutional expert, remarked, "The Constituent Assembly was a one-party body in an essentially one-party country. The Assembly was the Congress and the Congress was India." 5. Lawyer-politician domination. It is also maintained by the critics that the Constituent Assembly was dominated by lawyers and politicians. They pointed out that other sections of the society were not sufficiently represented. This, to them, is the main reason for the bulkiness and complicated language of the Constitution. 6. Dominated by Hindus. According to some critics, the Constituent Assembly was a Hindu-dominated body. Lord Viscount Simon called it a body of Hindus. Similarly, Winston Churchill commented that the Constituent Assembly represented only one major community in India. Important facts. 3. H.V.R. Iyengar was the secretary to the Constituent Assembly. 4. S.N. Mukherjee was the chief draftsman of the Constitution in the Constituent Assembly. 5. Prem Bihari Narain Rezada was the calligrapher of the Indian Constitution. The original Constitution was handwritten by him in a flowing italic style. 6. The original version was beautified and decorated by artists from Shantiniketan, including Nan Lal Bose and Bihar Ramanohar Sinha. 7. Bihar Ramanohar Sinha illuminated, beautified, and ornamented the original preamble calligraphed by Prem Bihari Narain Rezada. 8. The calligraphy of the Hindi version of the original Constitution was done by Vasant Krishan Vaidya and elegantly decorated and illuminated by Nan Lal Bose. Hindi text of the Constitution. Originally, the Constitution of India did not make any provision with respect to an authoritative text of the Constitution in the Hindi language. Later, a provision in this regard was made by the 58th Constitutional Amendment Act of 1987. This amendment inserted a new Article 394A in the last part of the Constitution, i.e., Part 22. This article contains the following provisions. 1. The President shall cause to be published under his authority, the translation of the Constitution in Hindi language. The modifications which are necessary to bring it in conformity with the language, style, and terminology adopted in the authoritative texts of the Central Acts in Hindi can be made in it. All the amendments of the Constitution made before such publication should be incorporated in it. 2. The translation in Hindi of every amendment of the Constitution made in English. 1. The elephant was adopted as the symbol, seal, of the Constituent Assembly. 2. Sir B.N. Rao was appointed as the constitutional advisor, legal advisor, to the Constituent Assembly. 18. Indian Polity. 2. The translation of the Constitution and its every amendment published shall be construed to have the same meaning as the original text in English. If any difficulty arises in this matter, the President shall cause the Hindi text to be revised suitably. 3. The translation of the Constitution and its every amendment published shall be deemed to be, for all purposes, its authoritative text in Hindi. Table 2.1 Allocation of seats in the Constituent Assembly of India, 1946. SI. No. Areas seats. 1. British Indian Provinces, 11, 292. 2. Princely States, Indian States, 93. 3. Chief Commissioners Provinces, 4. 4. Total 389. Table 2.2 Results of the elections to the Constituent Assembly, July-August 1946. SI. No. Name of the party seats 1. 1. Congress 208. 2. Muslim League 73. 3. Unionist Party 1. 4. Unionist Muslims 1. 5. Unionist Scheduled Caste 1. 6. Krishak, Praja Party 1. 7. Scheduled Caste Federation 1. 8. Sikhs and Non-Congress 1. 9. Communist Party 1. 10. Independents 8. Total 296. Table 2.3 Community-wise representation in the Constituent Assembly, 1946. ISI. No. Community Strength 1. Hindus 163. 2. Muslims 80. 3. Scheduled Caste 31. 4. Indian Christians 6. 5. Backward Tribes 6. 6. Sikhs 4. 7. Anglo-Indians 3. 3. Parsis 3. Total 296. Table 2.4 Women members of the Constituent Assembly SI. No. Name Constituency 1. Amma Swaminathan Madras General. 2. Annie Mascarene Travancore and Cochin Union. 3. Begum Izaz Rasool United Provinces Muslim 4. Dukshani Velayudin Madras General 5. G. Durgabai Madras General 6. Handsome Mehta Bombay General 7. Kamla Chaudhry United Provinces General 8. Leela Ray West Bengal General 9. Malati Chowdhury Orissa General 10. Purnima Banerjee United Provinces General 11. Rajkumari Amrit Kaur Central Provinces and Berar General making of the Constitution. SI. No. Name Constituency IIR. Renuka Ray West Bengal General 13. Sarojini Naidu Bihar General 14. Sucheta Kripalani United Provinces General 15. Vijay Lakshmi Pundit United Provinces General. Note, in total, the Constituent Assembly had 15 women members. Source, Selected Speeches of Women Members of the Constituent Assembly, Rajya Sabha Secretariat, 2012, page LX. Table 2.5 Statewise membership of the Constituent Assembly of India as on December 31, 1947. Continued. 20 Indian Polity. SI. No. Name no. Of members 15. Reva 216. Travancore 617. Udaipur 218. Sikkim and Cooch Behar Group 1 IS. Tripura, Manipur, and Khasi States. Group 1. 20. UP States Group 121. Eastern Rajputana States Group 322. Central India States Group and Clut. ING Bundelkhand and Malva. 3. 23. Western India States Group 424. Gujarat States Group 225. Deccan and Madras States Group 2M26. Punjab States Group 327. Eastern States Group I428. Eastern States Group 2329. Residuary States Group 4. Total 299. Table 2.6 Sessions of the Constituent Assembly at a glance. First session December 9-23, 1946. Second session January 20th to 25th, 1947. Third session April-May 28th to 1947. Fourth session July 14-31, 1947. Fifth session August 14th to 30th, 1947. Sixth session January 27, 1948. Seventh session November 4, 1948, January 8, 1949. Eighth session May 16, June 16, 1949. Ninth session July 30, September 18, 1949. 10th session October 6-17, 1949. 11th session November 14-26, 1949. Note: the Assembly met once again on January 24, 1950, when the members appended their signatures to the Constitution of India. Mokingoth Constitution 21. Table 2.7 Time taken by the framers of other constitutions 10. SI. No. Country no. Of articles working period time taken 1 USA May 7, 25, 1787 to September 17, 1787. Less than 4 months. 2 Canada 147 October 10, 1864. To March 1867. About 2 years and 6 months. 3 Australia 128 March 1891 to July 9, 1900. About 9 years. 4 South Africa 153 October 1908 to September 20, 1909. 1 year. 10 J.R. Savach, Dynamics of Indian Government and Politics, Sterling Publishers Private Limited, 2nd edition, 1990, p. 10. Table 2.8 Articles related to short title, commencement, Hindi text, and repeals at a glance. Chapter Concept of the Constitution. T. Meaning. The term constitution is derived from the Latin word constituere, which means to establish or to set up. In the present sense, the term constitution refers to a set of principles which specify the organization and working of the government and the relationship between the government and the people in terms of their rights and duties. The Constitution is variously described as the fundamental law of the land, supreme law of the state, basic law of the country, instrument of the government, rules of the state, basic structure of the polity, grundnorm of the country, and so on. Political scientists and constitutional experts have defined the Constitution in the following way. Gilchrist: the Constitution consists of that body of rules or laws which determine the organization of government, the distribution of powers to the various organs of government, and the general principles on which these powers are to be exercised. 1. To Gittel, R.G., Political Science, 1956, p. 244. 3 Ware, K.C., Modern Constitutions, 1956, p. 1. For Wade and Phillips, Constitutional Law, 1965, p. 1. Elliott Bulmer, What is a Constitution? Principles and Concepts, International Idea Constitution, Building Primer 1, 2nd edition, 2017, International Institute for Democracy and Electoral Assistance, pp. 6-7. Gittel, the fundamental principles that determine the form of a state are called its constitution. These include the method of which the state is organized, the distribution of its sovereign powers among the various organs of government, the scope and manner of exercise of governmental functions, and the Gilchrist, R.N., Principles of Political Science, 1961, p. 211. Relation of the government to the people over whom its authority is exercised. 2. Where, the Constitution describes the whole system of government of a country, the collection of rules which establish and regulate or govern the government. 3. Wade and Phillips, a constitution is a document having a special legal sanctity which sets out the framework and the principal functions of the organs of the government of a state and declares the principles governing the operation of those organs. 4. T. Functions. The constitutional scholar, Elliott Bulmer, has very well identified the functions or purposes of a constitution. His list is comprehensive and includes the following points. 1. It can declare and define the boundaries of the political community. 2. It can declare and define the nature and authority of the political community. 3. It can express the identity and values of a national community. Concept of the Constitution 23. 4. It can declare and define the rights and duties of citizens. 5. It can establish and regulate the political institutions of the community. 6. It can divide or share power between different layers of government or sub-state communities. 7. It can declare the official religious identity of the state and demarcate relationships between sacred and secular authorities. 8. It can commit states to particular social, economic, or developmental goals. F. Qualities. There are some qualities or characteristics of a good constitution. These are explained below. 1. Brevity. A constitution should be precise and should not contain unwanted provisions. A lengthy constitution with too many details creates confusion in the interpretation of its clauses. 2. Clarity. A constitution should specify its provisions in clear terms. A complicated language would reduce the degree of its understanding. 3. Definiteness. A constitution should contain a definite meaning for its provisions. The ambiguous and different meanings would increase the discretion of the judges in their interpretation. 4. Comprehensiveness. A constitution should be comprehensive in laying down the powers of the government as well as the rights and duties of the citizens. This would reduce the scope for controversies and litigations. 5. Suitability. A constitution should reflect the needs and aspirations of the people. It must be suitable to the historical, socio-cultural, economic, and political conditions of the nation. 6. Stability. A constitution should facilitate political stability and should not allow easy tampering. This would strengthen the obedience of the citizens to the Constitution. 7. Adaptability. A constitution should be dynamic and not static. It should be able to adapt itself to changing situations and requirements. It should be a living document. F. Classification. The constitutions are classified into the following types. Q. Evolved and enacted on the basis of evolution. The constitutions are classified into evolved and enacted constitutions. An evolved constitution is the outcome of a slow and gradual evolutionary process. Its provisions are contained in the form of conventions, practices, principles, and judicial decisions. It is also known as a cumulative constitution, and the British Constitution is a good example in this regard. An enacted constitution, on the other hand, is deliberately made by a constituent assembly or a constitutional council or promulgated by a king or parliament. Its provisions are contained in the form of a book or a document or a series of documents. It is also known as a conventional constitution, and the American and Indian constitutions are the good examples in this regard. Written and unwritten. On the basis of incorporation of provisions, the constitutions are classified into written and unwritten constitutions. A written constitution is one in which the provisions are incorporated in the form of a book or a document or a series of documents. It is consciously formulated and adopted by a body known as the Constituent Assembly or the Constitutional Convention or by any other name. It is also known as a documentary constitution or a codified constitution. The constitutions of the USA, Canada, Japan, France, and India are some of the good examples in this regard. 24. Indian Polity. An unwritten constitution, on the other hand, is one in which most of the provisions are not incorporated in the form of a book or a document or a series of documents. It is found in the form of conventions, practices, principles, charters, statutes, and judicial decisions. It is a product of historical evolution and not deliberately formulated by a body. It is also known as a non-documentary constitution or an uncodified constitution, and the constitutions of UK, New Zealand, and Israel are the good examples in this regard. The distinction between a written constitution and an unwritten constitution is more or less the same as is between an evolved constitution and an enacted constitution. Rigid and flexible. Based on the method of amendment, the constitutions are classified into rigid and flexible constitutions. This classification was given by Lord James Bryce 6 Bryce, J. Studies in History and Jurisprudence, Volume 1, p. 127. 7 same as footnote 5 above, pp. 9-10. A rigid constitution is one which cannot be amended in the same manner as the ordinary laws. It requires a special procedure for its amendment. In other words, it makes a distinction between the constitutional law and the ordinary law. A flexible constitution, on the other hand, is one which can be amended in the same manner as the ordinary laws. It does not require a special procedure for its amendment. In other words, it does not make a distinction between the constitutional law and the ordinary law. A flexible constitution is also known as an elastic constitution, and the constitutions of UK and New Zealand are some good examples in this regard. A rigid constitution is also known as an inelastic constitution, and the constitutions of the USA, Australia, and Switzerland are some examples in this regard. The Constitution of India is neither rigid nor flexible, but a synthesis of both. Federal and unitary. Based on the nature of relationship between the national government and the regional governments, the constitutions are classified into federal and unitary constitutions. A federal constitution is one which provides for a division of power between the national government and the regional governments. It enables them to operate in their respective jurisdictions independently. A unitary constitution, on the other hand, is one which provides for the concentration of power in the hands of the national government. It makes the regional governments to operate as the subordinate agencies of the national government and exercise only such powers which may be delegated to them by the national government. Federal constitution is prevalent in the USA, Switzerland, Australia, Canada, Russia, Brazil, and some other states. Unitary constitution is prevalent in the UK, France, Japan, China, Italy, Norway, and other states. The Constitution of India contains both the federal provisions as well as the unitary provisions. Hence, it was described as quasi-federal by K.C. Ware. 31 Procedural and prescriptive. According to the constitutional scholar, Elliot Bulmer, two broad constitutional archetypes can be identified, the procedural and the prescriptive. The difference between these two types of constitutions relate to the nature and purposes of the document itself. 7. A procedural constitution defines the legal and political structures of public institutions and sets out the legal limits of government power to protect democratic processes and fundamental human rights. In addition to describing how the government functions, a prescriptive constitution assumes, or attempts to impose, a broad consensus on common societal goals that public authorities must strive to achieve. Concept of the Constitution. 25. Constitutionalism and constitutional government. Meaning. The concepts of constitution and constitutionalism are closely related to each other, but there are a few differences between them. Like 1. A country may have the constitution, but not necessarily constitutionalism. For example, a country with a dictatorship, where the dictator's word is law, can be said to have a constitution, but not constitutionalism. 8. 2. Constitutionalism recognizes the need for government with power but, at the same time, insists that limitations should be placed on those powers. Unlimited power may lead to an authoritarian, oppressive government which jeopardizes the freedom of the people. Only when the constitution of a country imposes limitation upon governmental power does a country have not only a constitution, but also constitutionalism. 9. 3. The concept of constitutionalism is that of a polity governed by or under a constitution that ordains essentially limited government and rule of law as opposed to arbitrary, despotic, authoritarian, or totalitarian rule. Constitutional government should necessarily be democratic government. Arbitrary power in the hands of any individual or institution, even if conferred by a constitutional document, is a negation of the concept of constitutionalism. 10. 4. Constitutionalism desires a political order in which the power of the government are limited. It is another name for the concept of a limited, and for this reason. In Johari, J.C., Comparative Politics, 4th edition, Sterling Publishers Private Limited, New Delhi, 2011, p. 217. 12 Friedrich, Carl J. Constitutional Government and Democracy, Oxford and IBH, Calcutta, 1964, p. 25. 3 Rusek, J.S. and others, Introduction to Political Science, 1954, p. 981. 14 Ware, K.C., Modern Constitutions, Oxford University Press, London, 1956, p. 137. 8 Jain, M.P., Indian Constitutional Law, 8th edition, LexisNexis, Gurgaon, 2018, p. 6. 9 Ibid. 10 Kashyap, Dr. Subhash C. Constitutional Law of India, 2nd edition, Volume 1, Universal Law Publishing, Gurgaon, 2015, p. 7. A civilized government. The real justification of the Constitution finds place in having a limited government and of requiring those who govern to conform to laws and rules. 11. FH definition. The concepts of constitutionalism and constitutional government have been defined in the following way. Friedrich, constitutionalism provides a system of effective restraints upon governmental action. It is a body of rules ensuring fair play, thus rendering the government responsible. 12. Rusek, constitutionalism means essentially limited government. It is the antithesis of government by the unrestrained will be of rulers. Regardless of the actual form of effectiveness of restraints, it assumes limitations on government as opposed to arbitrary government. 13. Where constitutional government means something more than a government according to the terms of a constitution. It means government according to rule as opposed to arbitrary government. It means government limited by the terms of a constitution, not government limited only by the desires and capacities of those who exercise power. 14. Ibima, a form of government can only be classified as constitutional when the rulers are subject to a body of rules and principles which limit the exercise of their power. 26 Indian Polity. Constitutional government is the antithesis of arbitrary rule. 1. 15 Ibima, S.B., Constitutionalism and Civil Liberties, Leiden University Press, Leiden, 1973, p. 1. 16 Hankin, Lewis, A New Birth of Constitutionalism, Genetic Influences and Genetic Defects, Chapter 2 in Constitutionalism, Identity, Difference and ESI Elements. The constitutional scholar, Lewis Hankin, identified 8 elements, features, or principles of constitutionalism. These are mentioned below. 156. 1. Popular sovereignty. 2. Rule of law. 3. Democratic government, responsible and accountable government. 4. Separation of powers, checks and balances. 5. An independent judiciary. 6. Civilian control of the military. 7. Police governed by law and judicial control. 8. Respect for individual rights. Legitimacy, Theoretical Perspectives, edited by Michelle Rosenfeld, Duke University Press, Durham, 1994, pp. 39-54. Chapter 4 Salient Features of the Constitution. The Indian Constitution is unique in its contents and spirit. Though borrowed from almost every constitution of the world, the Constitution of India has several salient features that distinguish it from the constitutions of the other countries. It should be noted at the outset that a number of original features of the Constitution, as adopted in 1949, have undergone a substantial change on account of several amendments, particularly 7th, 42nd, 44th, 73rd, 74th, 97th, and 101st Amendments. In fact, the 42nd Amendment Act, 1976, is known as Mini-Constitution due to the important and large number of changes made by it in various parts of the Constitution. However, in the case of amenability Case 1, 1973, the Supreme Court ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. One case of amenability versus Staff of Kerala, 1973. 2. The American Constitution originally consisted of only 7 articles, the Australian 128, the Chinese 138, and the Canadian 147. Salient features of the Constitution. The salient features of the Constitution, as it stands today, are as follows. Q. Lengthiest written Constitution. Constitutions are classified into written, like the American Constitution, or unwritten, like the British Constitution. The Constitution of India is the lengthiest of all the written constitutions of the world. It is a very comprehensive, elaborate, and detailed document. Originally, 1949, the Constitution contained a preamble, 395 articles, divided into 22 parts, and 8 schedules. Presently, it consists of a preamble, about 470 articles, divided into 25 parts, and 12 schedules. The various amendments carried out since 1951 have deleted about 20 articles in one part, 7, and added about 95 articles, for parts, IVA, IXA, IXB, and ZIVA, and 4 schedules, 9, 10, 11, and 12. No other constitution in the world has so many articles and schedules too. The parts, important articles, and schedules of the Constitution of India are mentioned in Tables 4.1, 4.2, and 4.3 respectively. 4 factors have contributed to the elephantine size of our Constitution. They are A. Geographical factors, that is, the vastness of the country and its diversity. B. Historical factors, e.g., the influence of the Government of India Act of 1935, which was bulky. C. Single constitution for both the center and the states. D. Dominance of legal luminaries in the Constituent Assembly. The Constitution contains not only the fundamental principles of governance, but also detailed administrative provisions. Further, those matters which in other modern democratic countries have been left to the ordinary legislation or established political conventions have also been included in the constitutional document itself in India. $28 Indian Polity. Till 2019, the erstwhile state of Jammu and Kashmir had its own constitution and thus enjoyed a special status by virtue of Article 370 of the Constitution of India. In 2019, this special status was abolished by a presidential order known as the Constitution, Application to Jammu and Kashmir, Order, 2019. This order superseded the earlier order known as the Constitution, Application to Jammu and Kashmir, Order, 1954. The 2019 order extended all the provisions of the Constitution of India to Jammu and Kashmir also. Further, the Jammu and Kashmir Reorganization Act, 2019, bifurcated the erstwhile state of Jammu and Kashmir into 2 separate union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. Drawn from various sources. The Constitution of India has borrowed most of its provisions from the constitutions of various other countries as well as from the Government of India Act of 19,353. Dr. B.R. Ambedkar proudly acclaimed that the Constitution of India has been framed after ransacking all the known constitutions of the world 45. 3. About 250 provisions of the 1935 Act have been included in the Constitution. Constituent Assembly Debates, Volume 7, pp. 35-38. 5 P.M. Bakshi, The Constitution of India, Universal, 5th edition, 2002, p. 4. The structural part of the Constitution is, to a large extent, derived from the Government of India Act of 1935. The philosophical part of the Constitution, the fundamental rights and the directive principles of state policy, derives its inspiration from the American and Irish constitutions, respectively. The political part of the Constitution, the principle of cabinet government and the relations between the executive and the legislature, has been largely drawn from the British Constitution. The other provisions of the Constitution have been drawn from the constitutions of Canada, Australia, Germany, USSR, now Russia, France, South Africa, Japan, and so on. The most profound influence and material source of the Constitution is the Government of India Act, 1935. The federal scheme, judiciary, governors, emergency powers, the public service commissions, and most of the administrative details are drawn from this act. More than half of the provisions of Constitution are identical to or bear a close resemblance to the Act of 1935K. The features, provisions, of the Constitution that have been borrowed from various sources are mentioned in Table 4.4. Blend of rigidity and flexibility constitutions are also classified into rigid and flexible. A rigid constitution is one that requires a special procedure for its amendment, as for example, the American Constitution. A flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary laws are made, as for example, the British Constitution. The Constitution of India is neither rigid nor flexible, but a synthesis of both. Article 368 provides for two types of amendments. A. Some provisions can be amended by a special majority of the Parliament, i.e., a two-third majority of the members of each House present and voting, and a majority of the total membership of each House. B. Some other provisions can be amended by a special majority of the Parliament and with the ratification by half of the total states. At the same time, some provisions of the Constitution can be amended by a simple majority of the Parliament in the manner of ordinary legislative process. Notably, these amendments do not come under Article 368. EBI federal system with unitary bias. The Constitution of India establishes a federal system of government. It contains all the F. Brijkishore Sharma, Introduction to the Constitution of India, 7th edition, 2015, PHI Learning Private Limited, p. 42. 2. 3. Salient features of the Constitution. 29. Usual features of a federation, viz. Two governments, division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary, and bicameralism. However, the Indian Constitution also contains many unitary or non-federal features, viz. A strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state governor by the center, all India services, emergency provisions, and so on. Moreover, the term federation has nowhere been used in the Constitution. Article 1, on the other hand, describes India as a union of states, which implies two things. 1. The Indian Federation is not the result of an agreement by the states. And 2. No state has the right to secede from the federation. Hence, the Indian Constitution has been variously described as federal in form, but unitary in spirit, quasi-federal, by K.C. Ware, Bargaining Federalism, by Morris Jones, Cooperative Federalism, by Granville Austin, Federation with a centralizing tendency, by Ivor Jennings, and so on. SI Parliamentary form of government. The Constitution of India has opted for the British parliamentary system of government rather than the American presidential system of government. The parliamentary system is based on the principle of cooperation and coordination between the legislative and executive organs, while the presidential system is based on the doctrine of separation of powers between the two organs. The parliamentary system is also known as the Westminster 7 model of government, responsible government, and cabinet government. The Constitution establishes the parliamentary system not only at the center, but also in the states. Westminster is a place in London where the British Parliament is located. It is often used as a symbol synonym of the British Parliament. The features of parliamentary government in India are A. Presence of nominal and real executives, B. Majority party rule, C. Collective responsibility of the executive to the legislature, D. Membership of the ministers in the legislature, E. Leadership of the prime minister or the chief minister, F. Dissolution of the lower house, Lok Sabha or assembly, even though the Indian parliamentary system is largely based on the British pattern. There are some fundamental differences between the two. For example, the Indian Parliament is not a sovereign body like the British Parliament. Further, the Indian state has an elected head, republic, while the British state has a hereditary head, monarchy. In a parliamentary system, whether in India or Britain, the role of the prime minister has become so significant and crucial that the political scientists like to call it a prime ministerial government. A synthesis of parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. Just as the Indian parliamentary system differs from the British system, the scope of judicial review power of the Supreme Court in India is narrower than that of what exists in the U.S. This is because the American Constitution provides for due process of law against that of procedure established by law contained in the Indian Constitution, Article 21. Therefore, the framers of the Indian Constitution have preferred a proper synthesis between the British principle of parliamentary sovereignty and the American principle of judicial supremacy. The Supreme Court, on the one hand, can declare the parliamentary laws as unconstitutional through its power of 30 Indian Polity. Judicial review. The Parliament, on the other hand, can amend the major portion of the Constitution through its constituent power. Integrated and independent judiciary. The Indian Constitution establishes a judicial system that is integrated as well as independent. The Supreme Court stands at the top of the integrated judicial system in the country. Below it, there are high courts at the state level. Under a high court, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. This single system of courts enforces both the central laws as well as the state laws, unlike in USA, where the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. The Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens, and the guardian of the Constitution. Hence, the Constitution has made various provisions to ensure its independent security of tenure of the judges, fixed service conditions for the judges, all the expenses of the Supreme Court charged on the Consolidated Fund of India, Prohibition on discussion on the conduct of judges in the legislatures, ban on practice after retirement, power to punish for its contempt vested in the Supreme Court, separation of the judiciary from the executive, and so on. 131 Fundamental Rights Part 3 of the Indian Constitution guarantees 6 fundamental rights to all the citizens. A. Right to equality, Articles 14 to 18. B. Right to freedom, Articles 19 to 22. C. Right against exploitation, Articles 23 to 24. D. Right to freedom of religion, Articles 25 to 28. E. Cultural and educational rights, Articles 29 to 30. And F. Right to constitutional remedies. Article 32. Originally, the Constitution provided for 7 fundamental rights. However, the right to property, Article 31, was deleted from the list of fundamental rights by the 44th Amendment Act of 1978. It is made a legal right under Article 300, A in Part 12 of the Constitution. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. They are justiciable in nature, that is, they are enforceable by the courts for their violation. The aggrieved person can directly go to the Supreme Court, which can issue the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto for the restoration of his rights. However, the fundamental rights are not absolute and subject to reasonable restrictions. Further, they are not sacrosanct and can be curtailed or repealed by the Parliament through a Constitutional Amendment Act. They can also be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. QI Directive Principles of State Policy. According to Dr. B.R. Ambedkar, the Directive Principles of State Policy is a novel feature of the Indian Constitution. They are enumerated in Part 4 of the Constitution. They can be classified into 3 broad categories: socialistic, Gandhian, and liberal intellectual. The directive principles are meant for promoting the ideal of social and economic democracy. They seek to establish a welfare state in India. However, unlike the fundamental rights, the directives are non-justiciable in nature, that is, they are not enforceable by the courts for their violation. Yet, the Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Hence, they impose a moral obligation on the state authorities for their application. But the real force, sanction, behind them is political, that is, public opinion. In the Minerva Mills Case 8, 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. 8 Minerva Mills vs. Union of India, 1980. 9. The 1909, 1919, and 1935 Acts provided for communal representation. Fundamental duties. The original Constitution did not provide for the fundamental duties of the citizens. These were added during the operation of internal emergency, 1975-77, by the 42nd Constitutional Amendment Act of 1976 on the recommendation of the Sworn Singh Committee. The 86th Constitutional Amendment Act of 2002 added one more fundamental duty. Part 4A of the Constitution, which consists of only one Article 51A, specifies the 11 fundamental duties viz. To respect the Constitution, national flag and national anthem. To protect the sovereignty, unity, and integrity of the country. To promote the spirit of common brotherhood amongst all the people. To preserve the rich heritage of our composite culture, and so on. The fundamental duties serve as a reminder to citizens that while enjoying their rights, they also have to be quite conscious of duties they owe to their country, their society, and to their fellow citizens. However, like the directive principles, the duties are also non-justiciable in nature. A secular state. The Constitution of India stands for a secular state. Hence, it does not uphold any particular religion as the official religion of the Indian state. The following provisions of the Constitution reveal the secular character of the Indian state. A. The term secular was added to the Preamble of the Indian Constitution by the 42nd Constitutional Amendment Act of 1976. B. The Preamble secures to all citizens of India liberty of belief, faith, and worship. 10. Salient features of the Constitution. M31. C. The state shall not deny to any person equality before the law or equal protection of the laws. Article 14. D. The state shall not discriminate against any citizen on the ground of religion. Article 15. E. Equality of opportunity for all citizens in matters of public employment. Article 16. F. All persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate any religion. Article 25. G. Every religious denomination or any of its sections shall have the right to manage its religious affairs. Article 26. H. No person shall be compelled to pay any taxes for the promotion of a particular religion. Article 27. I. No religious instruction shall be provided in any educational institution maintained by the state. Article 28. J. Any section of the citizens shall have the right to conserve its distinct language, script, or culture. Article 29. K. All minorities shall have the right to establish and administer educational institutions of their choice. Article 30. L. The state shall endeavor to secure for all the citizens a uniform civil code. Article 44. The Western concept of secularism connotes a complete separation between the religion, the church, and the state, the politics. This negative concept of secularism is inapplicable in the Indian situation where the society is multireligious. Hence, the Indian constitution embodies the positive concept of secularism, i.e., giving equal respect to all religions or protecting all religions equally. Moreover, the Constitution has also abolished the old system of communal representation 9, that is, reservation of seats in the legislatures on the basis of religion. However, it provides for the temporary reservation of seats $32 Indian Polity for the scheduled castes and scheduled tribes to ensure adequate representation to them. Universal adult franchise. The Indian Constitution adopts universal adult franchise as a basis of elections to the Lok Sabha and the state legislative assemblies. Every citizen who is not less than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, literacy, wealth, and so on. The voting age was reduced to 18 years from 21 years in 1989 by the 61st Constitutional Amendment Act of 1988. The introduction of universal adult franchise by the Constitution makers was a bold experiment and highly remarkable in view of the vast size of the country, its huge population, high poverty, social inequality, and overwhelming illiteracy. 10. Even in the Western countries, the right to vote was extended only gradually. For example, USA gave franchise to women in 1920, Britain in 1928, USSR, now Russia, in 1936, France in 1945, Italy in 1948, and Switzerland in 1971. 11. At present, there are 3 All India services, namely Indian Administrative Service, IS, Indian Police Service, IPS, and Indian Forest Service, IFOS. In 1947, Indian Civil Service, ICS, was replaced by IS, and the Indian Police, IP, was replaced by IPS and were recognized by the Constitution as All India Services. In 1963, IFOS was created, and it came into existence in 1966. Universal adult franchise makes democracy broad-based, enhances the self-respect and prestige of the common people, upholds the principle of equality, enables minorities to protect their interests, and opens up new hopes and vistas for weaker sections. Though the Indian Constitution is federal and envisages a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. In countries like the USA, on the other hand, each person is not only a U.S. citizen but also a citizen of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one conferred by the national government and another by the state government. In India, all citizens irrespective of the state in which they are born or reside enjoy the same political and civil rights of citizenship. 12. All over the country, and no discrimination is made between them. Despite the constitutional provision for a single citizenship and uniform rights for all the people, India has been witnessing communal riots, class conflicts, caste wars, linguistic clashes, and ethnic disputes. This means that the cherished goal of the Constitution makers to build a united and integrated Indian nation has not been fully realized. Independent bodies. The Indian Constitution not only provides for the legislative, executive, and judicial organs of the government, central and state, but also establishes certain independent bodies. They are envisaged by the Constitution as the bulwarks of the democratic system of government in India. These are A. Election Commission to ensure free and fair elections to the Parliament, the state legislatures, the Office of President of India, and the Office of Vice President of India. B. Comptroller and Auditor General of India to audit the accounts of the central and state governments. He acts as the guardian of public purse and comments on the legality and propriety of government expenditure. C. Union Public Service Commission to conduct examinations for recruitment to all India services and higher central services and to advise the President on disciplinary matters. 11. D. State Public Service Commission in every state to conduct examinations for recruitment to state services and to advise the governor on disciplinary matters. 14. Salient features of the Constitution. 33. The Constitution ensures the independence of these bodies through various provisions like security of tenure, fixed service conditions, expenses being charged on the Consolidated Fund of India, and so on. 15. Emergency provisions. The Indian Constitution contains elaborate emergency provisions to enable the President to meet any extraordinary situation effectively. The rationality behind the incorporation of these provisions is to safeguard the sovereignty, unity, integrity, and security of the country, the democratic political system, and the Constitution. The Constitution envisages 3 types of emergencies, namely, A. National emergency on the ground of war or external aggression or armed rebellion. 12, Article 352. B. State emergency, President's rule. On the ground of failure of constitutional machinery in the states, Article 356, or failure to comply with the directions of the center, Article 365c. Financial emergency on the ground of threat to the financial stability or credit of India, Article 360. 12. The 44th Amendment Act, 1978, has replaced the original term, internal disturbance, by the new term, armed rebellion. During an emergency, the central government becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation of the political system from federal, during normal times, to unitary, during emergency, is a unique feature of the Indian Constitution. 16. Three-tier government. Originally, the Indian Constitution, like any other federal constitution, provided for a dual polity and contained provisions with regard to the organization and powers of the center and the states. Later, the 73rd and 74th Constitutional Amendment Acts 1992 have added a third tier of government, i.e., local, which is not found in any other constitution of the world. The 73rd Amendment Act of 1992 gave constitutional recognition to the panchayats, rural local governments, by adding a new Part 9 and a new Schedule 11 to the Constitution. This part provides for a three-tier system of panchayati raj in every state, i.e., panchayats at the village, intermediate, and district levels. Similarly, the 74th Amendment Act of 1992 gave constitutional recognition to the municipalities, urban local governments, by adding a new Part 9A and a new Schedule 12 to the Constitution. This part provides for three types of municipalities in every state, i.e., Nagar Panchayat for a transitional area, municipal council for a smaller urban area, and municipal corporation for a larger urban area. Cooperative societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following three changes in the Constitution. 1. It made the right to form cooperative societies a fundamental right, Article 19. 2. It included a new directive principle of state policy on promotion of cooperative societies, Article 43b. 3. It added a new Part 9b in the Constitution which is entitled as the Cooperative Societies, Articles 243, ZH to 243, ZT. The new Part 9b contains various provisions to ensure that the cooperative societies in the country function in a democratic, professional, autonomous, and economically sound manner. It empowers the Parliament in respect of multi-state cooperative societies and the state legislatures in respect of other cooperative societies to make the appropriate law. 17. 34 Indian Polity. Criticism of the Constitution the Constitution of India, as framed and adopted by the Constituent Assembly of India, has been criticized on the following grounds. QA borrowed Constitution. The critics opine that the Indian Constitution contains nothing new and original. They described it as a borrowed constitution, or a bag of borrowings, or a hodgepodge constitution, or a patchwork of several documents of the world constitutions. However, this criticism is unfair and illogical. This is because the framers of the Constitution made necessary modifications in the features borrowed from other constitutions for their suitability to the Indian conditions, at the same time avoiding their faults. While answering the above criticism in the Constituent Assembly, Dr. B.R. Ambedkar, the chairman of the drafting committee, said, "One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries reducing their constitutions to writing. What the scope of a constitution should be has long been settled. Similarly, what are the fundamentals of a constitution are recognized all over the world. Given these facts, all constitutions and their main provisions must look similar. The only new things, if there can be any, in a constitution framed so late in the day are the variations made to remove the faults and to accommodate it to the needs of the country. The charge of producing a blind copy of the constitutions of other countries is based, I am sure, on an inadequate study of the Constitution." 13. 14 Ibid. Constituent Assembly Debates, Volume 11, p. 616. EW a carbon copy of the 1935 Act. The critics said that the framers of the Constitution have included a large number of the Constituent Assembly Debates, Volume 7, pp. 35 to 38. Provisions of the Government of India Act of 1935 into the Constitution of India. Hence, they called the Constitution as a carbon copy of the 1935 Act, or an amended version of the 1935 Act. For example, N. Srinivasan observed that the Indian Constitution is both in language and substance a close copy of the Act of 1935 inch. Similarly, Sir Ivor Jennings, a British constitutionalist, said that the Constitution derives directly from the Government of India Act of 1935 from which, in fact, many of its provisions are copied almost textually. Further, P.R. Deshmukh, a member of the Constituent Assembly, commented that the Constitution is essentially the Government of India Act of 1935 with only adult franchise added. The same Dr. B.R. Ambedkar answered the above criticism in the Constituent Assembly in the following way, as to the accusation that the draft Constitution has reproduced a good part of the provisions of the Government of India Act. 1935, one make no apologies. There is nothing to be ashamed of in borrowing. It involves no plagiarism. Nobody holds any patent rights in the fundamental ideas of a constitution. What I am sorry about is that the provisions taken from the Government of India Act, 1935, relate mostly to the details of administration. Un-Indian or anti-Indian. According to the critics, the Indian Constitution is un-Indian or anti-Indian because it does not reflect the political traditions and the spirit of India. They said that the foreign nature of the Constitution makes it unsuitable to the Indian situation or unworkable in India. In this context, K. Hanumanthaya, a member of the Constituent Assembly, commented, "We wanted the music of Veena or sitar, but here we have the music of an English band. That was because our Constitution makers were educated that way." 11. Similarly, Lokanath Mishra, another member of the Constituent Assembly, criticized the Constitution 14 salient features of the Constitution 35 as a slavish imitation of the West, much more, a slavish surrender to the West. 16. Further, Lakshminarayan Sahu, also a member of the Constituent Assembly, observed, "The ideals on which this draft constitution is framed have no manifest relation to the fundamental spirit of India. This constitution would not prove suitable and would break down soon after being brought into operation." 17. Constituent Assembly Debates, Volume 7, p. 242. Constituent Assembly Debates, Volume 11, p. 613. Constituent Assembly Debates, Volume 11, p. 617. Constituent Assembly Debates, Volume 7, p. 387. 20. Ivor Jennings, Some Characteristics of the Indian Constitution, Oxford University Press, Madras, 1953, pp. 9-16. An un-Gandhian Constitution. According to the critics, the Indian Constitution is un-Gandhian because it does not contain the philosophy and ideals of Mahatma Gandhi, the father of the Indian nation. They opine that the Constitution should have been raised and built upon village panchayats and district panchayats. In this context, the same member of the Constituent Assembly, K. Hanumanthaya, said, "That is exactly the kind of constitution Mahatma Gandhi did not want and did not envisage." 18. T. Prakasam, another member of the Constituent Assembly, attributed this lapse to Ambedkar's non-participation in the Gandhian movement and the antagonism towards the Gandhian ideas. 19. Q. Elephantine Size. The critics stated that the Indian Constitution is too bulky and too detailed and contains some unnecessary elements. Sir Ivor Jennings, a British constitutionalist, observed that the provisions borrowed were not always well selected and that the Constitution, generally speaking, was too long and complicated. 20. In this context, H.V. Kamath, a member of the Constituent Assembly, commented, "The emblem and the crest that we have selected for our assembly is an elephant. It is perhaps in consonance with that our Constitution too is the bulkiest that the world has produced." 21. He also said, "I am sure the House does not agree that we should make the Constitution an elephantine one." 22. QI Paradise of the lawyers. According to the critics, the Indian Constitution is too legalistic and very complicated. They opine that the legal language and phraseology adopted in the Constitution makes it a complex document. The same Sir Ivor Jennings called it a lawyer's paradise. In this context, H.K. Maheshwari, a member of the Constituent Assembly, observed, "The draft tends to make people more litigious, more inclined to go to law courts, less truthful and less likely to follow the methods of truth and nonviolence. If I may say so, the draft is really a lawyer's paradise. It opens up vast avenues of litigation and will give our able and ingenious lawyers plenty of work to do." 28. Similarly, Pierre Deschmick, another member of the Constituent Assembly, said, "I should, however, like to say that the draft of the articles that have been brought before the House by Dr. Ambedkar seems to my mind to be far too ponderous, like the ponderous tomes of a law manual. A document dealing with the Constitution hardly uses so much of padding and so much of verbiage. Perhaps it is difficult for them to compose a document which should be, to my mind, not a law manual but a socio-political document, a vibrating, pulsating, and life-giving document. But, to our misfortune, that was not to be, and we have been burdened with so much of words which could have been very easily eliminated." 24. Constituent Assembly Debates, Volume 7, p. 1042. Constituent Assembly Debates, Volume 8, p. 127. Constituent Assembly Debates, Volume 7, p. 293. Constituent Assembly Debates, Volume 9, p. 613. 36. Indian Polity. Table 4.1. Parts of the Constitution at a glance. Parts: Subject Matter. Articles covered by the Union and its territory 1-4. 2. Citizenship 5-11. 3. Fundamental Rights 12-35. 4. Directive Principles of State Policy 36-51. 4a. Fundamental Duties 51a. b. The Union Government 52-151. Chapter 1. The Executive 52-78. Chapter 2. Parliament 79-122. Chapter 3. Legislative Powers of President 123. Chapter 4. The Union Judiciary 124-147. Chapter 5. Comptroller and Auditor General of India 148-151. 6. The State Governments 152-237. Chapter 1. General 152. Chapter 2. The Executive 153-167. Chapter 3. The State Legislature 168-212. Chapter 4. Legislative Powers of Governor 213. Chapter 5. The High Courts 214-232. Chapter 6. Subordinate Courts 233-237. 7. The States and Part B of the First Schedule, deleted. 238, deleted. 8. The Union Territories 239-242. 9. The Panchayats 243 to 243 to 09A. The Municipalities 243 P to 243 ZG 9B. The Cooperative Societies 243 ZH to 243 ZTX. The Scheduled and Tribal Areas 244 to 244 A. 11. Relations between the Union and the States 245 to 263. Chapter 1. Legislative Relations 245 to 255. Chapter 2. Administrative Relations 256 to 263. 12. Finance, Property, Contracts and Suits 264 to 300. Chapter 1. Finance 264 to 291. Chapter 2. Borrowing 292 to 293. Chapter 3. Property, Contracts, Rights, Liabilities, Obligations and Suits 294 to 300. Chapter 4. Right to Property 300. A 13. Trade, Commerce and Intercourse within the Territory of India 301 to 307. 14. Services under the Union and the States 308 to 323. Salient features of the Constitution 37. XIVA Tribunals 323 A to 323 to 8. 15. Elections 324 to 329 HA. Part Subject Matter Articles covered. Chapter 1. Services 308 to 314. Chapter 2. Public Service Commissions 315 to 323. 16. Special Provisions relating to certain classes 330 to 342 A. 17. Official Language 343 to 351. Chapter 1. Language of the Union 343 to 344. Chapter 2. Regional Languages 345 to 347. Chapter 4. Special Directives 350 to 351. 18. Emergency Provisions 352 to 360. 19. Miscellaneous 361 to 367. XX Amendment of the Constitution 368. XXI Temporary, Transitional and Special Provisions 369 to 392. XXI Short Title, Commencement, Authoritative Text in Hindi, and Repeals 393 to 395. Note: Part 7, dealing with Part 8 states, was deleted by the 7th Amendment Act, 1956. On the other hand, both Part 4A and Part XIVA were added by the 42nd Amendment Act, 1976, while Part 9A was added by the 74th Amendment Act, 1992, and Part 9B was added by the 97th Amendment Act, 2011. Table 4.2 Important Articles of the Constitution at a glance. Articles deals with 1. Name and territory of the Union. 3. Formation of new states and alteration of areas, boundaries, or names of existing states. 13. Laws inconsistent with or in derogation of the fundamental rights. 14. Equality before law. 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. 17. 16. Equality of opportunity in matters of public employment. 17. Abolition of untouchability. IS. Protection of certain rights regarding freedom of speech, etc. 21. Protection of life and personal liberty. J. 21A. Right to elementary education. L. A. Jew. 25. Freedom of conscience and free profession, practice, and propagation of religion. 30. Right of minorities to establish and administer educational institutions. 32. Remedies for enforcement of fundamental rights including writs. 38. State to secure a social order for the promotion of welfare of the people. Continued. 38. Indian Polity. 40. Organization of village panchayats. 44. Uniform Civil Code for the citizens. 45. Provision for early childhood care and education to children below the age of 6 years. 46. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. 50. Separation of judiciary from executive. Still promotion of international peace and security. 51A. Fundamental duties. 72. Power of President to grant pardons, etc. and to suspend, remit, or commute sentences in certain cases. 74. Council of Ministers to aid and advise the President. 110. Definition of money bills. 112. Annual financial statement, budget. 123. Power of President to promulgate ordinances during recess of Parliament. 143. Power of President to consult Supreme Court. 155. Appointment of Governor. 161. Power of Governor to grant pardons, etc. and to suspend, remit, or commute sentences in certain cases. 163. Council of Ministers to aid and advise the Governor. 169. Abolition or creation of legislative councils in states. 200. Assent to bills by Governor, including reservation for President. 213. Power of Governor to promulgate ordinances during recess of the state legislature. 226. Power of High Courts to issue certain writs. 239. AA. Special provisions with respect to Delhi. 249. Power of Parliament to legislate with respect to a matter in the state list in the national interest. 262. Adjudication of disputes relating to waters of interstate rivers or river valleys. 263. Provisions with respect to an interstate council. 275. Grants from the Union to certain states. 27. SA. Goods and Services Tax Council. 280. Finance Commission. 300 suits and proceedings. 300A persons not to be deprived of property save by authority of law, right to property. 311 dismissal, removal or reduction in rank of persons employed in civil capacities under the union or state. 312 all India services. 315 public service commissions for the union and for the state's salient features of the Constitution. 39 articles deals with. 320 functions of public service commissions. 323 administrative tribunals. 324 superintendents, direction, and control of elections to be vested in an election commission. 330 reservation of seats for scheduled castes and scheduled tribes in the House of the People, X. Underscore 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 X asterisk comma J dash caret X Del tax I 338 claims of scheduled castes and scheduled tribes to services and posts. 352 proclamation of emergency, national emergency. 356 provisions in case of failure of constitutional machinery in states, President's rule. 360 provisions as to financial emergency. 365 effect of failure to comply with, or to give effect to, directions given by the Union, President's rule. 368 power of Parliament to amend the Constitution and procedure therefore. Table 4.3 Schedules of the Constitution at a glance. Number subject matter articles covered. First Schedule 1. Names of the states and their territorial jurisdiction. 1 and 4. 2. Names of the Union territories and their extent. Second Schedule provisions relating to the emoluments, allowances, privileges, and so 59, 65, 75, 97. On of 125, 148, 158, 164, 186, and 221. I1. The President of India. 2. The Governors of States. 4. The Chairman and the Deputy Chairman of the Rajya Sabha. Single quote. 5. The Speaker and the Deputy Speaker of the Legislative Assembly and underscore 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 the states. 6. The Chairman and the Deputy Chairman of the Legislative Council in the states. 7. The Judges of the Supreme Court. L. 8. The Judges of the High Courts. 9. The Comptroller and Auditor General of India. Third Schedule forms of oaths or affirmations 4, 75, 84, 99,124. 148,164,173,188 and 219. 1. The Union Ministers J. 2. The candidates for election to the Parliament 3. The members of Parliament 1. II. J. 4. The Judges of the Supreme Court. 5. The Comptroller and Auditor General of India. Continued. 40. Indian Polity. Number subject matter articles covered. 6. The State Ministers. 7. The candidates for election to the state legislature. 8. The members of the state legislature. 9. The judges of the high courts. Fourth Schedule allocation of seats in the Rajya Sabha to the states and the Union territories. 4 and 80. Fifth Schedule provisions relating to the administration and control of scheduled areas and scheduled tribes. 244. Sixth Schedule provisions relating to the administration of tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram. 244 and 275. Seventh Schedule division of powers between the Union and the states in terms of List 1. Union List, List 2, State List, and List 3, Concurrent List. Presently, the Union List contains 98 subjects, originally 97. The State List contains 59 subjects, originally 66, and the Concurrent List contains 52 subjects, originally 47. 246. Eighth Schedule languages recognized by the Constitution. Originally, it had 14 languages, but presently there are 22 languages. They are Assamese, Bengali, Bodo, Dogri, Dongri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Mathili, Maithili, Malayalam, Manipur, Marathi, Nepali, Odia, Punjabi, Sanskrit, Santhali, Sindhi, Tamil, Telugu, and Urdu. Sindh was added by the 21st Amendment Act of 1967. Konkani, Manipur, and Nepali were added by the 71st Amendment Act of 1992. And Bodo, Dongri, Maithili, and Santhali were added by the 92nd Amendment Act of 2003. Oriya was renamed as Odia by the 96th Amendment Act of 2011. 344 and 351. Ninth Schedule Acts and Regulations, originally 13 but presently 282, 25 of the state legislatures dealing with land reforms and abolition of the zamindari system and of the Parliament dealing with other matters. This schedule was added by the First Amendment, 1951, to protect the laws included in it from judicial review on the ground of violation of fundamental rights. However, the Supreme Court ruled that the laws included in this schedule after April 24, 1973's FI are open to judicial review. 31b. 10th Schedule provisions relating to disqualification of the members of Parliament and state legislatures on the ground of defection. This schedule was added by the 52nd Amendment Act of 1985, also known as Anti-Defection Law. 102 and 191. 11th Schedule specifies the powers, authority, and responsibilities of panchayats. It has 29 matters. This schedule was added by the 73rd Amendment Act of 1992. 243g. 12th Schedule specifies the powers, authority, and responsibilities of municipalities. It has 18 matters. This schedule was added by the 74th Amendment Act of 1992. 243w. Though the last entry is numbered 284, the actual total number is 282. This is because 3 entries, 87, 92, and 130, have been deleted and 1 entry is numbered as 257a. 2.1 This is the date on which the Supreme Court delivered its judgment in the Kesavananda Burdi v. State of Kerala case. This case is popularly known as the Fundamental Rights case. Salient features of the Constitution 41. Table 4.4 Sources of the Constitution at a glance. Sources features borrowed. 1. Government of India Act of 1935 Federal Scheme, Office of Governor, Judiciary, Public Service. Commissions, Emergency Provisions and Administrative Details. 2. British Constitution Parliamentary Government, Rule of Law, Legislative Procedure, Single. Citizenship, Cabinet System, Prerogative Writs, Parliamentary Privileges and Bicameralism. 3. U.S. Constitution Fundamental Rights, Independence of Judiciary, Judicial Review, Impeach. Men of the President, Removal of Supreme Court and High Court Judges and Post of Vice President. 4. Lush Constitution. I. Directive Principles of State Policy, Nomination of Members to Rajya Sabha and Method of Election of President. 5. Canadian Constitution Federation with a strong centre, vesting of residuary powers in the centre, appointment of state governors by the centre, and advisory jurisdiction of the Supreme Court. 6. Australian Constitution concurrent list, freedom of trade, commerce and intercourse, and joint sitting of the 2 houses of Parliament. 7. Weimar Constitution of Germany emergency provisions relating to suspension of fundamental rights. 8. Soviet Constitution, USSR, now fundamental duties and the ideal of justice, social, economic and polity Russia, Cal, in the Preamble. 9. French Constitution Republic and the ideals of liberty, equality, and fraternity in the Preamble. 10. South African Constitution procedure for amendment of the Constitution and election of members of Rajya Sabha. 11. Japanese Constitution procedure established by law. Scan the QR code to access the conceptual video on important articles and other important topics on Edge Chapter Preamble of the Constitution. The American Constitution was the first to begin with a preamble. Many countries, including India, followed this practice. The term preamble refers to the introduction or preface to the Constitution. It contains the summary or essence of the Constitution. N.A. Palkiva Law, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. The preamble to the Indian Constitution is based on the Objectives Resolution, drafted and moved by Pandit Nehru, and adopted by the Constituent Assembly 1. It has been amended by the 42nd Constitutional Amendment Act, 1976, which added 3 new words, socialist, secular, and integrity. Text of the preamble in its present form reads, We, the people of India, having solemnly resolved to constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all. Moved by Nehru on December 13, 1946, and adopted by the Constituent Assembly on January 22, 1947. Fraternity assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly this 26th day of November, 1949, to hereby adopt, enact, and give to ourselves this Constitution. Ingredients of the preamble. The preamble reveals 4 ingredients or components. 1. Source of authority of the Constitution. The preamble states that the Constitution derives its authority from the people of India. 2. Nature of the Indian state. It declares India to be of a sovereign, socialist, secular democratic and republican polity. 3. Objectives of the Constitution. It specifies justice, liberty, equality, and fraternity as the objectives. 4. Date of adoption of the Constitution. It stipulates November 26, 1949, as the date. Key words in the preamble. Certain key words, sovereign, socialist, secular, democratic, republic, justice, liberty, equality, and fraternity, are explained as follows. Sovereign. The word sovereign implies that India is neither a dependency nor a dominion of preamble of the Constitution 43. Any other nation, but an independent state too. There is no authority above it, and it is free to conduct its own affairs, both internal and external. 2. Till the passage of the Indian Independence Act, 1947, India was a dependency colony of the British Empire. From August 15, 1947 to January 26, 1950, India's political status was that of a dominion in the British Commonwealth of Nations. India ceased to be a British dominion on January 26, 1950, by declaring herself a sovereign republic. However, Pakistan continued to be a British dominion until 1956. £3 dispel the lurking fears of some members of the Constituent Assembly, Pundit Nehru said in 1949 thus, "We took pledge long ago to achieve Puma Swaraj. We have achieved it." Does a nation lose its independence by an alliance with another country? Alliance normally means commitments. The free association of the sovereign Commonwealth of Nations does not involve such commitments. Its very strength lies in its flexibility and its complete freedom. It is well known that it is open to any member nation to go out of the Commonwealth if it so chooses. He further stated, it is an agreement by free will, to be terminated by free will. For India became a member of the UNO in 1945. Though in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth. This extra-constitutional declaration does not affect India's sovereignty in any manner. 3. Further, India's membership of the United Nations Organization, UNO, also in no way constitutes a limitation on her sovereignty. 4. Being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. Q. Socialist. Even before the term socialist was added by the 42nd Amendment in 1976, the Constitution had a socialist content in the form of certain directive principles of state policy. In other words, what was hitherto implicit in the Constitution has now been made explicit. Moreover, the Congress Party itself adopted a Resolution 5 to establish a socialistic pattern of society in its Avadi session as early as in 1955 and took measures accordingly. Notably, the Indian brand of socialism is a democratic socialism and not a communistic socialism, also known as state socialism, which involves the nationalization of all means of production and distribution and the abolition of private property. Democratic socialism, on the other hand, holds faith in a mixed economy where both public and private sectors coexist side by side. 6. As the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards the Gandhian socialism. 8. The new economic policy, 1991, of liberalization, privatization, and globalization has, however, diluted the socialist credentials of the Indian state. ESI secular. The term secular, too, was added by the 42nd Constitutional Amendment Act of 1976. However, as the Supreme Court said in 1974, the resolution said, in order to realize the object of Congress and to further the objectives stated in the Preamble and Directive Principles of State Policy of the Constitution of India, planning should take place with a view to the establishment of a socialistic pattern of society, where the principal means of production are under social ownership or control. Production is progressively speeded up, and there is equitable distribution of the national wealth. The Prime Minister, Indira Gandhi, said, "We have always said that we have our own brand of socialism. We will nationalize the sectors where we feel the necessity. Just nationalization is not our type of socialism." 7G.B. Pant University of Agriculture and Technology vs. State of Uttar Pradesh 2000. 8 Nikara vs. Union of India, 1982. Indian Polity. Although the words secular state 9 were not expressly mentioned in the Constitution, there can be no doubt that Constitution makers wanted to establish such a state, and accordingly Articles 25 to 28, guaranteeing the fundamental right to freedom of religion, have been included in the Constitution. 9. On the basis of the attitude of the state towards religion, 3 types of states can be conceived of. A. Atheistic state. The state is anti-religion and hence condemns all religions. B. Theocratic state. The state is pro-religion and hence declares one particular religion as the state religion, as for example, Bangladesh, Burma, Sri Lanka, Pakistan, and so on. C. Secular state. The state is neutral in the matter of religion and hence does not uphold any particular religion as the state religion, as for example, USA and India. G.S. Pandey, Constitutional Law of India, Allahabad Law Agency, 8th edition, 2002, p. 222. 10. The then Union Law Minister, H.R. Gokhale, defined this concept as, there will be freedom, liberty of faith and worship, whatever religion you belong to. The state will not have anything to do, as a state, with any religion excepting to treat every religion equally, but the state will not have any foundation of religion. Similarly, P.B. Gajendra Dhakkar, a former Chief Justice of India, defined secularism as in the Indian Constitution in the following way: the state does not owe loyalty to any particular religion as such. It is not irreligious or anti-religious. It gives equal freedom to all religions. In the term democracy is derived from 2 Greek words, namely, demos and kratia, meaning people, and rule, respectively. The Indian Constitution embodies the positive concept of secularism, i.e., all religions in our country, irrespective of their strength, have the same status and support from the state. 10. 31 Democratic 11 polity, as stipulated in the Preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracy is of two types, direct and indirect. In direct democracy, the people exercise their supreme power directly, as is the case in Switzerland. There are four devices of direct democracy, namely, referendum, initiative, recall, and plebiscite. 12. In indirect democracy, on the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the laws. This type of democracy, also known as representative democracy, is of two kinds, parliamentary and presidential. The Indian Constitution provides for representative parliamentary democracy, under which the executive is responsible to the legislature for all its policies and actions. Universal adult franchise, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds are the manifestations of the democratic character of the Indian polity. The term democratic is used in the Preamble in the broader sense, embracing not only political democracy but also social and economic democracy. This dimension was stressed by Dr. Ambedkar in his concluding speech in the Constituent Assembly on November 25, 1949, in the following way. Political democracy cannot last unless there lies at the base of it social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity. The principles of liberty, equality, and fraternity are not to be treated as. 12. Referendum is a procedure whereby a proposed legislation is referred to the electorate for settlement by their direct votes. Initiative is a method by means of which the people can propose a bill to the legislature for enactment. Recall is a method by means of which the voters can remove a representative or an officer before the expiry of his term, when he fails to discharge his duties properly. Plebiscite is a method of obtaining the opinion of people on any issue of public importance. It is generally used to solve the territorial disputes. Preamble of the Constitution. 45. Separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality, equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. 123. 12. Shiva Rao, The Framing of India's Constitution, Select Documents, Volume 4, p. 944. In the same context, the Supreme Court observed in 1997 that the Constitution envisions to establish an egalitarian social order rendering to every citizen social, economic and political justice in a social and economic democracy of the Bharat Republic. Republic. A democratic polity can be classified into two categories, monarchy and republic. In a monarchy, the head of the state, usually king or queen, enjoys a hereditary position, that is, Hisha comes to office through succession, e.g., Britain. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period, e.g., USA. Therefore, the term republic in our preamble indicates that India has an elected head called the president. Hisha is elected indirectly for a fixed period of 5 years. A republic also means two more things. 1. Vesting of political sovereignty in the people and not in a single individual like a king. Second, the absence of any privileged class and hence all public offices being open to every citizen without any discrimination. Justice. The term justice in the preamble embraces three distinct forms, social, economic, and political, secured through various provisions of fundamental rights and directive principles. Social justice denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, and so on. It means absence of privileges being extended to any particular section of the society and improvement in the conditions of backward classes, SCs, CITs and OBCs, and women. Economic justice denotes the non-discrimination between people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income, and property. A combination of social justice and economic justice denotes what is known as distributive justice. Political justice implies that all citizens should have equal political rights, equal access to all political offices, and equal voice in the government. The ideal of justice, social, economic, and political, has been taken from the Russian Revolution, 1917. Liberty. The term liberty means the absence of restraints on the activities of individuals, and at the same time, providing opportunities for the development of individual personalities. The preamble secures to all citizens of India liberty of thought, expression, belief, faith, and worship, through their fundamental rights, enforceable in court of law, in case of violation. Liberty, as elaborated in the preamble, is very essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes, and has to be enjoyed within the limitations mentioned in the Constitution itself. In brief, the liberty conceived by the preamble or fundamental rights is not absolute but qualified. The ideals of liberty, equality, and fraternity in our preamble have been taken from the French Revolution, 1789 to 1799. 8. The term equality means the absence of special privileges to any section of the society, Indian polity, and the provision of adequate opportunities for all individuals without any discrimination. The preamble secures to all citizens of India equality of status and opportunity. This provision embraces three dimensions of equality: civic, political, and economic. The following provisions of the chapter on fundamental rights ensure civic equality. A. Equality before the law, Article 14. B. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, Article 15. C. Equality of opportunity in matters of public employment, Article 16. D. Abolition of untouchability, Article 17. E. Abolition of titles, Article 18. There are two provisions in the Constitution that seek to achieve political equality. 1. No person is to be declared ineligible for inclusion in electoral rolls on grounds of religion, race, caste, or sex, Article 325. 2. Elections to the Lok Sabha and the state assemblies to be on the basis of adult suffrage, Article 326. The Directive Principles of State Policy, Article 39, secures to men and women equal right to an adequate means of livelihood and equal pay for equal work. L. Fraternity means a sense of brotherhood. The Constitution promotes this feeling of fraternity by the system of single citizenship. Also, the fundamental duties, Article 51A, say that it shall be the duty of every citizen of India to promote harmony in the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, or sectional diversities. The preamble declares that fraternity has to assure two things: the dignity of the individual and the unity and integrity of the nation. The word integrity has been added to the preamble by the 42nd Constitutional Amendment, 1976. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the phrase dignity of the individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred. This is highlighted through some of the provisions of the fundamental rights and directive principles of state policy, which ensure the dignity of individuals. Further, the fundamental duties, Article 51A, also protect the dignity of women by stating that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women, and also makes it the duty of every citizen of India to uphold and protect the sovereignty, unity, and integrity of India. The phrase unity and integrity of the nation embraces both the psychological and territorial dimensions of national integration. Article 1 of the Constitution describes India as a union of states to make it clear that the states have no right to secede from the union, implying the indestructible nature of the Indian Union. It aims at overcoming hindrances to national integration like communalism, regionalism, casteism, linguism, secessionism, and so on. T. Significance of the Preamble. The Preamble embodies the basic philosophy and fundamental values, political, moral, and religious, on which the Constitution is based. It contains the grand and noble vision of the Constituent Assembly and reflects the dreams and aspirations of the founding fathers of the Constitution. In the words of Sir Aladi Krishnaswamy Iyer, a member of the Constituent Assembly who played a significant role in making the Constitution, the preamble to our Constitution expresses what we had thought or dreamt so long. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the preamble is the horoscope of our sovereign democratic republic. Pandit Thakir Das Bhargava, another member of the Constituent Assembly, summed up the importance of the preamble in the preamble of the Constitution Q. Following words: the preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is a key to the Constitution. It is a jewel set in the Constitution. It is a proper yardstick with which one can measure the worth of the Constitution. Sir Ernest Barker, a distinguished English political scientist, paid a glowing tribute to the political wisdom of the authors of the Pre-Blee. He described the preamble as the keynote to the Constitution. He was so moved by the text of the preamble that he quoted 14 at the opening of his popular book, Principles of Social and Political Theory, 1951. He said that the preamble of the Indian Constitution states, in a brief and pithy form, the argument of much of the book, and it may care it accordingly serve as a keynote. He wrote, "I am all the more moved to quote it because I am proud that the people of India should begin their independent life by subscribing to the principles of a political tradition which we in the West call Western, but which is now something more than the Western. Imhidiyatullah, Democracy in India in the Judicial Process, p. 51. Referenced by the President of India, 1960, under Article 143 of the Constitution on the implementation of the Indo-Pakistan Agreement of 1958, relating to Barabari Union and exchange of enclaves. M. Hidayatullah, a former Chief Justice of India, observed, "Preamble resembles the Declaration of Independence of the United States of America, but is more than a declaration. It is the soul of our Constitution, which lays down the pattern of our political society. It contains a solemn resolve, which nothing but a revolution can alter. 15 provisions in the Constitution, and is thus a key to the minds of the makers of the Constitution. Further, where the terms used in any article are ambiguous or capable of more than one meaning, some assistance at interpretation may be taken from the objectives enshrined in the Preamble. Despite this recognition of the significance of the Preamble, the Supreme Court specifically opined that Preamble is not a part of the Constitution. In the Kesavananda case 17, 1973, the Supreme Court rejected the earlier opinion and held that Preamble is a part of the Constitution. It observed that the Preamble is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the Preamble. In the LC of India case 18, 1995, also, the Supreme Court again held that the Preamble is an integral part of the Constitution. Like any other part of the Constitution, the Preamble was also enacted by the Constituent Assembly. But, after the rest of the Constitution was already enacted. The reason for inserting the Preamble at the end was to ensure that it was in conformity with the Constitution as adopted by the Constituent Assembly. While forwarding the Preamble for votes, the President of the Constituent Assembly said, "The question is that Preamble stands part of the Constitution 19." The motion was then adopted. Hence, the current opinion held by the Supreme Court that the Preamble is a part of the Constitution is in consonance with the opinion of the Founding Fathers of the Constitution. However, two things should be noted. 1. The Preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. 2. It is non-justiciable, that is, its provisions are not enforceable in courts of law. Kesavananda Bharati vs. State of Kerala, 1973. LIC of India vs. Consumer Education and Research Center, 1995. 1S Constituent Assembly Debates, Volume 10, pp. 450 to 456. T. Preamble as part of the Constitution. One of the controversies about the Preamble is as to whether it is a part of the Constitution or not. In the Barabara Union 16 case, I-960, the Supreme Court said that the Preamble shows the general purposes behind the several 48 Indian Polity. Amenability of the Preamble X underscore 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 underscore. The question as to whether the Preamble can be amended under Article 368 of the Constitution arose for the first time in the historic Kesavananda Bharati case, 1973. It was urged that the Preamble cannot be amended as it is not a part of the Constitution. The petitioner contended that the amending power in Article 368 cannot be used to destroy or damage the basic elements or the fundamental features of the Constitution, which are enshrined in the Preamble. The Supreme Court, however, held that the Preamble is a part of the Constitution. The court stated that the opinion tendered by it in the Barabara Union, 1960, in this regard was wrong, and held that the Preamble can be amended, subject to the condition that no amendment is done to the basic features. In other words, the court held that the basic elements or the fundamental features of the Constitution as contained in the Preamble cannot be altered by an amendment under Article 368. The court observed, the edifice of our Constitution is based upon the basic elements mentioned in the Preamble. If any of these elements are removed, the structure will not survive, and it will not be the same Constitution or it cannot maintain its identity. An amending power cannot be interpreted so as to confer power on the Parliament to take away any of these fundamental and basic characteristics of the polity. The Preamble has been amended only once so far, in 1976, by the 42nd Constitutional Amendment Act, which has added 3 new words, socialist, secular, and integrity, to the Preamble. This amendment was held to be valid. Chapter Union and its Articles 1 to 4 under Part I of the Constitution deal with the Union and its territory. T. Union of States underscore 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 Article 1 describes India, that is, Bharat, as Union of States rather than a federation of states. This provision deals with 2 things: 1. Name of the country, and 2. Type of polity. There was no unanimity in the Constituent Assembly with regard to the name of the country. Some members suggested the traditional name, Bharat, while others advocated the modern name, India. Hence, the Constituent Assembly had to adopt a mix of both, India, that is, Bharat. Secondly, the country is described as Union, although its constitution is federal in structure. According to Dr. B.R. Ambedkar, the phrase Union of States has been preferred to Federation of States for 2 reasons. 1. The Indian Federation is not the result of an agreement among the states like the American Federation. And 2. The states have no right to secede from the Federation. The Federation is a union because it is indestructible. The country is an integral whole and divided into different states only for the convenience of administration. 1 Constituent Assembly Debates, Volume 7, p. 43. According to Article 1, the territory of India can be classified into 3 categories. 1. Territories of the states. 2. Union territories. 3. Territories that may be acquired by the government of India at any time. The names of states and union territories and their territorial extent are mentioned in the first schedule of the Constitution. At present, there are 28 states and 8 union territories. The provisions of the Constitution pertaining to the states are applicable to all the states in the same manner too. However, the special provisions under Part 21, applicable to the states of Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka override the general provisions relating to the states as a class. Further, the 5th and 6th schedules contain separate provisions with respect to the administration of scheduled areas and tribal areas within the states. Notably, the Territory of India is a wider expression than the Union of India because the latter includes only states while the former includes not only the states, but also union territories and territories that may be acquired by the Government of India at any future time. The states are the members of the federal system and share a distribution of powers with the center. The union territories and the acquired territories, on the other hand, are directly administered by the central government. Being a sovereign state, India can acquire foreign territories according to the modes recognized by international law, i.e., cession. Till 2019, the erstwhile state of Jammu and Kashmir enjoyed a special position by virtue of Article 370 of the Indian Constitution. It had its own separate state constitution. 50 Indian Polity. Following treaty, purchase, gift, lease or plebiscite, occupation hitherto unoccupied by a recognized ruler, conquest or subjugation. For example, India acquired several foreign territories such as Dadra and Nagar Haveli, Goa, Daman and Diu, Puducherry, and Sikkim since the commencement of the Constitution. The acquisition of these territories is discussed later in this chapter. Article 2 empowers the Parliament to admit into the Union of India or establish new states on such terms and conditions as it thinks fit. Thus, Article 2 grants 2 powers to the Parliament: A. The power to admit into the Union of India new states, and B. The power to establish new states. The first refers to the admission of states which are already in existence, while the second refers to the establishment of states which were not in existence before. Notably, Article 2 relates to the admission or establishment of new states that are not part of the Union of India. Article 3, on the other hand, relates to the formation of or changes in the existing states of the Union of India. In other words, Article 3 deals with the internal readjustment inter se of the territories of the constituent states of the Union of India. Parliament's power to reorganize the states. Article 3 authorizes the Parliament to A. Form a new state by separation of territory from any state or by uniting 2 or more states or parts of states or by uniting any territory to a part of any state. B. Increase the area of any state. C. Diminish the area of any state. D. Alter the boundaries of any state. And C. Alter the name of any state. However, Article 3 lays down 2 conditions in this regard. 1. A bill contemplating the above changes can be introduced in the Parliament only with the prior recommendation of the President. And 2. Before recommending the bill, the President has to refer the same to the state legislature, concerned for expressing its views within a specified period. Further, the power of Parliament to form new states includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. The President, or Parliament, is not bound by the views of the state legislature and may either accept or reject them, even if the views are received in time. Further, it is not necessary to make a fresh reference to the state legislature every time an amendment to the bill is moved and accepted in Parliament. In case of a union territory, no reference need be made to the concerned legislature to ascertain its views, and the Parliament can itself take any action as it deems fit. It is, thus, clear that the Constitution authorizes the Parliament to form new states or alter the areas, boundaries or names of the existing states without their consent. In other words, the Parliament can redraw the political map of India according to its will. Hence, the territorial integrity or continued existence of any state is not guaranteed by the Constitution. Therefore, India is rightly described as an indestructible union of destructible states. The union government can destroy the states whereas the state governments cannot destroy the union. In USA, on the other hand, the territorial integrity or continued existence of a state is guaranteed by the Constitution. The American federal government cannot form new states or alter the borders of existing states without the consent of the states concerned. That is why the USA is described as an indestructible union of indestructible states. Moreover, the Constitution, Article 4, itself declares that laws made for admission or establishment of new states, under Article 2, and formation of new states and alteration of areas, boundaries or names of existing states, under Articles 3, are not to be considered. 3 added by the 18th Constitutional Amendment Act of 1966. Babulal vs. State of Bombay, 1959. Union and its Territory 51. As amendments of the Constitution under Article 368. This means that such laws can be passed by a simple majority and by the ordinary legislative process. Does the power of Parliament to diminish the areas of a state, under Article 3, include also the power to cede Indian territory to a foreign country? This question came up for examination before the Supreme Court in a reference made by the President in I-960. The decision of the central government to cede part of a territory known as Barabari Union, West Bengal, to Pakistan led to political agitation and controversy and thereby necessitated the presidential reference. The Supreme Court held that the power of Parliament to diminish the area of a state, under Article 3, does not cover cession of Indian territory to a foreign country. Hence, Indian territory can be ceded to a foreign state only by amending the Constitution under Article 368. Consequently, the 9th Constitutional Amendment Act, 1960, was enacted to transfer the said territory to Pakistan. On the other hand, the Supreme Court in 1969 ruled that settlement of a boundary dispute between India and another country does not require a constitutional amendment. It can be done by executive action as it does not involve cession of Indian territory to a foreign country. The various laws made by the Parliament under Article 3 are mentioned in Table 6.4. T. Exchange of territories T with Bangladesh. The 100th Constitutional Amendment Act, 2015, was enacted to give effect to the acquiring of certain territories by India and transfer of certain other territories to Bangladesh in pursuance of the agreement and its protocol entered into between the governments of India and Bangladesh. Under this deal, India transferred 111 enclaves to Bangladesh, while Bangladesh transferred 51 enclaves to India. In addition, the deal also involved the transfer of adverse possessions and the demarcation of a 6.1 kilometers undemarcated border stretch. For these three purposes, the amendment modified the provisions relating to the territories of 4 states, Assam, West Bengal, Meghalaya, and Tripura, in the first schedule of the Constitution. The background of this amendment is as follows. 1. India and Bangladesh have a common land boundary of approximately 4,096.7 kilometers. The India-East Pakistan land boundary was determined as per the Radcliffe Award of 1947. Disputes arose out of some provisions in the Radcliffe Award, which were sought to be resolved through the Bagh Award of 1950. Another effort was made to settle these disputes by the Nehru-Noon Agreement of 1958. However, the issue relating to division of Barabari Union was challenged before the Supreme Court. To comply with the opinion rendered by the Supreme Court, the Constitution, 9th Amendment, Act, I-960 was passed by the Parliament. Due to the continuous litigation and other political developments at that time, the Constitution, 9th Amendment, Act, I-960 could not be notified in respect of territories in former East Pakistan, presently Bangladesh. 4.2. On May 16, 1974, the agreement between India and Bangladesh concerning the demarcation of the land boundary and related matters was signed between both the countries to find a solution to the complex nature of the border demarcation involved. This agreement was not ratified as it involved, inter alia, transfer of territory, which requires a constitutional amendment. In this connection, it was also required to identify the precise area on the ground which would be transferred. Subsequently, the issues relating to demarcation of undemarcated boundary, the territories in adverse possession, and for this information is downloaded from the website of Ministry of Law and Justice, Legislative Department, Government of India. 52. Indian Polity. Exchange of enclaves were identified and resolved by signing a protocol on September 6, 2011, which forms an integral part of the land boundary agreement between India and Bangladesh, 1974. The protocol was prepared with support and concurrence of the concerned state governments of Assam, Meghalaya, Tripura, and West Bengal. 411. Evolution of states and union territories. Integration of princely states at the time of independence. India comprised 2 categories of political units, namely, the British provinces, under the direct rule of British government, and the princely states, under the rule of native princes but subject to the paramountcy of the British Crown. The Indian Independence Act, 1947, created 2 independent and separate dominions of India and Pakistan and gave 3 options to the princely states viz. Joining India, joining Pakistan, or remaining independent. Of the 552 princely states situated within the geographical boundaries of India, 549 joined India, and the remaining 3, Hyderabad, Junagadh, and Kashmir, refused to join India. However, in course of time, they were also integrated with India, Hyderabad by means of police action, Junagadh by means of referendum, and Kashmir by the instrument of accession. In 1950, the Constitution contained a 4-fold classification of the states and territories of the Indian Union, Part A, Part B, and Part C states, and Part 1, territories. In all, they numbered 29. Part A states comprised 9 erstwhile governors' provinces of British India. Part B states consisted of 9 erstwhile princely states with legislatures. Part C states consisted of erstwhile chief commissioners' provinces of British India and some of the erstwhile princely states. These Part C states, in all 10 in number, were centrally administered. The Andaman and Nicobar Islands were kept as the solitary Part D territories. This 4-fold classification of the states and territories, 1950, is given in Fleas 6.1. Their Commission and JVP Committee. The integration of princely states with the rest of India has purely an ad hoc arrangement. There has been a demand from different Prohibition. Table 6.1 Territory of India in 1950. States in Part A, States in Part B, States in Part C, Territories in Part D. 1. Assam 1. Hyderabad 1. Ajmer 1. Andaman and Nicobar Islands. 2. Bihar 2. Jammu and Kashmir 2. Bhopal. 3. Bombay 3. Madhya Bharat 3. Bilaspur. 4. Madhya Pradesh 4. Mysore 4. Cooch Behar. 5. Madras 5. Patiala and East Punjab 5. Cork. 6. Orissa 6. Rajasthan 6. Delhi. 7. Punjab 7. Saurashtra 7. Himachal Pradesh. 8. United Provinces 8. Travancore Cochin 8. Kutch. 9. West Bengal 9. Vindhya Pradesh 9. Manipur. 10. Tripura Union and its territory 53. Regions, particularly South India, for reorganization of states on linguistic basis. Accordingly, in June 1948, the Government of India appointed the Linguistic Provinces Commission under the chairmanship of S.K. there to examine the feasibility of this. The commission submitted its report in December 1948 and recommended the reorganization of states on the basis of administrative convenience rather than linguistic factor. This created much resentment and led to the appointment of another Linguistic Provinces Committee by the Congress in December 1948, itself to examine the whole question afresh. It consisted of Jawaharlal Nehru, Vallabhbhai Patel, and Pattabhi Singh, and hence was popularly known as the JVP Committee. It had no chairman or convener. It submitted its report in April 1949 and formally rejected language as the basis for reorganization of states. However, in October 1953, the Government of India was forced to create the first linguistic state, known as Andhra State, by separating the Telugu-speaking areas from the Madras state. This followed a prolonged popular agitation and the death of Pai Shirulu, a congressperson of standing, after a 56-day hunger strike for the cause. Fazl Ali Commission. The creation of Andhra State intensified the demand from other regions for creation of states on linguistic basis. This forced the Government of India to appoint, in December 1953, a three-member States Reorganization Commission under the chairmanship of Fazl Ali to re-examine the whole question. Its other two members were K.M. Panikkar and H.N. Kunzru. It submitted its report in September 1955 and broadly accepted language as the basis of reorganization of states. But it rejected the theory of one language, one state. Its view was that the unity of India should be regarded as the primary consideration in any redrawing of the country's political units. It identified four major factors that can be taken into account in any scheme of reorganization of states. A. Preservation and strengthening of the unity and security of the country. B. Linguistic and cultural homogeneity. C. Financial, economic, and administrative considerations. D. Planning and promotion of the welfare of the people in each state as well as of the nation as a whole. The Commission suggested the abolition of the fourfold classification of states and territories under the original Constitution and creation of 16 states and 3 centrally administered territories. The Government of India accepted these recommendations with certain minor modifications. By the States Reorganization Act, 1956, and the 7th Constitutional Amendment Act, 1956, the distinction between Part A and Part B states was done away with, and Part C states were abolished. Some of them were merged with adjacent states, and some other were designated as union territories. As a result, 14 states and 6 union territories were created on November 1, 1956. These are mentioned in FLE 6.2. Table 6.2 Territory of India in 1956. States Union Territories. 1. Andhra Pradesh 1. Andaman and Nicobar Islands. 2. Assam 2. Delhi. 3. Bihar 3. Himachal Pradesh. 4. Bombay 4. Lakkadive, Minicoy and Amenability Islands. 5. Jammu and Kashmir 5. Manipur. 6. Kerala 6. Tripura. 7. Madhya Pradesh. 8. Madras. 9. Mysore. 10. Orissa. 11. Punjab. 12. Rajasthan. 13. Uttar Pradesh. 14. West Bengal. 54 Junior Indian Polity. The States Reorganization Act, 1956, established the new state of Kerala by merging the Travancore, Cochin state with the Malabar district of Madras state and Kasaragod of South Kannada, Dakshina Kannada. It merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the Andhra Pradesh state. Further, it merged the Madhya Bharat state, Vindhya Pradesh state, and Bhopal state into the Madhya Pradesh state. Similarly, it merged the Saurashtra state and Kutch state into that of the Bombay state, the Coorg state into that of Mysore state, the Patiala and East Punjab states union, PEPSU, into that of Punjab state. and the Ajmer state into that of Rajasthan state. Moreover, it created the new Union territory of Lakshadweep, Minicoy, and Aman Divi Islands from the territory detached from the Madras state. New states and Union territories created after 1956. Even after the large-scale reorganization of the states in 1956, the political map of India underwent continuous changes due to the pressure of popular agitations and political conditions. The demand for the creation of some more states on the basis of language or cultural homogeneity resulted in the bifurcation of existing states. Maharashtra and Gujarat in 1960, the bilingual state of Bombay was divided into two separate states, Maharashtra for Marathi-speaking people and Gujarat for Gujarati-speaking people. Gujarat was established as the 15th state of the Indian Union. 5 by the Bombay Reorganization Act, 1960. 6 by the Goa, Daman and Diu Reorganization Act, 1987. By the State of Nagaland Act, 1962, with effect from December 1963. 8 by Punjab Reorganization Act, 1966. Dadra and Nagar Haveli. The Portuguese ruled this territory until its liberation in 1954. Subsequently, the administration was carried on till 1961 by an administrator chosen by the people themselves. It was converted into a Union Territory of India by the 10th Constitutional Amendment Act, 1961. Later, in 2020, this Union Territory was merged with the Union Territory of Daman and Diu in order to form a new Union Territory of Dadra and Nagar Haveli and Daman and Diu. This was done by the Dadra and Nagar Haveli and Daman and Diu Merger of Union Territories Act, 2019. Goa, Daman and Diu India acquired these 3 territories from the Portuguese by means of a police action in 1961. They were constituted as a Union Territory by the 12th Constitutional Amendment Act, 1962. Later, in 1987, Goa was conferred a statehood. 6 Consequently, Daman and Diu was made a separate Union Territory. Again, in 2020, the Union Territory of Daman and Diu was merged with the Union Territory of Dadra and Nagar Haveli in order to form a new Union Territory of Dadra and Nagar Haveli and Daman and Diu. This was done by the Dadra and Nagar Haveli and Daman and Diu Merger of Union Territories Act, 2019. Puducherry. The territory of Puducherry comprises the former French establishments in India, known as Puducherry, Karaikal, Mahe, and Yanam. The French handed over this territory to India in 1954. Subsequently, it was administered as an acquired territory, till 1962 when it was made a Union Territory by the 14th Constitutional Amendment Act. Nagaland in 1963, the state of Nagaland was formed 78 by taking the Naga Hills and Tuensang area out of the state of Assam. This was done to satisfy the movement of the hostile Nagas. However, before giving Nagaland the status of the 16th state of the Indian Union, it was placed under the control of the governor of Assam in 1961. Haryana, Chandigarh and Himachal Pradesh in 1966, the state of Punjab was bifurcated to 1. Create Haryana, the 17th state of the Indian Union, and the Union Territory of Chandigarh. This followed the demand for a separate Sikh homeland, Punjabi Sabha, raised by the Akali Dal under the leadership of Master Thra Singh. On the recommendation of the Shah Commission, 1966, the Punjabi-speaking areas were constituted into the unilingual state of Punjab, the Hindi-speaking areas were constituted into the state of Haryana, and the hill areas were merged with the adjoining Union Territory of Himachal Pradesh. In 1971, the Union Territory of Himachal Pradesh was elevated 9 to the status of a state, 18th state of the Indian Union. And by the State of Mizoram Act, 1986, with effect from February 20, 1987. 12 by the State of Arunachal Pradesh Act, 1986, with effect from February 20, 1987. 13 by the Goa, Daman and Diu Reorganization Act, 1987. Manipur, Tripura and Meghalaya in 1972, the political map of northeast India underwent a major change. 10 Thus, the 2 Union Territories of Manipur and Tripura and the substate of Meghalaya got statehood, and the 2 Union Territories of Mizoram and Arunachal Pradesh, originally known as Northeast Frontier Agency (NIFA), came into being. With this, the number of states of the Indian Union increased to 21, Manipur 19th, Tripura 20th and Meghalaya 21st. Initially, the 22nd Constitutional Amendment Act, 1969, created Meghalaya as an autonomous state, or substate, within the state of Assam with its own legislature and council of ministers. However, this did not satisfy the aspirations of the people of Meghalaya. The Union Territories of Mizoram and Arunachal Pradesh were also formed out of the territories of Assam. Sikkim till 1947, Sikkim was an Indian princely state ruled by Chogyal. In 1947, after the lapse of British paramountcy, Sikkim became a protectorate of India, whereby the Indian government assumed responsibility for the defense, external affairs and communications of Sikkim. In 1974, Sikkim expressed its desire for greater 9 by the State of Himachal Pradesh Act, 1970, with effect from January 25, 1971. 10 by the Northeastern Areas Reorganization Act, 1971, with effect from January 21, 1972. Union and its territory 55. Association with India. Accordingly, the 35th Constitutional Amendment Act, 1974, was enacted by the Parliament. This amendment introduced a new class of statehood under the Constitution by conferring on Sikkim the status of an associate state of the Indian Union. For this purpose, a new Article 2A and a new Schedule, 10th Schedule containing the terms and conditions of association, were inserted in the Constitution. This experiment, however, did not last long as it could not fully satisfy the aspirations of the people of Sikkim. In a referendum held in 1975, they voted for the abolition of the institution of Chogyal and Sikkim becoming an integral part of India. Consequently, the 36th Constitutional Amendment Act, 1975, was enacted to make Sikkim a full-fledged state of the Indian Union, the 22nd state. This amendment amended the first and the fourth schedules to the Constitution and added a new Article 371, F to provide for certain special provisions with respect to the administration of Sikkim. It also repealed Article 2A and the 10th Schedule that were added by the 35th Amendment Act of 1974. Mizoram, Arunachal Pradesh and Goa in 1987, three new states of Mizoram 11, Arunachal Pradesh 12 and Goa 13 came into being as the 23rd, 24th and 25th states of the Indian Union respectively. The Union Territory of Mizoram was conferred the status of a full state as a sequel to the signing of a Memorandum of Settlement, Mizoram Peace Accord, in 1986 between the central government and the Mizo National Front, ending the two-decade-old insurgency. Arunachal Pradesh had also been a Union territory from 1972. The state of Goa was created by separating the territory of Goa from the Union Territory of Goa, Daman and Diu. Indian Polity. Chhattisgarh, Uttarakhand and Jharkhand in 2000. Three more new states of Chhattisgarh 1 Uttarakhand 415 and Jharkhand 16 were created out of the territories of Madhya Pradesh, Uttar Pradesh and Bihar, respectively. These became the 26th, 27th and 28th states of the Indian Union, respectively. L4 by the Madhya Pradesh Reorganization Act, 2000. 15 by the Uttar Pradesh Reorganization Act, 2000. 16 by the Bihar Reorganization Act, 2000. Telangana in 2014, the new state of Telangana came into existence as the 29th state of the Indian Union. It was carved out of the territories of Andhra Pradesh. The Andhra State Act, 1953, formed the first linguistic state of India, known as the state of Andhra, by taking out the Telugu-speaking areas from the state of Madras, now Tamil Nadu. Kurnool was the capital of Andhra State, and the state high court was established at Guntur. The States Reorganization Act, 1956, merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the enlarged Andhra Pradesh state. The capital of the state was shifted to Hyderabad. Again, the Andhra Pradesh Reorganization Act, 2014, bifurcated the Andhra Pradesh into two separate states, namely, the Andhra Pradesh Residuary and the Telangana. Jammu and Kashmir and Ladakh till 2019, the erstwhile state of Jammu and Kashmir had its own constitution and thus enjoyed a special status by virtue of Article 370 of the Constitution of India. In 2019, this special status was abolished by a presidential order known as the Constitution, Application to Jammu and Kashmir, Order, 2019. This order superseded the earlier order known as the Constitution, Application to Jammu and Kashmir, Order, 1954. The 2019 order extended all the provisions of the Constitution of India to Jammu and Kashmir also. Further, the Jammu and Kashmir Reorganization Act, 2019, bifurcated the erstwhile state of Jammu and Kashmir into two. Table 6.3 Territory of India as of now. States Union Territories. 1. Andhra Pradesh 1. Andaman and Nicobar Islands. 2. Arunachal Pradesh 2. Chandigarh. 3. Assam 3. Dadra and Nagar Haveli and Daman and Diu. 4. Bihar 4. Delhi, National Capital. Territory. 5. Chhattisgarh 5. Jammu and Kashmir. 6. Goa 6. Ladakh. 7. Gujarat 7. Lakshadweep. 8. Haryana 8. Puducherry. 9. Himachal Pradesh. 10. Jharkhand. 11. Karnataka. 12. Kerala. 13. Madhya Pradesh. 14. Maharashtra. 15. Manipur. 16. Meghalaya. 17. Mizoram. 18. Nagaland. 19. Odisha. 20. Punjab. 21. Rajasthan. 22. Sikkim. 23. Tamil Nadu. 24. Telangana. 25. Tripura. 26. Uttarakhand. 27. Uttar Pradesh. 28. West Bengal Union and its territory 57. Separate Union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. The Union Territory of Jammu and Kashmir comprises all the districts of the erstwhile state of Jammu and Kashmir except the Kargil and Leh districts which have gone to the Union Territory of Ladakh. Thus, the number of states and Union territories increased from 14 and 6 in 1956 to 28 and 8, as of now, respectively. This present position is indicated in TBLI 6.3. Change of names. The names of some states and Union territories have also been changed. The United Provinces was the first state to have a new name. It was renamed Uttar Pradesh in 1950. In 1969, Madras was renamed 17 Tamil Nadu. Similarly, in 1973, Mysore was renamed 18 Karnataka. In the same year, Lakshadweep, Minicoy and Amenability Islands were renamed 19 Lakshadweep. In 1992, the Union Territory of Delhi was redesignated as the National Capital Territory of Delhi, without being conferred the status of a full-fledged state, by the 69th Constitutional Amendment Act, 1991. In 2006, Uttarankal was renamed 20 as Uttarakhand. In the same year, Pondicherry was renamed 21 as Puducherry. In 2011, Orissa was renamed 22 as Odisha. Table 6.4 Laws made by Parliament under Article 3 of the Constitution. SI. No. Acts Provisions. 1. Assam Alteration of Boundaries, Act, 1951. Altered the boundaries of the state of Assam by ceding a strip of territory comprised in that state to Bhutan. 2. Andhra State Act, 1953 formed the first linguistic state, known as the state of Andhra, by taking out the Telugu-speaking areas from the state of Madras. Kurnool was the capital of Andhra State, and the state high court was established at Guntur. 3. Himachal Pradesh and Bilaspur, New State, Act, 1954. Formed the new state of Himachal Pradesh by uniting the existing states of Himachal Pradesh and Bilaspur. 4. Chandranagar, Merger, Act, 1954 merged the territory of Chandranagar, a former enclave of French India, into the state of West Bengal. 5. R.I. States Reorganization Act, 1956 made the extensive changes in the boundaries of various states for the purpose of meeting the linguistic, regional, and local demands. It created 14 states and 6 union territories. The states were Andhra Pradesh, Assam, Bihar, Bombay, Jammu and Kashmir, Kerala, Madhya Pradesh, Madras, Mysore, Orissa, Punjab, Rajasthan, Uttar Pradesh, and West Bengal. The union territories were Andaman and Nicobar Islands, Delhi, Himachal Pradesh, Lakshadweep, Minicoy and Amenability Islands, Manipur, and Tripura. It established the new state of Kerala by merging the Travancore Cochin state with the Malabar district of Madras state and the Kasaragod of South Kannada, Dakshina Kannada. Continued. 17 by the Madras state, Alteration of Name, Act, 1968, with effect from January 14, 1969. 18 by the Mysore state, Alteration of Name, Act, 1973. LS by the Lakshadweep, Minicoy and Amenability Islands, Alteration of Name, Act, 1973. 20 by the Uttarankal Alteration of Name, Act, 2006. 21 by the Pondicherry Alteration of Name, Act, 2006. 22 by the Orissa Alteration of Name, Act, 2011. 58 Indian Polity. 1 SI. No. Acts Provisions. It merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the Andhra Pradesh state. Further, it merged the Madhya Bharat state, Vindhya Pradesh state, and Bhopal state into the Madhya Pradesh state. Similarly, it merged the Saurashtra state and Kutch state into that of the Bombay state, the Coorg state into that of Mysore state, the Patiala and East Punjab states union Pepsu into that of Punjab state, and the Ajmer state into that of Rajasthan state. Moreover, it created the new union territory of Lakshadweep, Minicoy and Amenability Islands from the territory detached from the Madras state. 6. Bihar and West Bengal Transfer of Territories, Act, 1956. Provided for the transfer of certain territories from the state of Bihar to the state of West Bengal. 7. Rajasthan and Madhya Pradesh Transfer of Territories, Act, 1959. Provided for the transfer of certain territories from the state of Rajasthan to the state of Madhya Pradesh. 8. Andhra Pradesh and Madras Alteration of Boundaries, Act, 1959. Provided for the alteration of boundaries of the states of Andhra Pradesh and Madras. 9. Bombay Reorganization Act, 1960 formed the new state of Gujarat, 15th state, by taking out the Gujarati-speaking areas from the state of Bombay and renamed the other part of the Bombay state as Maharashtra state. The city of Ahmedabad was made the capital of Gujarat. 10. Acquired Territories Merger Act, 1960 provided for the merger into the states of Assam, Punjab, and West Bengal of certain territories acquired from Pakistan under the agreements entered into between the governments of India and Pakistan in 1958 and 1959. 11. State of Nagaland Act, 1962 formed the new state of Nagaland, 16th state, by taking out the Naga Hills, Tusang area from the state of Assam. The Naga Hills, Tusang area was a tribal area of Assam specified in the 6th schedule of the Constitution. 12. Punjab Reorganization Act, 1966 formed the new state of Haryana, 17th state, by taking out the Hindi-speaking areas from the state of Punjab. It also made Chandigarh a new union territory as well as a common capital for both Punjab and Haryana. 13. Bihar and Uttar Pradesh Alteration of Boundaries Act, 1968. Provided for the alteration of boundaries of the states of Bihar and Uttar Pradesh. 14. Andhra Pradesh and Mysore Transfer of Territory Act, 1968. Provided for the transfer of certain territory from the state of Mysore to the state of Andhra Pradesh. 15. Madras State Alteration of Name Act, 1968. Changed the name of the state of Madras to that of state of Tamil Nadu. 16. Assam Reorganization Meghalaya Act, 1969. Formed an autonomous state, substate, known as Meghalaya, within the state of Assam. 17. State of Himachal Pradesh Act, 1970 elevated the union territory of Himachal Pradesh to the status of a state, 18th state. Union and its territory 59. S. No. Act's provisions. 18. Northeastern Areas Reorganization Act, 1971. Elevated the two union territories of Manipur and Tripura to the status of states, 19th state and 20th state respectively. It also conferred full statehood on Meghalaya, 21st state, which was previously a substate within the state of Assam. Further, it formed the two union territories of Mizoram and Arunachal Pradesh out of the territories of Assam. 19. Mysore State Alteration of Name Act, 1973. Changed the name of the state of Mysore to that of the state of Karnataka. 20. Lakshadweep, Minicoy and Amenability Islands Alteration of Name Act, 1973. Changed the name of the Union Territory of the Lakshadweep, Minicoy and Amenability Islands to that of the Union Territory of Lakshadweep. 2. Haryana and Uttar Pradesh Alteration of Boundaries Act, 1979. Provided for the alteration of boundaries of the states of Haryana and Uttar Pradesh. 22. State of Mizoram Act, 1986 elevated the Union Territory of Mizoram to the status of a state, 23rd state. 23. State of Arunachal Pradesh Act, 1986. Elevated the Union Territory of Arunachal Pradesh to the status of a state, 24th state. 24. Goa, Daman and Diu Reorganization Act, 1987. Formed the new state of Goa, 25th state, by separating the territory of Goa from the Union Territory of Goa, Daman and Diu. 25. Madhya Pradesh Reorganization Act, 2000. Formed the new state of Chhattisgarh, 26th state, out of the territories of the state of Madhya Pradesh. 26. Uttar Pradesh Reorganization Act, 2000. Created the new state of Uttarankal, 27th state, by carving out its territory from that of the territories of the state of Uttar Pradesh. 27. Bihar Reorganization Act, 2000 established the new state of Jharkhand, 28th state, by separating its territory from the territories of the state of Bihar. 28. Uttarankal Alteration of Name Act, 2006. Changed the name of the state of Uttarankal to that of the state of Uttarakhand. 29. Pondicherry Alteration of Name Act, 2006. Renamed the Union Territory of Pondicherry as the Union Territory of Puducherry. 30. Orissa Alteration of Name Act, 2011 changed the name of the state of Orissa to that of the state of Odisha. 31. Andhra Pradesh Reorganization Act, 2014. Formed the new state of Telangana, 29th state, by carving out its territory from the territories of the state of Andhra Pradesh. 32. Jammu and Kashmir Reorganization Act, 2019. Bifurcated the erstwhile state of Jammu and Kashmir into two separate union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. 33. Dadra and Nagar Haveli and Daman and Diu, Merger of Union Territories, Act, 2019. Merged the erstwhile two separate union territories, the Union Territory of Dadra and Nagar Haveli and the Union Territory of Daman and Diu, in order to form a new Union Territory of Dadra and Nagar Haveli and Daman and Diu. 60. Indian Polity. Table 6.5 Articles related to Union and its territory at a glance. Article No. Subject Matter. 1. Name and territory of the Union. 2. Admission or establishment of new states. 2a. Sikkim to be associated with the Union, repealed. 3. Formation of new states and alteration of areas, boundaries or names of existing states. 4. Laws made under Articles 2 and 3 to provide for the amendment of the first and the fourth schedules. And supplemental, incidental and consequential matters. Chapter Citizenship. T. Meaning and significance. Like any other modern state, India has two kinds of people, citizens and aliens. Citizens are full members of the Indian state and owe allegiance to it. They enjoy all civil and political rights. Aliens, on the other hand, are the citizens of some other state and hence do not enjoy all the civil and political rights. They are of two categories, friendly aliens or enemy aliens. Friendly aliens are the subjects of those countries that have cordial relations with India. Enemy aliens, on the other hand, are the subjects of that country that is at war with India. They enjoy lesser rights than the friendly aliens, e.g., they do not enjoy protection against arrest and detention, Article 22. The Constitution confers the following rights and privileges on the citizens of India and denies the same to aliens. 1. Right against discrimination on grounds of religion, race, caste, sex, or place of birth, Article 15. 2. Right to equality of opportunity in the matter of public employment, Article 16. 3. Right to freedom of speech and expression, assembly, association, movement, residence, and profession, Article 19. 4. Cultural and educational rights, Articles 29 and 30. 5. Right to vote in elections to the Lok Sabha and State Legislative Assembly. 6. Right to contest for the membership of the Parliament and the state legislature. 7. Eligibility to hold certain public offices, that is, President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of States, Attorney General of India and Advocate General of States. Along with the above rights, the citizens also owe certain duties towards the Indian state, as for example, paying taxes, respecting the national flag and national anthem, defending the country, and so on. In India, both citizens by birth as well as naturalized citizens are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Australia, on the other hand, adopted the system of double citizenship. In USA, each person is not only a citizen of USA but also of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one set conferred by the national government and another by the state government. This system creates the problem of discrimination, that is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions, and so on. 62. Indian Polity. This problem is avoided in the system of single citizenship prevalent in India. In India, all citizens irrespective of the state in which they are born or reside enjoy the same political and civil rights of citizenship all over the country and no discrimination is made between them. However, this general rule of absence of discrimination is subject to some exceptions, viz. 1. The Parliament, under Article 16, can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory, or local authority or other authority within that state or union territory. Accordingly, the Parliament enacted the Public Employment Requirement as to Residence Act, 1957, and thereby authorized the Government of India to prescribe residential qualification only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur, and Tripura. As this act expired in 1974, there is no such provision for any state except Andhra Pradesh 1 and Telangana 2. 2. The Constitution, under Article 15, prohibits discrimination against any citizen on grounds of religion, race, caste, sex, or place of birth and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to the Indian citizens. For example, a state may offer concession in fees for education to its residents. 3. The freedom of movement and residence, under Article 19, is subjected to the protection of interests of any scheduled tribe. In other words, the right of outsiders. 3. Further, the Jammu and Kashmir Reorganization Act, 2019, bifurcated the erstwhile state of Jammu and Kashmir into two separate union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. By virtue of Article 371, inserted by the 32nd Constitutional Amendment Act, 1973. Article 371D has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act, 2014. To enter, reside, and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. 4. Till 2019, the legislature of the erstwhile state of Jammu and Kashmir was empowered to a. Define the persons who are permanent residents of the state, and b. Confer any special rights and privileges on such permanent residents as respects I. Employment under the state government, 2. Acquisition of a movable property in the state, 3. Settlement in the state, and 4. Right to scholarships and such other forms of aid provided by the state government. The above provision was based on Article 35A of the Constitution of India. This article was inserted in the Constitution by the Constitution Application to Jammu and Kashmir, Order, 1954. This order was issued by the President under Article 370 of the Constitution, which had provided a special status to the erstwhile state of Jammu and Kashmir. In 2019, this special status was abolished by a new presidential order known as the Constitution Application to Jammu and Kashmir, Order, 2019. This order superseded the earlier 1954 Order 34. The Constitution of India, like that of Canada, has introduced the system of single citizenship and provided uniform rights, except in few cases, for the people of India to promote the feeling of fraternity and unity among them and to build an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes, and ethnic disputes. Thus, the cherished goal of the Founding Fathers and the Constitution makers to build an united and integrated Indian nation has not been fully realized. Constitutional provisions. The Constitution deals with the citizenship from Articles 5 to 11 under Part 2. However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the persons who became citizens of India at its commencement, i.e., on January 26, 1950. It does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to citizenship. Accordingly, the Parliament has enacted the Citizenship Act, 1955, which has been amended from time to time. According to the Constitution, the following four categories of persons became the citizens of India at its commencement, i.e., on January 26, 1950. 1. A person who had his domicile in India and also fulfilled any one of the three conditions, viz. if his was born in India, or if either of his parents was born in India, or if his has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution, became a citizen of India. 2. A person who migrated to India from Pakistan became an Indian citizen if she, or either of their parents or any of their grandparents was born in undivided India and also fulfilled any one of the two conditions, viz. In case his migrated to India before July 19, 1948, his had been ordinarily resident in India since the date of his migration. Or in case his migrated to India on or after July 19, 1948, his had been registered as a citizen of India. But a person could be so registered only if his had been resident. 4. For on this date, the permit system for such migration was introduced. Citizenship 63. In India for 6 months preceding the date of his application for registration. 3. A person who migrated to Pakistan from India after March 1947, but later returned to India for resettlement could become an Indian citizen. For this, she had to be resident in India for 6 months preceding the date of his application for registration. 3. 4. A person who, or any of whose parents or grandparents, was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen if his has been registered as a citizen of India by the diplomatic or consular representative of India in the country of his residence, whether before or after the commencement of the Constitution. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. Sum up, these provisions deal with the citizenship of a. Persons domiciled in India, b. Persons migrated from Pakistan, c. Persons migrated to Pakistan but later returned, and d. Persons of Indian origin residing outside India. The other constitutional provisions with respect to the citizenship are as follows. 1. No person shall be a citizen of India or be deemed to be a citizen of India if she has voluntarily acquired the citizenship of any foreign state. 2. Every person who is or is deemed to be a citizen of India shall continue to be such citizen, subject to the provisions of any law made by Parliament. 3. Parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. 5. This provision refers to migration after March 1, 1947, but before January 26, 1950. The question of citizenship of persons who migrated after January 26, 1950, has to be decided under the provisions of the Citizenship Act, 1955. 64. Indian Polity. Citizenship Act, 1955. The Citizenship Act, 1955, provides for acquisition and loss of citizenship after the commencement of the Constitution. Originally, the Citizenship Act, 1955, also provided for the Commonwealth citizenship. But this provision was repealed by the Citizenship Amendment Act, 2003. Acquisition of citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, viz., birth, descent, registration, naturalization, and incorporation of territory. 1. By birth, a person born in India on or after January 26, 1950, but before July 1, 1987 is a citizen of India by birth irrespective of the nationality of his parents. A person born in India on or after July 1, 1987, but before December 3, 2004 is considered as a citizen of India only if either of his or her parents is a citizen of India at the time of his or her birth. Further, those born in India on or after December 3, 2004 are considered citizens of India only if both of their parents are citizens of India or one of whose parents is a citizen of India and the other is not an illegal migrant at the time of their birth. The children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. 2. By descent, a person born outside India on or after January 26, 1950, but before December 10, 1992 is a citizen of India by descent if his or father was a citizen of India at the time of his or birth. A person born outside India on or after December 10, 1992 is considered as a citizen of India if either of his or parents is a citizen of India at the time of his or birth. From December 3, 2004 onwards, a person born outside India shall not be a citizen of India by descent unless his or birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of the central government after the expiry of the said period. An application for registration of the birth of a minor child to an Indian consulate shall be accompanied by an undertaking in writing from the parents of such minor child that he or she does not hold the passport of another country. Further, a minor who is a citizen of India by virtue of descent and is also a citizen of any other country shall cease to be a citizen of India if he or she does not renounce the citizenship or nationality of another country within 6 months of his or attaining full age. 3. By registration, the central government may register as a citizen of India any person, not being an illegal migrant, if he or she belongs to any of the following categories, namely day. A person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. B. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. C. A person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. D. Minor children of persons who are citizens of India. C. A person of full age and capacity whose parents are registered as citizens of India. F. A person of full age and capacity who, or either of his or parents, was earlier citizen of independent India and is ordinarily resident in India for 12 months immediately before making an application for registration. G. A person of full age and capacity who has been registered as an overseas citizen of India cardholder for 5 years and who is ordinarily resident in India for 12 months before making an application for registration. A person shall be deemed to be of Indian origin if he or she, or either of their parents, was born in undivided India or in such other territory which became part of India after the August 15, 1947. All the above categories of persons must take an oath of allegiance before they are registered as citizens of India. 6. The form of the oath is as follows. I, A.B. do solemnly affirm, or swear, that I will bear true faith and allegiance to the Constitution of India as by law established, and that I will faithfully observe the laws of India and fulfill my duties as a citizen of India. 7. The 8th schedule of the Constitution recognizes presently 22, originally 14, languages. 8. Same as footnote 6 above. 4. B. That, if Hisha is a citizen of any country, they undertake to renounce the citizenship of that country in the event of their application for Indian citizenship being accepted. C. That Hisha has either resided in India or been in the service of a government in India or partly the one and partly the other, throughout the period of 12 months immediately preceding the date of the application. D. That during the 14 years immediately preceding the said period of 12 months, Hisha has either resided in India or been in the service of a government in India, or partly the one and partly the other, for periods amounting in the aggregate to not less than 11 years. However, the Citizenship Amendment Act 2019 has reduced this aggregate period of residence or service of government in India to not less than 5 years for the person belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community in Afghanistan, Bangladesh or Pakistan. Citizenship 65. E. That Hisha is of good character. F. That Hisha has an adequate knowledge of a language specified in the 8th schedule to the Constitution 7. And G. That in the event of a certificate of naturalization being granted to him or she intends to reside in India, or to enter into or continue in service under a government in India or under an international organization of which India is a member or under a society, company, or body of persons established in India. However, the government of India may waive all or any of the above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace, or human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India. 8.5. By incorporation of territory, if any foreign territory becomes a part of India, the government of India specifies the persons who among the people of the territory shall be the citizens of India. Such persons become the citizens of India from the notified date. For example, when Pondicherry became a part of India, the government of India issued the Citizenship Pondicherry Order 1962 under the Citizenship Act 1955. 6. Special provisions as to citizenship of persons covered by the Assam Accord. The Citizenship Amendment Act 1985 added the following special provisions as to citizenship of persons covered by the Assam Accord, which related to the foreigners issue A. All persons of Indian origin who came to Assam before January 1, 1966, from Bangladesh and who have been ordinarily residents in Assam since the date of their entry into Assam shall be deemed to be citizens of India as from January 1, 1966. 66 JK Indian Polity. B. Every person of Indian origin who came to Assam on or after January 1, 1966 but before March 25, 1971 from Bangladesh, and who has been ordinarily resident in Assam since the date of his entry to Assam, and who has been detected to be a foreigner shall register himself. Such a registered person shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years from the date of detection as a foreigner. But, in the intervening period of 10 years, Husha shall have the same rights and obligations as a citizen of India, excepting the right to vote. 7. Special provisions as to citizenship of persons migrated from Afghanistan, Bangladesh, or Pakistan. The Citizenship Amendment Act 2019 added the following special provisions as to the citizenship of migrants belonging to Hindu, Sikh, Buddhist, Jain, Parsi, or Christian communities from Afghanistan, Bangladesh, or Pakistan who entered into India on or before December 31, 2014, and who have been exempted from the adverse penal consequences of the Passport, Entry into India Act 1920 and the Foreigners Act 1946, A. The central government may grant a certificate of registration or certificate of naturalization to such a person on the fulfillment of the specified conditions for registration or qualifications for naturalization. Such a person who has been granted the certificate of registration or certificate of naturalization shall be deemed to be a citizen of India from the date of his entry into India. B. Any proceeding pending against such a person in respect of illegal migration or citizenship shall stand abetted on the conferment of citizenship to him. C. These special provisions are not applicable to tribal area of Assam, Meghalaya, Mizoram, or Tripura as included in the 6th Schedule to the Constitution and the area covered under the Inner Line, notified under the Bengal Eastern Frontier Regulation, 1873. Before the enactment of the Citizenship Amendment Act 2019, the migrants belonging to Hindu, Sikh, Buddhist, Jain, Parsi, or Christian communities from Afghanistan, Bangladesh, or Pakistan who entered into India without valid passport and other travel documents, or if the validity off-tier passport and other documents had expired, were regarded as illegal migrants and were ineligible to apply for Indian citizenship under the provisions, registration or naturalization, of the Citizenship Act 1955. In 2015, the central government exempted the said migrants from the adverse penal consequences of the Passport, Entry into India Act 1920 and the Foreigners Act 1946. Subsequently, in 2016, the central government also made them eligible for long-term visa to stay in India. With the enactment of the Citizenship Amendment Act 2019, the said migrants became eligible for Indian citizenship. ZI's Act came into force on January 10, 2020. Loss of citizenship. The Citizenship Act 1955 prescribes 3 ways of losing citizenship whether acquired under the Act or prior to it under the Constitution, viz., renunciation, termination, and deprivation. 1. By renunciation, any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Upon the registration of that declaration, that person ceases to be a citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Further, when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, citizenship 67, Hesha may, within 1 year, resume Indian citizenship. 2. By termination, when an Indian citizen voluntarily, consciously, knowingly and without duress, undue influence or compulsion, acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which India is engaged. 3. By deprivation, it is a compulsory termination of Indian citizenship by the central government if a. The citizen has obtained the citizenship by fraud, b. The citizen has shown disloyalty to the Constitution of India, c. The citizen has unlawfully traded or communicated with the enemy during a war, d. The citizen has, within 5 years after registration or naturalization, been imprisoned in any country for 2 years, and e. The citizen has been ordinarily resident out of India for 7 years continuously. 9. This will not apply if Husha is a student abroad, or is in the service of a government in India or an international organization of which India is a member, or is registered annually at an Indian consulate his intention to retain his Indian citizenship. T. Overseas citizenship of India. In September 2000, the Government of India, Ministry of External Affairs, had set up a high-level committee on the Indian diaspora under the chairmanship of L.M. Singhvi. The mandate of the committee was to conduct a comprehensive study of the global Indian diaspora and to recommend measures for a constructive relationship with them. The committee submitted its report in January 2002. It recommended the amendment of the Citizenship Act 1955 to provide for grant of dual citizenship to the persons of Indian origin (PIOs) belonging to certain specified countries. Accordingly, the Citizenship Amendment Act 2003 made provision for acquisition of overseas citizenship of India (OCI) by the PIOs of 16 specified countries other than Pakistan and Bangladesh. It also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. Later, the Citizenship Amendment Act, 2005, expanded the scope of grant of OCI for POs of all countries except Pakistan and Bangladesh as long as their home countries allowed dual citizenship under their local laws. It must be noted here that the OCI is not actually a dual citizenship, as the Indian Constitution forbids dual citizenship or dual nationality, Article 9. Again, the Citizenship Amendment Act, 2015, has modified the provisions pertaining to the OCI in the Principal Act. It has introduced a new scheme called Overseas Citizen of India Cardholder by merging the PIO card scheme and the OCI card scheme. The PIO card scheme was introduced on August 19, 2002, and thereafter the OCI card scheme was introduced December 2, 2005. Both the schemes were running in parallel even though the OCI card scheme had become more popular. This was causing unnecessary confusion in the minds of applicants. Keeping in view some problems being faced by applicants and to provide enhanced facilities to them, the Government of India decided to formulate one single scheme after merging the PIO and OCI schemes, containing positive attributes of both. Hence, for achieving this objective, the Citizenship Amendment Act, 2015, was enacted. The PIO scheme was rescinded January 9, 2015, and it was also notified that all existing PIO cardholders shall be deemed to be OCI cardholders January 9, 2015.10. Annual Report 2015-16, Ministry of Home Affairs, Government of India, p. 262. 68 Indian Polity. The Citizenship Amendment Act, 2015, replaced the nomenclature of Overseas Citizen of India with that of Overseas Citizen of India Cardholder and made the following provisions in the Principal Act. Registration of Overseas Citizen of India Cardholder. The central government may register as an Overseas Citizen of India Cardholder, a. any person of full age and capacity, I. who was a citizen of another country, but was a citizen of India at the time of, or at any time after the commencement of the Constitution, or 2. who was a citizen of another country, but was eligible to become a citizen of India at the time of the commencement of the Constitution, or 3. who was a citizen of another country, but belonged to a territory that became part of India after the August 15, 1947, or 4. who was a child or a grandchild or a great-grandchild of such a citizen, or B. a person who is a minor child of a person mentioned in above clause A, or C. a person who is a minor child and whose both parents are citizens of India or one of the parents is a citizen of India, or D. spouse of foreign origin of a citizen of India or spouse of foreign origin of an overseas citizen of India cardholder and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. But a person who or either of whose parents or grandparents or great-grandparents is or had been a citizen of Pakistan, Bangladesh, or such other country as the central government may specify, shall not be eligible for registration as an Overseas Citizen of India cardholder. JJ Confirmative Rights on Overseas Citizen of India cardholder. 1. An Overseas Citizen of India cardholder shall be entitled to such rights as the central government may specify in this behalf. These are mentioned in FLE 7.1, under serial number 7. 2. An Overseas Citizen of India cardholder shall not be entitled to the following rights, which are conferred on a citizen of India. A. Husha shall not be entitled to the right to equality of opportunity in matters of public employment. Article 16. B. Hisha shall not be eligible for election as President, Article 58. C. Hisha shall not be eligible for election as Vice President, Article 66. D. Hisha shall not be eligible for appointment as a Judge of the Supreme Court, Article 124. E. Hisha shall not be eligible for appointment as a Judge of the High Court, Article 217. F. Hisha shall not be entitled for registration as a voter. G. Hisha shall not be eligible for being a member of the House of the People or of the Council of States. H. Hisha shall not be eligible for being a member of the State Legislative Assembly or the State Legislative Council. I. Husha shall not be eligible for appointment to public services and posts in connection with affairs of the Union or of any state except for appointment in such services and posts as the central government may specify. 111. Renunciation of Overseas Citizen of India Card. 1. Any Overseas Citizen of India cardholder can make a declaration renouncing Hisho Overseas Citizen of India Citizenship 69. Cardholder status. After that declaration is registered by the central government, such person ceases to be an Overseas Citizen of India cardholder. 2. Where a person ceases to be an Overseas Citizen of India cardholder, the spouse of foreign origin of that person, who has obtained Overseas Citizen of India card, and every minor child of that person, registered as an Overseas Citizen of India cardholder, also ceases to be an Overseas Citizen of India cardholder. 4. Cancellation of registration as Overseas Citizen of India cardholder. The central government may cancel the registration of a person as an Overseas Citizen of India cardholder if it is satisfied that A. The registration as an Overseas Citizen of India cardholder was obtained by means of fraud, false representation, or the concealment of any material fact. Or B. The Overseas Citizen of India cardholder has shown disaffection towards the Constitution of India. Or C, the overseas citizen of India cardholder has, during any war in which India may be engaged, unlawfully traded or communicated with an enemy. Or D, the overseas citizen of India cardholder has, within 5 years after registration, been sentenced to imprisonment for a term of not less than 2 years. Or E, the overseas citizen of India cardholder has violated the provisions of the Citizenship Act, 1955, or the provisions of any other law as may be specified by the central government. This provision was added by the Citizenship Amendment Act, 2019. Or F, it is necessary so to do in the interests of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interests of the general public. Or G, the marriage of an overseas citizen of India cardholder, I, has been dissolved by a competent court of law or otherwise. Or 2, has not been dissolved but, during the subsistence of such marriage, Husha has solemnized marriage with any other person. However, before the cancellation of Husha registration as an overseas citizen of India cardholder, Husha will be given a reasonable opportunity of being heard. This provision was also added by the Citizenship Amendment Act, 2019. Table 7.1 comparing NRI, PIO, and OCI cardholder 11. SI. No. Elements of comparison. Non-resident Indian, NRI. Person of Indian origin, PIO. Overseas citizen of India, OCI, cardholder. 1. Who? An Indian. Citizen who is ordinarily residing outside India and holds an Indian passport. A person who or whose any of ancestors was an Indian national and who is presently holding another country's citizenship nationality, i.e. Husha, is holding foreign passport. A person registered as overseas citizen of India, OCI, cardholder under the Citizenship Act, 1955. Continued. This table is downloaded from the website of Ministry of Home Affairs, Government of India. 7E are Indian Polity. SI. Elements of non-resident person of Indian overseas citizen of India, OCI, cardholder no. Comparison Indian, NRI, origin, PIO. 2. Who is eligible? Following categories of foreign nationals are eligible for registration as overseas citizen of India, OCI, cardholder, I, who was a citizen of India at the time of, or at any time after the commencement of the Constitution, i.e., January 26, 1950. Or 2. Who was eligible to become a citizen of India on January 26, 1950. Or who belonged to a territory that became part of India after August 15, 1947. Or 4. Who is a child or a grandchild or a great-grandchild of such a citizen. Or V. Who is a minor child of such persons mentioned above. Or 6. Who is a minor child and whose both parents are citizens of India or one of the parents is a citizen of India. Or 7. Spouse of foreign origin of a citizen of India or spouse of foreign origin of an overseas citizen of India cardholder registered under the Citizenship Act, 1955, and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. 3. How can one get eligible persons to apply online? 4. Where to? I. Applicants outside India apply. A. The Indian mission post having jurisdiction over the country of which applicant is a citizen. Or B. If Husha is not living in the country of his citizenship, to the Indian mission post having jurisdiction over the country of which the applicant is ordinarily resident. 2. Applicants in India. If the applicant is residing in India, to the foreigners' regional registration offices, FRROs, according to their jurisdictional one control. Note, for the above purpose, ordinarily resident will mean a person staying in a particular country or in India for a continuous period of 6 months. 5. Fees. A. In case of application submitted in Indian mission post abroad US $275 or equivalent in local currency. B. In case of application submitted in Lundaya, M 5.000, Citizenship 71. ISC. NC. Elements of non-resident person of Indian overseas citizen of India, OCI, cardholder comparison Indian, NRI, origin, PIO. 6. Which nationals? No person, who or either of whose parents are ineligible, or grandparents or great-grandparents is, or what benefits one is entitled to? All benefits as available to Indian citizens subject to notifications issued by the government from time to time. No specific benefits. Had been a citizen of Pakistan, Bangladesh, or such other country as the central government may specify, shall be eligible for registration as an overseas citizen of India cardholder. I. Multiple entry lifelong visa for visiting India for any purpose. However, the OCI cardholder is required to obtain a special permission or a special permit from the competent authority or the FRROs or the Indian mission concerned for understanding the following activities. A. To undertake research. B. To undertake any missionary or tabli or mountaineering or journalistic activities. C. To undertake internship in any foreign diplomatic missions or foreign government organizations in India, or to take up employment in any foreign diplomatic missions in India. D. To visit any place which falls within the protected or restricted or prohibited areas as notified by the central government or competent authority. 2. Exemption from registration with Foreigners Regional Registration Officer, FRRO, or Foreigners Registration Officer, FRO, for any length of stay in India. Parity with Indian nationals in the matter of A. Tariffs in airfares in domestic sectors in India, and B. Entry fees to be charged for visiting national parks, wildlife sanctuaries, the national monuments, historical sites, and museums in India. 4. Parity with non-resident Indians in the matter of A. Inter-country adoption of Indian children. Continued. $72 *__ Indian Polity. Elements of non-resident person of Indian overseas citizen of India, OCI, cardholder. Comparison Indian, NRI, origin, PIO. B. Appearing for the All India entrance tests such as National Eligibility Entrance Test, Joint Entrance Examination, Mains Advanced, or such other tests to make them eligible for admission only against any non-resident Indian seat or any supernumeracy seat. However, the OCI cardholder is not eligible for admission against any seat reserved exclusively for Indian citizens. C. Purchase or sale of immovable properties other than agricultural land or farmhouse or plantation property. And D. Pursuing the following professions in India: doctors, dentists, nurses and pharmacists, advocates, architects, and chartered accountants. V. The OCI cardholder shall have the same rights and privileges as a foreigner in respect of all other economic, financial, and educational fields not specified in the notification issued by the central government or the rights and privileges not covered in the notifications issued by the Reserve Bank of India under the Foreign Exchange Management Act, 1999. 6. The OCI cardholders are eligible for appointment as teaching faculty in ILs, NITs, IIMs, users, HSC, central universities, and in the new All-MS set up under Pradhan Mantri Swasthya Suraksha Yojana. 8. Does HESHA require visa for visiting India? No. Yes. OCI card is itself a multiple entry lifelong visa for visiting India. 9. Is HESHA required to register with the local police authorities in India? No. Yes, if the period of stay is for more than 180 days. No. Citizenship 73. Table 7.2 articles related to citizenship at a glance. St. No. Elements of comparison. Non-resident Indian NRI. Person of Indian origin PIO. Overseas citizen of India OCI cardholder. 10. What activities can be undertaken in India? All activities activity as per the type of visa obtained. All activities except certain activities for which prior permission or special permit is required. 11. How can one acquire Indian citizenship? HESHA is an Indian citizen. As per the Citizenship Act, 1955, HESHA has to be ordinarily resident in India for a period of 7 years before making an application for registration. As per the Citizenship Act, 1955, a person registered as an OCI cardholder for 5 years and who is ordinarily resident in India for 12 months before making an application for registration is eligible for grant of Indian citizenship. Article No. Subject Matter. 5. Citizenship at the commencement of the Constitution. 6. Rights of citizenship of certain persons who have migrated to India from Pakistan. 7. Rights of citizenship of certain migrants to Pakistan. 8. Rights of citizenship of certain persons of Indian origin residing outside India. 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. 10. Continuance of the rights of citizenship. 11. Parliament to regulate the right of citizenship by law. Chapter Fundamental Rights. Fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA, i.e., Bill of Rights. Part 3 of the Constitution is rightly described as the Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. The fundamental rights are guaranteed by the Constitution to all persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest, and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not of men. The fundamental rights are named so because they are guaranteed and protected. Magna Carta is the Charter of Rights issued by King John of England in 1215 under pressure from the barons. This is the first written document relating to the fundamental rights of citizens. By the Constitution, which is the fundamental law of the land. They are fundamental also in the sense that they are most essential for the all-round development, material, intellectual, moral, and spiritual, of the individuals. Originally, the Constitution provided for 7 fundamental rights viz. 1. Right to equality, Articles 14 to 18, 2. Right to freedom, Articles 19 to 22, 3. Right against exploitation, Articles 23 to 24, 4. Right to freedom of religion, Articles 25 to 28, 5. Cultural and educational rights, Articles 29 to 36. Right to property, Article 31, 7. Right to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act, 1978. It is made a legal right under Article 300, A in Part 12 of the Constitution. So, at present, there are only 6 fundamental rights. These are mentioned in Table 8.1. T features of fundamental rights underscore 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 underscore. The fundamental rights guaranteed by the Constitution are characterized by the following. 1. Some of them are available only to the citizens while others are available to all persons whether citizens, foreigners, or legal persons like corporations or companies. The fundamental rights that are fundamental rights 75. Table 8.1 Fundamental rights at a glance. A category consists of 1. Right to equality, Articles 14 to 18. A. Equality before law and equal protection of laws, Article 14. B. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, Article 15. C. Equality of opportunity in matters of public employment, Article 16. D. Abolition of untouchability and prohibition of its practice, Article 17. E. Abolition of titles except military and academic, Article 18. 2. Right to freedom, Articles 19 to 22. A. Protection of 6 rights regarding freedom of speech and expression. 2. Assembly. Association, 4. Movement, v. Residence, and 6. Profession, Article 19. B. Protection in respect of conviction for offenses, Article 20. C. Protection of life and personal liberty, Article 21. D. Right to elementary education, Article 21A. E. Protection against arrest and detention in certain cases, Article 22. 3. Right against exploitation, Articles 23 to 24. A. Prohibition of traffic in human beings and forced labor, Article 23. B. Prohibition of employment of children in factories, etc. Article 24. 4. Right to freedom of religion, Article 25 to 28. A. Freedom of conscience and free profession, practice and propagation of religion, Article 25. B. Freedom to manage religious affairs, Article 26. C. Freedom from payment of taxes for promotion of any religion, Article 27. D. Freedom from attending religious instruction or worship in certain educational institutions, Article 28. 5. Cultural and educational rights, Articles 29 to 30. A. Protection of language, script, and culture of minorities, Article 29. B. Right of minorities to establish and administer educational institutions, Article 30. 6. RRGHD to constitutional rep. Case. Article 32. Right to move the Supreme Court for the enforcement of fundamental rights including the writs of I. Habeas corpus, 2. Mandamus, 2. Prohibition, 4. Certiorari, and v. Quo warranto, Article 32. Available the foreigners are mentioned in Table 8.2. 2. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. 3. All of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. 4. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. 5. They are justiciable, allowing persons to move the courts for their enforcement if and when they are violated. 6. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the high courts. 7. They are not sacrosanct or permanent. The Parliament can curtail or repeal them, but only by a constitutional amendment act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. 76 YJ Indian Polity. Table 8.2 Fundamental Rights, FR, of foreigners. F are available only to citizens and not to foreigners. F are available to both citizens and foreigners, except enemy aliens. 1. Prohibition of discrimination on grounds of religion. 1. Equality before law and equal protection of laws race, caste, sex, or place of birth, Article 15. Article 14. 2. Equality of opportunity in matters of public employ. 2. Protection in respect of conviction for offenses merit. Article 16. Article 20. 3. Protection of 6 rights regarding freedom of speech. 3. Protection of life and personal liberty. Article 21. And expression. Assembly. Association. 4. Movement. Residence. And 6. Profession. Article 19. 4. Protection of language, script, and culture of minor. 4. Right to elementary education. Article 21a. Ties. Article 29. 5. Right of minorities to establish and administer educa. 5. Protection against arrest and detention in certain penal institutions. Article 30. Cases. Article 22f. 6. Prohibition of traffic in human beings and forced labor. Article 23. 7. Prohibition of employment of children in factories, etc. Article 24. 8. Freedom of conscience and free profession, practice, and propagation of religion. Article 25. 9. Freedom to manage religious affairs. Article 26. 10. Freedom from payment of taxes for promotion of any religion. Article 27. 11. Freedom from attending religious instruction or worship in certain educational institutions. Article 28. 8. They can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 are automatically suspended only when emergency is declared on the grounds of war or external aggression, external emergency, and not on the ground of armed rebellion, internal emergency. 9. Their scope of operation is limited by Article 31a, saving of laws providing for acquisition of estates, etc. Article 31b, validation of certain acts and regulations included in the 9th Schedule, and Article 31c, saving of laws giving effect to certain directive principles. 10. Their application to the members of armed forces, paramilitary forces, police forces. Intelligence agencies and analogous services can be restricted or abrogated by the Parliament. Article 33. 11. Their application can be restricted while martial law is in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order. Article 34. It is different from the imposition of national emergency. 12. Most of them are directly enforceable, self-executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament and not by state legislatures, so that uniformity throughout the country is maintained. Article 35. Fundamental rights. Definition of state The term state has been used in different provisions concerning the fundamental rights. Hence, Article 12 has defined the term for the purposes of Part 3. According to it, the state includes the following: A. Government and Parliament of India, that is, executive and legislative organs of the Union Government. B. Government and legislature of states, that is, executive and legislative organs of state government. C. All local authorities, that is, municipalities, panchayats, district boards, improvement trusts, etc. D. All other authorities, that is, statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. Thus, state has been defined in a wider sense, so as to include all its agencies. It is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. T. Laws inconsistent with T. Fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressively provides for the doctrine of judicial review. This power has been conferred on the Supreme Court, Article 32, and the High Courts, Article 226, that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following: A. Permanent laws enacted by the Parliament or the state legislatures. B. Temporary laws like ordinances issued by the President or the state governors. C. Statutory instruments in the nature of delegated legislation, executive legislation, like order, bylaw, rule, regulation, or notification. And D. Non-legislative sources of law, that is, custom or usage having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right and hence can be declared as void. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Kesavananda Bharti Case 2, 1973, that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence can be declared as void. Kesavananda Bharati vs. State of Kerala, 1973. T. Right to equality be equality before law and equal protection of laws. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision confers rights on all persons whether citizens or foreigners. Moreover, the word person includes legal persons, viz., statutory corporations, companies, registered societies, or any other type of legal person. The concept of equality before law is of British origin, while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes a. The absence of any special privileges in favor of any person, b. The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and c. No person, whether rich or poor, high or low, official or non-official, is above the law. The second concept, on the other hand, connotes a. The equality of treatment under 78 Indian Polity. Equal circumstances, both in the privileges conferred and liabilities imposed by the laws, b. The similar application of the same laws to all persons who are similarly situated, and c. The like should be treated alike without any discrimination. Thus, the former is a negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity, and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. While Article 14 forbids class legislation, it permits reasonable classification of persons, objects, and transactions by the law. But the classification should not be arbitrary, artificial, or evasive. Rather, it should be based on an intelligible differential and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law, propounded by A.V. Dicey, the British jurist. His concept has the following three elements or aspects. I. Absence of arbitrary power, that is, no man can be punished except for a breach of law. 2. Equality before the law, that is, equal subjection of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. 3. The primacy of the rights of the individual, that is, the Constitution is the result of the rights of the individual as defined and enforced by the courts of law rather than the Constitution being the source of the individual rights. 3. Dicey observe, no man is above the law, but every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. Every official from the Prime Minister down to a constable or a collector of taxes is under the same responsibility for every act done without legal justification as any other citizen. A.V. Dicey, Introduction to the Study of the Law of the Constitution, Macmillan, 1931 edition pp. 183 to 191. The first and the second elements are applicable to the Indian system and not the third one. In the Indian system, the Constitution is the source of the individual rights. The Supreme Court held that the rule of law, as embodied in Article 14, is a basic feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Exceptions to equality. The rule of equality before law is not absolute, and there are constitutional and other exceptions to it. These are mentioned below. 1. The President of India and the Governor of States enjoy the following immunities. Article 361. I. The President or the Governor is not answerable to any court for the exercise and performance of the powers and duties of his show office. 2. No criminal proceedings shall be instituted or continued against the President or the Governor in any court during his term of office. 3. No process for the arrest or imprisonment of the President or the Governor shall be issued from any court during his term of office. 4. No civil proceedings against the President or the Governor shall be instituted during his term of office in any court in respect of any act done by him or in his her personal capacity, whether before or after his entered upon his office, until the expiration of 2 months next after notice has been delivered to him or. 2. No person shall be liable to any civil or criminal proceedings in any court in respect of the publication in a newspaper, or by radio or television, of a substantially true report of any proceedings of either House of Parliament or either House of the Legislature of a state, Article 361, a. 3. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote. Fundamental Right 79. Given by him her in Parliament or any committee thereof, Article 105. 4. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him her in the legislature or any committee thereof, Article 194. 5. Article 31C is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. 6. The foreign sovereigns, rulers, ambassadors, and diplomats enjoy immunity from criminal and civil proceedings. 7. The UNO and its agencies enjoy the diplomatic immunity. Prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. The two crucial words in this provision are discrimination and only. The word discrimination means to make an adverse distinction with regard to or to distinguish unfavorably from others. The use of the word only connotes that discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction, or condition on grounds only of religion, race, caste, sex, or place of birth with regard to a. access to shops, public restaurants, hotels, and places of public entertainment, or b. the use of wells, tanks, bathing ghats, road, and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. This provision prohibits discrimination both by the state and private individuals, while the former provision prohibits discrimination only by the state. There are 4 exceptions to this general rule of non-discrimination. A. The state is permitted to make any special provision for women and children. For example, reservation of seats for women in local bodies or provision of free education for children. B. The state is permitted to make any special provision for the advancement of any socially and educationally backward classes or for the scheduled castes and the scheduled tribes. For example, reservation of seats or fee concessions in public educational institutions. 4. C. The state is empowered to make any special provision for the advancement of any socially and educationally backward classes or for the scheduled castes and the scheduled tribes regarding their admission to educational institutions. This also includes the private educational institutions, whether aided or unaided by the state, except the minority educational institutions. D. The state is empowered to make any special provision for the advancement of any economically weaker sections. Further, the state is allowed to make a provision for the reservation of up to 10% of seats for such sections in admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This reservation of up to 10% would be in addition to the existing reservations. For this purpose, the economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. For this provision was added by the First Amendment Act of 1951. The various provisions contained in Article 15 are summarized in THB 8.3. Reservation for OBCs and educational institutions. The above exception, C, was added by the 93rd Indian Polity. Table 8.3 provisions of Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, at a glance. Article No. Subject matter underscore 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 15. 1. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. 15.2. No citizen shall be subjected to any disability, liability, restriction, or condition on grounds only of religion, race, caste, sex, place of birth, or any of them with regard to the following. A. Access to shops, public restaurants, hotels, and places of public entertainment. Or B. The use of walls, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. 15.3. The state is not prevented from making any special provision for women and children. 15.4. The state is not prevented from making any special provision for the advancement of any socially and educationally backwards classes or for the scheduled castes and scheduled tribes. This provision was added by the First Amendment Act, 1951. 15.5. The state is not prevented from making any special provision for the advancement of any socially and educationally backwards classes or for the scheduled castes and the scheduled tribes regarding their admission to educational institutions. This also includes the private educational motivations, whether aided or unaided by the state, except the minority educational institutions. This provision was added by the 93rd Amendment Act, 2005. 15.6. The state is not prevented from making the following. A. Any special provision for the advancement of any economically weaker sections. And B. A provision for the reservation of up to 10% of seats for such sections in admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This provision was added by the 103rd Amendment Act, 2019. Amendment Act of 2005. In order to give effect to this provision, the Center enacted the Central Educational Institutions Reservation and Admission Act, 2006, providing a quota of 27% for candidates belonging to the other backward classes, OBCs, in all central higher educational institutions including the Indian Institutes of Technology, ILS, and the Indian Institutes of Management, IIMs. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act. But the court directed the central government to exclude the creamy layer, advanced sections, among the OBCs while implementing the law. The children of the following different categories of people belong to the creamy layer among the OBCs and thus will not get the quota benefit. I. Persons holding constitutional posts like president, vice president, judges of SC and HCs, chairmen and members of UPSC and SPSCs, CEC, CAG, and so on. 2. Group A Class 1 and Group B Class 2 officers of the All India, Central and State Services, and employees holding equivalent posts in PSUs, banks, insurance organizations, universities, etc., and also in private employment. 3. Persons who are in the rank of colonel and above in the Army and equivalent posts in the Navy, the Air Force, and the paramilitary forces. 4. Professionals like doctors, lawyers, engineers, artists, authors, consultants, and so on. 5. Persons engaged in trade, business, and industry. 6. People holding agricultural land above a certain limit and vacant land or buildings in urban areas. Fundamental Rights 81. 7. Persons having gross annual income of more than 8 lakh or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was lakh. It was subsequently revised to T2.5 lakh in 2004, 4.5 lakh in 2008, 6 lakh in 2013, and 8 lakh in 2017. Reservation for EWSs and educational institutions. The above exception, D, was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker sections EWSs in admission to educational institutions. The benefit off this reservation can be availed by the persons belonging to EWSs who are not covered under any of the existing schemes of reservations for SCs, SITs, and OBCs. The eligibility criteria laid down in this regard is as follows. 1. Persons whose family has gross annual income below 8 lakh are to be identified as EWSs for the benefit of reservation. The income would include income from all sources, i.e., salary, agriculture, business, profession, etc. And it would be income for the financial year prior to the year of application. 2. Persons whose family owns or possesses any one of the following assets are to be excluded from being identified as EWSs, irrespective of the family income. A. 5 acres of agricultural land and above. B. Residential flat of 1,000 SQ. FT and above. C. Residential plot of 100 SQ. Yards and above in notified municipalities. D. Residential plot of 200 SQ. Yards and above in areas other than the notified municipalities. 3. The property held by a family in different locations or different places cities would be clubbed while applying the land or property holding test to determine EWS status. 4. Family for this purpose would include the person who seeks benefit of reservation, HISHO parents and siblings below the age of 18 years as also HISHO spouse and children below the age of 18 years. Equality of opportunity in public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. No citizen can be discriminated against or be ineligible for any employment or office under the state on grounds of only religion, race, caste, sex, descent, place of birth, or residence. There are 4 exceptions to this general rule of equality of opportunity in public employment. A. Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority. As the Public Employment Requirement as to Residence Act of 1957 expired in 1974, there is no such provision for any state except Andhra Pradesh 5 and Telangana 5A. B. The state can provide for reservation of appointments or posts in favor of any backward class that is not adequately represented in the state services. Also, the state is empowered to provide for reservation in promotions with consequential seniority in the services under the state in favor of the scheduled castes and scheduled tribes that are not adequately represented in the state services. Further, the state is empowered to consider the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancies are not to be combined with the vacancies of the year in which they are being filled, up to determine the ceiling of 50% reservation on total number of vacancies of that year. 5. By virtue of Article 371D inserted by the 32nd Amendment Act of 1973. 5A Article 371D has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act, 2014. $82 Indian Polity. Table 8.4 Provisions of Article 16, Equality of Opportunity in Matters of Public Employment, at a glance. Article No. Subject Matter. 16. 1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 16.2. No citizen can be ineligible for or discriminated against any employment or office under the state on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them. 16. 3. Parliament is not prevented from making any law to prescribe residence as a requirement for certain employment or appointment to an office under the government of a state or union territory or any local or other authority within them. 16. 4. The state is not prevented from making any provision for the reservation of appointments or posts in favor of any backward class which is not adequately represented in the services under the state. 16. For A, the state is not prevented from making any provision for reservation in matters of promotion, with consequential seniority, in the services under the state in favor of the scheduled castes and scheduled tribes which are not adequately represented in the services under the state. This provision was added by the 77th Amendment Act, 1995. Later, the 85th Amendment Act, 2001 made a modification in this provision by including the consequential seniority. 1648. The state is not prevented from considering the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years. Further, such class of vacancies are not to be combined with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on total number of vacancies of that year. This provision was added by the 81st Amendment Act, 2000. 16.5. The operation of any law is not affected even though it provides that the incumbent of any religious or denominational institution or any member of its governing body should belong to that particular religion or denomination. 16.6. The state is not prevented from making any provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker sections. This provision was added by the 103 ID Amendment Act, 2019. C. A law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to the particular religion or denomination. This means that the appointment of the office bearers in any religious or denominational institution can be restricted to the persons of that particular religion or denomination. In brief, the religious qualification can be prescribed by the law in this regard. D. The state is permitted to make a provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker sections. This reservation of up to 10% would be in addition to the existing reservation. For this purpose, the economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. The various provisions contained in Article 16 are summarized in Table 8.4. Mundell Commission and Aftermath. In 1679, the Morarji Desai government appointed the Second Backward Classes Commission under the chairmanship of B.P. Mundell, a member of Parliament, in terms of Article 340 of the Constitution to investigate the conditions of the socially and educationally backward classes and suggest measures for their advancement. The Commission submitted its report in 1980 and identified as many as 3,743 castes as socially and educationally backward classes. EFTLIC First Backward Classes Commission was appointed in 1953 under the chairmanship of Kaka Kalelkar. It submitted its report in 1955. They constitute nearly 52% component of the population, excluding the scheduled castes, SCs, and the scheduled tribes, STK. The Commission recommended for reservation of 27% government jobs for the other backward classes, OBCs, so that the total reservation for all, 80s, STK, and OBCs, amounts to 50%. 7. It was after 10 years in 1990 that the VP Singh government declared reservation of 27% government jobs for the OBCs. Again in 1991, the Narasimha Rao government introduced two changes: A. Preference to the poorer sections among the OBCs and the 27% quota, i.e., adoption of the economic criteria and granting reservation, and B. Reservation of another 10% of jobs for other economically backward sections who are not covered by any existing schemes of reservation. In 1963, the Supreme Court ruled that more than 50% reservation of jobs in a single year would be unconstitutional. Indra Soni vs. Union of India, 1992. In the Indra Soni Case 8, 1992, also called as the Mundell Case, the scope and extent of Article 16.4, which provides for reservation off jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. Though the court has rejected the additional reservation of 10% for other economically backward sections, it upheld the constitutional validity of 27% reservation for the OBCs with certain conditions, viz. A. The advanced sections among the OBCs, the creamy layer, should be excluded from the list of beneficiaries of reservation. B. No reservation in promotions. Reservation should be confined to initial appointments only. Any existing reservation in promotions can continue for 5 years only, i.e., up to 1997. C. The total reserve quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. D. The carry-forward rule in case of unfilled, backlog vacancies is valid, but it should not violate 50% rule. E. A permanent statutory body should be established to examine complaints of Fundamental Rights 83. Over-inclusion and under-inclusion in the list of OBCs. F. No relaxations in qualifying marks and standards of evaluation in matters of reservation and promotions due to the requirement of maintenance of efficiency in administration under Article 335. With regard to the above rulings of the Supreme Court, the government has taken the following actions. A. Ram Nandan Committee was appointed to identify the creamy layer among the OBCs. It submitted its report in 1993, which was accepted. B. National Commission for Backward Classes was established in 1993 by an Act of Parliament. Its mandate was to examine the complaints of under-inclusion, over-inclusion, or non-inclusion of any class of citizens in the list of backward classes for the purpose of job reservation. Later, the 102nd Amendment Act of 2018 conferred a constitutional status on the Commission and also enlarged its functions. For this purpose, the amendment inserted a new Article 338(b) in the Constitution. C. In order to nullify the ruling with regard to reservation and promotions, the 77th Amendment Act was enacted in 1995. It added a new provision in Article 16 that empowers the state to provide for reservation and promotions of any services under the state in favor of the SCs and STK that are not adequately represented in the state services. Again, the 85th Amendment Act of 2001 provides for consequential seniority. In the case of promotion by virtue of rule of reservation for the government servants belonging to the SCs and SITs with retrospective effect from June 1995. D. The ruling with regard to backlog vacancies was nullified by the 81st Amendment Act of 2000. It added another new provision in Article 16 that empowers the state to consider the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years. Further, such class of 84 Indian Polity vacancies are not to be combined with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on total number of vacancies of that year. In brief, it ends the 50% ceiling on reservation and backlog vacancies. E. The 76th Amendment Act of 1994 has placed the Tamil Nadu Reservations Act of 1993 in the 9th Schedule to protect it from judicial review as it provided for 69% of reservation, far exceeding the 50% ceiling. 9. F. In order to nullify the ruling with regard to relaxations in qualifying marks and standards of evaluation in matters of reservation and promotions, the 82nd Amendment Act was enacted in 2000. It added a new provision in Article 335 that empowers the state to make any provision in favor of the SCs and SITs for relaxation in qualifying marks or lowering the standards of evaluation in matters of reservation and promotions. 9. The Tamil Nadu Backward Classes, Scheduled Castes and Scheduled Tribes, Reservation of Seats in Educational Institutions and of Appointments or Posts in the Services under the State, Act, 1993. Reservation for EWSs and public employment. The above exception, D, was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order, in 2019, providing 10% reservation to the economically weaker sections EWSs in civil posts and services in the Government of India. The benefit of this reservation can be availed by the persons belonging to EWSs who are not covered under any of the existing schemes of reservation for SCs, SITs and OBCs. The eligibility criteria laid down in this regard has already been explained under Article 15. Further, the scientific and technical posts which satisfy all the following conditions can be exempted from the purview of this reservation. I. The post should be in grades above the lower grade in Group A of the service concerned. 2. They should be classified as scientific or technical in terms of Cabinet Secretariat Order, 1961. According to which scientific and technical posts for which qualifications in the natural sciences or exact sciences or applied sciences or in technology are prescribed and the incumbents of which have to use that knowledge in the discharge of their duties. 3. The post should be for conducting research or for organizing, guiding, and directing research. Abolition of untouchability. Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. In 1976, the Untouchability Offenses Act, 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act, 1955 to enlarge the scope and make penal provisions more stringent. The Act defines civil right as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution or in the Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense, but the practice as it had developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. Hence, it does not cover social boycott of a few individuals or their exclusion from religious services, etc. In the People's Union for Democratic Rights Case 93, 1982, the Supreme Court held that the right under Article 17 is available against private individuals, and it is the constitutional obligation of the state to take necessary action to ensure that this right is not violated. People's Union for Democratic Rights vs. Union of India, 1982. Fundamental Rights 85. 31 Abolition of Titles. Article 18 abolishes titles and makes 4 provisions in that regard. A. It prohibits the state from conferring any title, except a military or academic distinction, on any body, whether a citizen or a foreigner. B. It prohibits a citizen of India from accepting any title from any foreign state. C. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the President. D. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument, or office from or under any foreign state without the consent of the President. From the above, it is clear that the hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Dewan Bahadur, etc., which were conferred by colonial states are banned by Article 18 as these are against the principle of equal status of all. In the Balaji Raghavan Case 10, 1995, the Supreme Court upheld the constitutional validity of the national awards, Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. It ruled that these awards do not amount to titles, within the meaning of Article 18 that prohibits only hereditary titles of nobility. Therefore, they are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. However, it also ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. 10 Balaji Raghavan vs. Union of India, 1995. These national awards were instituted in 1954. The Janata Party government, headed by Morarji Desai, discontinued them in 1977. But they were again revived in 1980 by the Indira Gandhi government. The Padma Awards are announced every year on the occasion of Republic Day except for brief interruptions during the years 1978 and 1979 and 1993 to 1997. The total number of Padma Awards to be given in a year, excluding posthumous awards and awards given to NRS foreigners OCIs, should not be more than 120. Similarly, the number of Bharat Ratna Awards is restricted to a maximum of 3 in a particular year. T. Right to freedom. B. Protection of 6 rights. Article 19 guarantees to all citizens the 6 rights. These are I. Right to freedom of speech and expression. 2. Right to assemble peaceably and without arms. 3. Right to form associations or unions or cooperative societies. 10 feet 1 inch. 4. Right to move freely throughout the territory of India. V. Right to reside and settle in any part of the territory of India. 6. Right to practice any profession or to carry on any occupation, trade, or business. Originally, Article 19 contained 7 rights. But the right to acquire, hold, and dispose of property was deleted by the 44th Amendment Act of 1978. These 6 rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company but not to foreigners or legal persons like companies or corporations, etc. The state can impose reasonable restrictions on the enjoyment of these 6 rights only on the grounds mentioned in the Article 19 itself and not on any other grounds. The 6 rights contained in Article 19 and the grounds of imposing reasonable restrictions on them are mentioned in BLE 8.5. Freedom of speech and expression. It implies that every citizen has the right to express his views, opinions, belief, and convictions freely by word of mouth, writing, printing, picturing, or in any other manner. The Supreme. The provision for cooperative societies was made by the 97th Constitutional Amendment Act of 2011. Indian Polity. Table 8.5 rights under Article 19 and the grounds of restrictions. SI. No. Rights. Grounds of restrictions. 1. Right to freedom of speech and expression, Article 19, 1a. Under Article 19, 2, I. Sovereignty and integrity of India, added by the 16th Amendment Act, 1963, the 2nd. Security of the state, 3. Friendly relations with foreign states, added by the First Amendment Act, 1951, 4. Public order, added by the First Amendment Act, 1951, v. Decency or morality, 6. Contempt of court, 7. Defamation, 8. Incitement to an offense, added by the First Amendment Act, 1951. 2. Right to assemble peaceably and without arms, Article 19, 1b. Under Article 19, 3, I. Sovereignty and integrity of India, added by the 16th Amendment Act, 1963, 2. Public order. 3. Right to form associations or unions or cooperative societies, Article 19, 1c. Under Article 19, 4, I. Sovereignty and integrity of India, added by the 16th Amendment Act, 1963, 2. Public order. 3. Morality. 4. Right to move freely throughout the territory of India, Article 19, 1d. Under Article 19, 5, I. In the interests of the general public. 2. Protection of the interests of any scheduled tribe. 5. Right to reside and settle in any part of the territory of India, Article 19, 1e. Under Article 19, 5, I. In the interests of the general public. 2. Protection of the interests of any scheduled tribe. 6. A right to acquire, hold, and dispose of property, Article 19, 1f, omitted by the 44th Amendment Act, 1978. 7. Right to practice any profession, or to carry on any occupation, trade, or business, Article 19, 1g. Under Article 19, 6, In the interests of the general public. 2. Requirement of necessary professional or technical qualification. 3. Any trade, business, industry, or service carried on by the state to the exclusion of citizens. Added by the First Amendment Act, 1951. Court held that the freedom of speech and expression includes the following. A. Right to propagate one's views, freedom of circulation. B. Freedom of the press. C. Freedom of commercial advertisements. D. Right against tapping of telephonic conversation. E. Right to telecast, that is, government has no monopoly on electronic media. F. Right against boon called by a political party or organization. G. Right to know about government activities. H. Freedom of silence. I. Right against imposition of pre-censorship on a newspaper. J. Right to demonstration or picketing but not right to strike. K. Right to fly the national flag. L. Right of voters to know the antecedents of the candidates contesting elections. M. Right to choose the medium of instruction at the stage of primary school. N. Right to express gender identity. O. Right to reply. Right to answer the criticism. P. Right to post information videos on the internet, social media. Q. Right of filmmakers to exhibit their films. R. Right to access to the internet. Right to access to information via the internet. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Freedom of assembly. Every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstrations, and take out processions. This freedom can be exercised only on public land, and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies, or one that causes breach of public peace, or one that involves arms. This right does not include the right to strike. The state can impose reasonable restrictions on the exercise of right of assembly on 2 grounds, namely, sovereignty and integrity of India and public order, including the maintenance of traffic in the area concerned. Under Section 144 of Criminal Procedure Code, 1973, a magistrate can restrain an assembly, meeting, or procession if there is a risk of obstruction, annoyance, or danger to human life, health or safety, or a disturbance of the public tranquility, or a riot, or any affray. Under Section 141 of the Indian Penal Code, as assembly of 5 or more persons becomes unlawful if object is A. To resist the execution of any law or legal process. B. To forcibly occupy the property of some person. C. To commit any mischief or criminal trespass. D. To force some person to do an illegal act. And E. To threaten the government or its officials on exercising lawful powers. Freedom of association. All citizens have the right to form associations or unions or Fundamental Rights, 87. Cooperative Societies, 1013. It includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions, or any body of persons. It not only includes the right to start an association or union, but also to continue with the association or union as such. Further, it covers the negative right of not to form or join an association or union. Reasonable restrictions can be imposed on the exercise of this right by the state on the grounds of sovereignty and integrity of India, public order, and morality. Subject to these restrictions, the citizens have complete liberty to form associations or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade unions have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike can be controlled by an appropriate industrial law. Freedom of movement. This freedom entitles every citizen to move freely throughout the territory of the country. Husha can move freely from one state to another or from one place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling and not parochialism. The grounds of imposing reasonable restrictions on this freedom are 2, namely, the interests of general public and the protection of interests of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. The Supreme Court held that the freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. The Bombay High Court validated the restrictions on the movement of persons affected by AIDS. 10b. Indian Polity. The freedom of movement has 2 dimensions, viz., internal, right to move inside the country, and external, right to move out of the country and right to come back to the country. Article 19 protects only the first dimension. The second dimension is dealt by Article 21, right to life and personal liberty. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. This right has 2 parts. A. The right to reside in any part of the country, which means to stay at any place temporarily, and B, the right to settle in any part of the country, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism and avoids narrow-mindedness. The state can impose reasonable restrictions on the exercise of this right on two grounds, namely, the interest of general public and the protection of interests of any scheduled tribes. The right of outsiders to reside and settle in tribal areas is restricted to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. In many parts of the country, the tribals have been permitted to regulate their property rights in accordance with their customary rules and laws. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. Freedom of profession, etc. All citizens are given the right to practice any profession or to carry on any occupation, trade, or business. This right is very wide as it covers all the means of earning one's livelihood. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to A. Prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. And B. Carry on by itself any trade, business, industry, or service whether to the exclusion, complete or partial, of citizens or otherwise. Thus, no objection can be made when the state carries on a trade, business, industry, or service either as a monopoly, complete or partial, to the exclusion of citizens, all or some only, or in competition with any citizen. The state is not required to justify its monopoly. This right does not include the right to carry on a profession or business or trade or occupation that is immoral, trafficking in women or children, or dangerous, harmful drugs or explosives, etc. The state can absolutely prohibit these or regulate them through licensing. In Unaratabhasan Case 101 Foot, 2020, the Supreme Court held that the freedom to practice any profession or carry on any trade, business, or occupation over the medium of Internet enjoys constitutional protection under Article 19(1)(g). The restriction on this right should be in consonance with the mandate under Article 19(6), inclusive of the test of proportionality. Further, an order suspending Internet services indefinitely is impermissible under the temporary suspension of a telecom services, public emergency, or public safety rules, 2017. 10C Unaratabhasan vs. Union of India, 2020. Protection in respect of conviction for offenses. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. It contains three provisions in that direction. A. No ex post facto law. No person shall be, I, convicted of any offense except for violation of a law in force at the time of the commission of the act, nor 2. Subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. B. No double jeopardy. No person shall be prosecuted and punished for the same offense more than once. C. No self-incrimination. No person accused of any offense shall be compelled to be a witness against himself or herself. An ex post facto law is one that imposes penalties retroactively, that is, upon acts already done or which increases the penalties for such acts. The enactment of such a law is prohibited by the first provision of Article 20. However, this limitation is imposed only on criminal laws and not on civil laws or tax laws. In other words, a civil liability or a tax can be imposed retrospectively. Further, this provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. Finally, the protection, immunity, under this provision cannot be claimed in case of preventive detention or demanding security from a person. The protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. The protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to I. Compulsory production of material objects, 2. Compulsion to give thumb impression, specimen signature, blood specimens, and 3. Compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. 3. Protection of life and personal liberty. Article 21 declares that no person shall be deprived of his or her life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. In the famous Gopalan Case 11, 1950, the Supreme Court has taken a narrow interpretation of the Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive the right to life and personal liberty of a person based on a law. This is because of the expression procedure established by law in Article 21, which is different from the expression due process of law contained in the American Constitution. Hence, the validity of a law that has prescribed a procedure cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. Secondly, the Supreme Court held that the personal liberty means only liberty relating to the person or body of the individual. But, in Manika Case 12, 1978, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of the Article 21. Therefore, it ruled that the right to life and personal liberty of a person can be deprived by a law provided the procedure prescribed by that law is reasonable, fair, and just, and not arbitrary, fanciful, or oppressive. In order that the procedure is reasonable, fair, and just, the procedure should conform to the principles of natural justice. In other words, it has introduced the American expression due process of law. In effect, the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. Further, the court held that the right to life, as embodied in Article 21, is not merely confined to animal existence or survival, but it includes within its ambit the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete, and worth living. It also ruled that the expression personal liberty in Article 21 is of the widest amplitude, and it covers a variety of rights that go to constitute the personal liberties of a man. A.K. Gopalan vs. State of Madras, 1950. Maneka Gandhi vs. Union of India, 1978, 90-pound Indian Polity. The Supreme Court has reaffirmed its judgment in the Maneka case in the subsequent cases. It has declared the following rights as part of Article 21. 1. Right to live with human dignity. 2. Right to decent environment including pollution-free water and air and protection against hazardous industries. 3. Right to livelihood. 4. Right to privacy. Z. Right to shelter. 6. Right to health. 7. Right to free education up to 14 years of age. 8. Right to free legal aid. 9. Right against solitary confinement. 10. Right to speedy trial. 11. Right against handcuffing. 12. Right against inhuman treatment. 13. Right against delayed execution. 14. Right to travel abroad. 15. Right against bonded labor. 16. Right against custodial harassment. 17. Right to emergency medical aid. Right to doctor's assistance. 18. Right to timely medical treatment in government hospital. 19. Right not to be driven out of a state. 20. Right to fair trial. 21. Right of prisoner to have necessities off life. 22. Right of women to be treated with decency and dignity. 23. Right against public hanging. 24. Right to road in hilly areas. 25. Right to information. 26. Right to reputation. 27. Right of appeal from a judgment of conviction. 28. Right to family pension. 29. Right to social and economic justice and empowerment. 30. Right against bar fetters. 31. Right to appropriate life insurance policy. 32. Right to sleep. 33. Right to freedom from noise pollution. 34. Right to sustainable development. 35. Right to opportunity. 36. Right to decent burial cremation. 37. Right to marry a person of one's choice. 38. Right to die with dignity, passive euthanasia. The important cases relating to the expansion of the scope of Article 21, protection of life and personal liberty, are mentioned in FBLE 8.6. Our right to education. Article 21A declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only elementary education a fundamental right and not higher or professional education. This provision was added by the 86th Constitutional Amendment Act of 2002. This amendment is a major milestone in the country's aim to achieve education for all. The government described this step as the dawn of the second revolution in the chapter of citizens' rights. Even before this amendment, the Constitution contained a provision for free and compulsory education for children under Article 45 in Part 4. However, being a directive principle, it was not enforceable by the courts. Now, there is scope for judicial intervention in this regard. This amendment changed the subject matter of Article 45 in directive principles. It now reads, "The state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years." It also added a new fundamental duty under Article 51A that reads, "It shall be the duty of every citizen of India to provide opportunities for education to his child or ward between the age of 6 and 14 years. In Uni Krishnan Case 12, 1, 1993, itself, the Supreme Court recognized a fundamental right to primary education and the right to life under Article 21. It held that every child has a right to free education until Husha. L2 Uni Krishnan vs. State of Andhra Pradesh, 1993. Fundamental rights. Table 8.6 Important cases expanding the scope of Article 21, protection of life and personal liberty. SI. No. Case year, right declared by the Supreme Court as an integral part of Article 21. 1. Sawant Singh Soni vs. Dr. Ramaratnam, Assistant Passport Officer, 1967. Right to travel abroad. 2. M.H. Hoskett vs. State of Maharashtra, 1978. right to free legal aid. 3. Hussainara Khatun versus Home Secretary, Bihar, 1979, right to speedy trial. 4. Francis Coralie Mullen versus Administrator, Delhi, 1981, right to live with human dignity and right of prisoner to have necessities of life. 5. Sheila Bars versus State of Maharashtra, 1983, right against custodial harassment. 6. Rural Litigation and Entitlement Kindra versus State of Uttar Pradesh, 1985, right to decent environment. 7. Olga Tellis versus Bombay Municipal Corporation, 1985, right to livelihood. 8. Parmanand Katara versus Union of India, 1989, right to emergency medical aid, right to doctor's assistance. 9. Shanistar Builders versus N.K. Tadame, 1990, right to shelter. 10. K.S. Puttaswamy versus Union of India, 2017, right to privacy. 11. Common Cause, a registered society versus Union of India, 2018, right to die with dignity, passive euthanasia. Completes the age of 14 years. Thereafter, her right to education is subject to the limits of economic capacity and development of the state. In this judgment, the court overruled its earlier judgment delivered in Mohini Jain Case 12B, 1992, wherein it partly declared that there was a fundamental right to education up to any level including professional education like medicine and engineering. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education, RTE, Act, 2009. This act seeks to provide that every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. This legislation is anchored in the belief that the values of equality, social justice and democracy, and the creation of a just and humane society. Mohini Jain versus State of Karnataka, 1992, can be achieved only through provision of inclusive elementary education to all. The Constitution, 86th Amendment, Act, 2002, and the Right of Children to Free and Compulsory Education Act, 2009 have come into force WF April 1, 2010. S. Protection against arrest and detention. Article 22 grants protection to persons who are arrested or detained. Detention is of two types, namely, punitive and preventive. Punitive detention is to punish a person for an offense committed by him or after trial and conviction in a court. Preventive detention, on the other hand, means detention of a person without trial and conviction by a court. Its purpose is not to punish a person for a past offense, but to prevent him or her from committing an offense in the near future. Thus, preventive detention is only a precautionary measure and based on suspicion. The Article 22 has two parts. The first part deals with the cases of ordinary law, and the second part deals with the cases of preventive detention law. A. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. I. Right to be informed of the grounds of arrest. 2. Right to consult and be defended by a legal practitioner. 3. Right to be produced before a magistrate within 24 hours, excluding the journey time. 4. Right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. The Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of a court, civil arrest, arrest on failure to pay the income tax, and deportation of an alien. They apply only to an act of a criminal or quasi-criminal nature or some activity prejudicial to public interest. B. The second part of Article 22 grants protection to persons who are arrested or detained under a preventive detention law. This protection is available to both citizens as well as aliens and includes the following. J. The detention of a person cannot exceed 3 months unless an advisory board reports sufficient cause for extended detention. The board is to consist of judges of a high court. 2. The grounds of detention should be communicated to the detainee. However, the facts considered to be against the public interest need not be disclosed. 3. The detainee should be afforded an opportunity to make a representation against the detention order. Article 22 also authorizes the Parliament to prescribe a. The circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. B. The maximum period for which a person can be detained in any classes of cases under a preventive detention law. And C. The procedure to be followed by an advisory board in an inquiry. The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. However, this provision has not yet been brought into force, hence, the original period of 3 months still continues. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislatures. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with defense, foreign affairs, and the security of India. Both the Parliament as well as the state legislatures can concurrently make a law of preventive detention for reasons connected with the security of a state, the maintenance of public order, and the maintenance of supplies and services essential to the community. The preventive detention laws made by the Parliament are: A. Preventive Detention Act, 1950. Expired in 1969. B. Maintenance of Internal Security Act, MISA, 1971. Repealed in 1978. C. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, COFAPOSA, 1974. D. National Security Act, NASA, 1980. E. Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act, PMSICA, 1980. F. Terrorist and Disruptive Activities Prevention Act, TADA, 1985. Repealed in 1995. G. Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, PINPSA, 1988. Fundamental Rights 93. H. Prevention of Vibrism Act, POTA, 2002. Repealed in 2004. I. Unlawful Activities Prevention Act, UAPA, 1967, as amended in 2004, 2008, 2012, and 2019. It is unfortunate to know that no democratic country in the world has made preventive detention as an integral part of the Constitution as has been done in India. It is unknown in USA. It was resorted to in Britain only during First and Second World War time. In India, preventive detention existed even during the British rule. For example, the Bengal State Prisoners Regulation of 1818 and the Defence of India Act of 1939 provided for preventive detention. T. Right against exploitation, a prohibition of traffic in human beings, and forced labor. Article 23 prohibits traffic in human beings, bigar, forced labor, and other similar forms of forced labor. Any contravention of this provision shall be an offense punishable in accordance with law. This right is available to both citizens and non-citizens. It protects the individual not only against the state, but also against private persons. The expression traffic in human beings include: A. Selling and buying of men, women, and children like goods. B. Immoral traffic in women and children, including prostitution. C. Devadesis. And D. Slavery. IB punish these acts. The Parliament has implemented the Immoral Traffic Prevention Act 13, 1956. Originally known as the Suppression of Immoral Traffic in Women and Girls Act, 1956. The term, bigar, means compulsory work without remuneration. It was a peculiar Indian system under which the local zamindars sometimes used to force their tenants to render services without any payment. In addition to bigar, the Article 23 prohibits other similar forms of forced labor, like bonded labor. The term forced labor means compelling a person to work against his or will. The word force includes not only physical or legal force, but also force arising from the compulsion of economic circumstances, that is, working for less than the minimum wage. In this regard, the Bonded Labor System Abolition Act, 1976. The Minimum Wages Act, 1948. The Contract Labor Act, 1970, and the Equal Remuneration Act, 1976 were made. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purposes, as for example, military service or social service, for which it is not bound to pay. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste, or class. Prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway. But it does not prohibit their employment in any harmless or innocent work. The Child Labor, Prohibition and Regulation Act, 1986, is the most important law in this direction. In addition, the Employment of Children Act, 1938. The Factories Act, 1948. The Mines Act, 1952. The Merchant Shipping Act, 1958. The Plantation Labor Act, 1951. The Motor Transport Workers Act, 1951. Apprentices Act, 1961. The Bidi and Cigar Workers Act, 1966. And other similar acts prohibit the employment of children below a certain age. In 1996, the Supreme Court directed the establishment of Child Labor Rehabilitation Welfare Fund, in which the offending employer should deposit a fine of $20,000 for each child employed by him or her. It also issued directions for the improvement of education, health, and nutrition of children. The Commissions for Protection of Child Rights Act, 2005 was enacted to provide for the establishment of a National Commission and State Commissions for Protection of Child. 94 Indian Polity. Rights in Children's Courts for providing speedy trial of offenses against children or a violation of child rights. In 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dabas, restaurants, shops, factories, resorts, spas, tea shops, and so on. It warned that anyone employing children below 14 years of age would be liable for prosecution and penal action. The Child Labor, Prohibition and Regulation Amendment Act, 2016, amended the Child Labor, Prohibition and Regulation Act, 1986. It has renamed the principal act as the Child and Adolescent Labor, Prohibition and Regulation Act, 1986. Right to freedom of religion. Freedom of conscience and free profession, practice and propagation of religion. Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. The implications of these are: A. Freedom of conscience. Inner freedom of an individual to mold his or her relation with God or creatures in whatever way he or she desires. B. Right to profess. Declaration of one's religious beliefs and faith openly and freely. C. Right to practice. Performance of religious worship, rituals, ceremonies, and exhibition of beliefs and ideas. D. Right to propagate. Transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion. But it does not include a right to convert another person to one's own religion. Forcible conversions impinge on the freedom of conscience guaranteed to all the persons alike. From the above, it is clear that Article 25 covers not only religious beliefs, doctrines, but also religious practices, rituals. Moreover, these rights are available to all persons, citizens as well as non-citizens. However, these rights are subject to public order, morality, health, and other provisions relating to fundamental rights. Further, the state is permitted to: A. Regulate or restrict any economic, financial, political, or other secular activity associated with religious practice. And B. Provide for social welfare and reform or throw open Hindu religious institutions of a public character to all classes and sections of Hindus. Article 25 also contains two explanations. 1. Wearing and carrying of kirpans is to be included in the profession of the Sikh religion. And 2. The Hindus, in this context, include Sikhs, Jains, and Buddhists. 2. Freedom to manage religious affairs. According to Article 26, every religious denomination or any of its section shall have the following rights. A. Right to establish and maintain institutions for religious and charitable purposes. B. Right to manage its own affairs and matters of religion. C. Right to own and acquire movable and immovable property. And D. Right to administer such property in accordance with law. Article 25 guarantees rights of individuals, while Article 26 guarantees rights of religious denominations or their sections. In other words, Article 26 protects collective freedom of religion. Like the rights under Article 25, the rights under Article 26 are also subject to public order, morality, and health, but not subject to other provisions relating to the fundamental rights. In this clause, the reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jaina, and Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. Article 25. The Supreme Court held that a religious denomination must satisfy three conditions. A. It should be a collection of individuals who have a system of beliefs, doctrines, which they regard as conducive to their spiritual well-being. B. It should have a common organization. And C. It should be designated by a distinctive name. Under the above criteria, the Supreme Court held that the Ramakrishna Mission and Ananda Marga are religious denominations within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. Freedom from taxation for promotion of a religion. Article 27 lays down that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. In other words, the state should not spend the public money collected by way of tax for the promotion or maintenance of any particular religion. This provision prohibits the state from favoring, patronizing, and supporting one religion over the other. This means that the taxes can be used for the promotion or maintenance of all religions. This provision prohibits only levy of a tax and not a fee. This is because the purpose of a fee is to control secular administration of religious institutions and not to promote or maintain religion. Thus, a fee can be levied on pilgrims to provide them some special service or safety measures. Similarly, a fee can be levied on religious endowments for meeting the regulation expenditure. A freedom from attending religious instruction. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of state funds. However, this provision shall not apply to an educational institution administered by the Fundamental Rights 95 state but established under any endowment or trust, requiring imparting of religious instruction in such institution. Further, no person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to attend any religious instruction or worship in that institution without his or her consent. In case of a minor, the consent of his or her guardian is needed. Thus, Article 28 distinguishes between four types of educational institutions. A. Institutions wholly maintained by the state. B. Institutions administered by the state but established under any endowment or trust. C. Institutions recognized by the state. D. Institutions receiving aid from the state. In A. Religious instruction is completely prohibited, while in B. Religious instruction is permitted. In C and D. Religious instruction is permitted on a voluntary basis. Cultural and educational rights. BL. Protection of interests of minorities. Article 29 provides that any section of the citizens residing in any part of India having a distinct language, script, or culture of its own shall have the right to conserve the same. Further, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, or language. The first provision protects the right of a group, while the second provision guarantees the right of a citizen as an individual irrespective of the community to which he belongs. Article 29 grants protection to both religious minorities as well as linguistic minorities. However, the Supreme Court held that the scope of this article is not necessarily restricted to minorities only, as it is commonly assumed to be. This is because of the use of words section of citizens in the article that include minorities as well as majority. 96. Indian Polity. The Supreme Court also held that the right to conserve the language includes the right to agitate for the protection of the language. Hence, the political speeches or promises made for the conservation of the language of a section of the citizens does not amount to corrupt practice under the Representation of the People Act, 1951. Right of minorities to establish and administer educational institutions. Article 30 grants the following rights to minorities, whether religious or linguistic. A. All minorities shall have the right to establish and administer educational institutions of their choice. B. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. This provision was added by the 44th Amendment Act of 1978 to protect the right of minorities in this regard. The Act deleted the right to property as a fundamental right, Article 31. C. In granting aid, the state shall not discriminate against any educational institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious or linguistic, and does not extend to any section of citizens, as under Article 29. However, the term minority has not been defined anywhere in the Constitution. The right under Article 30 also includes the right of a minority to impart education to its children in its own language. Minority educational institutions are of three types. A. Institutions that seek recognition as well as aid from the state. B. Institutions that seek only recognition from the state and not aid. And C. Institutions that neither seek recognition nor aid from the state. The institutions of first and second type are subject to the regulatory power of the state with regard to syllabus prescription, academic standards, discipline, sanitation, employment of teaching staff, and so on. The institutions of third type are free to administer their affairs but subject to operation of general laws like contract law, labor law, industrial law, tax law, economic regulations, and so on. In a judgment delivered in the Secretary of Malankara Syrian Catholic College case 14-1, 2006, the Supreme Court has summarized the general principles relating to establishment and administration of minority educational institutions in the following way. 14. Secretary of the Malankara Syrian Catholic College versus T. Jose, 2006. 1. The right of minorities to establish and administer educational institutions of their choice comprises the following rights. I. LB choose its governing body in whom the founders of the institution have faith and confidence to conduct and manage the affairs of the institution. 2. To appoint teaching staff, teachers, lecturers, and headmasters, principals, as also non-teaching staff, and to take action if there is dereliction of duty on the part of any of its employees. 3. To admit eligible students of their choice and to set up a reasonable fee structure. And 4. To use its properties and assets for the benefit of the institution. 2. The right conferred on minorities under Article 30 is only to ensure equality with the majority and not intended to place the minorities in a more advantageous position vis-a-vis the majority. There is no reverse discrimination in favor of minorities. The general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc., applicable to all, will equally apply to minority institutions also. 3. The right to establish and administer educational institutions is not absolute. Fundamental Rights 97. Nor does it include the right to maladminister. There can be regulatory measures for ensuring educational character and standards and maintaining academic excellence. There can be checks on administration as are necessary to ensure that the administration is efficient and sound, so as to serve the academic needs of the institution. Regulations made by the state concerning generally the welfare of students and teachers, regulations laying down eligibility criteria and qualifications for appointment, as also conditions of service of employees, both teaching and non-teaching, regulations to prevent exploitation or oppression of employees, and regulations prescribing syllabus and curriculum of study fall under this category. Such regulations do not in any manner interfere with the right under Article 31. 4. Subject to the eligibility conditions qualifications prescribed by the state being met, the unaided minority educational institutions will have the freedom to appoint teachers lecturers by adopting any rational procedure of selection. 5. Extension of aid by the state does not alter the nature and character of the minority educational institutions. The conditions can be imposed by the state to ensure proper utilization of the aid, without however diluting or abridging the right under Article 31. Right of constitutional L remedies. A mere declaration of fundamental rights in the Constitution is meaningless, useless, and worthless without providing an effective machinery for their enforcement, if and when they are violated. Hence, Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental rights protected is, in itself, a fundamental right. This makes the fundamental rights real. That is why Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abridged or taken away even by way of an amendment to the Constitution. It contains the following 4 provisions. A. The right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental rights is guaranteed. B. The Supreme Court shall have power to issue directions or orders or writs for the enforcement of any of the fundamental rights. The writs issued may include habeas corpus, mandamus, prohibition, certiorari, and quo warranto. C. Parliament can empower any other court to issue directions, orders, and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. Any other court here does not include high courts because Article 226 has already conferred these powers on the high courts. D. The right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Thus, the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental rights during a national emergency, Article 359. It is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental rights of the citizens. It has been vested with the original and wide powers for that purpose. Original, because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Wide, because its power is not restricted to issuing of orders or directions but also writs of all kinds. 98 YS Indian Polity. The purpose of Article 32 is to provide a guaranteed, effective, expeditious, inexpensive, and summary remedy for the protection of the fundamental rights. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other right like non-fundamental constitutional rights, statutory rights, customary rights, and so on. The violation of a fundamental right is the sine qua non for the exercise of the right conferred by Article 32. In other words, the Supreme Court, under Article 32, cannot determine a question that does not involve fundamental rights. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or a legislation unless it directly infringes any of the fundamental rights. In case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. It vests original powers in the High Court to issue directions, orders, and writs of all kinds for the enforcement of the fundamental rights. It means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Since the right guaranteed by Article 32, i.e., the right to move the Supreme Court where a fundamental right is infringed, is in itself a fundamental right, the availability of alternate remedy is no bar to relief under Article 32. However, the Supreme Court has ruled that where relief through High Court is available under Article 226, the aggrieved party should first move the High Court. Efforts, types, and scope. The Supreme Court, under Article 32, and the High Courts, under Article 226, can issue the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Further, the Parliament, under Article 32, can empower any other court to issue these writs. Since no such provision has been made so far, only the Supreme Court and the High Courts can issue the writs and not any other court. Before 1950, only the High Courts of Calcutta, Bombay, and Madras had the power to issue the writs. Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king who was, and is still, described as the fountain of justice. Later, the High Court started issuing these writs as extraordinary remedies to uphold the rights and liberties of the British people. The writ jurisdiction of the Supreme Court differs from that of a High Court in 3 respects. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas a High Court can issue writs not only for the enforcement of fundamental rights but also for any other purpose. The expression "for any other purpose" refers to the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court, in this respect, is narrower than that of a high court. 2. The Supreme Court can issue writs against a person or government throughout the territory of India, whereas a high court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. Thus, the territorial jurisdiction of the Supreme Court for the purpose of issuing writs is wider than that of a high court. 1. 3. A remedy under Article 32 is in itself a fundamental right, and hence, the Supreme Court may not refuse to exercise its writ jurisdiction. On the other 5. The second provision was added by the 15th Constitutional Amendment Act of 1963. And a remedy under Article 226 is discretionary, and hence, a high court may refuse to exercise its writ jurisdiction. Article 32 does not merely confer power on the Supreme Court as Article 226 does on a high court to issue writs for the enforcement of fundamental rights or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as a defender and guarantor of the fundamental rights. Now, we will proceed to understand the meaning and scope of different kinds of writs mentioned in Articles 32 and 226 of the Constitution. Habeas corpus, it is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of detention. It would set the detained person free if the detention is found to be illegal. Thus, this writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the a. detention is lawful, b. the proceeding is for contempt of a legislature or a court, c. detention is by a competent court, and d. detention is outside the jurisdiction of the court. Mandamus. It literally means we command. It is a command issued by the court to a public official asking him or her to perform his official duties that Husha has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. The writ of mandamus cannot be issued, a. against a private individual or body, b. to enforce departmental instruction that does not possess statutory force, c. when the duty, Fundamental Rights 99, is discretionary and not mandatory, d. to enforce a contractual obligation, e. against the President of India or the state governors, and f. against the Chief Justice of a high court acting in judicial capacity. Prohibition. Literally, it means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus that directs activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari. In the literal sense, it means to be certified or to be informed. It is issued by a higher court to a lower court or tribunal to quash the order passed by the latter in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction. Thus, like the writ of prohibition, the writ of certiorari is also a jurisdictional writ. However, they are issued at different stages of proceedings before a lower court or tribunal. The prohibition is issued before the final order is passed for stopping the further continuance of the proceedings, whereas the certiorari is issued after the final order is passed for quashing the same. Like prohibition, certiorari can be issued only against the judicial and quasi-judicial authorities. Similarly, the certiorari is also not available against administrative authorities, legislative bodies, and private individuals or bodies. Quo warranto in the literal sense, it means by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. Indian Polity. This writ can be issued only in case of a substantive public office of a permanent character created by a statute or by the Constitution. It cannot be issued in cases of ministerial office or private office. This writ can be sought by any public-minded person and not necessarily by the aggrieved person. 7 Armed Forces and 1 Fundamental Rights. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. The objective of this provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on Parliament and not on state legislatures. Any such law made by Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Accordingly, the Parliament has enacted the Army Act, 1950, the Navy Act, 1950, the Air Force Act, 1950, the Police Forces Restriction of Rights Act, 1966, the Border Security Force Act, and so on. These impose restrictions on their freedom of speech, right to form associations, right to be members of trade unions or political associations, right to communicate with the press, right to attend public meetings or demonstrations, etc. The expression members of the armed forces also covers such employees of the armed forces as barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors who are non-combatants. A parliamentary law enacted under Article 33 can also exclude the court-martial, tribunals established under the military law, from the writ jurisdiction of the Supreme Court and the High Courts, so far as the enforcement of fundamental rights is concerned. Martial law and fundamental rights. Article 34 provides for the restrictions on fundamental rights while martial law is in force in any area within the territory of India. It empowers the Parliament to indemnify any government servant or any other person for any act done by him or her in connection with the maintenance or restoration of order in any area where martial law was in force. The Parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial law in such area. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. The concept of martial law has been borrowed in India from the English common law. However, the expression martial law has not been defined anywhere in the Constitution. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary law. It thus implies the suspension of ordinary law and the government by military tribunals. It is different from the military law that is applicable to the armed forces. There is also no specific or express provision in the Constitution that authorizes the executive to declare martial law. However, it is implicit in Article 34 under which martial law can be declared in any area within the territory of India. The martial law is imposed under the extraordinary circumstances like war, invasion, insurrection, rebellion, riot, or any violent resistance to law. Its justification is to repel force by force for maintaining or restoring order in the society. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of the civilians, can punish the civilians, and even condemn them to death. Fundamental Rights 101. Table 8.7 Martial Law versus National Emergency. Martial law national emergency. 1. It affects only fundamental rights. 1. It affects not only fundamental rights, but also center. State relations, distribution of revenues and legislative powers between center and states, and may extend the tenure of the Parliament. J2. It suspends the government and ordinary law courts. 2. It continues the government and ordinary law courts. 3. It is imposed to restore the breakdown of law, and 3. It can be imposed only on 3 grounds: war, external order due to any reason, aggression or armed rebellion. RCJ and GX. 4. It is imposed in some specific area of the country. 4. It is imposed either in the whole country or in any part of it. 5. It has no specific provision in the Constitution. If 5. It has specific and detailed provision in the Constitution, is implicit. It is explicit. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. The declaration of a martial law under Article 34 is different from the declaration of a national emergency under Article 352. The differences between the two are summarized in FBLE 8.7. Affecting certain fundamental rights. Article 35 lays down that the power to make laws, to give effect to certain specified fundamental rights, shall vest only in the Parliament and not in the state legislatures. This provision ensures that there is uniformity throughout India with regard to the nature of those fundamental rights and punishment for their infringement. In this direction, Article 35 contains the following provisions. 1. The Parliament shall have, and the legislature of a state shall not have, power to make laws with respect to the following matters. A. Prescribing residence as a condition for certain employments or appointments in a state or union territory or local authority or other authority. Article 16. B. Empowering courts other than the Supreme Court and the High Courts to issue directions, orders, and writs of all kinds for the enforcement of fundamental rights. Article 32. C. Restricting or abrogating the application of fundamental rights to members of armed forces, police forces, etc. Article 33. D. Indemnifying any government servant or any other person for any act done during the operation of martial law in any area. Article 34. 2. Parliament shall have, and the legislature of a state shall not have, powers to make laws for prescribing punishment for those acts that are declared to be offenses under the fundamental rights. These include the following. A. Untouchability. Article 17. B. Traffic in human beings and forced labor. Article 23. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishment for the above acts. thus making it obligatory on the part of the Parliament to enact such laws. 3. Any law in force at the commencement of the Constitution with respect to any of 102 Indian Polity. The matters specified above is to continue in force until altered or repealed or amended by the Parliament. It should be noted that Article 35 extends the competence of the Parliament to make a law on the matters specified above, even though some of those matters may fall within the sphere of the state legislatures, i.e., state list. Present position of right to property. Originally, the right to property was one of the 7 fundamental rights under Part 3 of the Constitution. It was dealt by Article 19, 1, F, and Article 31. Article 19, L, F, guaranteed to every citizen the right to acquire, hold, and dispose of property. Article 31, on the other hand, guaranteed to every person, whether citizen or non-citizen, right against deprivation of his or her property. It provided that no person shall be deprived of his or her property except by authority of law. It empowered the state to acquire or requisition the property of a person on 2 conditions. A, it should be for public purpose, and B, it should provide for payment of compensation, amount, to the owner. Since the commencement of the Constitution, the fundamental right to property has been the most controversial. It has caused confrontations between the Supreme Court and the Parliament. It has led to a number of constitutional amendments, that is, 1st, 4th, 7th, 25th, 39th, 40th, and 42nd Amendments. Through these amendments, Articles 31A, 31B, and 31C have been added and modified from time to nullify the effect of Supreme Court judgments and to protect certain laws from being challenged on the grounds of contravention of fundamental rights. Most of the litigation centered around the obligation of the state to pay compensation for acquisition or requisition of private property. Therefore, the 44th Amendment Act of 1978 abolished the right to property as a fundamental right by repealing Article 19, 1, F, and Article 31 from Part 3. Instead, the Act inserted a new Article 300A in Part 12 under the heading Right to Property. It provides that no person shall be deprived of his or her property except by authority of law. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. The right to property as a legal right, as distinct from the fundamental rights, has the following implications. A, it can be regulated, i.e., curtailed, abridged, or modified without constitutional amendment by an ordinary law of the Parliament. B, it protects private property against executive action but not against legislative action. C, in case of violation, the aggrieved person cannot directly move the Supreme Court under Article 32, right to constitutional remedies including writs, for its enforcement. PSHA can move the High Court under Article 226. D, no guaranteed right to compensation in case of acquisition or requisition of the private property by the state. Though the fundamental right to property under Part 3 has been abolished, the Part 3 still carries 2 provisions which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. These 2 cases where compensation has to be paid are A, when the state acquires the property of a minority educational institution, Article 30, and FB, when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limits, Article 31A. The first provision was added by the 44th Amendment Act, 1978, while the second provision was added by the 17th Amendment Act, 1964. Further, Articles 31A, 31B, and 31C have been retained as exceptions to the fundamental rights. Exceptions to fundamental rights. Saving of laws providing for acquisition of estates, etc. Article 31A-16 saves 5 categories of laws from being challenged and invalidated on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, and Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. They are related to agricultural land reforms, industry, and commerce and include the following. 16 added by the First Constitutional Amendment Act of 1951 and amended by the 4th, 17th, and 44th Amendments. 7. The expression estate includes any jagir, anam, mwafi, or other similar grant, any jam right in Tamil Nadu and Kerala, and any land held for agricultural purposes. 18. Article 31B along with the 9th Schedule was added by the First Constitutional Amendment Act of 1951. 18. A. Kesavananda Bharati vs. State of Kerala, 1973. 18. B. Vaman Rao vs. Union of India, 1980. 19. L.R. Qualo vs. State of Tamil Nadu, 2007. 20. Though the last entry is numbered 284, the actual total number is 282. T is because the 3 entries 87, 92, and 130 have been deleted and 1 entry is numbered as 257A. A. Acquisition of estates and related rights by the state. 17. B. Taking over the management of properties by the state. C. Amalgamation of corporations. D. Extinguishment or modification of rights of directors or shareholders of corporations. And E. Extinguishment or modification of mining leases. Article 31A does not immunize a state law from judicial review unless it has been reserved for the President's consideration and has received his assent. This article also provides for the payment of compensation at market value when the state acquires the land held by a person under his or personal cultivation and the land is within the statutory ceiling limit. Validation of certain acts and regulations. Article 31B saves the acts and regulations included in the 9th Schedule 18* from being fundamental rights M103, challenged and invalidated on the ground of contravention of any of the fundamental rights. Thus, the scope of Article 31B is wider than Article 31A. Article 31B immunizes any law included in the 9th Schedule from all the fundamental rights whether or not the law falls under any of the 5 categories specified in Article 31A. However, in the Kesavananda case 18A, 1973, the Supreme Court rules that the acts and regulations that are included in the 9th Schedule are open to challenge on the grounds of being violative of the basic structure of the condition. This was later clarified by the court in the Woman Rao case 18B, 1980, wherein it held that the various acts and regulations includes in the 9th Schedule after April 24, 1973, date of judgment in the Kesavananda case, are valid only if they do not damage the basic structure of the Constitution. Again, in the Arakwalo case 19, 2007, the Supreme Court reaffirmed the above view. In this case, the court ruled that there could not be any blanket immunity from judicial review of the laws included in the 9th Schedule. It held that judicial review is a basic feature of the Constitution, and it could not be taken away putting a law under the 9th Schedule. It said that the laws placed under the 9th Schedule after April 24, 1973, are open to challenge in court if they violated fundamental rights guaranteed under Articles 14, 15, 19, and 21, or the basic structure of the Constitution. Originally, in 1951, the 9th Schedule contained only 13 acts and regulations, but at present, their number is 282.20 of these. The acts and regulations of the state legislature deal with land reforms and abolition of the zamindari system, and that of the parliament deal with other matters. 104 Indian Polity. Saving of laws giving effect to certain directive principles. Article 31C, inserted by the 25th Amendment Act of 1971, contains the following 2 provisions. A. No law that seeks to implement the socialistic directive principles specified in Article 39, B, or C, shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, or Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. 21-22. B. No law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Article 39, B, says, the state shall direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. 2. Article 39, C, says, the state shall direct its policy towards securing that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. 22. Kesavananda vs. State of Kerala, 1973. 24. Minerva Mills vs. Union of India, 1980. In the Kesavananda case 23, 1973, the Supreme Court declared the above B provision as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above A provision was held to be constitutional and valid. The 42nd Amendment Act, 1976, extended the scope of the above A provision by including within its protection any law to implement any of the directive principles specified in Part 4 of the Constitution and not merely in Article 39, B, or C. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case 24, 1980. Article 31C does not immunize a state law from judicial review unless it has been reserved for the President's consideration and has received his assent. Criticism of fundamental rights. The fundamental rights enshrined in Part I of the Constitution have met with a wide and varied criticism. The arguments of the critics are as follows. BL excessive limitations. They are subjected to innumerable exceptions, restrictions, qualifications, and explanations. Hence, the critics remark that the Constitution grants fundamental rights with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental rights should be renamed as Limitations on Fundamental Rights or Fundamental Rights and Limitations thereon. No social and economic rights. The list is not comprehensive as it mainly consists of political rights. It makes no provision for important social and economic rights like right to social security, right to work, right to employment, right to rest and leisure, and so on. These rights are made available to the citizens of advanced democratic countries. Also, the socialistic constitutions of erstwhile USSR or China provided for such rights. No clarity. They are stated in a vague, indefinite, and ambiguous manner. The various phrases and words used in the chapter like public order, minorities, reasonable restriction, public interest, and so on are not clearly defined. The language used to describe them is very complicated and beyond the comprehension of the common man. It is alleged that the Constitution was made by the lawyers for the lawyers. Sir Ivor Jennings called the Constitution of India a paradise for lawyers. 2. Fundamental rights M1Q5. No permanency, they are not sacrosanct or immutable as the Parliament can curtail or abolish them, as for example, the abolition of the fundamental right to property in 1978. Hence, they can become a play tool in the hands of politicians having majority support in the Parliament. The judicially innovated doctrine of basic structure is the only limitation on the authority of Parliament to curtail or abolish the fundamental right. Q. Suspension during emergency, the suspension of their enforcement during the operation of national emergency, except Articles 20 and 21, is another blot on the efficacy of these rights. This provision cuts at the roots of democratic system in the country by placing the rights of the millions of innocent people in continuous jeopardy. According to the critics, the fundamental rights should be enjoyable in all situations, emergency or no emergency. 31. Expensive remedy, the judiciary has been made responsible for defending and protecting these rights against the interference of the legislatures and executives. However, the judicial process is too expensive and hinders the common man from getting his rights enforced through the courts. Hence, the critics say that the rights benefit mainly the rich section of the Indian society. 31. Preventive detention, the critics assert that the provision for preventive detention, Article 22, takes away the spirit and substance of the chapter on fundamental rights. It confers arbitrary powers on the state and negates individual liberty. It justifies the criticism that the Constitution of India deals more with the rights of the state against the individual than with the rights of the individual against the state. Notably, no democratic country in the world has made preventive detention as an integral part of their constitutions as has been made in India. No consistent philosophy. According to some critics, the chapter on fundamental rights is not the product of any philosophical principle. Sir Ivor Jennings expressed this view when he said that the fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. 0. The critics say that this creates difficulty for the Supreme Court and the High Courts in interpreting the fundamental rights. Significance of fundamental rights. In spite of the above criticism and shortcomings, the fundamental rights are significant in the following respects. 1. They constitute the bedrock of the democratic system in the country. 2. They provide necessary conditions for the material and moral protection of man. 3. They serve as a formidable bulwark of individual liberty. 4. They facilitate the establishment of rule of law in the country. 5. They protect the interests of minorities and weaker sections of society. 6. They strengthen the secular fabric of the Indian state. 7. They check the absoluteness of the authority of the government. 8. They lay down the foundation stone of social equality and social justice. Sir Ivor Jennings wrote, a thread of 19th century liberalism runs through it. There are consequences of the political problems of Britain in it. There are relics of the bitter experience in opposition to British rule. And there is evidence of a desire to reform some of the social institutions which time and circumstances have developed in India. The result is a series of complex formulae, in 24 articles, some of them lengthy, which must become the basis of a vast and complicated case law. 106. Indian Polity. 9. They ensure the dignity and respect of individuals. 10. They facilitate the participation of people in the political and administrative process. Rights outside Part 3 besides the fundamental rights included in Part 3, there are certain other rights contained in other parts of the Constitution. These rights are known as Constitution's rights or legal rights or non-fundamental rights. They are 1. No tax shall be levied or collected except by authority of law, Article 265 in Part 12. 2. No person shall be deprived of his or her property save by authority of law, Article 300, A in Part 12. 3. 8. Commerce and intercourse throughout the territory of India shall be free, Article 301 in Part 13. 4. The elections to the Lok Sabha and the State Legislative Assembly shall be on the basis of adult suffrage, Article 326 in Part 15. Even though the above rights are equally justiciable, they are different from the fundamental rights. In case of violation of a fundamental right, the aggrieved person can directly move the Supreme Court for its enforcement under Article 32, which is in itself a fundamental right. But, in case of violation of the above rights, the aggrieved person cannot avail this constitutional remedy. Pisha can move the High Court by an ordinary suit or under Article 226, writ jurisdiction of High Court. Table 8.8 Articles related to fundamental rights at a glance. Article No. Subject Matter. General. 12. Definition of state 13-foot laws inconsistent with or in derogation of the fundamental rights. Right to equality. 14. Equality before law. 5. Prohibition of discrimination on grounds of religion, race, sex or pie. Of birth. 16. Equality of opportunity in matters of public employment. 17. Abolition of untouchability. 1g. Abolition of titles. Right to freedom. 19. Protection of certain rights regarding freedom of speech, etc. 20. Protection in respect of conviction for offenses. 21. Protection of life and personal liberty. 21a. Right to education 22. Protection against arrest and detention in certain cases. Right against exploitation. 23. Prohibition of traffic in human beings and forced labor. 24. Prohibition of employment of children in factories, etc. Fundamental Rights 107. Article No. Subject Matter. Right to freedom of religion. 25. Freedom of conscience and free profession, practice and propagation of religion. Right to property repealed. 26. Freedom to manage religious affairs L27. Freedom as to payment of taxes for promotion of any particular religion 28. Freedom as to attendance at religious instruction or religious worship in certain educational institutions. Cultural and educational rights. 29. Protection of interests of minorities 30. Right of minorities to establish and administer educational institutions. 31. Compulsory acquisition of property repealed. Saving of certain laws. 31A. Saving of laws providing for acquisition of estates, etc. 318. Validation of certain acts and regulations. 31C. Saving of laws giving effect to certain directive principles. 3ID. Saving of laws in respect of anti-national activities repealed. Right to constitutional remedies. 32. Remedies for enforcement of rights conferred by this part. 32A. Constitutional validity of state laws not to be considered in proceedings under Article 32 repealed. 33. Power of Parliament to modify the rights conferred by this part in their application to forces, etc. 34. Restriction on rights conferred by this part while martial law is in force in any area. 38. Legislation to give effect to the provisions of this part. Scan the QR code to access the conceptual video on fundamental rights and other important topics on EDGE Chapter Directive Principles of State Policy. TH Directive Principles of State Policy are enumerated in Part 4 of the Constitution from Articles 36 to 51 foot. The framers of the Constitution borrowed this idea from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. Dr. B.R. Ambedkar described these principles as novel features of the Indian Constitution. The directive principles along with the fundamental rights contain the philosophy of the Constitution and is the soul of the Constitution. Granville Austin has described the directive principles and the fundamental rights as the conscience of the Constitution *2*. Actually, directive principles are mentioned in Articles 38 to 51. Article 36 deals with the definition of state while Article 37 deals with the nature and significance of directive principles. 2. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, p. 75. Features of the directive principles. 1. The phrase, directive principles of state policy, denotes the ideals that the state should keep in mind while formulating policies and enacting laws. These are the constitutional instructions or recommendations to the state in legislative, executive, and administrative matters. According to Article 36, the term state in Part 4 has the same meaning as in Part 3 dealing with fundamental rights. Therefore, it includes the legislative and executive organs of the central and state governments, all local authorities, and all other public authorities in the country. 2. The directive principles resemble the instrument of instructions enumerated in the Government of India Act of 1935. In the words of Dr. B.R. Ambedkar, the directive principles are like the instrument of instructions, which were issued to the Governor-General and to the governors of the colonies of India by the British government under the Government of India Act of 1935. What is called directive principles is merely another name for the instrument of instructions. The only difference is that they are instructions to the legislature and the executive. 3. The directive principles constitute a very comprehensive economic, social, and political program for a modern democratic state. They aim at realizing the high ideals of justice, liberty, equality, and fraternity as outlined in the Preamble to the Constitution. They embody the concept of a welfare state, and not that of a police state, which existed during the colonial era. In brief, they seek to establish economic and social democracy in the country. 4. The directive principles are non-justiciable in nature, that is, they are not legally police state, is mainly concerned with the maintenance of law and order and defense of the country against external aggression. Such a restrictive concept of state is based on the 19th century theory of individualism or laissez-faire. Directive Principles of State Policy 109. Enforceable by the courts for their violation. Therefore, the government, central, state, and local, cannot be compelled to implement them. Nevertheless, the Constitution, Article 37, itself says that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. 5. The directive principles, though non-justiciable in nature, help the courts in examining and determining the constitutional validity of a law. The Supreme Court has ruled many a times that in determining the constitutionality of any law, if a court finds that the law in question seeks to give effect to a directive principle, it may consider such law to be reasonable. In relation to Article 14, equality before law, or Article 19, 6 freedoms, and thus save such law from unconstitutionality. T. Classification of the directive principles. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three broad categories, viz., socialistic, Gandhian, and liberal intellectual. Socialistic principles. These principles reflect the ideology of socialism. They lay down the framework of a democratic socialist state, aim at providing social and economic justice, and set the path towards welfare state. They direct the state, 1. To promote the welfare of the people by securing a social order permeated by justice, social, economic, and political, and to minimize inequalities in income, status, facilities, and opportunities. 4. Article 38. 2. To secure a. The right to adequate means of livelihood for all citizens. The first aspect of point F was added by the 42nd Constitutional Amendment Act of 1976. B's directive was added by the 42nd Constitutional Amendment Act of 1976. 7-foot living wage is different from minimum wage, which includes the bare needs of life like food, shelter, and clothing. In addition to these bare needs, a living wage includes education, health, insurance, etc. A fair wage is a mean between living wage and minimum wage. 8. This directive was added by the 42nd Constitutional Amendment Act of 1976. For the second aspect of this provision was added by the 44th Constitutional Amendment Act of 1978. B. The equitable distribution of material resources of the community for the common good. C. Prevention of concentration of wealth and means of production. D. Equal pay for equal work for men and women. E. Preservation of the health and strength of workers and children against forcible abuse. And F. Opportunities for healthy development of children and protection of childhood and youth against exploitation and against moral and material abandonment. 5. Article 39. 3. TB promote equal justice and to provide free legal aid to the poor. 6. Article 39a. 4. LB secure the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. Article 41. 5. TB make provision for just and humane conditions of work and maternity relief. Article 42. 6. TB secure a living wage, a decent standard of life and social and cultural opportunities for all workers. Article 43. 7. 7. TB take steps to secure the participation of workers in the management of industries. 8. Article 43a. 8. TB raise the level of nutrition and the standard of living of people and to improve public health. Article 47. Gandhian principles. These principles are based on Gandhian ideology. They represent the program of reconstruction enunciated by Gandhi during the national movement. In order to fulfill the Indian polity dreams of Gandhi, some of his ideas were included as directive principles. They require the state, 1. TB organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-government. Article 40. 2. TB promote cottage industries on an individual or cooperation basis in rural areas. Article 43. 3. 7b promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. 8*1. Article 43b. 4. TB promote the educational and economic interests of SCs, STK, and other weaker sections of the society and to protect them from social injustice and exploitation. Article 46. 5. TB prohibit the consumption of intoxicating drinks and drugs which are injurious to health. Article 47. 6. TB prohibit the slaughter of cows, calves, and other milch and draft cattle and to improve their breeds. Article 48. Liberal intellectual principles. The principles included in this category represent the ideology of liberalism. They direct the state, 1. TB secure for all citizens a uniform civil code throughout the country. Article 44. 2. TB provide early childhood care and education for all children until they complete the age of 6 years. 9. Article 45. 3. TB organize agriculture and animal husbandry on modern and scientific lines. Article 48. 4. TB protect and improve the environment and to safeguard forests and wildlife. Article 48a. 10. 8. This directive was added by the 97th Constitutional Amendment Act of 2011. 9. This directive was changed by the 86th Constitutional Amendment Act of 2002. Originally, it made a provision for free and compulsory education for all children until they complete the age of 14 years. 10. This directive was added by the 42nd Constitutional Amendment Act of 1976. 5. TB protect monuments, places, and objects of artistic or historic interest which are declared to be of national importance. Article 49. 6. TB separate the judiciary from the executive in the public services of the state. Article 50. 7. To promote international peace and security and maintain just and honorable relations between nations. To foster respect for international law and treaty obligations, and to encourage settlement of international disputes by arbitration. Article 51. New directive principles. The 42nd Amendment Act of 1976 added 4 new directive principles to the original list. They require the state, 1. TB secure opportunities for healthy development of children, Article 39. 2. TB promote equal justice and to provide free legal aid to the poor, Article 39A. 3. TB take steps to secure the participation of workers in the management of industries, Article 43A. 4. TB protect and improve the environment and to safeguard forest and wildlife, Article 48A. The 44th Amendment Act of 1978 added one more directive principle, which requires the state to minimize inequalities in income, status, facilities, and opportunities, Article 38. The 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. The 97th Amendment Act of 2011 added a new directive principle relating to cooperative societies. It requires the state to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies, Article 438. Directive Principles of State Policy 111. Sanction behind Directive Principles. Sir B. N. Rao, the constitutional advisor to the Constituent Assembly, recommended that the rights of an individual should be divided into two categories, justiciable and non-justiciable, which was accepted by the drafting committee. Consequently, the fundamental rights, which are justiciable in nature, are incorporated in Part 3, and the directive principles, which are non-justiciable in nature, are incorporated in Part 4 of the Constitution. The specific differences between the two are summarized in THBLI 9.1. Though the directive principles are non-justiciable, the Constitution, Article 37, makes it clear that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Thus, they impose a moral obligation on the state authorities for their application, but the real force behind them is political, that is, public opinion. As observed by Aladi Krishnaswamy Iyer, no ministry responsible to the people can afford lightheartedly to ignore the provisions in Part 4 of the Constitution. Similarly, Dr. B. R. Ambedkar said in the Constituent Assembly that a government which rests on popular vote can hardly ignore the directive principles while shaping its policy. If any government ignores them, it will certainly have to answer for that before the electorate at the election time. 11. The framers of the Constitution made the directive principles non-justiciable and legally non-enforceable because 1. The country did not possess sufficient financial resources to implement them. 2. The presence of vast diversity and backwardness in the country would stand in the way of their implementation. 3. The newly bombed independent Indian state with its many preoccupations might be crushed under the burden unless it was free to decide the order, the time, the place, and the mode of fulfilling them. The Constitution makers, therefore, taking a pragmatic view, refrained from giving teeth to these principles. They believed more in it. Table 9.1 Distinction between fundamental rights and directive principles. Fundamental rights directive principles J1. These are negative as they prohibit the state from doing certain things. 1. These are positive as they require the state to do certain things. 2. These are justiciable, that is, they are legally enforceable by the courts in case of their violation. 2. These are non-justiciable, that is, they are not legally enforceable by the courts for their violation. 3. They aim at establishing political democracy in the country. 3. They aim at establishing social and economic democracy in the country. 4. These have legal sanctions. 4. These have moral and political sanctions. 5. They promote the welfare of the individual. Hence, they are personal and individualistic. 5. They promote the welfare of the community. Hence, they are societarian and socialistic. 6. They do not require any legislation for their implementation. They are automatically enforced. 6. They require legislation for their implementation. They are not automatically enforced. 7. The courts are bound to declare a law violative of any of the fundamental rights as unconstitutional. And 7. The courts cannot declare a law violative of any of the directive principles as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to a directive. U Constituent Assembly Debates, Volume 7, p. 476. 112 Indian Polity. Awaken public opinion rather than in court procedures as the ultimate sanction for the fulfillment of these principles. 1. 12m.p. Jain, Indian Constitutional Law, Wadhwa, 3rd edition, 1978, p. 595. Constituent Assembly Debates, Volume 7, p. 470. 14 in. Srinivasan, Democratic Government in India, p. 182. 15 Sir Ivor Jennings, Some Characteristics of the Indian Constitution, 1953, pp. 31-33. Criticism of the directive principles underscore 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 underscore. The directive principles of state policy have been criticized by some members of the Constituent Assembly as well as other constitutional and political experts on the following grounds. Legal force. The directives have been criticized mainly because of their non-justiciable character. While Katie Shaw dubbed them as pious superfluities and compared them with a check on a bank, payable only when the resources of the bank permit, 123, Nasiruddin contended that these principles are no better than the New Year's resolutions, which are broken on the 2nd of January. Even as T.D. Krishnamachari described the directives as *a veritable dustbin of sentiments, K.C. Ware called them as a manifesto of aims and aspirations and opined that they serve as mere moral homily, and Sir Ivor Jennings thought they are only as pious aspirations. Illogically arranged critics opine that the directives are not arranged in a logical manner based on a consistent philosophy. According to N. Srinivasan, the directives are neither properly classified nor logically arranged. The declaration mixes up relatively unimportant issues with the most vital economic and social questions. It combines rather incongruously the modern with the old and provisions suggested by the reason and science with provisions based purely on sentiment and prejudice. 14. Sir Ivor Jennings too pointed out that these principles have no consistent philosophy. Conservative. According to Sir Ivor Jennings, the directives are based on the political philosophy of the 19th century England. He remarked, the ghosts of Sidney Webb and Beatrice Webb stalk through the pages of the text. Part 4 of the Constitution expresses Fabian socialism without the socialism. He opined that the directives are deemed to be suitable in India in the middle of the 20th century. The question whether they are suitable for the 21st century cannot be answered, but it is quite probable that they will be entirely outmoded. 15. QI Constitutional Conflict. K. Santhanam has pointed out that the directives lead to a constitutional conflict, a. between the center and the states, b. between the president and the prime minister, and c. between the governor and the chief minister. According to him, the center can give directions to the states with regard to the implementation of these principles, and in case of non-compliance, can dismiss the state government. Similarly, when the prime minister gets a bill, which violates the directive principles, passed by the parliament, the president may reject the bill on the ground that these principles are fundamental to the governance of the country and hence, the ministry has no right to ignore them. The same constitutional conflict may occur between the governor and the chief minister at the state level. Utility of directive principles. In spite of the above criticisms and shortcomings, the directive principles are not an unnecessary appendage to the Constitution. The Constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singhavi, an eminent jurist, directive principles of state policy M113. In Diplomat, the directives are the life-giving provisions of the Constitution. They constitute the stuff of the Constitution and its philosophy of social justice. 16. M.C. Chagla, former Chief Justice of India, is of the opinion that, if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then be not only democracy in the political sense, but also a welfare state looking after the welfare of its citizens. 17. Dr. B.R. Ambedkar had pointed out that the directives have great value because they laid down that the goal of Indian polity is economic democracy, as distinguished from political democracy. Granville Austin opined that the directive principles are aimed at furthering the goals of the social revolution or to foster this revolution by establishing the conditions necessary for its achievement. 18. Sir B. N. Rao, the constitutional advisor to the Constituent Assembly, stated that the directive principles are intended as moral precepts for the authorities of the state. They have at least an educative value. IFI Journal of Constitutional and Parliamentary Studies, June 1975. 17 M.C. Chagla, an ambassador speaks, p. 35. 1b. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, pp. 50-52. According to M.C. Setlavad, the former Attorney General of India, the directive principles, although confer no legal rights and create no legal remedies, are significant and useful in the following ways. 1. They are like an instrument of instructions or general recommendations addressed to all authorities in the Indian Union. They remind them of the basic principles of the new social and economic order, which the Constitution aims at building. 2. They have served as useful beacon lights to the courts. They have helped the courts in exercising their power of judicial review, that is, the power to determine the constitutional validity of a law. 3. They form the dominating background to all state action, legislative or executive, and also a guide to the courts in some respects. 4. They amplify the Preamble, which solemnly resolves to secure to all citizens of India justice, liberty, equality, and fraternity. The directives also play the following roles. 1. They facilitate stability and continuity in domestic and foreign policies in political, economic, and social spheres in spite of the changes of the party in power. 2. They are supplementary to the fundamental rights of the citizens. They are intended to fill in the vacuum in Part 3 by providing for social and economic rights. 3. Their implementation creates a favorable atmosphere for the full and proper enjoyment of the fundamental rights by the citizens. Political democracy, without economic democracy, has no meaning. 4. They enable the opposition to exercise influence and control over the operations of the government. The opposition can blame the ruling party on the ground that its activities are opposed to the directives. 5. They serve as a crucial test for the performance of the government. The people can examine the policies and programs of the government in the light of these constitutional declarations. 6. They serve as common political manifesto. A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher, and friend in its legislative and executive acts. 19. Conflict between fundamental rights and directive principles. The justiciability of fundamental rights and non-justiciability of directive principles on the one hand, and the moral obligation of state to implement directive principles, Article 37, on the other hand, have led to a conflict between the two since the commencement of 19 p.b. Gajendra Gadkar, The Constitution of India, Its Philosophy and Postulates, p. 11. 114 Indian Polity. The Constitution. In the Champakam-Durarajan case 20, 1951, the Supreme Court ruled that in case of any conflict between the fundamental rights and the directive principles, the former would prevail. It declared that the directive principles have to conform to and run as subsidiary to the fundamental rights. But it also held that the fundamental rights could be amended by the Parliament by enacting constitutional amendment acts. As a result, the Parliament made the First Amendment Act, 1951, the Fourth Amendment Act, 1955, and the 17th Amendment Act, 1964, to implement some of the directives. 2° State of Madras vs. Champakam-Durarajan, 1951. 21 Goloknath vs. State of Punjab, 1967. 22 Article 39, b, says, the state shall direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. 23 Article 39, c, says, the state shall direct its policy towards securing that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. 24 Kesavananda Bharati vs. State of Kerala, 1973. 25 Minerva Mills vs. Union of India, 1980. The above situation underwent a major change in 1967 following the Supreme Court's judgment in the Goloknath case, 1, 1967. In that case, the Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights, which are sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of the directive principles. The Parliament reacted to the Supreme Court's judgment in the Goloknath case, 1967, by enacting the 24th Amendment Act, 1971, and the 25th Amendment Act, 1971. The 24th Amendment Act declared that the Parliament has the power to abridge or take away any of the fundamental rights by enacting constitutional amendment acts. The 25th Amendment Act inserted a new Article 31c, which contained the following two provisions. 1. No law which seeks to implement the socialistic directive principles specified in Article 39, b, and c, shall be void on the ground of contravention. 22, 23. Of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, Article 19, protection of 6 rights in respect of speech, assembly, movement, etc., or Article 31, right to property. 2. No law containing a declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Kesavananda Bharati case 2 foot, 1973, the Supreme Court declared the above second provision of Article 31c as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31c was held to be constitutional and valid. Later, the 42nd Amendment Act, 1976, extended the scope of the above first provision of Article 31c by including within its protection any law to implement any of the directive principles and not merely those specified in Article 39, b, and c. In other words, the 42nd Amendment Act accorded the position of legal primacy and supremacy to the directive principles over the fundamental rights conferred by Articles 14, 19, and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case 25, 1980. It means that the directive principles were once again made subordinate to the fundamental rights. But the fundamental rights conferred by Article 14 and Article 19 were accepted as subordinate to the directive principles specified in Article 39, b, and c. Further, Article 31, right to property, was omitted by the 44th Amendment Act, 1978. In the Minerva Mills case, 1980, the Supreme Court also held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. They together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one number 115. Less than the other, lb give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between the two is an essential feature of the basic structure of the Constitution. The goals set out by the directive principles have to be achieved without the abrogation of the means provided by the fundamental rights. Therefore, the present position is that the fundamental rights enjoy supremacy over the directive principles. Yet, this does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles, so long as the amendment does not damage or destroy the basic structure of the Constitution. Implementation of directive principles. Since 1950, the successive governments at the center and in the states have made several laws and formulated various programs for implementing the directive principles. These are mentioned below. 1. The Planning Commission was established in 1950 to take up the development of the country in a planned manner. The successive 5-year plans aimed at securing socio-economic justice and reducing inequalities of income, status, and opportunities. In 2015, the Planning Commission was replaced by a new body called Niti Aayog, National Institution for Transforming India. 2. Almost all the states have passed land reform laws to bring changes in the agrarian society and to improve the conditions of the rural masses. These measures include a. Abolition of intermediaries like zamindars, jagirdars, inamdars, etc. b. Tenancy reforms like security of tenure, fair rents, etc. c. Imposition of ceilings on landholdings. d. Distribution of surplus land among the landless laborers. And e. Cooperative farming. 3. The Minimum Wages Act, 1948, the Payment of Wages Act, 1936, the Payment of Bonus Act, 1965, the Contract Labor Regulation and Abolition Act, 1970, the Child Labor Prohibition and Regulation Act, 1986, the Bonded Labor System Abolition Act, 1976, the Trade Unions Act, 1926, the Factories Act, 1948, the Mines Act, 1952, the Industrial Disputes Act, 1947, the Workmen's Compensation Act, 1923, and so on have been enacted to protect the interests of the labor sections. In 2006, the government banned the child labor. In 2016, the Child Labor Prohibition and Regulation Act, 1986, was renamed as the Child and Adolescent Labor Prohibition and Regulation Act, 1986. 4. The Maternity Benefit Act, 1961, and the Equal Remuneration Act, 1976, have been made to protect the interests of women workers. 5. Various measures have been taken to utilize the financial resources for promoting the common good. These include nationalization of life insurance, 1956, the nationalization of 14 leading commercial banks, 1969, nationalization of general insurance, 1971, abolition of privy purses, 1971, and so on. 6. The Legal Services Authorities Act, 1987, has established a nationwide network to provide free and competent legal aid to the poor and to organize Lok Adalat for promoting equal justice. Lok Adalat is a statutory forum for conciliatory settlement of legal disputes. It has been given the status of a civil court. Its awards are enforceable, binding on the parties and final as no appeal lies before any court against them. 7. Khadi and Village Industries Board, Khadi and Village Industries Commission, Small-Scale Industries Board, National Small Industries Corporation, Handloom Board, Handicrafts Board, Core Board, Silk Board, and so on have been set up 116 Indian P degree and Y for the development of cottage industries in rural areas. G. The Community Development Program, 1952, Hill Area Development Program, 1960, Drought-Prone Area Program, 1973, Minimum Needs Program, 1974, Integrated Rural Development Program, 1978, Jauhar Rozgar Yojana, 1989, Swamijayani Gram Swarozgar Yojana, 1999, Sampoorn Gramina Rozgar Yojana, 2001, National Rural Employment Guarantee Program, 2006. And so on have been launched for raising the standard of living of people. 9. The Wildlife Protection Act, 1972, and the Forest Conservation Act, 1980, have been enacted to safeguard the wildlife and the forest respectively. Further, the Water and Air Acts have provided for the establishment of the central and state pollution control boards, which are engaged in the protection and improvement of environment. The National Forest Policy, 1988, aims at the protection, conservation, and development of forests. 10. Agriculture has been modernized by providing improved agricultural inputs, seeds, fertilizers, and irrigation facilities. Various steps have also been taken to organize animal husbandry on modern and scientific lines. 11. Three-tier Panchayati Raj system at village, talaka, and zila levels has been introduced to translate into reality Gandhiji's dream of every village being a republic. The 73rd Amendment Act, 1992, has been enacted to provide constitutional status and protection to these Panchayati Raj institutions. 12. Seats are reserved for SCs, SITs, and other weaker sections in educational institutions, government services, and representative bodies. The Untouchability Offences Act, 1955, which was renamed as the Protection of Civil Rights Act in 1976, and the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, 1989, have been enacted to protect the SCs in 8 TDZ from social injustice and exploitation. The 65th Constitutional Amendment Act of 1990 established the National Commission for Scheduled Castes and Scheduled Tribes to protect the interests of SCs and CITs. Later, the 89th Constitutional Amendment Act of 2003 bifurcated this combined commission into two separate bodies, namely, National Commission for Scheduled Castes and National Commission for Scheduled Tribes. 12a. Various national-level commissions have been established to promote and protect the social, educational, and economic interests of the weaker sections of the society. These include the National Commission for Backward Classes 1993, the National Commission for Minorities 1993, the National Commission for Women 1992, and the National Commission for Protection of Child Rights 2007. Further, the 102nd Amendment Act of 2018 conferred a constitutional status on the National Commission for Backward Classes and also enlarged its functions. 12b. In 2019, the central government issued orders providing 10% reservation to the economically weaker sections, EWSs, in admission to educational institutions and civil posts and services in the Government of India. The benefit of this reservation can be availed by the persons belonging to EWSs who are not covered under any of the existing schemes of reservations for SCs, CITs, and OBCs. This reservation was facilitated by the 103rd Amendment Act of 2019. 13. The Criminal Procedure Code, 1973, separated the judiciary from the executive and the public services of the state. Prior to this separation, the district authorities like the collector, the subdivisional officer, the tahsildar, and so on used to exercise judicial powers along with the traditional executive powers. After the separation, the judicial powers were taken away from these executive authorities and vested in the hands of district judicial magistrates who work under the direct control of the state high court. 14. The Ancient and Historical Monument and Archaeological Sites and Remains Act, 1951, has been enacted to protect the monuments, places, and objects of national importance. 15. Primary health centers and hospitals have been established throughout the country to improve the public health. Also, special programs have been launched to eradicate widespread diseases like malaria, TB, leprosy, AIDS, cancer, filaria, cholera, guinea worm, yaws, Japanese encephalitis, and so on. 16. Laws to prohibit the slaughter of cows, calves, and bullocks have been enacted in some states. 17. Some states have initiated the old age pension schemes for people above 65 years. 18. India has been following the policy of non-alignment and Panchsheel to promote international peace and security. In spite of the above steps by the central and state governments, the directive principles have not been implemented fully and effectively due to several reasons like inadequate financial resources, unfavorable socio-economic conditions, population explosion, strained center-state relations, and so on. Directive Principles of State Policy 117. F. Directives outside Part 4. Apart from the directives included in Part 4, there are some other directives contained in other parts of the Constitution. They are 1. Claims of SCs and STs to services. The claims of the members of the scheduled castes and the scheduled tribes shall be taken into consideration, consistently with the maintenance of efficiency of administration, in the making of appointments to services and posts in connection with the affairs of the Union or a state. Article 335 in Part 16. 2. Instruction in mother tongue. It shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 350, A in Part 17. 3. Development of the Hindi language. It shall be the duty of the Union to promote the spread of the Hindi language and to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India. Article 351 in Part 17. The above directives are also non-justiciable in nature. However, they are also given equal importance and attention by the judiciary on the ground that all parts of the Constitution must be read together. Table 9.2 Articles related to directive principles of state policy at a glance. Article No. Subject matter. 36. Definition of state. 37. Application of the principles contained in this part. 38. State to secure a social order for the promotion of welfare of the people. 39. Certain principles of policy to be followed by the state. 39a. Equal justice and free legal aid. 40. Organization of village panchayats. 41. Right to work, to education, and to public assistance in certain cases. 118 Indian Polity. 45. Provision for early childhood care and education to children below the age of 6 years. Article No. Subject matter. 42. Provision for just and humane conditions of work and maternity relief. 43. Living wage, etc. For workers. 43a. I. 1. Participation of workers and management of industries. 43b. Promotion of cooperative societies. 44. F. 17. I. Uniform Civil Code for the citizens. 46. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. 47. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. 48. Organization of agriculture and animal husbandry. 48A. Protection and improvement of environment and safeguarding of forest and wildlife. 49. Protection of monuments and places and objects of national importance. 50. Separation of judiciary from executive. 51. Promotion of international peace and security. Chapter 810 Fundamental Duties. The rights and duties of the citizens are correlative and inseparable. The original Constitution contained only the fundamental rights and not the fundamental duties. In other words, the framers of the Constitution did not feel it necessary to incorporate the fundamental duties of the citizens in the Constitution. However, they incorporated the duties of the state in the Constitution in the form of directive principles of state polity. Later in 1976, the fundamental duties of citizens were added in the Constitution. In 2002, one more fundamental duty was added. The fundamental duties in the Indian Constitution are inspired by the Constitution of erstwhile USSR. Notably, none of the constitutions of major democratic countries like USA, Canada, France, Germany, Australia, and so on specifically contain a list of duties of citizens. Japanese Constitution is, perhaps, the only democratic constitution in the world which contains a list of duties of citizens. The socialist countries, on the contrary, gave equal importance to the fundamental rights and duties of their citizens. Hence, the Constitution of erstwhile USSR declared that the citizens' exercise of their rights and freedoms was inseparable from the performance of their duties and obligations. Sworn Singh Committee. Recommendations. In 1976, the Congress Party set up the Sardar Sworn Singh Committee to make recommendations about fundamental duties, the need and necessity of which was felt during the operation of the internal emergency, 1975 to 1977. The committee recommended the inclusion of a separate chapter on fundamental duties in the Constitution. It stressed that the citizens should become conscious that in addition to the enjoyment of rights, they also have certain duties to perform as well. The Congress government at center accepted these recommendations and enacted the 42nd Constitutional Amendment Act in 1976. This amendment added a new part, namely, Part IVA to the Constitution. This new part consists of only one article, that is, Article 51A, which for the first time specified a code often fundamental duties of the citizens. The ruling Congress Party declared the non-inclusion of fundamental duties in the Constitution as a historical mistake and claimed that what the framers of the Constitution failed to do was being done now. Though the Sworn Singh Committee suggested the incorporation of 8 fundamental duties in the Constitution, the 42nd Constitutional Amendment Act, 1976, included 10 fundamental duties. Interestingly, certain recommendations of the committee were not accepted by the Congress Party and hence, not incorporated in the Constitution. These include 1. The Parliament may provide for the imposition of such penalty or punishment as may be considered appropriate for any non-compliance with or refusal to observe any of the duties. 2. No law imposing such penalty or punishment shall be called in question in any 120 Indian Polity court on the ground of infringement of any of fundamental rights or on the ground of repugnancy to any other provision of the Constitution. 3. Duty to pay taxes should also be a fundamental duty of the citizens. List of fundamental duties. According to Article 51A, it shall be the duty of every citizen of India, A. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. B. To cherish and follow the noble ideals that inspire the national struggle for freedom. C. To uphold and protect the sovereignty, unity and integrity of India. D. To defend the country and render national service when called upon to do so. E. To promote harmony and the spirit of common brotherhood amongst all the people of India transcending religious, linguistic and regional or sectional diversities and to renounce practices derogatory to the dignity of women. F. To value and preserve the rich heritage of the country's composite culture. G. To protect and improve the natural environment including forests, lakes, rivers and wildlife and to have compassion for living creatures. H. To develop scientific temper, humanism and the spirit of inquiry and reform. I. To safeguard public property and abjure violence. J. To strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. And K. To provide opportunities for education to his child or ward between the age of 6 and 14 years. This duty was added by the 86th Constitutional Amendment Act, 2002. Features of the fundamental duties. Following points can be noted with regard to the characteristics of the fundamental duties. 1. Some of them are moral duties while others are civic duties. For instance, cherishing noble ideals of freedom struggle is a moral precept and respecting the Constitution, national flag, and national anthem is a civic duty. 2. They refer to such values which have been a part of the Indian tradition, mythology, religions, and practices. In other words, they essentially contain just a codification of tasks integral to the Indian way of life. 3. Unlike some of the fundamental rights which extend to all persons whether citizens or foreigners, the fundamental duties are confined to citizens only and do not extend to foreigners. 1. 4. Like the directive principles, the fundamental duties are also non-justiciable. The Constitution does not provide for their direct enforcement by the courts. Moreover, there is no legal sanction against their violation. However, the Parliament is free to enforce them by suitable legislation. The fundamental rights guaranteed by Articles 14, 20, 21, 21A, 22, 23, 24, 25, 26, 27, and 28 are available to all persons whether citizens or foreigners. F. Criticism of fundamental duties underscore 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 the fundamental duties mentioned in Part IVA of the Constitution have been criticized on the following grounds. 1. The list of duties is not exhaustive as it does not cover other important duties like casting vote, paying taxes, family planning, and so on. In fact, duty to pay taxes was recommended by the Sworn Singh Committee. 2. Some of the duties are vague, ambiguous, and difficult to be understood by the common man. For example, different interpretations can be given to the phrases like noble ideals, composite culture, scientific temper, and so on too. 3. They have been described by the critics as a code of moral precepts due to their non-justiciable character. Interestingly, the Sworn Singh Committee had suggested for penalty or punishment for the non-performance of fundamental duties. 4. Their inclusion in the Constitution was described by the critics as superfluous. This is because the duties included in the Constitution as fundamental would be performed by the people even though they were not incorporated in the Constitution. 3. It were the people of India who created the Sovereign Democratic Republic of India in 1950, but the Republic is now claiming to be the master of the citizens enjoining habitual obedience to its command to do its duty. The state's confidence in the citizens is obviously shaken. For Mohan Kumar Singhania vs. Union of India, 1991. 3 Ramlila Maidan Incident, 2012. 2D.D. Chawla, the then president of the National Forum of Lawyers and Legal Aid, Delhi, observed, the duties may be spelt out in a more concrete form. 1 I left guessing the noble ideals. 1 some even the Bhagat Singh cult may be such an ideal as inspired our national struggle. Again, what is the rich heritage of our composite culture, and what is scientific temper, humanism, and the spirit of inquiry and reform? The values are beyond the ken of the general run of the people and carry no meaning to them. Duties should be such and so worded as to catch the imagination of the common man. D.D. Chawla, The Concept of Fundamental Duties, Socialist India, New Delhi, October 23, 1976, pp. 44-45. C.K. Daftari, former Attorney General of India, while opposing the inclusion of fundamental duties in the Constitution, said that more than 99.9% of the citizens were law-abiding, and there was no need to tell them about their duties. He argued that as long as the people are satisfied and contented, they willingly perform their duties. He said, "TB tell them what their duties are implies that they are not content. If that is the case after 26 years, it is not their fault." A. Kaysen also opposed the inclusion of fundamental duties in the Constitution and remarked, a democratic setup, instead of thriving on the willing cooperation and confidence of people, is reduced to the position of a harsh schoolmaster asking the studento stand upon the classroom bench because he has not done the homework. LB begin. Fundamental Duties 121. 5. The critics said that the inclusion of fundamental duties as an appendage to Part 4 of the Constitution has reduced their value and significance. They should have been added after Part 3 so as to keep them on par with fundamental rights. Significance of L. Fundamental Duties. In spite of criticisms and opposition, the fundamental duties are considered significant from the following viewpoints. 1. They serve as a reminder to the citizens that while enjoying their rights, they should also be conscious of duties they owe to their country, their society, and to their fellow citizens. 2. They serve as a warning against the anti-national and antisocial activities like burning the national flag, destroying public property, and so on. 3. They serve as a source of inspiration for the citizens and promote a sense of discipline and commitment among them. They create a feeling that the citizens are not mere spectators, but active participants in the realization of national goals. 4. They help the courts in examining and determining the constitutional validity of a law. In Mohan Kumar Singhania case, 1991, the Supreme Court held that Article 51A, Fundamental Duties, can be used to interpret ambiguous laws in order to determine their constitutionality. Further, in Ramlila Maidan Incident case, 2012, the court observed that a common thread runs through Parts 3, 4, and IVA of the Constitution. One part enumerates 4, 5, 122 are Indian polity. The fundamental rights, the second declares the fundamental principles of governance, and the third lays down the fundamental duties of the citizens. While interpreting any of these provisions, it shall always be advisable to examine the scope and impact of such interpretation on all the three constitutional aspects emerging from these parts. 5. They are enforceable by law. Hence, the Parliament can provide for the imposition of appropriate penalty or punishment for failure to fulfill any of them. H.R. Gokhale, the then Law Minister, gave the following reason for incorporating the fundamental duties in the Constitution after 26 years of its inauguration. In post-independent India, particularly on the eve of emergency in June 1975, a section of the people showed no anxiety to fulfill their fundamental obligations of respecting the established legal order. The provisions of chapter on fundamental duties would have a sobering effect on these restless spirits who have had a host of anti-national, subversive, and unconstitutional agitations in the past. Indira Gandhi, the then Prime Minister, justified the inclusion of fundamental duties in the Constitution and argued that their inclusion would help to strengthen democracy. She said, the moral value of fundamental duties would be not to smoother rights, but to establish a democratic balance by making the people conscious of their duties equally as they are conscious of their rights. The opposition in the parliament strongly opposed the inclusion of fundamental duties in the Constitution by the Congress government. However, the new Janata government headed by Morarji Desai in the post-emergency period did not annul the fundamental duties. Notably, the new government sought to undo many changes introduced in the Constitution by the 42nd Amendment Act, 1976, through the 43rd Amendment Act, 1977, and the 44th Amendment Act, 1978. This shows that there was an eventual consensus on the necessity and desirability of including the fundamental duties in the Constitution. This is more clear with the addition of one more fundamental duty in 2002 by the 86th Amendment Act. Varma Committee Observations. The Varma Committee on Fundamental Duties of the Citizens, 1999, identified the existence of legal provisions for the implementation of some of the fundamental duties. They are mentioned below. 1. The Prevention of Insults to National Honor Act, 1971, prevents disrespect to the Constitution of India, the national flag, and the national anthem. 2. The various criminal laws in force provide for punishments for encouraging enmity between different sections of people on grounds of language, race, place of birth, religion, and so on. 3. The Protection of Civil Rights Act, 1955, provides for punishments for offenses related to caste and religion. 11. 4. The Indian Penal Code, IPC, declares the imputations and assertions prejudicial to national integration as punishable offenses. 5. The Unlawful Activities Prevention Act of 1967 provides for the declaration of a communal organization as an unlawful association. 6. The Representation of People Act, 1951, provides for the disqualification of members of the parliament or a state legislature for indulging in corrupt practice, that is, soliciting votes on the ground of religion or promoting enmity between different sections of people on grounds of caste, race, language, religion, and so on. 7. The Wildlife Protection Act of 1972 prohibits trade in rare and endangered species. 8. The Forest Conservation Act of 1980 checks indiscriminate deforestation and diversion of forest land for non-forest purposes. This act was known as the Untouchability Offences Act till 1976. Chapter Amendment of the Constitution. Like any other written constitution, the Constitution of India also provides for its amendment in order to adjust itself to the changing conditions and needs. However, the procedure laid down for its amendment is neither as easy as in Britain nor as difficult as in USA. In other words, the Indian Constitution is neither flexible nor rigid but a synthesis of both. Article 368 in Part 20 of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. It states that the Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of the Constitution in accordance with the procedure laid down for the purpose. However, the Parliament cannot amend those provisions which form the basic structure of the Constitution. This was ruled by the Supreme Court in the Kesavananda Burdi case, 1973. Procedure for amendment. The procedure for the amendment of the Constitution as laid down in Article 368 is as follows. 1. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament and not in the state legislatures. 2. The bill can be introduced either by a minister or by a private member and Kesavananda Burdi vs. State of Kerala, 1973. Does not require prior permission of the President. 3. The bill must be passed in each House by a special majority, that is, a majority of the total membership of the House and a majority of 2/3 of the members of the House present and voting. 4. Each House must pass the bill separately. In case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses for the purpose of deliberation and passage of the bill. 5. If bill seeks to amend the federal provisions of the Constitution, it must also be ratified by the legislatures of half of the states by a simple majority, that is, a majority of the members of the House present and voting. 6. After duly passed by both the Houses of Parliament and ratified by the state legislatures, where necessary, the bill is presented to the President for assent. 7. The President must give his assent to the bill. He can neither withhold his or her assent to the bill nor return the bill for reconsideration of the Parliament. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to a constitutional amendment bill. 8. After the President's assent, the bill becomes an act, i.e., a Constitutional Amendment Act, and the Constitution stands amended in accordance with the terms of the Act. 124 Indian Polity. T. Types of amendments. Article 368 provides for two types of amendments, that is, by a special majority of Parliament and also through the ratification of half of the states by a simple majority. But some other articles provide for the amendment of certain provisions of the Constitution by a simple majority of Parliament, that is, a majority of the members of each House present and voting, similar to the ordinary legislative process. Notably, these amendments are not deemed to be amendments of the Constitution for the purposes of Article 368. Therefore, the Constitution can be amended in three ways: A. Amendment by simple majority of the Parliament, B. Amendment by special majority of the Parliament, and C. Amendment by special majority of the Parliament and the ratification of half of the state legislatures. By simple majority of Parliament, a number of provisions in the Constitution can be amended by a simple majority of the two houses of Parliament outside the scope of Article 368. These provisions include: 1. Admission or establishment of new states. 2. Formation of new states and alteration of areas, boundaries, or names of existing states. 3. Abolition or creation of legislative councils and states. 4. Second schedule, emoluments, allowances, privileges, and so on of the President, the governors, the speakers, judges, etc. 5. Quorum in Parliament. 6. Salaries and allowances of the members of Parliament. 7. Rules of procedure in Parliament. 8. Privileges of the Parliament, its members, and its committees. G. Use of English language in Parliament. 10. Number of puisne judges in the Supreme Court. 11. Conferment of more jurisdiction on the Supreme Court. 12. Use of official language. 13. Citizenship, acquisition, and termination. 14. Elections to Parliament and state legislatures. 15. Delimitation of constituencies. 16. Union territories. 17. Fifth Schedule administration of scheduled areas and scheduled tribes. 18. Sixth Schedule administration of tribal areas. By special majority of Parliament, the majority of the provisions in the Constitution need to be amended by a special majority of the Parliament, that is, a majority of the total membership of each House and a majority of 2/3 of the members of each House present and voting. The expression total membership means the total number of members comprising the House irrespective of fact whether there are vacancies or absentees. Strictly speaking, the special majority is required only for voting at the third reading stage of the bill, but by way of abundant caution, the requirement for special majority has been provided for in the rules of the Houses in respect of all the effective stages of the bill. The provisions which can be amended by this way includes: I. Fundamental rights. 2. Directive principles of state policy. And 3. All other provisions which are not covered by the first and third categories. By special majority of Parliament and consent of states. Those provisions of the Constitution which are related to the federal structure of the polity can be amended by a special majority of the Parliament and also with the consent of half of the state legislatures by a simple majority. If one or some or all the remaining states take no action on the bill, it does not. 2. Sabas C. Kashyap, Our Parliament, National Book Trust, 1999, p. 168. Amendment of the Constitution 125. Matter. The moment half of the states give their consent, the formality is completed. There is no time limit within which the states should give their consent to the bill. The following provisions can be amended in this way: 1. Election of the President and its manner. 2. Extent of the executive power of the Union and the states. 3. Supreme Court and High Courts. 4. Distribution of legislative powers between the Union and the states. 5. Goods and Services T. Checks Council 3. This provision was added by the 101st Amendment Act of 2016. This is related to Article 279A. For inches USA, an amendment can also be proposed by a constitutional convention called by the Congress, American legislature, on the petition of 2/3 of the state legislatures. 8. Any of the lists in the 7th Schedule. 7. Representation of states in Parliament. 8. Power of Parliament to amend the Constitution and its procedure, Article 368 itself. T. Criticism of the amendment procedure. Critics have criticized the amendment procedure of the Constitution on the following grounds. 1. There is no provision for a special body like Constitutional Convention, as in USA, or Constitutional Assembly for amending the Constitution. The constituent power is vested in the Parliament and only in few cases, in the state legislatures. 2. The power to initiate an amendment to the Constitution lies with the Parliament. Hence, unlike in USA, the state legislatures cannot initiate any bill or proposal for amending the Constitution except in one case, that is, passing a resolution requesting the Parliament for the creation or abolition of legislative councils in the states. Here also, the Parliament can either approve or disapprove such a resolution or may not take any action on it. 4. 3. Major part of the Constitution can be amended by the Parliament alone, either by a special majority or by a simple majority. Only in few cases, the consent of the state legislatures is required, and that too, only half of them, while in USA, it is 3/4 of the states. 4. The Constitution does not prescribe the time frame within which the state legislatures should ratify or reject an amendment submitted to them. Also, it is silent on the issue whether the states can withdraw their approval after according the same. 5. There is no provision for holding a joint sitting of both the houses of Parliament if there is a deadlock over the passage of a constitutional amendment bill. On the other hand, a provision for a joint sitting is made in the case of an ordinary bill. 6. The process of amendment is similar to that of a legislative process. Except for the special majority, the constitutional amendment bills are to be passed by the Parliament in the same way as ordinary bills. 7. The provisions relating to the amendment procedure are too sketchy. Hence, they leave a wide scope for taking the matters to the judiciary. Despite these defects, it cannot be denied that the process has proved to be simple and easy and has succeeded in meeting the changed needs and conditions. The procedure is not so flexible as to allow the ruling parties to change it according to their whims. Nor is it so rigid as to be incapable of adapting itself to the changing needs. It, as rightly said by K.C. Ware, strikes a good balance between flexibility and rigidity. 5. In this context, Pundit Jawaharlal Nehru said in the Constituent Assembly, "While we want this constitution to be as solid and permanent as we can make it, there is no permanence in a constitution. There should be a certain." K.C. Ware, Modern Constitutions, 1966, p. 43. 126 GS Indian Polity. Flexibility. If you make any constitution rigid and permanent, you stop the nation's growth, the growth of a living, vital, organic people. 6. Constituent Assembly Debates, Volume 7, pp. 322-23. 7 Constituent Assembly Debates, Volume 9, p. 976. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, p. 25. Similarly, Dr. B.R. Ambedkar observed in the Constituent Assembly that the Assembly has not only refrained from putting a seal of finality and infallibility upon this Constitution by denying the people the right to amend the Constitution as in Canada, or by making the amendment of the Constitution subject to the fulfillment of extraordinary terms and conditions as in America or Australia, but has provided for a facile procedure for amending the Constitution. 7. K.C. Ware has admired the variety of amendment procedures contained in the Constitution of India. He said, "This variety in the amending process is wise but rarely found." According to Granville Austin, the amending process has proved itself one of the most ably conceived aspects of the Constitution. Although it appears complicated, it is merely diverse. Chapter 12 Basic Structure of the Constitution. The emergence of the basic structure. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. In the Shankari Prasad Case 1, 1951, the constitutional validity of the First Amendment Act, 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. The word law in Article 13 includes only ordinary laws and not the Constitutional Amendment Act's constituent laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a Constitutional Amendment Act, and such a law will not be void under Article 13. 1 Shankari Prasad vs. Union of India, 1951. 3 Sajjan Singh vs. State of Rajasthan, 1964. 2 Goloknath vs. State of Punjab, 1967. Again, in the Sajjan Singh Kasila, 1964, the Supreme Court reaffirmed the above stand. In other words, the court held that a Constitutional Amendment Act made under Article 368 is not a law within the meaning of Article 13. But in the Goloknath Case 2, 1967, the Supreme Court reversed its earlier stand. In this case, the constitutional validity of the 17th Amendment Act, 1964, which inserted certain state acts in the Ninth Schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence, the Parliament cannot abridge or take away any of these rights. A Constitutional Amendment Act is also a law within the meaning of Article 13 and hence would be void for violating any of the fundamental rights. The Parliament reacted to the Supreme Court's judgment in the Goloknath Case, 1967, by enacting the 24th Amendment Act, 1971. This act amended Articles 13 and 368. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. However, in the Kesavananda Burdi Case 3, 1973, the Supreme Court overruled its judgment in the Goloknath Case, 1967. It upheld the validity of the 24th Amendment Act, 1971, and stated that Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure or basic features of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi Case 3D, 1975. In this case, the Supreme Court invalidated a provision of the 39th Amendment. Kesavananda Bharati vs. State of Kerala, 1973, 33 Indira Nehru Gandhi vs. Raj Narayan, 1975, Act 1975, which kept the election disputes involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act, 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court on any ground including that of the contravention of any of the fundamental rights. However, the Supreme Court in the Minerva Mills Case 45, 1980, invalidated this provision as it excluded judicial review, which is a basic feature of the Constitution. Applying the doctrine of basic structure with respect to Article 368, the court held that Minerva Mills vs. Union of India, 1980, 5 Vamanhow vs. Union of India, 1980. Since the Constitution had conferred a limited amending power on the Parliament cannot under the exercise of that limited power enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of the Constitution and, therefore, the limitations on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic features. The donee of a limited power cannot by the exercise of that power convert the limited power into an unlimited 1 inch. Again, in the Vaman Rao Case 0, 1980, the Supreme Court adhered to the doctrine of the basic structure and further clarified that it would apply to constitutional amendments enacted after April 24, 1973, i.e., the date of the judgment in the Kesavananda Bharati case. Elements of the basic structure underscore 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 underscore. The present position is that the Parliament under Article 368 can amend any part of the Constitution including the fundamental rights but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. From the various judgments, the following have emerged as basic features of the Constitution or elements of the basic structure of the Constitution. 1. Supremacy of the Constitution. 2. Sovereign, democratic, and republican nature of the Indian polity. 3. Secular character of the Constitution. 4. Separation of powers between the legislature, the executive, and the judiciary. 5. Federal character of the Constitution. 6. Unity and integrity of the nation. 7. Welfare state, socio-economic justice. 8. Judicial review. 9. Freedom and dignity of the individual. 10. Parliamentary system. 11. Rule of law. 12. Harmony and balance between fundamental rights and directive principles. 13. Principle of equality. 14. Free and fair elections. 15. Independence of judiciary. 16. Limited power of Parliament to amend the Constitution. 7. Effective access to justice. 18. Principles, or essence, underlying fundamental rights. 19. Powers of the Supreme Court under Articles 32, 136, 141, and 1426-20. Powers of the High Courts under Articles 226 and 2277. Article 32, Remedies for enforcement of fundamental rights including writs. Article 136, Special leave to appeal by the Supreme Court. Article 141, Law declared by Supreme Court to be binding on all courts. And Article 142, Enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. Article 226, Power of High Courts to issue certain writs, and Article 227, Power of Superintendence over all courts by the High Court. Basic structure of the Constitution. 129. Continued. 1. Principle of equality. 2. Unity and integrity of India. 12. Raghunath Rao Case 16, 1993. Table 12.1 Evolution of the basic structure of the Constitution. SI. No. Name of the case, year, elements of the basic structure, as declared by the Supreme Court. 1. Kesavananda Bharati Case 3, 1973, popularly known as the Fundamental Rights Case. 1. Supremacy of the Constitution. 2. Separation of powers between the legislature, the executive, and the judiciary. 3. Republic and democratic form of government. 4. Secular character of the Constitution. 5. Federal character of the Constitution. 6. Sovereignty and unity of India 7. Freedom and dignity of the individual 8. Mandate to build a welfare state 9. Parliamentary system 2. I. Indira Nehru Gandhi Case 3A, 1975, popularly known as the election case. 1. India as a sovereign democratic republic 2. Equality of status and opportunity of an individual 3. Secularism and freedom of conscience and religion 4. Government of laws and not of men, i.e., rule of law 5. Judicial review 6. Free and fair elections which is implied in democracy 3. Minerva Mills Case 4, 1980, 1. Limited power of Parliament to amend the Constitution 2. Judicial review 3. Harmony and balance between fundamental rights and directive principles. Central Coal Fields Ltd. Case 8, 1980, Effective Access to Justice 5. Bhim Singhi Case 9, 1980, Welfare State, Socio-Economic Justice 6. S. R. Sampath Kumar Case 10, 1986, 1. Rule of Law 2. Judicial Review 7. P. Sambamurthy Case 11, 1986, 1. Rule of Law 2. Judicial Review 8. Delhi Judicial Service Association Case 12, 1991, Powers of the Supreme Court under Articles 32,136,141 and 142. 9. Indra Soni Case 13, 1992, popularly known as the Mundal Case. Rule of Law 10. Kumar Padma Prasad Case 14, 1992, Independence of Judiciary 11. Kahoto Halahan Case 156, 1992, popularly known as Defection Case. 1. Free and fair elections 2. Sovereign, democratic, republican structure. B. Central Coal Fields Ltd. versus Jeswal Coal Company. 1980, 9. Bhim Singhi versus Union of India, 1980, 10S. P. Sampath Kumar versus Union of India, 1986, and P. Sambamurthy versus State OFA. P. 1986, 12. Delhi Judicial Service Association versus State of Gujarat, 1991, 13. Indra Soni versus Union of India, 1992, 14. Kumar Padma Prasad versus Union of India, 1992, 15. Kahoto Halahan versus Zakilhu, 1992, I6. Raghunath Rao versus Union of India, 1993, 130. Indian Polity. ISI. 1. No. Name of the case, year, elements of the basic structure, as declared by the Supreme Court. 13. S.R. Bommai Case 17, 1994, 1. Federalism. 2. Secularism 3. Democracy 4. Unity and integrity of the nation 5. Social justice 6. Judicial review 14. L. Chandrakumar Case 18, 1997, Powers of the High Courts under Articles 226 and 227-15. Indra Soni 2 Case 19, 1999, Principle of Equality 16. All India Judges Association Case 20, 2001. Independent Judicial System 17. Kuldip Nayyar Case 21, 2006, 1. Democracy 2. Free and fair elections 18. M. Nagaraj Case 22, 2006, Principle of Equality 19. Arqualo Case 23, 2007, popularly known as 9 Schedule Case. 1. Rule of Law 2. Separation of Powers 3. Principles, or essence, underlying fundamental rights 4. Judicial Review 5. Principle of Equality. 20. Ram Jethmalani Case 24, 2011, Powers of the Supreme Court under Article 3221. Namit Sharma Case 25, 2012, Freedom and Dignity of the Individual 22. Madras Bar Association Case 26, 2014. 1. Judicial Review 2. Powers of the High Courts under Articles 226 and 227. 17 S.K. Bommai versus Union of India, 1994, 18L. Chandrakumar versus Union of India, 1997, 9 Indra Soni 2 versus Union of India, 1999, 20 All India Judges Association versus Union of India 2001, 21 Kuldip Nayyar versus Union of India 2006, 22L. Nagaraj versus Union of India 2006, 2II. R. Qualo versus State of Tamil Nadu 2007, 24 Ram Jethmalani versus Union of India 2011, Namit Sharma versus Union of India 2012, 26 Madras Bar Association versus Union of India 2014, Part System of Government. Parliamentary System. The Constitution of India provides for a parliamentary form of government, both at the center and in the states. Articles 74 and 75 deal with the parliamentary system at the center and Articles 163 and 164 in the states. Modern democratic governments are classified into parliamentary and presidential on the basis of the nature of relations between the executive and the legislative organs of the government. The parliamentary system of government is the one in which the executive is responsible to the legislature for its policies and acts. The presidential system of government, on the other hand, is one in which the executive is not responsible to the legislature for its policies and acts, and is constitutionally independent of the legislature with respect of its term of office. The parliamentary government is also known as cabinet government or responsible government or Westminster model of government and is prevalent in Britain, Japan, Canada, and India, among others. The presidential government, on the other hand, is also known as non-responsible or non-parliamentary or fixed executive system of government and is prevalent in USA, Brazil, Russia, and Sri Lanka, among others. Ivor Jennings called the parliamentary system as cabinet system because the cabinet is the nucleus of power in a parliamentary system. The parliamentary government is also known as responsible government, as the cabinet, the real executive, is accountable to the parliament and stays in office so long as it enjoys the latter's confidence. It is described as Westminster model of government after the location of the British Parliament, where the parliamentary system originated. In the past, the British constitutional and political experts described the Prime Minister as primus inter pares, first among equals, in relation to the cabinet. In the recent period, the Prime Minister's power, influence, and position have increased significantly vis-a-vis the cabinet. Pusha has come to play a dominant role in the British politico-administrative system. Hence, the later political analysts like Crossman, Mackintosh, and others have described the British system of government as prime ministerial government. The same description holds good in the Indian context too. T features of parliamentary T government. The features or principles of parliamentary government in India are as follows. 1. Nominal and real executives. The president is the nominal executive, de jure executive, or titular executive, while the parliamentary system 133. Kitchen cabinet. It is only an advisory body and consists of non-elected departmental secretaries. They are selected and appointed by him/her, are responsible only to him/her, and can be removed by him/her any time. D. The president and his secretaries are not responsible to the Congress for their acts. They neither possess membership in the Congress nor attend its sessions. E. The president cannot dissolve the House of Representatives, the lower house of the Congress. F. The doctrine of separation of powers is the basis of the American presidential system. The legislative, executive, and judicial powers of the government are separated and vested in the three independent organs of the government. Merits of the parliamentary system. The parliamentary system of government has the following merits. 1. Harmony between legislature and executive. The greatest advantage of the parliamentary system is that it ensures harmonious relationship and cooperation between the legislative and executive organs of the government. The executive is a part of the legislature and both are interdependent at work. As a result, there is less scope for disputes and conflicts between the two organs. 2. Responsible government. By its very nature, the parliamentary system establishes a responsible government. The ministers are responsible to the parliament for all their acts of omission and commission. The parliament exercises control over the ministers through various devices like question hour, discussions, adjournment motion, no confidence motion, etc. 3. Prevents despotism. Under this system, the executive authority is vested in a group of individuals, council of ministers, and not in a single person. This dispersal of authority checks the dictatorial tendencies of the executive. Moreover, the executive is responsible to the parliament and can be removed by a no-confidence motion. 4. Ready alternative government. In case the ruling party loses its majority, the head of the state can invite the opposition party to form the government. This means an alternative government can be formed without fresh elections. Hence, Dr. Jennings says, the leader of the opposition is the alternative prime minister. 5. Wide representation. In a parliamentary system, the executive consists of a group of individuals, i.e., ministers who are representatives of the people. Hence, it is possible to provide representation to all sections and regions in the government. The Prime Minister, while selecting his ministers, can take this factor into consideration. Demerits of the parliamentary system. In spite of the above merits, the parliamentary system suffers from the following demerits. 1. Unstable government. The parliamentary system does not provide a stable government. There is no guarantee that a government can survive its tenure. The ministers depend on the mercy of the majority legislators for their continuity and survival in office. A no-confidence motion or political defection or evils of multi-party coalition can make the government unstable. The government headed by Morarji Desai, Charan Singh, VP Singh, Chandrasekhar, Devagowda, and I.K. Gujral are some such examples. 2. No continuity of policies. The parliamentary system is not conducive for the formulation and implementation of long-term policies. This is due to the uncertainty of the tenure of the government. A change in the ruling party is usually followed by changes in the 132 or Indian Polity. Prime Minister is the real executive, de facto executive. Thus, the President is head of the state, while the Prime Minister is head of the government. Article 74 provides for a council of ministers headed by the Prime Minister to aid and advise the President in the exercise of his functions. The advice so tendered is binding on the President. 1. The 42nd and 44th Amendment Acts of 1976 and 1978 respectively have made the ministerial advice binding on the President. 2. Majority party rule. The political party which secures majority seats in the Lok Sabha forms the government. The leader of that party is appointed as the Prime Minister by the President. Other ministers are appointed by the President on the advice of the Prime Minister. However, when no single party gets the majority, a coalition of parties may be invited by the President to form the government. 3. Collective responsibility. This is the bedrock principle of parliamentary government. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular, Article 75. They act as a team and swim and sink together. The principle of collective responsibility implies that the Lok Sabha can remove the ministry, i.e., Council of Ministers headed by the Prime Minister, from office by passing a vote of no confidence. 4. Political homogeneity. Usually members of the Council of Ministers belong to the same political party, and hence they share the same political ideology. In case of coalition government, the ministers are bound by consensus. 5. Double membership. The ministers are members of both the legislature and the executive. This means that a person cannot be a minister without being a member of the Parliament. The Constitution stipulates that a minister who is not a member of the Parliament for a period of 6 consecutive months ceases to be a minister. 6. Leadership of the Prime Minister. The Prime Minister plays the leadership role in this system of government. Husha is the leader of Council of Ministers, leader of the Parliament, and leader of the party in power. In these capacities, Husha plays a significant and highly crucial role in the functioning of the government. 7. Dissolution of the lower house. The lower house of the Parliament, Lok Sabha, can be dissolved by the President on recommendation of the Prime Minister. In other words, the Prime Minister can advise the President to dissolve the Lok Sabha before the expiry of its term and hold fresh elections. This means that the executive enjoys the right to get the legislature dissolved in a parliamentary system. 8. Secrecy. The ministers operate on the principle of secrecy of procedure and cannot divulge information about their proceedings, policies, and decisions. They take the oath of secrecy before entering their office. The oath of secrecy to the ministers is administered by the President. Features of presidential government. Unlike the Indian Constitution, the American Constitution provides for the presidential form of government. The features of the American presidential system of government are as follows. A. The American president is both the head of the state and the head of government. As the head of state, Husha occupies a ceremonial position. As the head of government, Husha leads the executive organ of government. B. The president is elected by an electoral college for a fixed tenure of 4 years. Husha cannot be removed by the Congress except by impeachment for a grave unconstitutional act. C. The president governs with the help of a cabinet or a smaller body called 134 or Indian Polity. Policies of the government. For example, the Janata government headed by Morarji Desai in 1977 reversed a large number of policies of the previous Congress government. The same was repeated by the Congress government after it came back to power in 1980. 3. Dictatorship of the cabinet. When the ruling party enjoys absolute majority in the parliament, the cabinet becomes autocratic and exercises nearly unlimited powers. H. A. Lasky says that the parliamentary system gives the executive an opportunity for tyranny. Ramsay Muir, the former British Prime Minister, also complained of the dictatorship of the cabinet. This phenomenon was witnessed during the era of Indira Gandhi and Rajiv Gandhi. 23. 4. Against separation of powers in the parliamentary system, the legislature and the executive are together and inseparable. The cabinet acts as the leader of legislature as well as the executive. As Badgett points out, the cabinet is a hyphen that joins the buckle that binds the executive and legislative departments together. Hence, the whole system of government goes against the letter and spirit of the theory of separation of powers. In fact, there is a fusion of powers. 5. Government by amateurs. The parliamentary system is not conducive to administrative efficiency as the ministers are not experts in their fields. The Prime Minister has a limited choice in the selection of ministers. His choice is restricted to the members of Parliament alone and does not extend to external talent. Moreover, the ministers devote most of their time to parliamentary work, cabinet meetings, and party activities. 2. How Britain is Governed is a popular book written by him. 3. This theory was propounded by Montesquieu, a French political thinker, in his book The Spirit of Laws, 1748, to promote individual liberty. He stated that concentration of powers in one person or a body of persons would result in despotism and negate individual liberty. For K.T., Shaw favored the adoption of the presidential system. 5. Constituent Assembly Debates, Volume 7, pp. 284-5. 6. Constituent Assembly Debates, Volume 7, p. 32. The comparison of the parliamentary and presidential systems in terms of their features, merits, and demerits is given in Plea 13.1. T. Reasons for adopting parliamentary system. A plea was made in favor of the U.S. presidential system of government in the Constituent Assembly 456. But the Founding Fathers preferred the British parliamentary system due to the following reasons. 1. Familiarity with the system. The constitution makers were somewhat familiar with the parliamentary system as it had been in operation in India during the British rule. K.M. Munshi argued that, for the last 30 or 40 years, some kind of responsibility has been introduced in the governance of this country. Our constitutional traditions have become parliamentary. After this experience, why should we go back and buy a novel? 5. Experience. 2. Preference to more responsibility. Dr. B.R. Ambedkar pointed out in the Constituent Assembly that a democratic executive must satisfy two conditions: stability and responsibility. Unfortunately, it has not been possible so far to devise a system which can ensure both in equal degree. The American system gives more stability but less responsibility. The British system, on the other hand, gives more responsibility but less stability. The draft constitution, in recommending the parliamentary system of executive, has preferred more responsibility to more stability. 3. Need to avoid legislative, executive conflicts. The framers of the Constitution wanted to avoid the conflicts between the legislature and the executive which are bound to occur in the presidential system prevalent in USA. They thought that an infant democracy parliamentary system 135. Table 13.1 comparing parliamentary and presidential systems. Parliamentary system. Presidential system features: 1. Dual executive. 2. Majority party rule. 3. Collective responsibility. 4. Political homogeneity. 5. Double membership. 6. Leadership of Prime Minister. 7. Dissolution of Lower House. 8. Fusion of powers. Features: 1. Single executive. 2. President and legislators elected separately for a fixed term. 3. Non-responsibility. 4. Political homogeneity may not exist. 5. Single membership. 6. Domination of president. 7. No dissolution of lower house. 8. Separation of powers. Merits: 1. Harmony between legislature and executive. 2. Responsible government. 3. Prevents despotism. 4. Wide representation. Demerits: 1. Conflict between legislature and executive. 2. Non-responsible government. 3. May lead to autocracy. 4. Narrow representation. Demerits: 1. Unstable government. 2. No continuity of policies. 3. Against separation of powers. 4. Government by amateurs. Merits: 1. Stable government. 2. Definiteness in policies. 3. Based on separation of powers. 4. Government by experts. Could not afford to take the risk of a perpetual cleavage, feud, or conflict or threatened conflict between these two organs of the government. They wanted a form of government that would be conducive to the manifold development of the country. 4. Nature of Indian society. India is one of the most heterogeneous states and most complex plural societies in the world. Hence, the constitution makers adopted the parliamentary system as it offers greater scope for giving representation to various sections, interests, and regions in the government. This promotes a national spirit among the people and builds a united India. Whether the parliamentary system should be continued or should be replaced by the presidential system has been a point of discussion and debate in our country since the 1970s. This matter was considered in detail by the Swaran Singh Committee appointed by the Congress government in 1975. The committee opined that the parliamentary system has been doing well and hence, there is no need to replace it by the presidential system. Distinction between Indian and British models. The parliamentary system of government in India is largely based on the British parliamentary system. However, it never became a replica of the British system and differs in the following respects. 1. India has a republican system in place of the British monarchical system. In other words, the head of the state in India, that is, president, is elected, while the head of the state in Britain, that is, king or queen, enjoys a hereditary position. 2. The British system is based on the doctrine of the sovereignty of Parliament, while the Parliament is not supreme in India and enjoys limited and restricted powers due to a written constitution, federal system, judicial review, and fundamental rights. 3. In Britain, the Prime Minister should be a member of the lower house, House of Commons, of the Parliament. In India, the Prime Minister may be a 136 Indian Polity member of any of the two houses of Parliament. 7. For example, 3 Prime Ministers, Indira Gandhi, 1966, Deve Gowda, 1996, and Manmohan Singh, 2004, were members of the Rajya Sabha. 4. Usually, the members of Parliament alone are appointed as ministers in Britain. In India, a person who is not a member of Parliament can also be appointed as minister, but for a maximum period of 6 months. 5. Britain has a system of legal responsibility of the minister while India has no such system. Unlike in Britain, the ministers in India are not required to countersign the official acts of the head of the state. 6. Shadow Cabinet is a unique institution of the British cabinet system. It is formed by the opposition party to balance the ruling cabinet and to prepare its members for future ministerial office. There is no such institution in India. See CHAPTF 14 Federal System. Political scientists have classified governments into unitary and federal on the basis of the nature of relations between the national government and the regional governments. By definition, a unitary government is one in which all the powers are vested in the national government, and the regional governments, if at all exist, derive their authority from the national government. A federal government, on the other hand, is one in which powers are divided between the national government and the regional governments by the Constitution itself, and both operate in their respective jurisdictions independently. Britain, France, Japan, China, Italy, Norway, Sweden, and so on have a unitary model of government, while the US, Switzerland, Australia, Canada, Russia, Brazil, Argentina, and so on have a federal model of government. In a federal model, the national government is known as the federal government, or the central government, or the union government, and the regional government is known as the state government, or the provincial government. The specific features of the federal and unitary governments are mentioned in a comparative manner in FBLE 14.1. The term federation is derived from a Latin word foedus, which means treaty, or agreement. Thus, a federation is a new state political system, which is formed through a treaty or an agreement between the various units. The units of a federation are known by various names like states, as in US, or cantons, as in Switzerland, or provinces, as in Canada, or republics, as in Russia. A federation can be formed in two ways, that is, by way of integration or by way of disintegration. In the first case, a number of. Table 14.1 comparing features of federal and unitary governments. Federal government, unitary government. 1. Dual government, that is, national government and regional government. 1. Single government, that is, the national government which may create regional governments. 2. Written constitution. 2. Constitution may be written, France, or unwritten, Britain. 3. Division of powers between the national and regional government. 3. No division of powers. All powers are vested in the national government. 4. Supremacy of the Constitution. 4. Constitution may be supreme, Japan, or may not be supreme, Britain. 5. Rigid Constitution. 5. Constitution may be rigid, France, or flexible, Britain. 6. Independent Judiciary. 6. Judiciary may be independent or may not be independent. 7. Bicameral Legislature. 7. Legislature may be bicameral, Britain, or unicameral, China. Militarily weak or economically backward states, independent, come together to form a big and a strong union, as for example, the US. In the second case, a big unitary state is converted into a federation by granting autonomy to the provinces to promote regional interest, for example, Canada. The US is the first and the oldest federation in the world. It was formed in 1787 following the American Revolution, 1775 to 83. It comprises 50 states, originally 13 states, and is taken as the model of federation. The Canadian Federation, comprising 10 provinces, originally 4 provinces, is also quite old, formed in 1867. The Constitution of India provides for a federal system of government in the country. The framers adopted the federal system due to two main reasons: the large size of the country and its socio-cultural diversity. They realized that the federal system not only ensures the efficient governance of the country but also reconciles national unity with regional autonomy. However, the term federation has nowhere been used in the Constitution. Instead, Article 1 of the Constitution describes India as a union of states. According to Dr. B.R. Ambedkar, the phrase union of states has been preferred to federation of states to indicate two things. The Indian Federation is not the result of an agreement among the states like the American Federation. And 2, the states have no right to secede from the Federation. The Federation is a union because it is indestructible. 1. The American Constitution originally consisted of 7 articles only, the Australian 128 and the Canadian 147. 3. The various amendments carried out since 1951 have deleted about 20 articles in one part, 7, and added about 95 articles, for parts, IV, IXA, IXB, and XIVA, and 4 schedules, 9, 10, 11, and 12. The Indian federal system is based on the Canadian model and not on the American model. The Canadian model differs fundamentally from the American model insofar as it establishes a very strong center. The Indian Federation resembles the Canadian Federation, in its formation, i.e., by way of disintegration. 2. In its preference to the term union, the Canadian Federation is also called a union. And 3. In its centralizing tendency, i.e., vesting more powers in the center vis-a-vis the states. Constituent Assembly Debates, Volume 7, p. 43. Federal Features of the Constitution. The federal features of the Constitution of India are explained below. Dual polity. The Constitution establishes a dual polity consisting of the Union at the center and the states at the periphery. Each is endowed with sovereign powers to be exercised in the field assigned to them respectively by the Constitution. The Union government deals with matters of national importance like defense, foreign affairs, currency, communication, and so on. The state governments, on the other hand, look after matters of regional and local importance like public order, agriculture, health, local government, and so on. Written Constitution. The Constitution is not only a written document, but also the lengthiest constitution of the world. Originally, it contained a preamble, 395 articles, divided into 22 parts and 8 schedules. 2. At present, it consists of a preamble, about 470 articles, divided into 25 parts and 12 schedules. 3. It specifies the structure, organization, powers, and functions of both the central and state governments and prescribes the limits within which they must operate. Thus, it avoids the misunderstandings and disagreements between the two. Division of powers. The Constitution divided the powers between the center and the states in terms of the Union List, State List, and Concurrent List in Federal System 139. The 7th Schedule. The Union List consists of 98 subjects, originally 97, the State List 59 subjects, originally 66, and the Concurrent List 52 subjects, originally 47. Both the center and the states can make laws on the subjects of the Concurrent List, but in case of a conflict, the central law prevails. The residuary subjects, i.e., which are not mentioned in any of the 3 lists, are given to the center. Supremacy of the Constitution. The Constitution is the supreme, or the highest, law of the land. The laws enacted by the center and the states must conform to its provisions. Otherwise, they can be declared invalid by the Supreme Court or the High Courts through their power of judicial review. Thus, the organs of the government, legislative, executive, and judicial, at both the levels must operate within the jurisdiction prescribed by the Constitution. Rigid Constitution. The division of powers established by the Constitution as well as the supremacy of the Constitution can be maintained only if the method of its amendment is rigid. Hence, the Constitution is rigid to the extent that those provisions which are concerned with the federal structure, i.e., center-state relations and judicial organization, can be amended only by the joint action of the central and state governments. Such provisions require for their amendment a special majority of the Parliament and also an approval of half of the state legislatures. For a majority of 2/3 of the members of each House present and voting, and a majority of the total membership of each House. 3. Independent judiciary. The Constitution establishes an independent judiciary headed by the Supreme Court for 2 purposes. 1. To protect the supremacy of the Constitution by exercising the power of judicial review. And 2. To settle the disputes between the center and the states or between the states. The Constitution contains various measures like security of tenure to judges, fixed service conditions, and so on to make the judiciary independent of the government. Bicameralism. The Constitution provides for a bicameral legislature consisting of an upper house, Rajya Sabha, and a lower house, Lok Sabha. The Rajya Sabha represents the states of Indian Federation, while the Lok Sabha represents the people of India as a whole. The Rajya Sabha, even though a less powerful chamber, is required to maintain the federal equilibrium by protecting the interests of the states against the undue interference of the center. Unitary features of the Constitution. Besides the above federal features, the Indian Constitution also possesses the following unitary or non-federal features. Strong center. The division of powers is in favor of the center and highly inequitable from the federal angle. Firstly, the Union List contains more subjects than the State List. Secondly, the more important subjects have been included in the Union List. Thirdly, the center has overriding authority over the Concurrent List. Finally, the residuary powers have also been left with the center, while in the U.S., they are vested in the states. Thus, the Constitution has made the center very strong. States not indestructible. Unlike in other federations, the states in India have no right to territorial integrity. The Parliament can by unilateral action change the area, boundaries, or name of any state. Moreover, it requires only a simple majority and not a special majority. Hence, the 140 Indian Polity. Indian Federation is an indestructible union of destructible states. The American Federation, on the other hand, is described as an indestructible union of indestructible states. Single constitution. Usually, in a federation, the states have the right to frame their own constitution separate from that of the center. In India, on the contrary, no such power is given to the states. The Constitution of India embodies not only the constitution of the center but also those of the states. Both the center and the states must operate within this single frame. The only exception in this regard was the case of erstwhile Jammu and Kashmir, which had its own state constitution. 5. Flexibility of the Constitution. The process of constitutional amendment is less rigid than what is found in other federations. The bulk of the Constitution can be amended by the unilateral action of the Parliament, either by simple majority or by special majority. Further, the power to initiate an amendment to the Constitution lies only with the center. In U.S., the states can also propose an amendment to the Constitution. 5. No equality of state representation. The states are given representation in the Rajya Sabha on the basis of population. Hence, the membership varies from 1 to 31. In U.S., on the other hand, the principle of equality of representation of states in the upper house is fully recognized. Thus, the American Senate has 100 members, 2 from each state. This principle is regarded as a safeguard for smaller states. Emergency provisions. The Constitution stipulates 3 types of emergencies: national, state, and financial. During an emergency, the central government. Till 2019, the erstwhile state of Jammu and Kashmir enjoyed a special status by virtue of Article 370 of the Constitution of India. Becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation is not found in any other federation. QI single citizenship. In spite of a dual polity, the Constitution of India, like that of Canada, adopted the system of single citizenship. There is only Indian citizenship and no separate state citizenship. All citizens, irrespective of the state in which they are born or reside, enjoy the same rights all over the country. The other federal states like US and Australia have dual citizenship, that is, national citizenship as well as state citizenship. Q. Integrated judiciary. The Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the state high courts below it. This single system of courts enforces both the central laws as well as the state laws. In US, on the other hand, there is a double system of courts whereby the federal laws are enforced by the federal judiciary and the state laws by the state judiciary. QI All India services. In US, the federal government and the state governments have their separate public services. In India also, the center and the states have their separate public services. But, in addition, there are All India services, IS, IPS, and IFOS, which are common to both the center and the states. The members of these services are recruited and trained by the center, which also possess ultimate control over them. Thus, these services violate the principle of federalism under the Constitution. Integrated audit machinery. The Comptroller and Auditor General of India audits the accounts of not only the central government but also those of the states. But 10. Federal System 141. Issue appointment and removal is done by the President without consulting the states. Hence, this office restricts the financial autonomy of the states. The American Comptroller General, on the contrary, has no role with respect to the accounts of the states. Parliament's authority over state list. Even in the limited sphere of authority allotted to them, the states do not have exclusive control. The Parliament is empowered to legislate on any subject of the state list if the Rajya Sabha passes a resolution to that effect in the national interest. This means that the legislative competence of the Parliament can be extended without amending the Constitution. Notably, this can be done when there is no emergency of any kind. Appointment of governor. The governor, who is the head of the state, is appointed by the President. Husha holds office during the pleasure of the President. Husha also acts as an agent of the center. Through him/her, the center exercises control over the states. The American Constitution, on the contrary, provided for an elected head in the states. In this respect, India adopted the Canadian system. 12. Integrated election machinery. The Election Commission conducts elections not only to the central legislature but also to the state legislatures. But this body is constituted by the President and the states have no say in this matter. The position is same with regard to the removal of its members as well. On the other hand, US has separate machineries for the conduct of elections at the federal and state levels. I3. Veto over state bills. The governor is empowered to reserve certain types of bills passed by the state legislature for the consideration of the President. The President can withhold his assent to such bills. I4. Not only in the first instance but also in the second instance. Thus, the President enjoys absolute veto, and not suspensive veto, over state bills. But in US and Australia, the states are autonomous within their fields and there is no provision for any such reservation. 7. Critical evaluation of the federal system. From the above, it is clear that the Constitution of India has deviated from the traditional federal systems like US, Switzerland, and Australia and incorporated a large number of unitary or non-federal features, tilting the balance of power in favor of the center. This has prompted the constitutional experts to challenge the federal character of the Indian Constitution. Thus, K.C. Ware described the Constitution of India as quasi-federal. He remarked that Indian Union is a unitary state with subsidiary federal features rather than a federal state with subsidiary unitary features. 6. 6K.C. Ware, Federal Government, 1951, p. 28. In 2015, the Planning Commission was replaced by a new body called the Niti Aayog, National Institution for Transforming India. 7K. Santhanam, Union-State Relations in India, 1960, pp. 50-70. 8. Paul Appleby, Public Administration in India, 1953, p. 51. According to K. Santhanam, the two factors have been responsible for increasing the unitary bias, tendency of centralization, of the Constitution. These are I. The dominance of the center in the financial sphere and the dependence of the states upon the central grants. And 2. The emergence of a powerful erstwhile planning commission which controlled the developmental process in the states. 63. He observed, India has practically functioned as a unitary state though the Union and the states have tried to function formally and legally as a federation. 7. However, there are other political scientists who do not agree with the above descriptions. Thus, Paul Appleby 8 characterizes the Indian 142 Indian Polity system as extremely federal. Morris Jones 9 termed it as a bargaining federalism. Ivor Jennings 10 has described it as a federation with a strong centralizing tendency. He observed that the Indian Constitution is mainly federal with unique safeguards for enforcing national unity and growth. Alexandrowicz 11 stated that India is a case sui generis, i.e., unique in character. Granville-Austin 1213-4 called the Indian federalism as a cooperative federalism. He said that though the Constitution of India has created a strong central government, it has not made the state governments weak and has not reduced them to the level of administrative agencies for the execution of policies of the central government. He described the Indian Federation as a new kind of federation to meet India's peculiar needs. 9. Morris-Jones, The Government and Politics in India, I 960, p. 14. Wyvern-Jennings, Some Characteristics of the Indian Constitution, 1953, p. 1. C. H. Alexandrowicz, Constitutional Development in India, 1957, pp. 157-70. L. Z. Granville-Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, pp. 186-88. 13. Constituent Assembly Debates, Volume 8, p. 33. 14. Ibid, Volume 7, pp. 33-34. 15. Dr. B.R. Ambedkar's speech in the Constituent Assembly on November 25, 1949 reproduced in the Constitution and the Constituent Assembly. Lok Sabha Secretariat, 1990, p. 176. 16. S.R. Bommai vs. Union of India, 1994. On the nature of the Indian Constitution, Dr. B.R. Ambedkar made the following observation in the Constituent Assembly. The Constitution is a federal constitution inasmuch as it establishes a dual polity. The Union is not a league of states, united in a loose relationship, nor are the states the agencies of the Union, deriving powers from it. Both the Union and the states are created by the Constitution. Both derive their respective authority from the Constitution. He further observed, yet the Constitution avoids the tight mold of federalism and could be both unitary as well as federal according to the requirements of time and circumstances. While replying to the criticism of over-centralization in the Constitution, he stated, a serious complaint is made on the ground that there is too much centralization and the states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relations between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principle of federalism is that the legislative and executive authority is partitioned between the center and the states not by any law to be made by the center, but by the Constitution itself. This is what the Constitution does. The states are in no way dependent upon the center for their legislative or executive authority. The states and the center are co-equal in this matter. It is difficult to see how such a constitution can be called centralism. It is, therefore, wrong to say that the states have been placed under the center. The center cannot by its own will alter the boundary of this partition. Nor can the judiciary. 1516 in the Bommai case, 1994, the Supreme Court laid down that the Constitution is federal and characterized federalism as its basic feature. It observed, the fact that under the scheme of our Constitution, greater power is conferred upon the center vis-a-vis the states does not mean that the states are mere appendages of the center. The states have an independent constitutional existence. They are not satellites or agents of the center. Within the sphere allotted to them, the states are supreme. The fact that during emergency and in certain other eventualities their powers are overridden or invaded by the center is not destructive of the essential federal feature of the Constitution. They are exceptions, and the exceptions are not a rule. Let it be said that the federalism in the Indian Constitution is not a matter of administrative convenience, but one of principle, the outcome of our own process and a recognition of the ground realities. Federal System M143. In fact, the federalism in India represents a compromise between the following two conflicting considerations. 17 Subhash C. Kashyap, Our Parliament, National Book Trust, 1999 edition, p. 40. 18 S.R. Bommai vs. Union of India, 1994. I. Normal division of powers under which states enjoy autonomy within their own spheres. And 2. Need for national integrity and a strong union government under exceptional circumstances. The following trends in the working of Indian political system reflects its federal spirit. I. Territorial disputes between states, for example, between Maharashtra and Karnataka over Belgaum. 2. Disputes between states over sharing of river water, for example, between Karnataka and Tamil Nadu over Kaveri water. 3. The emergence of regional parties and their coming to power in states like Andhra Pradesh, Tamil Nadu, etc. 4. The creation of new states to fulfill the regional aspirations, for example, Mizoram or Jharkhand or Telangana. V. Demand of the states for more financial grants from the center to meet their developmental needs. 6. Assertion of autonomy by the states and their resistance to the interference from the center. 7. Supreme Court's imposition of several procedural limitations on the use of Article 356, President's rule in the states, by the center. 18. Chapter Center-State Relations. The Constitution of India, being federal in structure, divides all powers, legislative, executive, and financial, between the center and the states. However, there is no division of judicial power as the Constitution has established an integrated judicial system to enforce both the central laws as well as state laws. Though the center and the states are supreme in their respective fields, the maximum harmony and coordination between them is essential for the effective operation of the federal system. Hence, the Constitution contains elaborate provisions to regulate the various dimensions of the relations between the center and the states. The center-state relations can be studied under three heads: legislative relations, administrative relations, financial relations. Legislative relations. Articles 245 to 255 in Part 11 of the Constitution deal with the legislative relations between the center and the states. Besides these, there are some other articles dealing with the same subject. Like any other federal constitution, the Indian Constitution also divides the legislative powers between the center and the states with respect to both the territory and the subjects of legislation. Further, the Constitution provides for the parliamentary legislation in the state field under 5 extraordinary situations as well as the center's control over state legislation in certain cases. Thus, there are 4 aspects in the center state's legislative relations, viz. Territorial extent of central and state legislation, distribution of legislative subjects, parliamentary legislation in the state field, and a center's control over state legislation. Territorial extent of central and state legislation. The Constitution defines the territorial limits of the legislative powers vested in the center and the states in the following way. The Parliament can make laws for the whole or any part of the territory of India. The territory of India includes the states, the Union territories, and any other area for the time being included in the territory of India. 2. A state legislature can make laws for the whole or any part of the state. The laws made by a state legislature are not applicable outside the state, except when there is a sufficient nexus between the state and the object. 3. The Parliament alone can make extraterritorial legislation. Thus, the laws of the Parliament are also applicable to the Indian citizens and their property in any part of the world. However, the Constitution places certain restrictions on the plenary territorial jurisdiction of the Parliament. In other words, the laws of Parliament are not applicable in the following areas. The President can make regulations for the peace, progress, and good government of the Union territories of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu, and Ladakh. In the case of Puducherry also, the President can legislate by making regulations, but only when the Assembly is suspended or dissolved. A regulation so made has the same force and effect as an Act of Parliament. It may also repeal or amend any Act of Parliament in relation to these Union territories. 2. The Governor is empowered to direct that an Act of Parliament does not apply to a scheduled area in the state or apply with specified modifications and exceptions. 3. The Governor of Assam may likewise direct that an Act of Parliament does not apply to a tribal area, autonomous district, in the state or apply with specified modifications and exceptions. The President enjoys the same power with respect to tribal areas, autonomous districts, in Meghalaya, Tripura, and Mizoram. Distribution of legislative subjects. The Constitution provides for a threefold distribution of legislative subjects between the center and the states, viz. List I, the Union list, List II, the state list, and List IL, the concurrent list, in the 7th Schedule. The Parliament has exclusive powers to make laws with respect to any of the matters enumerated in the Union list. This list has at present 98 subjects, originally 97 subjects, like defense, banking, foreign affairs, currency, atomic L. Even now, the last entry is numbered as 66, but the total number of entries is 59. The entries numbered 3 as 11, 19, 20, 29, 36, 52, and 55 have been omitted. Even now, the last entry is numbered as 47, but the total number of entries is 52. The entries numbered as 11A, 17A, 17B, 20A, and 33A have been added. Even now, the last entry is numbered as 97, but the total number of entries is 98. The entries numbered as 2A, 92A, and 928 have been added, and entries 33, 92, and 92C have been omitted. Center-state relations, M145. Energy, insurance, communication, interstate trade and commerce, census, audit, and so on. 2. The state legislature has, in normal circumstances, exclusive powers to make laws with respect to any of the matters enumerated in the state list. This has at present 59 subjects, originally 66 subjects, like public order, police, public health and sanitation, agriculture, prisons, local government, fisheries, markets, theaters, gambling, and so on. 2. 3. Both the Parliament and state legislature can make laws with respect to any of the matters enumerated in the concurrent list. This list has at present 52 subjects, originally 47 subjects, like criminal law and procedure, civil procedure, marriage and divorce, population control and family planning, electricity, labor welfare, economic and social planning, drugs, newspapers, books and printing press, and others. The 42nd Amendment Act of 1976 transferred 5 subjects to concurrent list from state list, that is, A. Education, B. Forests, C. Weights and measures, D. Protection of wild animals and birds, and E. Administration of justice. Constitution and organization of all courts except the Supreme Court and the High Courts. 3. 4. The Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state even though that matter is one which is enumerated in the state list. This provision has reference to the Union territories or the acquired territories, if any. V. The 101st Amendment Act of 2016 has made a special provision with respect to goods and services tax. Accordingly, 146 VJ Indian Polity. The Parliament and the state legislature have power to make laws with respect to goods and services tax imposed by the Union or by the state. Further, the Parliament has exclusive power to make laws with respect to goods and services tax where the supply of goods or services or both takes place in the course of interstate trade or commerce. 6. The power to make laws with respect to residuary subjects, i.e., the matters which are not enumerated in any of the 3 lists, is vested in the Parliament. This residuary power of legislation includes the power to levy residuary taxes. From the above scheme, it is clear that the matters of national importance and the matters which require uniformity of legislation nationwide are included in the Union list. The matters of regional and local importance and the matters which permit diversity of interest are specified in the state list. The matters on which uniformity of legislation throughout the country is desirable but not essential are enumerated in the concurrent list. Thus, it permits diversity along with uniformity. In U.S., only the powers of the federal government are enumerated in the Constitution and the residuary powers are left to the states. The Australian Constitution followed the American pattern of single enumeration of powers. In Canada, on the other hand, there is a double enumeration, federal and provincial, and the residuary powers are vested in the centre. The Government of India Act of 1935 provided for a threefold enumeration, viz. Federal, provincial, and concurrent. The present Constitution follows the scheme of this Act but with one difference, that is, under this Act, the residuary powers were given neither to the federal legislature nor to the provincial legislature but to the Governor-General of India. In this respect, India follows the Canadian precedent. The Constitution expressly secures the predominance of the Union list over the state list and the concurrent list and that of the concurrent list over the state list. Thus, in case of overlapping between the Union list and the state list, the former should prevail. In case of overlapping between the Union list and the concurrent list, it is again the former which should prevail. Where there is a conflict between the concurrent list and the state list, it is the former that should prevail. In case of a conflict between the central law and the state law on a subject enumerated in the concurrent list, the central law prevails over the state law. But there is an exception. If the state law has been reserved for the consideration of the President and has received his assent, then the state law prevails in that state. But it would still be competent for the Parliament to override such a law by subsequently making a law on the same matter. Parliamentary legislation in the state field. The above scheme of distribution of legislative powers between the center and the states is to be maintained in normal times. But in abnormal times, the scheme of distribution is either modified or suspended. In other words, the Constitution empowers the Parliament to make laws on any matter enumerated in the state list under the following 5 extraordinary circumstances. A. When Rajya Sabha passes a resolution if the Rajya Sabha declares that it is necessary in the national interest that Parliament should make laws with respect to goods and services tax 3A or a matter in the state list, then the Parliament becomes competent to make laws on that matter. Such a resolution must be supported by 2/3 of the members present and voting. The resolution remains in force for 1 year. It can be renewed any number of times but not exceeding 1 year at a time. The law ceases to have effect on the expiration of 6 months after the resolution has ceased to be in force. 3A. The provision for goods and services tax was added by the 101st Amendment Act of 2016. This provision does not restrict the power of a state legislature to make laws on the same matter. But, in case of inconsistency between a state law and a parliamentary law, the latter is to prevail. B. During a national emergency, the Parliament acquires the power to legislate with respect to goods and services tax 3B or matters in the state list, while a proclamation of national emergency is in operation. The laws become inoperative on the expiration of 6 months after the emergency has ceased to operate. Here also, the power of a state legislature to make laws on the same matter is not restricted. But, in case of repugnancy between a state law and a parliamentary law, the latter is to prevail. C. When states make a request when the legislatures of 2 or more states pass resolutions requesting the Parliament to enact laws on a matter in the state list, then the Parliament can make laws for regulating that matter. A law so enacted applies only to those states which have passed the resolutions. However, any other state may adopt it afterwards by passing a resolution to that effect in its legislature. Such a law can be amended or repealed only by the Parliament and not by the legislatures of the concerned states. The effect of passing a resolution under the above provision is that the Parliament becomes entitled to legislate with respect to a matter for which it has no power to make a law. On the other hand, the state legislature ceases to have the power to make a law with respect to that matter. The resolution operates as abdication or surrender of the power of the state legislature with respect to that matter, and it is placed entirely in the hands of Parliament, which alone can then legislate with respect to it. Some examples of laws passed under the above provision are Prize Competition Act, 1955, Wildlife Protection Act, 1972, Water, Interstate Relations 547, Prevention and Control of Pollution Act, 1974, Urban Land, Sealing and Regulation Act, 1976, and Transplantation of Human Organs Act, 1994. D. To implement international agreements, the Parliament can make laws on any matter in the state list for implementing the international treaties, agreements, or conventions. This provision enables the central government to fulfill its international obligations and commitments. Some examples of laws enacted under the above provision are United Nations Privileges and Immunities Act, 1947, Geneva Convention Act, 1960, Anti-Hijacking Act, 1982, and legislations relating to environment and TRIPS. E. During President's Rule, when the President's Rule is imposed in a state, the Parliament becomes empowered to make laws with respect to any matter in the state list in relation to that state. A law made so by the Parliament continues to be operative even after the President's Rule. This means that the period for which such a law remains in force is not coterminous with the duration of the President's Rule. But such a law can be repealed or altered or reenacted by the state legislature. A center's control over state legislation, besides the Parliament's power to legislate directly on the state subjects under the exceptional situations. The Constitution empowers the center to exercise control over the state's legislative matters in the following ways. I. The governor can reserve a bill passed by the state legislature for the consideration of the president. It must be noted here that the president enjoys absolute veto over such a bill, Articles 200 and 201. 2. A state bill imposing restrictions on the freedom of trade, commerce, and intercourse with that state or within that state can be introduced in the legislature of the state only with the previous sanction of the president, Article 304. 3b Ibid. 148 are Indian Polity. 3. The center can direct the states to reserve money bills and other financial bills passed by the state legislature for the president's consideration during a financial emergency, Article 360. JV. The governor cannot make an ordinance without the instructions from the president in certain cases, Article 213. From the above, it is clear that the Constitution has assigned a position of superiority to the center in the legislative sphere. In this context, the Sarkaria Commission on Center-State Relations, 1983-88, observed, the rule of federal supremacy is a technique to avoid absurdity, resolve conflict, and ensure harmony between the union and state laws. If this principle of union supremacy is excluded, it is not difficult to imagine its deleterious results. There will be every possibility of our two-tier political system being stultified by interference, strife, legal chaos, and confusion caused by a host of conflicting laws, much to the bewilderment of the common citizen. Integrated legislative policy and uniformity on basic issues of common union-state concern will be stymied. The federal principle of unity and diversity will be very much a casualty. This rule of federal supremacy, therefore, is indispensable for the successful functioning of the federal system. T. Administrative Relations Articles 256 to 263 in Part 11 of the Constitution deal with the administrative relations between the center and the states. In addition, there are various other articles pertaining to the same matter. Q. Distribution of executive powers. The executive power has been divided between the center and the states on the lines of the distribution of legislative powers, except in few cases. Thus, the executive power of the center extends to the whole of India. I. To the matters on which the Parliament has exclusive power of legislation. E. The subjects enumerated in the Union list. And 2. To the exercise of rights, authority, and jurisdiction conferred on it by any treaty or agreement. Similarly, the executive power of a state extends to its territory in respect of matters on which the state legislature has exclusive power of legislation. E. The subjects enumerated in the state list. In respect of matters on which both the Parliament and the state legislatures have power of legislation, i.e., the subjects enumerated in the concurrent list, the executive power rests with the states except when a constitutional provision or a parliamentary law specifically confers it on the center. Therefore, a law on a concurrent subject, though enacted by the Parliament, is to be executed by the states except when the Constitution or the Parliament has directed otherwise. All obligation of states, and the center. The Constitution has placed 2 restrictions on the executive power of the states in order to give ample scope to the center for exercising its executive power in an unrestricted manner. Thus, the executive power of every state is to be exercised in such a way, a. as to ensure compliance with the laws made by the Parliament and any existing law which apply in the state, and b. as not to impede or prejudice the exercise of executive power of the center in the state. While the former lays down a general obligation upon the state, The latter imposes a specific obligation on the state not to hamper the executive power of the center. In both the cases, the executive power of the center extends to giving of such directions to the state as are necessary for the purpose. The sanction behind these directions of the center is coercive in nature. Thus, Article 365 says that where any state has failed to 5. For example, under the Essential Commodities Act, made by the Parliament on a concurrent subject, the executive power is vested in the center. Report of the Commission on Center-State Relations, Part 1, Government of India, 1988, pp. 28-29. Center-State Relations, 149. Comply with, or to give effect to, any directions given by the center, it will be lawful for the President to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. It means that, in such a situation, the President's rule can be imposed in the state under Article 356. ESI centers directions to the states. In addition to the above two cases, the center is empowered to give directions to the states with regard to the exercise of their executive power in the following matters. I. The construction and maintenance of means of communication, declared to be of national or military importance, by the state. 2. The measures to be taken for the protection of the railways within the state. 3. The provision of adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups in the state. And 4. The drawing up and execution of the specified schemes for the welfare of the scheduled tribes in the state. The coercive sanction behind the central directions under Article 365, mentioned above, is also applicable in these cases. 3. Mutual delegation of functions. The distribution of legislative powers between the center and the states is rigid. Consequently, the center cannot delegate its legislative powers to the states, and a single state cannot request the Parliament to make a law on a state subject. The distribution of executive power in general follows the distribution of legislative powers. But such a rigid division in the executive sphere may lead to occasional conflicts between the two. Hence, the Constitution provides for inter-government delegation of executive functions in order to mitigate rigidity and avoid a situation of deadlock. Accordingly, the President may, with the consent of the state government, entrust to that government any of the executive functions of the center. Conversely, the governor of a state may, with the consent of the central government, entrust to that government any of the executive functions of the state. 6. This mutual delegation of administrative functions may be conditional or unconditional. 6. This provision, the power of the states to entrust functions to the center, was added by the 7th Constitutional Amendment Act of 1956. Before that, only the center had the power. The Constitution also makes a provision for the entrustment of the executive functions of the center to a state without the consent of that state. But, in this case, the delegation is by the Parliament and not by the President. Thus, a law made by the Parliament on a subject of the Union list can confer powers and impose duties on a state, or authorize the conferring of powers and imposition of duties by the center upon a state, irrespective of the consent of the state concerned. Notably, the same thing cannot be done by the state legislature. From the above, it is clear that the mutual delegation of functions between the center and the state can take place either under an agreement or by a legislation. While the center can use both the methods, a state can use only the first method. Cooperation between the center and states. The Constitution contains the following provisions to secure cooperation and coordination between the center and the states. I. The Parliament can provide for the adjudication of any dispute or complaint with respect to the use, distribution, and control of waters of any interstate river and river valley. 2. The President can establish, under Article 263, an interstate council to investigate and discuss subject of common interest between the center and the states. Such a council was set up in 1990. 5. 5Q Indian Polity. Full faith and credit is to be given throughout the territory of India to public acts, records, and judicial proceedings of the center and every state. 5. The Parliament can appoint an appropriate authority to carry out the purposes of the constitutional provisions relating to the interstate freedom of trade, commerce, and intercourse. But no such authority has been appointed so far. All India services like in MV Other Federation, the center and the states also have their separate public services called as the Central Services and the State Services respectively. In addition, there are All India Services IS, IPS, and IFOS. The members of these services occupy top positions or key posts under both the center and the states and serve them by turns. But they are recruited and trained by the center. These services are controlled jointly by the center and the states. The ultimate control lies with the central government, while the immediate control vests with the state governments. In 1947, Indian Civil Service, ICS, was replaced by IS, and the Indian Police, IP, was replaced by IPS and were recognized by the Constitution as All India Services. In 1966, the Indian Forest Service, IFOS, was created as the third All India Service. Article 312 of the Constitution authorizes the Parliament to create new All India services on the basis of a Rajya Sabha resolution to that effect. Each of these three All India services, irrespective of their division among different states, form a single service with common rights and status and uniform scales of pay throughout the country. Though the All India services violate the principle of federalism under the Constitution by restricting the autonomy and patronage of the states, they are supported on the ground that I. They help in maintaining high standard of administration in the center as well as in the states. 2. They help to ensure uniformity of the administrative system throughout the country. And 3. They facilitate liaison, cooperation, coordination, and joint action on the issues of common interest between the center and the states. CN while justifying the institution of EU India services in the Constituent Assembly, Dr. B.R. Ambedkar observed that the dual polity which is inherent in a federal system is followed in all federations by a dual service. In all federations, there is a federal civil service and a state civil service. The Indian Federation, though a dual polity, will have a dual service, but with one exception. It is recognized that in every country there are certain posts in its administrative setup which might be called strategic from the point of view of maintaining the standard of administration. There can be no doubt that the standard of administration depends upon the caliber of the civil servants who are appointed to the strategic posts. The Constitution provides that without depriving the states of their rights to form their own civil services, there shall be an All India service, recruited on an All India basis with common qualifications, with uniform scale of pay and members of which alone could be appointed to those strategic posts throughout the Union. EBI Public Service Commissions in the field of public service commissions, the center-state relations are as follows. The chairman and members of a state public service commission, though appointed by the governor of the state, can be removed only by the president. The Parliament can establish a joint state public service commission, JSPSC, for 2 or more states on the request of the state legislatures concerned. The chairman and members of the JSPSC are appointed by the president. The Union Public Service Commission, UPSC, can serve the needs of a state on the request of the state governor and with the approval of the president. Constituent Assembly Debates, Volume 7, pp. 41-42. 4. The UPSC assists the states, when requested by 2 or more states, in framing and operating schemes of joint recruitment for any services for which candidates possessing special qualifications are required. QI Integrated Judicial System. Though India has a dual polity, there is no dual system of administration of justice. The Constitution, on the other hand, established an integrated judicial system with the Supreme Court at the top and the state high courts below it. This single system of courts enforces both the central laws as well as the state laws. This is done to eliminate diversities in the remedial procedure. The judges of a state high court are appointed by the president in consultation with the Chief Justice of India and the governor of the state. They can also be transferred and removed by the president. The parliament can establish a common high court for 2 or more states. For example, Maharashtra and Goa or Punjab and Haryana have a common high court. AIL relations during emergency 0. During the operation of a national emergency, under Article 352, the center becomes entitled to give executive directions to a state on any matter. Thus, the state governments are brought under the complete control of the center, though they are not suspended. 2. When the president's rule is imposed in a state, under Article 356, the president can assume to himself or herself the functions of the state government and powers vested in the governor or any other executive authority in the state. 3. During the operation of a financial emergency, under Article 360, the center can direct the states to observe canons of financial propriety and can give other necessary directions, including the reduction of salaries of persons serving in the state. Center-state relations. Other provisions. The Constitution contains the following other provisions which enable the center to exercise control over the state administration. I. Article 355 imposes 2 duties on the center. A. To protect every state against external aggression and internal disturbance. And B. To ensure that the government of every state is carried on in accordance with the provisions of the Constitution. 2. The governor of a state is appointed by the president. Pusha holds office during the pleasure of the president. In adding to the constitutional head of the state, the governor acts as an agent of the center in the state. Pusha submits periodical reports to the center about the administrative affairs of the state. 3. The state election commissioner, though appointed by the governor of the state, can be removed only by the president. 10. Extra-constitutional devices. In addition to the above-mentioned constitutional devices, there are extra-constitutional devices to promote cooperation and coordination between the center and the states. These include a number of advisory bodies and conferences held at the central level. The non-constitutional advisory bodies include the Niti Aayog, which succeeded the Planning Commission, the National Integration Council, the Central Council of Health and Family Welfare, the Central Council of Local Government, the Zonal Councils, the Northeastern Council, the Central Council of Indian Medicine, the Central Council of Homeopathy, the Transport Development Council, the University Grants Commission, and so on. The important conference is held either annually or otherwise to facilitate center-state consultation on a wide range of matters are as follows. I. The Governor's Conference, presided over by the President. 2. The Chief Minister's Conference, presided over by the Prime Minister. 3. The Chief. 11. 152 Indian Polity. Secretaries' Conference, presided over by the Cabinet Secretary. 4. The Conference of Inspector General of Police. V. The Chief Justice's Conference, presided over by the Chief Justice of India. 6. The Conference of Vice-Chancellors. 7. The Home Ministers' Conference, presided over by the Central Home Minister. 8. The Law Ministers' Conference, presided over by the Central Law Minister. T. Financial Relations. Articles 268 to 293 in Part 12 of the Constitution deal with interstate financial relations. Besides these, there are other provisions dealing with the same subject. These together can be studied under the following heads. IB. Allocation of taxing powers. The Constitution divides the taxing powers between the center and the states in the following way. The Parliament has exclusive power to levy taxes on subjects enumerated in the Union list, which are 13 in number 8. The state legislature has exclusive power to levy taxes on subjects enumerated in the state list, which are 18 in number 9. There are no tax entries in the concurrent list. In other words, the concurrent jurisdiction is not available with respect to tax legislation. But the 101st Amendment Act of 2016 has made an exception by making a special provision with respect to goods and services tax. This amendment has conferred concurrent power upon the Parliament and state legislatures to make laws governing goods and services tax. 10. The residuary power of taxation, that is, the power to impose taxes not enumerated in any of the three lists, is vested in entries 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92A, 92B, and 96. Entries 45, 46, 47, 48, 49, 50, 51, 53, 54, 56, 57, 58, 59, 60, 61, 62, 63, and 66. 10 inches this regard, the 101st Amendment Act of 2016 inserted Article 246A in the Constitution. The Parliament. Under this provision, the Parliament has imposed gift tax, wealth tax, and expenditure tax. The Constitution also draws a distinction between the power to levy and collect a tax and the power to appropriate the proceeds of the tax so levied and collected. For example, the income tax is levied and collected by the center, but its proceeds are distributed between the center and the states. Further, the Constitution has placed the following restrictions on the taxing powers of the states. A state legislature can impose taxes on professions, trades, callings, and employments. But the total amount of such taxes payable by any person should not exceed $2,500 per annum. 2. A state legislature is prohibited from imposing a tax on the supply of goods or services or both in the following two cases. A. Where such supply takes place outside the state. And B. Where such supply takes place in the course of import or export. Further, the Parliament is empowered to formulate the principles for determining when a supply of goods or services or both takes place outside the state, or in the course *12 of import or export. 3. A state legislature can impose tax on the consumption or sale of electricity. But no tax can be imposed on the consumption or sale of electricity which is A. consumed by the center or sold to the center, or B. consumed in the construction, maintenance, or operation of any railway by the center or by the concerned railway company or sold to the center or the railway company for the same purpose. 4. A state legislature can impose a tax in respect of any water or electricity stored, generated, consumed, distributed, or. Originally, this limit was only $250 per annum. The 60th Amendment Act of 1988 raised it to $500 per annum. 12. These provisions are contained in Article 286, as amended by the 101st Amendment Act of 2016. Sold by any authority established by Parliament for regulating or developing any interstate river or river valley. But such a law, to be effective, should be reserved for the President's consideration and receive his assent. 9. Distribution of tax revenues. The 80th Amendment Act of 2000 and the 101st Amendment Act of 2016 have introduced major changes in the scheme of the distribution of tax revenues between the center and the states. The 80th Amendment was enacted to give effect to the recommendations of the 10th Finance Commission. The Commission recommended that out of the total income obtained from certain central taxes and duties, 29% should go to the states. This is known as the Alternative Scheme of Devolution and came into effect retrospectively from April 1, 1996. This amendment has brought several central taxes and duties like corporation tax and customs duties at par with income tax, taxes SJ on income other than agricultural income, as near as their constitutionally mandated sharing with the states is concerned. 13J. The 101st Amendment has paved the way for the introduction of a new tax regime, i.e., Goods and Services Tax, GST, in the country. Accordingly, the amendment conferred concurrent taxing powers upon the Parliament and the state legislatures to make laws for levying GST on every transaction of supply of goods or services or both. The GST replaced a number of indirect taxes levied by the Union and the state governments and is intended to remove the cascading effect of taxes and provide for a common national market for goods and services. The amendment provided for subsum ing of various central indirect taxes and levies such as I. Central excise duty, 2. Additional excise duties, 3. Excise duty levied under the medicinal and toilet preparations excise. I3. This amendment deleted Article 272, taxes which are levied and collected by the center and may be distributed between the center and the states. Center-State Relations M153. Duties, Act, 1955, 4. Service Ikes v. Additional customs duty commonly known as countervailing duty, 6. Special additional duty of customs, and 7. Central surcharges and cesses so far as they related to the supply of goods and services. Similarly, the amendment provided for subsuming of I. State value-added TKX sales T-checks, 2. Entertainment TKX, other than the tax levied by the local bodies, 3. Central sales TKX, levied by the center and collected by the states, 4. Octroi and entry TKX, v. Purchase tax, 6. Luxury Ikes, 7. Taxes on lottery, betting and gambling, and 8. State surcharges and cesses and so far as they related to the supply of goods and services. Further, the amendment deleted Article 268A as well as Entry 92C in the Union List. Both were dealing with service tax. They were added earlier by the 88th Amendment Act of 2003. The service tax was levied by the center but collected and appropriated by both the center and the states. After the above two amendments, i.e., 80th Amendment and 101st Amendment, the present position with respect to the distribution of tax revenues between the center and the states is as follows. A. Taxes levied by the center but collected and appropriated by the states. Article 268. This category includes the stamp duties on bills of exchange, checks, promissory notes, policies of insurance, transfer of shares, and others. The proceeds of these duties levied within any state do not form a part of the Consolidated Fund of India, but are assigned to that state. B. Taxes levied and collected by the center but assigned to the states. Article 269. The following taxes fall under this category. I. Fees on the sale or purchase of goods, other than newspapers, in the course of interstate trade or commerce. 2. Ixes on the consignment of goods in the course of interstate trade or commerce. The net proceeds off these taxes do not form a part of the Consolidated Fund of India. They are assigned to the concerned states in 154p Indian Polity, accordance with the principles laid down by the Parliament. C. Levy and collection of goods and services tax in course of interstate trade or commerce. Article 269. A. The goods and services tax, GST, on supplies in the course of interstate trade or commerce are levied and collected by the center. But this tax is divided between the center and the states in the manner provided by Parliament on the recommendations of the GST Council. Further, the Parliament is also authorized to formulate the principles for determining the place of supply, and when a supply of goods or services or both takes place in the course of interstate trade or commerce. D. Taxes levied and collected by the center but distributed between the center and the states. Article 270. This category includes all taxes and duties referred to in the Union List except the following. I. Duties and taxes referred to in Articles 268, 269, and 269, A mentioned above. 2. Surcharge on taxes and duties referred to in Article 271, mentioned below. And 3. Any cess levied for specific purposes. The manner of distribution of the net proceeds of these taxes and duties is prescribed by the President on the recommendation of the Finance Commission. D. Surcharge on certain taxes and duties for purposes of the center. Article 271. The Parliament can at any time levy the surcharges on taxes and duties referred to in Articles 269 and 270, mentioned above. The proceeds of such surcharges go to the center exclusively. In other words, the states have no share in these surcharges. However, the goods and services T-checks, GST, is exempted from this surcharge. In other words, this surcharge cannot be imposed on the GST. F. Taxes levied and collected and retained by the states. These are the taxes belonging to the states exclusively. They are enumerated in the state list and are 18 in number. These are 14. I. Land revenue. 2. Taxes on agricultural income. 3. Duties in respect of succession to agricultural land. Entry 52. Taxes on the entry of goods into a local area for consumption, use or sale therein. And entry 55. Taxes on advertisements other than advertisements published in the newspapers and advertisements broadcast by radio or television were omitted by the 101st Amendment Act of 2016. 4. Estate duty in respect of agricultural land. V. Taxes on lands and buildings. 6. Taxes on mineral rights. 7. Duties of excise on alcoholic liquors for human consumption. Opium, Indian hemp and other narcotic drugs and narcotics, but not including medicinal and toilet preparations containing alcohol or narcotics. 8. Taxes on the consumption or sale or electricity. 9. Taxes on the sale of petroleum crude, high-speed diesel, motor spirit, commonly known as petrol, natural gas, aviation turbine fuel and alcoholic liquor for human consumption, but not including sale in the course of interstate trade or commerce or sale in the course of international trade or commerce of such goods. X. Taxes on goods and passengers carried by road or inland waterways. 11. Taxes on vehicles. 12. Taxes on animals and boats. 13. Tolls. 14. Taxes on professions, trades, callings, and employments. 15. Capitation taxes. 16. Taxes on entertainments and amusements to the extent levied and collected by a panchayat or a municipality or a regional council or a district council. 17. Stamp duty on documents, except those specified in the union list. And 18. Fees on the matters enumerated in the state list, except court fees. ESI distribution of non-tax revenues. A. The center. The receipts from the following form the major sources of non-tax revenues of the center. I. Posts and telegraphs. 2. Railways. 3. Banking. 4. Broadcasting v. Coinage and currency. 6. Central public sector enterprises. 7. Escheat and lapse. And 8. Others. Center-state relations 155. B. The states. The receipts from the following form the major sources of non-tax revenues of the states. I. Irrigation. 2. Forests. 3. Fisheries. 4. State public sector enterprises. V. Escheat and lapse. And 6. Others. Q. Grants and aid to the states. Besides sharing of taxes between the center and the states, the Constitution provides for grants and aid to the states from the central resources. There are two types of grants and aid, viz., statutory grants and discretionary grants. A. Statutory grants. Article 275 empowers the Parliament to make grants to the states which are in need of financial assistance and not to every state. Also, different sums may be fixed for different states. These sums are charged on the Consolidated Fund of India every year. Apart from this general provision, the Constitution also provides for specific grants for promoting the welfare of the scheduled tribes in a state or for raising the level of administration of the scheduled areas in a state, including the state of Assam. The statutory grants under Article 275, both general and specific, are given to the states on the recommendation of the Finance Commission. B. Discretionary grants. Article 282 empowers both the center and the states to make any grants for any public purpose, even if it is not within their respective legislative competence. Under this provision, the center makes grants to the states. These grants are also known as discretionary grants, the reason being that the center is under no obligation to give these grants and the matter lies within its discretion. These grants have a twofold purpose: to help the state financially to fulfill planned targets, and to give some leverage to the center to influence and coordinate state action to effectuate the national plan. 15. MP Jain, Indian Constitutional Law, Wadhwa, 4th edition, pp. 342-43. C. Other grants. The Constitution also provided for a third type of grants and aid, but for a temporary period. Thus, a provision was made for grants in lieu of export duties on jute and jute products to the states of Assam, Bihar, Orissa, and West Bengal. These grants were to be given for a period of 10 years from the commencement of the Constitution. These sums were charged on the Consolidated Fund of India and were made to the states on the recommendation of the Finance Commission. 31. Goods and Services Tax Council. The smooth and efficient administration of the Goods and Services Tax, GST, requires a cooperation and coordination between the center and the states. In order to facilitate this consultation process, the 101st Amendment Act of 2016 provided for the establishment of a Goods and Services Tax Council, or the GST Council. Article 279, A, empowered the President to constitute a GST Council by an Order 16. The Council is a joint forum of the center and the states. It is required to make recommendations to the center and the states on the following matters: A. The taxes, cesses, and surcharges levied by the center, the states, and the local bodies that would get merged in GST. B. The goods and services that may be subjected to GST or exempted from GST. C. Model GST laws, principles of levy, apportionment of GST levied on supplies in the course of interstate trade or commerce, and the principles that govern the place of supply. D. The threshold limit of turnover below which goods and services may be exempted from GST. LB Article 279, A. L. says that the President shall, within 60 days from the commencement of the Constitution, 101st Amendment, Act, 2016, by order, constitute a council to be called the Goods and Services T-Checks Council. 155. Indian Polity. C. The rates including floor rates with bands of GST. F. Any special rate or rates for a specified period to raise additional resources during any natural calamity or disaster. BL Finance Commission. Article 280 provides for a Finance Commission as a quasi-judicial body. It is constituted by the President every 5th year or even earlier. It is required to make recommendations to the President on the following matters: the distribution of the net proceeds of taxes to be shared between the center and the states, and the allocation between the states, the respective shares of such proceeds. The principles which should govern the grants and aid to the states by the CENTI, i.e., out of the Consolidated Fund of India. The measures needed to augment the Consolidated Fund of a state to supplement the resources of the panchayats and the municipalities in the state on the basis of the recommendations made by the State Finance Commission. Any other matter referred to it by the President in the interests of sound finance. Till 1960, the Commission also suggested the amounts paid to the states of Assam, Bihar, Orissa and West Bengal in lieu of assignment of any share of the net proceeds in each year of export duty on jute and jute products. The Constitution envisages the Finance Commission as the balancing wheel of fiscal federalism in India. QI protection of the state's interest to protect the interest of states in the financial matters. The Constitution lays down that the following bills can be introduced in the 17. This function was added by the 73rd and 74th Amendment Acts of 1992, which have granted constitutional status on the panchayats and the municipalities respectively. Parliament only on the recommendation of the President, a bill which imposes or varies any tax or duty in which states are interested. A bill which varies the meaning of the expression agricultural income as defined for the purposes of the enactments relating to Indian income tax. A bill which affects the principles on which monies are or may be distributable to states. And a bill which imposes any surcharge on any specified tax or duty for the purpose of the center. The expression tax or duty in which states are interested means a tax or duty the whole or part of the net proceeds whereof are assigned to any state, or b. a tax or duty by reference to the net proceeds whereof sums are for the time being payable out of the Consolidated Fund of India to any state. The phrase net proceeds means the proceeds of a tax or a duty minus the cost of collection. The net proceeds of a tax or a duty in any area is to be ascertained and certified by the Comptroller and Auditor General of India. Issue certificate is final. Q. Borrowing by the center and the states. The Constitution makes the following provisions with regard to the borrowing powers of the center and the states. The central government can borrow either within India or outside upon the security of Consolidated Fund of India or can give guarantees, but both within the limits fixed by the Parliament. So far, no such law has been enacted by the Parliament. Similarly, a state government can borrow within India and not abroad, upon the security of the Consolidated Fund of the state or can give guarantees, but both within the limits fixed by the legislature of that state. The central government can make loans to any state or give guarantees in Center-State Relations 157. Respect of loans raised by any state. Any sums required for the purpose of making such loans are to be charged on the Consolidated Fund of India. A state cannot raise any loan without the consent of the center if there is still outstanding any part of a loan made to the state by the center or in respect of which a guarantee has been given by the center. Intergovernmental tax immunities. Like any other federal constitution, the Indian Constitution also contained the rule of immunity from mutual taxation and makes the following provisions in this regard. A. Exemption of central property from state taxation. The property of center is exempted from all taxes imposed by a state or any authority within a state like municipalities, district boards, panchayats, and so on. But the Parliament is empowered to remove this ban. The word property includes lands, buildings, chattels, shares, debts, everything that has a money value, and every kind of property, movable or immovable and tangible or intangible. Further, the property may be used for sovereign, like armed forces, or commercial purposes. The corporations or the companies created by the central government are not immune from state taxation or local taxation. The reason is that a corporation or a company is a separate legal entity. B. Exemption of state property or income from central taxation. The property and income of a state is exempted from central taxation. Such income may be derived from sovereign functions or commercial functions. But the center can tax the commercial operations of a state if Parliament so provides. However, the Parliament can declare any particular trade or business as incidental to the ordinary functions of the government, and it would then not be taxable. Notably, the property and income of local authorities situated within a state are not exempted from the central taxation. Similarly, the property or income of corporations and companies owned by a state can be taxed by the center. The Supreme Court, in an advisory opinion 18/1963, held that the immunity granted to a state in respect of central taxation does not extend to the duties of customs or duties of excise. In other words, the center can impose customs duty on goods imported or exported by a state, or an excise duty on goods produced or manufactured by a state. 18 inches re. See Customs Act, 1963. Effects of emergencies. The center-state financial relations in normal times, described above, undergo changes during emergencies. These are as follows. A. National emergency. While the proclamation of national emergency under Article 352 is in operation, the President can modify the constitutional distribution of revenues between the center and the states. This means that the President can either reduce or cancel the transfer of finances, both tax sharing and grants and aid, from the center to the states. Such modification continues till the end of the financial year in which the emergency ceases to operate. B. Financial emergency. While the proclamation of financial emergency under Article 360 is in operation, the center can give directions to the states. I. To observe the specified canons of financial propriety. 2. To reduce the salaries and allowances of all class of persons serving in the state. And 3. To reserve all money bills and other financial bills for the consideration of the President. Trends in center-state relations. Till 1967, the center-state relations by and large were smooth due to one-party rule. 10. 158 Indian Polity. At the center and in most of the states. In 1967 elections, the Congress Party was defeated in 9 states and its position at the center became weak. This changed political scenario heralded a new era in the center-state relations. The non-Congress governments in the states opposed the increasing centralization and intervention of the central government. They raised the issue of state autonomy and demanded more powers and financial resources to the states. This caused tensions and conflicts in center-state relations. Tension areas in center-state relations. The issues which created tensions and conflicts between the center and states are 1. Mode of appointment and dismissal of governor. 2. Discriminatory and partisan role of governors. 3. Imposition of president's rule for partisan interests. 4. Deployment of central forces in the states to maintain law and order. 5. Reservation of state bills for the consideration of the president. 6. Discrimination in financial allocations to the states. 7. Role of Planning Commission in approving state projects, till its replacement by the needy AIOG in 2015. 8. Management of all one-dia services, IS, IPS, and IFOS. 9. Use of electronic media for political purposes. 10. Appointment of inquiry commissions against the chief ministers. 11. Sharing of finances between center and states. 12. Encroachment by the center on the state list. 13. Implementation of the centrally sponsored schemes by the states. And 14. Modus operandi of the central agencies like CBI, ED, and so on. The issues in center-state relations have been under consideration since the mid-1960s. In this direction, the following developments have taken place. Administrative Reforms Commission. The central government appointed a 6-member First Administrative Reforms Commission, ARC, of India in 1966 under the chairmanship of Morarji Desai, followed by K. Hanumanthaya. Its terms of references included, among others, the examination of center-state relations. In order to examine thoroughly the various issues in center-state relations, the ARC constituted a study team under MC Setlavat. On the basis of the report of this study team, the ARC finalized its own report and submitted it to the central government in 1969. It made 22 recommendations for improving the center-state relations. The important recommendations are establishment of an interstate council under Article 263 of the Constitution, appointment of persons having long experience in public life and administration and nonpartisan attitude as governors, delegation of powers to the maximum extent to the states, transferring of more financial resources to the states to reduce their dependency upon the center, deployment of central armed forces in the states either on their request or otherwise. No action was taken by the central government on the recommendations of the ARC. Rajamandar Committee in 1969, the Tamil Nadu government, DMK, appointed a 3-member committee under the chairmanship of Dr. P.V. Rajamandar to examine the entire question of center-state relations and to suggest amendments to the Constitution so as to secure utmost autonomy to the states. 19. The committee submitted its report to the Tamil Nadu government in 1971. 19. The other 2 members of the committee were Dr. Laxmikanth Mudliyar and P.C. Chandra Reddy. The committee identified the reasons for the prevailing unitary trends, tendencies of centralization in the country. They include certain provisions in the Constitution which confer special powers on the center. 2. One-party rule both at the center and in the states. 3. Inadequacy of states' fiscal resources and consequent dependence on the center for financial assistance. And 4. The institution of central planning and the role of the Planning Commission. The important recommendations of the committee are as follows. An interstate council should be set up immediately. 2. Finance Commission should be made a permanent body. 3. Planning Commission should be disbanded and its place should be taken by a statutory body. 4. Articles 356, 357, and 365, dealing with President's rule, should be totally omitted. The provision that the state ministry holds office during the pleasure of the governor should be omitted. 6. Certain subjects of the Union list and the concurrent list should be transferred to the state list. 7. The residuary powers should be allocated to the states. And 8. All India services, IS, IPS, and IFOS, should be abolished. The central government completely ignored the recommendations of the Rajamandar Committee. Anandpur Sahib Resolution in 1973, the Akali Dal adopted a resolution containing both political and religious demands in a meeting held at Anandpur Sahib in Punjab. The resolution, generally known as Anandpur Sahib Resolution, demanded that the center's jurisdiction should be restricted only to defense, foreign affairs, communications, and currency, and the entire residuary powers should be vested in the states. It stated that the Constitution should be made federal in the real sense and should ensure equal authority and representation to all the states at the center. Center-State Relations 159. West Bengal Memorandum in 1977, the West Bengal government, led by the Communists, published a memorandum on center-state relations and sent it to the central government. The memorandum inter alia suggested the following. The word union in the Constitution should be replaced by the word federal. 2. The jurisdiction of the center should be confined to defense, foreign affairs, currency, communications, and economic coordination. 3. All other subjects including the residuary should be vested in the states. 4. Articles 356 and 357, President's Rule, and 360, Financial Emergency, should be repealed. V. States' consent should be made obligatory for formation of new states or reorganization of existing states. 6. Of the total revenue raised by the center from all sources, 75% should be allocated to the states. 7. Rajya Sabha should have equal powers with that of the Lok Sabha. And 8. There should be only central and state services, and the All India services should be abolished. The central government did not accept the demands made in the memorandum. Sarkaria Commission. In 1983, the central government appointed a 3-member commission on center-state relations under the chairmanship of R.S. Sarkaria, a retired judge of the Supreme Court. 2011, the commission was asked to examine and review the working of existing arrangements between the center and states in all spheres and recommend appropriate changes and measures. It submitted its report in 1988. 20b. Sivaraman and Esarson were 2 other members of the commission. The commission did not favor structural changes and regarded the existing constitutional arrangements and principles relating to the institutions basically sound. But it emphasized on the need for changes in the functional or operational aspects. It observed that federalism is more a functional 160, or Indian Polity, arrangement for cooperative action than a static institutional concept. It outrightly rejected the demand for curtailing the powers of the center and stated that a strong center is essential to safeguard the national unity and integrity, which is being threatened by the vociferous tendencies in the body politic. However, it did not equate strong center with centralization of powers. It observed that over-centralization leads to blood pressure at the center and anemia at the periphery. The Commission made 247 recommendations to improve center-state relations. The important recommendations are mentioned below. 1. A permanent interstate council called the Intergovernmental Council should be set up under Article 263. 2. Article 356, President's Rule, should be used very sparingly, in extreme cases as a last resort when all the available alternatives fail. 3. The institution of All India services should be further strengthened and more of such services should be created. 4. The residuary powers of taxation should continue to remain with the Parliament, while the other residuary powers should be placed in the concurrent list. 5. When the President withholds his assent to the state bills, the reasons should be communicated to the state government. 6. The National Development Council, NDC, should be renamed and reconstituted as the National Economic and Development Council, NEDC. 7. The zonal councils should be constituted afresh and reactivated to promote the spirit of federalism. 8. The center should have powers to deploy its armed forces, even without the consent of states. However, it is desirable that the states should be consulted. G. The center should consult the states before making a law on a subject of the concurrent list. 10. The procedure of consulting the chief minister in the appointment of the state governor should be prescribed in the Constitution itself. 11. The net proceeds of the corporation tax may be made permissibly shareable with the states. 12. The governor cannot dismiss the Council of Ministers so long as it commands a majority in the Assembly. 13. The governor's term of 5 years in a state should not be disturbed except for some extremely compelling reasons. 14. No commission of inquiry should be set up against a state minister unless a demand is made by the Parliament. 15. The surcharge on income tax should not be levied by the center except for a specific purpose and for a strictly limited period. 16. The present division of functions between the Finance Commission and the Planning Commission is reasonable and should continue. 17. Steps should be taken to uniformly implement the 3-language formula in its true spirit. 18. No autonomy for radio and television, but decentralization in their operations. 19. No change in the role of Rajya Sabha and center's power to reorganize the states. 20. The Commissioner for Linguistic Minorities should be activated. The central government has implemented 180 out of 247 recommendations of the Sarkaria Commission. The most important is the establishment of the Interstate Council in 1990. Punchy Commission. The second Commission on Center-State Relations was set up by the Government of India in 2007 under the chairmanship of Madan Mohan Punchy, former Chief Justice of India. 21. It was required to look into the 2I. The other 4 members of the Commission were Dhirendra Singh, former Secretary to the Government of India, Vinod Kumar Digol, former Secretary to the Government of India, Prof. N.R. Center-State Relations J. 4161. Issues of center-state relations keeping in view the sea changes that have taken place in the polity and economy of India since the Sarkaria Commission had last looked at the issue of center-state relations over 2 decades ago. The Commission submitted its report to the government in 2010. In finalizing the 1,456-page report in 7 volumes, the Commission took extensive help from the Sarkaria Commission report, the National Commission to Review the Working of the Constitution, NCRWC, report, and the Second Administrative Reforms Commission report. However, in a number of areas, the Commission report differed from the Sarkaria Commission recommendations. After examining at length the issues raised in its terms of reference and the related aspects in all their hues and shades, the Commission came to the conclusion that cooperative federalism will be the key for sustaining India's unity. integrity in social and economic development in future. The principles of cooperative federalism thus may have to act as a practical guide for Indian polity and governance. In all, the Commission made over 310 recommendations, touching upon several significant areas in the working of center-state relations. The important recommendations are mentioned below. 1. LB facilitate effective implementation of the laws on list 3 subjects. It is necessary that some broad agreement is reached between the Union and states before introducing legislation in Parliament on matters in the concurrent list. 2. The Union should be extremely restrained in asserting parliamentary supremacy in matters assigned to the states. Greater flexibility to states in relation to subjects in the state list and transferred items in the concurrent list is the key for better center-state relations. 3. The Union should occupy only that many of subjects in concurrent or overlapping jurisdiction which are absolutely necessary to achieve uniformity of policy and demonstrable national interest. 4. There should be a continuing auditing role for the Interstate Council in the management of matters in concurrent or overlapping jurisdiction. 5. The period of 6 months prescribed in Article 201 for state legislature to act when the bill is returned by the President can be made applicable for the President also to decide on assenting or withholding assent to a state bill reserved for consideration of the President. 6. Parliament should make a law on the subject of Entry 14 of List I, treaty making and implementing it through parliamentary legislation, to streamline the procedures involved. The exercise of the power obviously cannot be absolute or unchartered in view of the federal structure of legislative and executive powers. 7. Financial obligations and its implications on state finances arising out of treaties and agreements should be a permanent term of reference to the finance commissions constituted from time to time. 8. While selecting governors, the central government should adopt the following strict guidelines as recommended in the Sarkaria Commission report and follow its mandate in letter and spirit. I. Husha should be imminent in some walk of life. 2. Husha should be a person from outside the state. 3. Husha should be a detached figure and not too intimately connected with the local politics of the state. 4. Husha should be a person who has not taken too great a part in Madhava Menon, former director, National Judicial Academy, Bhopal and National Law School of India, Bangalore, and Dr. Amaresh Bagchi, Emeritus Professor, National Institute of Public Finance and Policy, New Delhi. With a Pasingaway of Dr. Bagchi in February 2008, Vijay Shankar, former director, Central Bureau of Investigation, Government of India, was appointed in his place as a member of the Commission in October 2008. $162 Indian Polity. Politics generally and particularly in the recent past 9. Governors should be given a fixed tenure of 5 years and their removal should not be at the sweet will of the government at the center. 10. The procedure laid down for impeachment of president, mutatis mutandis, can be made applicable for impeachment of governors as well. 11. Article 163 does not give the governor a general discretionary power to act against or without the advice of Hisho Council of Ministers. In fact, the area for the exercise of discretion is limited, and even in this limited area, Hisho choice of action should not be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. 12. In respect of bills passed by the Legislative Assembly of a state, the governor should take the decision within 6 months whether to grant assent or to reserve it for consideration of the President. 13. On the question of governor's role and appointment of chief minister in the case of an hung assembly, it is necessary to lay down certain clear guidelines to be followed as constitutional conventions. These guidelines may be as follows. I. The party or combination of parties which commands the widest support in the Legislative Assembly should be called upon to form the government. 2. If there is a pre-poll alliance or coalition, it should be treated as one political party, and if such coalition obtains a majority, the leader of such coalition shall be called by the governor to form the government. 3. In case no party or pre-poll coalition has a clear majority, the governor should select the chief minister in the order of preference indicated here. A. The group of parties which had pre-poll alliance commanding the largest number. B. The largest single party staking a claim to form the government with the support of others. C. A post-electoral coalition with all partners joining the government. D. A post-electoral alliance with some parties joining the government and the remaining including independents supporting the government from outside. 14. On the question of dismissal of a chief minister, the governor should invariably insist on the chief minister proving Hisho majority on the floor of the House, for which Hisho should prescribe a time limit. 15. The governor should have the right to sanction for prosecution of a state minister against the advice of the Council of Ministers, if cabinet decision appears to the governor to be motivated by bias in the face of overwhelming material. 16. The convention of governors acting as chancellors of universities and holding other statutory positions should be done away with. Hisho role should be confined to the constitutional provisions only. 17. When an external aggression or internal disturbance paralyses the state administration, creating a situation of a potential breakdown of the constitutional machinery of the state, all alternative courses available to the Union for discharging its paramount responsibility under Article 355 should be exhausted to contain the situation, and the exercise of the power under Article 356 should be limited, strictly to rectifying a failure of the constitutional machinery in the state. 18. On the question of invoking Article 356 in case of failure of constitutional machinery in states, suitable amendments are required to incorporate the guidelines set forth in the landmark judgment Center-State Relations 163 of the Supreme Court in S.R. Baumai Case 22, 1994. This would remove possible misgivings in this regard on the part of states and help in smoothing center-state relations. 22S.R. Baumai v. Union of India, 1994. 19. Given the strict parameters now set for invoking the emergency provisions under Articles 352 and 356 to be used only as a measure of last resort, and the duty of the Union to protect states under Article 355, it is necessary to provide a constitutional or legal framework to deal with situations which require central intervention but do not warrant invoking the extreme steps under Articles 352 and 356. Providing the framework for localized emergency would ensure that the state government can continue to function and the assembly would not have to be dissolved while providing a mechanism to let the central government respond to the issue specifically and locally. The imposition of local emergency is fully justified under the mandate of Article 355 read with Entry 2A of List I and Entry 1 of List 2 of the 7th Schedule. 20. Suitable amendments to Article 263 are required to make the Interstate Council a credible, powerful, and fair mechanism for management of interstate and center-state differences. 21. The zonal councils should meet at least twice a year with an agenda proposed by states concerned to maximize coordination and promote harmonization of policies and action having interstate ramification. The Secretariat of a strengthened interstate council can function as the Secretariat of the zonal councils as well. 22. The Empowered Committee of Finance Ministers of States proved to be a successful experiment in interstate coordination on fiscal matters. There is need to institutionalize similar models in other sectors as well. A forum of chief ministers, chaired by one of the chief minister by rotation, can be similarly thought about particularly to coordinate policies of sectors like energy, food, education, environment, and health. 23. New All India services in sectors like health, education, engineering, and judiciary should be created. 24. Factors inhibiting the composition and functioning of the Second Chamber as a representative forum of states should be removed or modified even if it requires amendment of the constitutional provisions. In fact, Rajya Sabha offers immense potential to negotiate acceptable solutions to the friction points which emerge between center and states in fiscal, legislative, and administrative relations. 25. A balance of power between states inter-SE is desirable, and this is possible by equality of representation in the Rajya Sabha. This requires amendment of the relevant provisions to give equality of seats to states in the Rajya Sabha, irrespective of their population size. 26. The scope of devolution of powers to local bodies to act as institutions of self-government should be constitutionally defined through appropriate amendments. 27. All future central legislations involving states' involvement should provide for cost sharing as in the case of the RT Act. Existing central legislations where the states are entrusted with the responsibility of implementation should be suitably amended providing for sharing of cost by the central government. 28. The royalty rates on major minerals should be revised at least every 3 years without any delay. States should be properly compensated for any delay in the revision of royalty beyond 3 years. 29. The current ceiling on profession tax should be completely done away with by a constitutional amendment. 30. The scope for raising more revenue from the taxes mentioned in Article 268 should be examined afresh. This issue may 164J Indian Polity be either referred to the next Finance Commission or an expert committee be appointed to look into the matter. 31. LB bring greater accountability. All fiscal legislation should provide for an annual assessment by an independent body, and the reports of these bodies should be laid in both houses of Parliament state legislature. 32. Consideration specified in the TBRMS of reference tour of the Finance Commission should be even-handed as between the center and the states. There should be an effective mechanism to involve the states in the finalization of the TBR of the Finance Commissions. 33. The central government should review all the existing cesses and surcharges with a view to bringing down their share in the gross tax revenue. 34. Because of the close linkages between the plan and non-plan expenditure, an expert committee may be appointed to look into the issue of distinction between the plan and non-plan expenditure. 35. There should be much better coordination between the Finance Commission and the Planning Commission. The synchronization of the periods covered by the Finance Commission and the 5-year plan will considerably improve such coordination. 36. The Finance Commission division in the Ministry of Finance should be converted into a full-fledged department, serving as the permanent secretariat for the Finance Commissions. 37. The Planning Commission has a crucial role in the current situation, but its role should be that of coordination rather than of micromanaging sectoral plans of the central ministries and the states. 38. Steps should be taken for the setting up of an interstate trade and commerce commission under Article 307 read with Entry 42 of List 1. This commission should be vested with both advisory and executive roles with decision-making powers. As a constitutional body, the decisions of the commission should be final and binding on all states as well as the Union of India. Any party aggrieved with the decision of the Commission may prefer an appeal to the Supreme Court. The recommendations contained in the report of the Punchy Commission have been considered by the Standing Committee of the Interstate Council in its meetings held in 2017 and 2018. The recommendations of the Commission along with the recommendations of the Standing Committee thereon have been circulated to the state governments for comments. 23. Annual Report 2021-22, Ministry of Home Affairs, Government of India, p. 246. Table 15.1 Articles related to interstate legislative relations at a glance. Article No. Subject Matter. 245. Extent of laws made by Parliament and by the legislatures of states. 246. Subject matter of laws made by Parliament and by the legislatures of states. 246a. Special provision with respect to goods and services tax. 247. Power of Parliament to provide for the establishment of certain additional courts. 248. Residuary powers of legislation underscore 249. Power of Parliament to legislate with respect to a matter in the state list in the national interest. 250. Power of Parliament to legislate with respect to any matter in the state list if a proclamation of emergency is in operation. Interstate Relations 165. Article No. Subject Matter. 251. Inconsistency between laws made by Parliament under Articles 249 and 250 and laws made by the legislatures of states. 252. Power of Parliament to legislate for two or more states by consent and adoption of such legislation by any other state. 253. Legislation for giving effect to international agreements. 254. Inconsistency between laws made by Parliament and laws made by the legislatures of states. 255. Requirements as to recommendations and previous sanctions to be regarded as matters of procedure only. Table 15.2 Articles related to interstate administrative relations at a glance. Article No. Subject Matter. 256. Obligation of states in the Union. 257. Control of the Union over states in certain cases. 257a. Assistance to states by deployment of armed forces or other forces of the Union, repealed. 258. Power of the Union to confer powers, etc. on states in certain cases. 258a. Power of the states to entrust functions to the Union. 259. Armed forces in states in Part B of the First Schedule, repealed. 260. Jurisdiction of the Union in relation to territories outside India. 261. Public acts, records, and judicial proceedings. 262. Adjudication of disputes relating to waters of interstate rivers or river valleys. 263. Provisions with respect to an interstate council. Table 15.3 Articles related to interstate financial relations at a glance. Article No. Subject Matter. Distribution of revenues between the Union and the states. 268. Duties levied by the Union but collected and appropriated by the states. 268a. Service tax levied by the Union and collected and appropriated by the Union and the states, repealed. 269. Taxes levied and collected by the Union but assigned to the states. 269a. Levy and collection of goods and services tax in course of interstate trade or commerce. 270. Taxes levied and distributed between the Union and the states. 271. Surcharge on certain duties and taxes for purposes of the Union. 272. Taxes which are levied and collected by the Union and may be distributed between the Union and the states, repeated. 273. Grants in lieu of export duty on jute and jute products. 274. Prior recommendation of the President required to bills affecting taxation in which states are interested. 275. Grants from the Union to certain states. Continued. 166. 1 Article No. Subject Matter. 276. Taxes on professions, trades, callings, and employments. 277. Savings. 278. Agreement with states in Part 8 of the First Schedule with regard to certain financial matters, repealed. 279. Calculation of net proceeds, etc. 279a. Goods and Services Tax Council. 280. Finance Commission. 281. Recommendations of the Finance Commission. Miscellaneous financial provisions. 282. Expenditure defrayable by the Union or a state out of its revenues. 283. Custody, etc. of consolidated funds, contingency funds, and monies credited to the public accounts. 284. Custody of suitors' deposits and other monies received by public servants in courts. 285. Exemption of property of the Union from state taxation. 286. Restrictions as to imposition of tax on the sale or purchase of goods. 287. Exemption from taxes on electricity. 288. Exemption from taxation by states in respect of water or electricity in certain cases. 289. Exemption of property and income of a state from union taxation. 290. Adjustment in respect of certain expenses and pensions. 290A. Annual payment to certain devaswum funds. 291. Privy purse sums of rulers repealed. Borrowing. 292. Borrowing by the Government of India. 293. Borrowing by states Chapter 816 Interstate Relations. The successful functioning of the Indian federal system depends not only on the harmonious relations and close cooperation between the center and the states, but also between the states inter se. Hence, the Constitution makes the following provisions with regard to interstate comity. 1. Adjudication of interstate water disputes. 2. Coordination through interstate councils. 3. Mutual recognition of public acts, records, and judicial proceedings. 4. Freedom of interstate trade, commerce, and intercourse. In addition, the zonal councils have been established by the Parliament to promote interstate cooperation and coordination. 1. Interstate water disputes. Article 262 of the Constitution provides for the adjudication of interstate water disputes. It makes two provisions. Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution, and control of waters of any interstate river and river valley. 2. Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect of any such dispute or complaint. Under this provision, the Parliament has enacted two laws, the River Boards Act, 1956, and the Interstate River Water Disputes Act, 1956. The River Boards Act provides for the establishment of river boards for the regulation. States Reorganization Act, 1956, and development of interstate river and river valleys. A river board is established by the central government on the request of the state governments concerned to advise them. The Interstate River Water Disputes Act empowers the central government to set up an ad hoc tribunal for the adjudication of a dispute between two or more states in relation to the waters of an interstate river or river valley. The decision of the tribunal would be final and binding on the parties to the dispute. Neither the Supreme Court nor any other court is to have jurisdiction in respect of any water dispute which may be referred to such a tribunal under this act. So far, the central government has set up several interstate water dispute tribunals. The name of the tribunals, the years in which they were constituted, and the states involved in the dispute are mentioned in PLE 16.1. F. Interstate Councils. Article 263 contemplates the establishment of an interstate council to effect coordination between the states and between center and states. Thus, the President can establish such a council if at any time it appears to her that the public interest would be served by its establishment. Pusha can define the nature of duties to be performed by such a council and its organization and procedure. Even though the President is empowered to define the duties of an interstate council, 168 Indian Polity. Table 16.1 Interstate Water Dispute Tribunals set up so far. SI. No. Name set up in states involved 1. Krishna Water Disputes Tribunal, 1969 Maharashtra, Karnataka, and Andhra Pradesh 2. Godavari Water Disputes Tribunal 1969 Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh, and Odisha. 3. Narmada Water Disputes Tribunal 1969 Rajasthan, Gujarat, Madhya Pradesh, and Maharashtra 4. Ravi and Bias Water Disputes Tribunal 1986 Punjab, Haryana, and Rajasthan 5. Kaveri Water Disputes Tribunal 1990 Karnataka, Kerala, Tamil Nadu, and Puducherry 6. Krishna Water Disputes Tribunal LL 2004 Maharashtra, Karnataka, and Andhra Pradesh 7. Vansadhara Water Disputes Tribunal 2010 Odisha and Andhra Pradesh 8. Mamadei Water Disputes Tribunal 2010 Goa, Karnataka, and Maharashtra 9. Mahanadi Water Disputes Tribunal 2018 Odisha and Chhattisgarh. Article 263 specifies the duties that can be assigned to it in the following manner. A. Inquiring into and advising upon disputes which may arise between states. B. Investigating and discussing subjects in which the states or the center and the states have a common interest. And C. Making recommendations upon any such subject, and particularly for the better coordination of policy and action on it. The Council's function to inquire and advise upon interstate disputes is complementary to the Supreme Court's jurisdiction under Article 131 to decide a legal controversy between the governments. The Council can deal with any controversy whether legal or non-legal, but its function is advisory unlike that of the Court which gives a binding decision. 23. ZM. P. Jain, Indian Constitutional Law, Wadhwa, 4th edition, p. 382. 3. It was originally known as the Central Council of Local Self-Government, 1954. For the Central Council of Indian Medicine and the Central Council of Homeopathy were set up under the Acts of Parliament. 5. The Interstate Council Order dated May 28, 1990. Under the above provisions of Article 263, the President has established the following councils to make recommendations for the better coordination of policy and action in the related subjects. Central Council of Health and Family Welfare. Central Council of Local Government 1. For regional councils for sales tax for the northern, eastern, western, and southern zones. 45. Establishment of Interstate Council. The Sarkaria Commission on Center-State Relations, 1983-88, made a strong case for the establishment of a permanent interstate council under Article 263 of the Constitution. It recommended that in order to differentiate the interstate council from other bodies established under the same Article 263, it must be called as the Intergovernmental Council. The Commission recommended that the council should be charged with the duties laid down in clauses B and C of Article 263, see above. In pursuance of the above recommendations of the Sarkaria Commission, the Janata Dal government headed by V.P. Singh established the Interstate Council in 1990. It consists of the following members: I. Prime Minister as the chairman, 2. Chief Ministers of all the states, 3. Chief Ministers of Union Territories having legislative assemblies, 4. Administrators of Union Territories not having legislative assemblies, v. Governors of states under President's Rule 6. 6 Central Cabinet Ministers, including the Home Minister, to be nominated by the Prime Minister. 5 Ministers of Cabinet rank Minister of State, independent charge, nominated by the Chairman of the Council, i.e., Prime Minister, are permanent invitees to the Council. The Council is a recommendatory body on issues relating to interstate, center-state, and center-union territories relations. It aims at promoting coordination between them by examining, discussing, and deliberating on such issues. Its duties, in detail, are as follows: investigating and discussing such subjects in which the states or the center have a common interest, making recommendations upon any such subject for the better coordination of policy and action on it, and deliberating upon such other matters of general interest to the states as may be referred to it by the chairman. The Council may meet at least thrice in a year. Its meetings are held in camera and all questions are decided by consensus. There is also a standing committee of the Council. It was set up in 1996 for continuous consultation and processing of matters for the consideration of the Council. It consists of the following members: I. Union Home Minister as the chairman, 2. 5 Union Cabinet Ministers, 3. 9 Chief Ministers. The Council is assisted by a secretariat called the Interstate Council Secretariat. This secretariat was set up in 1991 and is headed by a secretary to the Government of India. Since 2011, it is also functioning as the secretariat of the zonal councils. Public acts, records, and judicial proceedings. Under the Constitution, the jurisdiction of each state is confined to its own territory. Hence, it is possible that the acts and records of one state may not be recognized in another state. Lb. Remove any such difficulty, the Constitution contains the full faith and credit clause which lays down the following. I. Full faith and credit is to be given throughout the territory of India to public acts, records, and judicial proceedings of the center in every state. The expression public acts includes both legislative and executive acts of the government. The expression public record includes any official book, register, or record made by a public servant in the discharge of his official duties. 2. The manner in which and the conditions under which such acts, records, and proceedings are to be proved and their effect determined would be as provided by the laws of Parliament. This means that the general rule mentioned above is subject to the power of Parliament to lay down the mode of proof as well as the effect of such acts, records, and proceedings of one state in another state. 3. Final judgments and orders of civil courts in any part of India are capable of execution anywhere within India, without the necessity of a fresh suit upon the judgment. The rule applies only to civil judgments and not to criminal judgments. In other words, it does not require the courts of a state to enforce the penal laws of another state. T. Interstate Trade, L. and Commerce. Articles 301 to 307 and Part 13 of the Constitution deal with the trade, commerce, and intercourse within the territory of India. Article 301 declares that trade, commerce, and intercourse throughout the territory of India shall be free. The object of this provision is to break down the border barriers between the states and to create one unit with a view to encourage the free flow of trade, commerce, and intercourse in the country. The freedom under this provision is not 170 or Indian polity, confined to interstate trade, commerce, and intercourse, but also extends to interstate trade, commerce, and intercourse. Thus, Article 301 will be violated whether restrictions are imposed at the frontier of any state or at any prior or subsequent stage. The freedom guaranteed by Article 301 is a freedom from all restrictions, except those which are provided for in the other provisions, Articles 302 to 305, of Part 13 of the Constitution itself. These are explained below. I. Parliament can impose restrictions on the freedom of trade, commerce, and intercourse between the states or within a state in public interest. But the Parliament cannot give preference to one state over another or discriminate between the states except in the case of scarcity of goods in any part of India. 2. The legislature of a state can impose reasonable restrictions on the freedom of trade, commerce, and intercourse with that state or within that state in public interest. But a bill for this purpose can be introduced in the legislature only with the previous sanction of the President. Further, the state legislature cannot give preference to one state over another or discriminate between the states. 3. The legislature of a state can impose on goods imported from other states or the Union territories any tax to which similar goods manufactured in that state are subject. This provision prohibits the imposition of discriminatory taxes by the state. 4. The freedom, under Article 301, is subject to the nationalization laws, i.e., laws providing for monopolies in favor. 6. For example, the Parliament has made the Essential Commodities Act, 1955. This act enables the central government to control the production, supply, and distribution of certain essential commodities like petroleum, coal, iron, and steel, and so on, of the center or the states. Thus, the Parliament or the state legislature can make laws for the carrying on by the respective government of any trade, business, industry, or service, whether to the exclusion, complete or partial, of citizens or otherwise. The Parliament can appoint an appropriate authority for carrying out the purposes of the above provisions relating to the freedom of trade, commerce, and intercourse and restrictions on it. The Parliament can also confer on that authority the necessary powers and duties. But no such authority has been appointed so far. Zonal councils. The zonal councils are the statutory, and not the constitutional, bodies. They are established by an act of the Parliament, that is, States Reorganization Act of 1956. The act divided the country into 5 zones: northern, central, eastern, western, and southern, and provided a zonal council for each zone. While forming these zones, several factors have been taken into account, which include the natural divisions of the country, the river systems and means of communication, the cultural and linguistic affinity, and the requirements of economic development, security, and law and order. Each zonal council consists of the following members: A. Home Minister of Central Government, B. Chief Ministers of all the states in the zone, C. 2 other ministers from each state in the zone, D. Administrator of each Union territory in the zone. Besides, the following persons can be associated with the zonal council as advisors, i.e., without the right to vote in the meetings: I. A person nominated by the needy AIOC. 2. Chief Secretary of the government of each. In USA, such authority is known as the Interstate Commerce Commission. Interstate Relations 171. LB enable the center and states to cooperate with each other in social and economic matters and exchange ideas and experience in order to evolve uniform policies. LB cooperate with each other in the successful and speedy execution of major development projects. LB secure some kind of political equilibrium between different regions of the country. State in the zone. And 3. Development Commissioner of each state in the zone. The Home Minister of Central Government is the common chairman of the 5 zonal councils. Each chief minister acts as a vice chairman of the council by rotation, holding office for a period of 1 year at a time. The zonal councils aim at promoting cooperation and coordination between states, union territories, and the center. They discuss and make recommendations regarding matters like economic and social planning, linguistic minorities, border disputes, interstate transport, and so on. They are only deliberative and advisory bodies. The objectives or the functions of the zonal councils, in detail, are as follows: LB achieve an emotional integration of the country. LB help in arresting the growth of acute state consciousness, regionalism, linguism, and particularistic trends. LB help in removing the after effects of separation in some cases so that the process of reorganization, integration, and economic advancement may synchronize. Northeastern Council. In addition to the above zonal councils, a Northeastern Council was created by a separate Act of Parliament, the Northeastern Council Act of 1971.8. Its members include Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, Tripura, and Sikkim. 9. Its functions are similar to those of the zonal councils, but with few additions. It has to formulate a unified and coordinated regional plan covering matters of common importance. It has to review from time to time the measures taken by the member states for the maintenance of security and public order in the region. Table 16.2 Zonal Councils at a glance. Name members: Parliament Arc 1 Northern Zonal Council Himachal Pradesh, Haryana, Punjab, Rajasthan, Delhi. Chandigarh, Jammu, and Kashmir, and Ladakh, New Delhi. 2. Central Zonal Council Uttar Pradesh, Uttarakhand, Chhattisgarh, and Madhya Pradesh. Allahabad. 3. Eastern Zonal Council Bihar, Jharkhand, West Bengal, and Odisha. Kolkata. 4. Western Zonal Council Gujarat, Maharashtra, Goa, and Dadra and Nagar Haveli and Daman and Diu. Mumbai. 5. Southern Zonal Council Andhra Pradesh, Telangana, Karnataka, Tamil Nadu, Kerala. In Puducherry, Chennai. 9. It came into existence on August 8, 1972. In 2002, Sikkim was added as the 8th member of the Northeastern Council. $172 Indian Polity. Table 16.3 Articles related to interstate relations at a glance. Article No. Subject matter: mutual recognition of public acts, etc. 261. Public acts, records, and judicial proceedings. Disputes relating to waters. 262. Adjudication of disputes relating to waters of interstate rivers or river valleys. Coordination between states. 263. Provisions with respect to an interstate council. Interstate trade and commerce. 301. Freedom of trade, commerce and intercourse. 302. Power of Parliament to impose restrictions on trade, commerce and intercourse. 303. Restrictions on the legislative powers of the Union and of the states with regard to trade and commerce. 304. Restrictions on trade, commerce and intercourse among states. 305. Saving of existing laws and laws providing for state monopolies. 306. Power of certain states in Part B of the first schedule to impose restrictions on trade and commerce, repealed. 307. Appointment of authority for carrying out the purposes of Articles 301 to 304 Chapter Emergency Provisions. The emergency provisions are contained in Part 18 of the Constitution, from Articles 352 to 360. These provisions enable the central government to meet any abnormal situation effectively. The rationality behind the incorporation of these provisions in the Constitution is to safeguard the sovereignty, unity, integrity, and security of the country, the democratic political system, and the Constitution. During an emergency, the central government becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation of the political system from federal during normal times to unitary during emergency is a unique feature of the Indian Constitution. In this context, Dr. B.R. Ambedkar observed in the Constituent Assembly that 1 Constituent Assembly Debates, Volume 7, p. 34. 2. The phrase armed rebellion was inserted by the 44th Amendment Act of 1978, replacing the original phrase internal disturbance. All federal systems, including American, are placed in a tight mold of federalism. No matter what the circumstances, it cannot change its form and shape. It can never be unitary. On the other hand, the Constitution of India can be both unitary as well as federal according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system. But in times of emergency, it is so designed as to make it work as though it was a unitary system. The Constitution stipulates 3 types of emergencies. 1. An emergency due to war, external aggression, or armed rebellion, Article 352. This is popularly known as national emergency. However, the Constitution employs the expression proclamation of emergency to denote an emergency of this type. 2. An emergency due to the failure of the constitutional machinery in the states, Article 356. This is popularly known as President's Rule. It is also known by 2 other names, state emergency or constitutional emergency. However, the Constitution does not use the word emergency for this situation. 3. Financial emergency due to a threat to the financial stability or credit of India, Article 360. National emergency. Grounds of declaration. Under Article 352, the President can declare a national emergency when the security of India or a part of it is threatened by war or external aggression or armed rebellion. It may be noted that the President can declare a national emergency even before the actual occurrence of war or external aggression or armed rebellion, if HSA is satisfied that there is an imminent danger. 174W Indian Polity. The President can also issue different proclamations on grounds of war, external aggression, armed rebellion, or imminent danger thereof, whether or not there is a proclamation already issued by him/her and such proclamation is in operation. This provision was added by the 38th Amendment Act of 1975. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. On the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. A proclamation of national emergency may be applicable to the entire country or only a part of it. The 42nd Amendment Act of 1976 enabled the President to limit the operation of a national emergency to a specified part of India. Originally, the Constitution mentioned internal disturbance as the third ground for the proclamation of a national emergency, but the expression was too vague and had a wider connotation. Hence, the 44th Amendment Act of 1978 substituted the words armed rebellion for internal disturbance. Thus, it is no longer possible to declare a national emergency on the ground of internal disturbance, as was done in 1975 by the Congress government headed by Indira Gandhi. The President, however, can proclaim a national emergency only after receiving a written recommendation from the Cabinet. 3. This means that the emergency can be declared only on the concurrence of the Cabinet and not merely on the advice of the Prime Minister. In 1975, the then Prime Minister, Indira Gandhi, advised the President to proclaim emergency without consulting her Cabinet. The Cabinet was informed of the proclamation after it was made, as a fait accompli. The 44th Amendment Act of 1978 introduced the safeguard to eliminate any. For Minerva Mills vs. Union of India, 1980. Article 352 defines the term Cabinet as the council consisting of the Prime Minister and other ministers of the Cabinet rank. Possibility of the Prime Minister alone taking a decision in this regard. The 38th Amendment Act of 1975 made the declaration of a national emergency immune from the judicial review. But this provision was subsequently deleted by the 44th Amendment Act of 1978. Further, in the Minerva Mills Case 4, 1980, the Supreme Court held that the proclamation of a national emergency can be challenged in a court on the ground of malified or that the declaration was based on wholly extraneous and irrelevant facts or is absurd or perverse. Parliamentary approval and duration. The proclamation of emergency must be approved by both the Houses of Parliament within 1 month from the date of its issue. Originally, the period allowed for approval by the Parliament was 2 months, but was reduced by the 44th Amendment Act of 1978. However, if the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. If approved by both the Houses of Parliament, the emergency continues for 6 months and can be extended to an indefinite period with an approval of the Parliament for every 6 months. This provision for periodical parliamentary approval was also added by the 44th Amendment Act of 1978. Before that, the emergency, once approved by the Parliament, could remain in operation as long as the executive cabinet desired. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuance of emergency, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuation. Every resolution approving the proclamation of emergency or its continuance must be passed by either House of Parliament by a special majority, that is, a majority of the total membership of that House, and b, a majority of not less than 2/3 of the members of that House present and voting. This special majority provision was introduced by the 44th Amendment Act of 1978. Previously, such resolution could be passed by a simple majority of the Parliament. Revocation of proclamation. A proclamation of emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Further, the President must revoke a proclamation if the Lok Sabha passes a resolution disapproving its continuation. Again, this safeguard was introduced by the 44th Amendment Act of 1978. Before the amendment, a proclamation could be revoked by the President on his own, and the Lok Sabha had no control in this regard. The 44th Amendment Act of 1978 also provided that, where 1/10 of the total number of members of the Lok Sabha give a written notice to the Speaker or to the President if the House is not in session, a special sitting of the House should be held within 14 days for the purpose of considering a resolution disapproving the continuation of the proclamation. A resolution of disapproval is different from a resolution approving the continuation of a proclamation in the following 2 respects. 1. The first one is required to be passed by the Lok Sabha only, while the second one needs to be passed by the both Houses of Parliament. 2. The first one is to be adopted by a simple majority only, while the second one needs to be adopted by a special majority. Emergency Provisions M175. Effects of national emergency. A proclamation of emergency has drastic and wide-ranging effects on the political system. These consequences can be grouped into 3 categories. 1. Effect on the center-state relations. 2. Effect on the life of the Lok Sabha and State Assembly. And 3. Effect on the fundamental rights. Effect on the center-state relations. While a proclamation of emergency is in force, the normal fabric of the center-state relations undergoes a basic change. This can be studied under 3 heads, namely, executive, legislative, and financial. A. Executive. During a national emergency, the executive power of the center extends to directing any state regarding the manner in which its executive power is to be exercised. In normal times, the center can give executive directions to a state only on certain specified matters. However, during a national emergency, the center becomes entitled to give executive directions to a state on any matter. Thus, the state governments are brought under the complete control of the center, though they are not suspended. B. Legislative. During a national emergency, the Parliament becomes empowered to make laws on any subject mentioned in the state list. Although the legislative power of a state legislature is not suspended, it becomes subject to the overriding power of the Parliament. Thus, the normal distribution of the legislative powers between the center and states is suspended, though the state legislatures are not suspended. In brief, the Constitution becomes unitary rather than federal. The laws made by Parliament on the state subjects during a national emergency become inoperative 6 months after the emergency has ceased to operate. Notably, while a proclamation of national emergency is in operation, the President can issue ordinances on the state subjects also, if the Parliament is not in session. 176 Indian Polity. Further, the Parliament can confer powers and impose duties upon the center or its officers and authorities in respect of matters outside the Union list, in order to carry out the laws made by it under its extended jurisdiction as a result of the proclamation of a national emergency. The 42nd Amendment Act of 1976 provided that the 2 consequences mentioned above, executive and legislative, extends not only to a state where the emergency is in operation but also to any other state. C. Financial. While a proclamation of national emergency is in operation, the President can modify the constitutional distribution of revenues between the center and the states. This means that the president can either reduce or cancel the transfer of finances from center to the states. Such modification continues till the end of the financial year in which the emergency ceases to operate. Also, every such order of the president has to be laid before both the houses of parliament. Effect on the life of the Lok Sabha and State Assembly. While a proclamation of national emergency is in operation, the life of the Lok Sabha may be extended beyond its normal term, 5 years, by a law of parliament for 1 year at a time, for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. For example, the term of the 5th Lok Sabha, 1971 to 1977, was extended 2 times by 1 year at a time. Similarly, the parliament may extend the normal tenure of a state legislative assembly. 5. The term of the 5th Lok Sabha, which was to expire on March 18, 1976, was extended by 1 year up till March 18, 1977 by the House of the People, Extension of Duration, Act, 1976. It was extended for a further period of 1 year up till March 18, 1978 by the House of the People, Extension of Duration, Amendment Act, 1976. However, the House was dissolved on January 18, 1977, after having been in existence for a period of 5 years, 10 months and 6 days. 5 years, by 1 year each time, for any length of time, during a national emergency, subject to a maximum period of 6 months after the emergency has ceased to operate. Effect on the fundamental rights. Articles 358 and 359 describe the effect of a national emergency on the fundamental rights. Article 358 deals with the suspension of the fundamental rights guaranteed by Article 19, while Article 359 deals with the suspension of other fundamental rights, except those guaranteed by Articles 20 and 21. These two provisions are explained below. A. Suspension of fundamental rights under Article 19. According to Article 358, when a proclamation of national emergency is made, the 6 fundamental rights under Article 19 are automatically suspended. No separate order for their suspension is required. While a proclamation of national emergency is in operation, the state is freed from the restrictions imposed by Article 19. In other words, the state can make any law or can take any executive action abridging or taking away the 6 fundamental rights guaranteed by Article 19. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the 6 fundamental rights guaranteed by Article 19. When the national emergency ceases to operate, Article 19 automatically revives and comes into force. Any law made during emergency, to the extent of inconsistency with Article 19, ceases to have effect. However, no remedy lies for anything done during the emergency even after the emergency expires. This means that the legislative and executive actions taken during the emergency cannot be challenged even after the emergency ceases to operate. The 44th Amendment Act of 1978 restricted the scope of Article 358 in 2 ways. Firstly, the 6 fundamental rights under Article 19 stand suspended only when the national emergency is declared on the ground of war or external aggression and not on the ground of armed rebellion. Secondly, only those laws which are related with the emergency are protected from being challenged and not other laws. Also, the executive action taken only under such a law is protected. B. Suspension of other fundamental rights. Article 359 authorizes the President to suspend the right to move any court for the enforcement of fundamental rights during a national emergency. This means that under Article 359, the fundamental rights as such are not suspended, but only their enforcement. The said rights are theoretically alive, but the right to seek remedy is suspended. The suspension of enforcement relates to only those fundamental rights that are specified in the presidential order. Further, the suspension could be for the period during the operation of emergency or for a shorter period as mentioned in the order, and the suspension order may extend to the whole or any part of the country. It should be laid before each House of Parliament for approval. While a presidential order is in force, the state can make any law or can take any executive action abridging or taking away the specified fundamental rights. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the specified fundamental rights. When the order ceases to operate, any law so made, to the extent of inconsistency with the specified fundamental rights, ceases to have effect. But no remedy lies for anything done during the operation of the order even after the order ceases to operate. This means that the legislative and executive actions taken during the operation of the order cannot be challenged even after the order expires. The 44th Amendment Act of 1978 restricted the scope of Article 359 in 2 ways. Firstly, the President cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed by Articles 20 and 21. In other words, the right to protection in respect of conviction for offenses, Article 20, and the right to life and personal liberty, Article 21, remain enforceable even during emergency. Secondly, only those laws which emergency provisions VJ 177 are related with the emergency are protected from being challenged and not other laws, and the executive action taken only under such a law is protected. Distinction between Articles 358 and 359. The differences between Articles 358 and 359 can be summarized as follows. 1. Article 358 is confined to fundamental rights under Article 19 only, whereas Article 359 extends to all those fundamental rights whose enforcement is suspended by the presidential order. 2. Article 358 automatically suspends the fundamental rights under Article 19 as soon as the emergency is declared. On the other hand, Article 359 does not automatically suspend any fundamental right. It only empowers the president to suspend the enforcement of the specified fundamental rights. 3. Article 358 operates only in case of external emergency, that is, when the emergency is declared on the grounds of war or external aggression, and not in the case of internal emergency, i.e., when the emergency is declared on the ground of armed rebellion. Article 359, on the other hand, operates in case of both external emergency as well as internal emergency. 4. Article 358 suspends fundamental rights under Article 19 for the entire duration of emergency, while Article 359 suspends the enforcement of fundamental rights for a period specified by the President, which may either be the entire duration of emergency or a shorter period. 5. Article 358 extends to the entire country, whereas Article 359 may extend to the entire country or a part of it. 6. Article 358 suspends Article 19 completely, while Article 359 does not empower the suspension of the enforcement of Articles 20 and 21. 7. Article 358 enables the state to make any law or take any executive action inconsistent with fundamental rights under Article 19, while Article 359 enables 178 Indian Polity. The state to make any law or take any executive action inconsistent with those fundamental rights whose enforcement is suspended by the presidential order. There is also a similarity between Article 358 and Article 359. Both provide immunity from challenge to only those laws which are related with the emergency and not other laws. Also, the executive action taken only under such a law is protected by both declarations made so far. This type of emergency has been proclaimed 3 times so far, in 1962, 1971, and 1975. The first proclamation of national emergency was issued in October 1962 on account of Chinese aggression in the NIFA, Northeast Frontier Agency, now Arunachal Pradesh, and was enforced till January 1968. Hence, a fresh proclamation was not needed at the time of war against Pakistan in 1965. The second proclamation of national emergency was made in December 1971 in the wake of attack by Pakistan. Even when this emergency was in operation, a third proclamation of national emergency was made in June 1975. Both the second and third proclamations were revoked in March 1977. The first 2 proclamations, 1962 and 1971, were made on the ground of external aggression, while the third proclamation, 1975, was made on the ground of internal disturbance, that is, certain persons have been inciting the police and the armed forces against the discharge of their duties and their normal functioning. The emergency declared in 1975, internal emergency, proved to be the most controversial. There was widespread criticism of the misuse of emergency powers. In the elections held to the Lok Sabha in 1977 after the emergency, the Congress Party led by Indira Gandhi lost and the Janta Party came to power. This government appointed the Shah Commission to investigate the circumstances that warranted the declaration of an emergency in 1975. The commission did not justify the declaration of the emergency. Hence, the 44th Amendment Act was enacted in 1978 to introduce a number of safeguards against the misuse of emergency provisions. President's Rule. Grounds of imposition. Article 355 imposes a duty on the center to protect every state against external aggression and internal disturbance and to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. It is this duty in the performance of which the center takes over the government of a state under Article 356 in case of failure of constitutional machinery in state. This is popularly known as President's Rule. It is also known as state emergency or constitutional emergency. The President's Rule can be proclaimed under Article 356 on 2 grounds, one mentioned in Article 356 itself and another in Article 365. 1. Article 356 empowers the President to issue a proclamation if Husha is satisfied that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. Notably, the President can act either on a report of the governor of the state or otherwise too, i.e., even without the governor's report. 2. Article 365 says that whenever a state fails to comply with or to give effect to any direction from the center, it will be lawful for the President to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. Parliamentary approval and duration. A proclamation imposing President's Rule must be approved by both the Houses of Parliament within 2 months from the date of its issue. However, if the proclamation of President's Rule is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha approves it in the meantime. If approved by both the Houses of Parliament, the President's Rule continues for 6 months. It can be extended for a maximum period of 3 years 7 with the approval of the Parliament every 6 months. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuation of the President's rule, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuance. 8 inches case of dissolution, fresh elections are held for constituting a new legislative assembly in the state. Every resolution approving the proclamation of President's rule or its continuation can be passed by either House of Parliament only by a simple majority, that is, a majority of the members of that House present and voting. The 44th Amendment Act of 1978 introduced a new provision to put restraint on the power of Parliament to extend a proclamation of President's rule beyond 1 year. Thus, it provided that, beyond 1 year, the President's rule can be extended by 6 months at a time only when the following 2 conditions are fulfilled. 1. A proclamation of national emergency should be in operation in the whole of India, or in the whole or any part of the state. And 2. The Election Commission must certify that the general elections to the legislative. 6. The 42nd Amendment Act of 1976 had raised the period of 6 months to 1 year. Thus, once approved by both the Houses of Parliament, the proclamation of President's rule could continue for 1 year. But the 44th Amendment Act of 1978 again reduced the period to 6 months. The President's rule imposed in May 1987 in Punjab was allowed to continue for 5 years under the 68th Amendment Act of 1991. Emergency provisions 179. Assembly of the concerned state cannot be held on account of difficulties. A proclamation of President's rule may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Consequences of President's rule: the President acquires the following extraordinary powers when the President's rule is imposed in a state. 1. Husha can take up the functions of the state government and powers vested in the governor or any other executive authority in the state. 2. Husha can declare that the powers of the state legislature are to be exercised by the Parliament. 3. Husha can take all other necessary steps including the suspension of the constitutional provisions relating to any body or authority in the state. Therefore, when the President's rule is imposed in a state, the President dismisses the State Council of Ministers headed by the Chief Minister. The State Governor, on behalf of the President, carries on the state administration with the help of the Chief Secretary of the state or the advisors appointed by the President. This is the reason why a proclamation under Article 356 is popularly known as the imposition of President's rule in a state. Further, the President either suspends or dissolves the State Legislative Assembly. 8. The Parliament passes the state legislative bills and the state budget. When the state legislature is thus suspended or dissolved, 1. The Parliament can delegate the power to make laws for the state to the President or to any other authority specified by her in this regard. 2. The Parliament, or in case of delegation, the President, or any other specified authority can make laws conferring powers and imposing duties on the center or its officers and authorities in 180 Indian Polity. 3. The President can authorize, when the Lok Sabha is not in session, expenditure from the State Consolidated Fund pending its sanction by the Parliament. A law made by the Parliament or the President or any other specified authority continues to be operative even after the President's rule. This means that the period for which such a law remains in force is not coterminous with the duration of the proclamation, but it can be repealed or altered or reenacted by the state legislature. It should be noted here that the President cannot assume to himself the powers vested in the concerned state high court or suspend the provisions of the Constitution relating to it. In other words, the constitutional position, status, powers, and functions of the concerned state high court remain the same even during the President's rule. A comparison of the national emergency and the President's rule in terms of the grounds, parliamentary approval, duration, revocation, and consequences is given in THBLE 17.1. Table 17.1 comparing national emergency and President's rule. National emergency, Article 352, President's rule, Article 356. 1. It can be proclaimed only when the security of India or a part of it is threatened by war, external aggression, or armed rebellion. 1. It can be proclaimed when the government of a state cannot be carried on in accordance with the provisions of the Constitution due to reasons which may not have any connection with war, external aggression, or armed rebellion. 2. During its operation, the state executive and legislature continue to function and exercise the powers assigned to them under the Constitution. Its effect is that the center gets concurrent powers of administration and legislation in the state. 2. During its operation, the state executive is dismissed and the state legislature is either suspended or dissolved. The President administers the state through the governor and the Parliament makes laws for the state. In brief, the executive and legislative powers of the state are assumed by the center. 3. Under this, the Parliament can make laws on the subjects enumerated in the state list only by itself, that is, it cannot delegate the same to any other body or authority. 3. Under this, the Parliament can delegate the power to make laws for the state to the President or to any other authority specified by him or her. So far, the practice has been for the President to make laws for the state in consultation with the members of Parliament from that state. Such laws are known as President's Acts. 4. There is no maximum period prescribed for its operation. It can be continued indefinitely with the approval of Parliament for every 6 months. 4. There is a maximum period prescribed for its operation, that is, 3 years. Thereafter, it must come to an end, and the normal constitutional machinery must be restored in the state. 5. Under this, the relationship of the center with all the states undergoes a modification. 5. Under this, the relationship of only the state under emergency with the center undergoes a modification. 6. Every resolution of Parliament approving its proclamation or its continuance must be passed by a special majority. 6. Every resolution of Parliament approving its proclamation or its continuance can be passed only by a simple majority. 7. It affects fundamental rights of the citizens. 7. It has no effect on fundamental rights of the citizens. 8. Lok Sabha can pass a resolution for its revocation. 8. There is no such provision. It can be revoked by the President only on his or own. Use of Article 356. Since 1950, the President's rule has been imposed on more than 125 occasions. Further, on a number of occasions, the President's rule has been imposed in an arbitrary manner for political or personal reasons. Hence, Article 356 has become one of the most controversial and most criticized provision of the Constitution. For the first time, the President's rule was imposed in Punjab in 1951. By now, almost all the states have been brought under the President's rule, once or twice or more. When general elections were held to the Lok Sabha in 1977 after the internal emergency, the ruling Congress Party lost and the Janata Party came to power. The new government headed by Morarji Desai imposed President's rule in 9 states, where the Congress Party was in power, on the ground that the assemblies in those states no longer represented the wishes of the electorate. When the Congress Party returned to power in 1980, it did the same in 9 states, 10 on the same ground. Those 9 states include Rajasthan, Uttar Pradesh, Madhya Pradesh, Punjab, Bihar, Himachal Pradesh, Orissa, West Bengal, and Haryana. Those 9 states include Uttar Pradesh, Bihar, Rajasthan, Madhya Pradesh, Punjab, Orissa, Gujarat, Maharashtra, and Tamil Nadu. Esarbami vs. Union of India, 1994. In 1992, President's rule was imposed in 3 BJP-ruled states, Madhya Pradesh, Himachal Pradesh, and Rajasthan, by the Congress Party on the ground that they were not implementing sincerely the ban imposed by the Center on religious organizations. In a landmark judgment in the Bombay Case 11, 1994, the Supreme Court upheld the validity of this proclamation on the ground that secularism is a basic feature of the Constitution. But the court did not uphold the validity of the imposition of the President's rule in Nagaland in 1988, Karnataka in 1989, and Meghalaya in 1991. Dr. B. R. Ambedkar, while replying to the critics of this provision in the Constituent Assembly, hoped that the drastic power conferred by Article 356 would remain a dead letter and would be used only as a measure of last resort. He observed 12. The intervention of the center must be deemed to be barred, because that would be an invasion on the sovereign authority of the province-state. That is a fundamental proposition which we must accept by reason of the fact that we have a federal constitution. That being so, if the center is to interfere in the administration of provincial affairs, it must be under some obligation which the Constitution imposes upon the center. The proper thing we ought to expect is that such articles will never be called into operation and that they would remain a dead letter. If at all they are brought into operation, I hope the President who is endowed with this power will take proper precautions before actually suspending the administration of the province. However, the subsequent events show that what was hoped to be a dead letter of the Constitution has turned to be a deadly weapon against a number of state governments and legislative assemblies. In this context, H.V. Kamath, a member of the Constituent Assembly, commented, Dr. Ambedkar is dead and the articles are very much alive. Scope of judicial review. The 38th Amendment Act of 1975 made the satisfaction of the President in invoking Article 356 final and conclusive, which could not be challenged in any court on any ground. But this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of the President is not beyond judicial review. In the Bombay Case, 1994, the following propositions have been laid down by the Constituent Assembly Debates, Volume 9, pp. 133 and 177. 182 F. Indian Polity. Supreme Court on imposition of President's rule in a state under Article 356. 1. The presidential proclamation imposing President's rule is subject to judicial review. 2. The satisfaction of the President must be based on relevant material. The action of the President can be struck down by the court if it is based on irrelevant or extraneous grounds, or if it was found to be malified or perverse. 3. Burden lies on the center to prove that relevant material exists to justify the imposition of the President's rule. 4. The court cannot go into the correctness of the material or its adequacy, but it can see whether it is relevant to the action. 5. If the court holds the presidential proclamation to be unconstitutional and invalid, it has power to restore the dismissed state government and revive the state legislative assembly if it was suspended or dissolved. 6. The state legislative assembly should be dissolved only after the parliament has approved the presidential proclamation. Until such approval is given, the president can only suspend the assembly. In case the parliament fails to approve the proclamation, the assembly would get reactivated. 7. Secularism is one of the basic features of the Constitution. Hence, a state government pursuing anti-secular politics is liable to action under Article 356. 8. The question of the state government losing the confidence of the Legislative Assembly should be decided on the floor of the House, and until that is done the ministry should not be unseated. 9. Where a new political party assumes power at the center, it will not have the authority to dismiss ministries formed by other parties in the states. 10. The power under Article 356 is an exceptional power and should be used only occasionally to meet the requirements of special situations. Cases of proper and improper use based on the report of the Sarkaria Commission on Center-State Relations, 1988, the Supreme Court in Bombay case, 1994, enlisted the situations where the exercise of power under Article 356 could be proper or improper. 13. Report of the Commission on Center-State Relations, Part 1, pp. 165-180, 1988. Imposition of President's rule in a state would be proper in the following situations. 1. Where after general elections to the Assembly, no party secures a majority, that is, hung Assembly. 2. Where the party having a majority in the Assembly declines to form a ministry and the governor cannot find a coalition ministry commanding a majority in the Assembly. 3. Where a ministry resigns after its defeat in the Assembly and no other party is willing or able to form a ministry commanding a majority in the Assembly. 4. Where a constitutional direction of the central government is disregarded by the state government. 5. Internal subversion where, for example, a government is deliberately acting against the Constitution and the law or is fomenting a violent revolt. 6. Physical breakdown where the government willfully refuses to discharge its constitutional obligations, endangering the security of the state. The imposition of president's rule in a state would be improper under the following situations. 1. Where a ministry resigns or is dismissed on losing majority support in the Assembly and the governor recommends imposition of president's rule without probing the possibility of forming an alternative ministry. 2. Where the governor makes his own assessment of the support of a ministry in the Assembly and recommends imposition of president's rule without allowing the ministry to prove its majority on the floor of the Assembly. 3. Where the ruling party enjoying majority support in the Assembly has suffered a massive defeat in the general elections to the Lok Sabha, such as in 1977 and 1980. 4. Internal disturbances not amounting to internal subversion or physical breakdown. 5. Maladministration in the state or allegations of corruption against the ministry or stringent financial exigencies of the state. 6. Where the state government is not given prior warning to rectify itself except in case of extreme urgency leading to underscore disastrous consequences. 7. Where the power is used to sort out intra-party problems of the ruling party, or for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution. It happy face financial emergency. Grounds of declaration. Article 360 empowers the President to proclaim a financial emergency if Husha is satisfied that a situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened. The 38th Amendment Act of 1975 made the satisfaction of the President in declaring a financial emergency final and conclusive and not questionable in any court on any ground. But this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of the President is not beyond judicial review. Parliamentary approval and duration. A proclamation declaring financial emergency must be approved by both the Houses of Parliament within 2 months from the date of its issue. However, if the proclamation of financial emergency is issued at a time when the Lok Sabha has been dissolved or the emergency provisions 1ZZ. Dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. Once approved by both the Houses of Parliament, the financial emergency continues indefinitely till it is revoked. This implies 2 things. 1. There is no maximum period prescribed for its operation. And 2. Repeated parliamentary approval is not required for its continuation. A resolution approving the proclamation of financial emergency can be passed by either House of Parliament only by a simple majority, that is, a majority of the members of that House present and voting. A proclamation of financial emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Effects of financial emergency. The consequences of the proclamation of a financial emergency are as follows. 1. The executive authority of the center extends to the giving of a. Directions to any state to observe the canons of financial propriety, and b. Such other directions to any state as the President may deem necessary. 2. Any such direction may include a provision requiring a. The reduction of salaries and allowances of all or any class of persons serving in the state, and b. The reservation of all money bills or other financial bills for the consideration of the President after they are passed by the legislature of the state. 3. The President may issue directions for the reduction of salaries and allowances of a. All or any class of persons serving the Union, and b. The judges of the Supreme Court and the High Court. 184 Indian Polity. Thus, during the operation of a financial emergency, the center acquires full control over the states in financial matters. H.N. Kunzru, a member of the Constituent Assembly, stated that the financial emergency provisions pose a serious threat to the financial autonomy of the states. Explaining the reasons for their inclusion in the Constitution, Dr. B. R. Ambedkar observed in the Constituent Assembly 14. Constituent Assembly Debates, Volume X, pp. 361-372. LS quoted from M. V. Piley, India's Constitution, S. Chand, 5th edition, 1994, p. 280. Constituent Assembly Debates, Volume 9, p. 105. Ibid, p. 123. 18 Ibid, p. 547. 1 Ibid, p. 177. This article more or less follows the pattern of what is called the National Recovery Act of the United States passed in 1933, which gave the President power to make similar provisions in order to remove the difficulties, both economical and financial, that had overtaken the American people as a result of the Great Depression. No financial emergency has been declared so far, though there was a financial crisis in 1991. Criticism of the emergency provisions underscore some members of the Constituent Assembly criticized the incorporation of emergency provisions in the Constitution on the following grounds. 15. 1. The federal character of the Constitution will be destroyed and the Union will become all-powerful. 2. The powers of the state, both the Union and the units, will entirely be concentrated in the hands of the Union executive. 3. The President will become a dictator. 4. The financial autonomy of the state will be nullified. 5. Fundamental rights will become meaningless and, as a result, the democratic foundations of the Constitution will be destroyed. Thus, H. V. Kamath observed, I fear that by this single chapter we are seeking to lay the foundation of a totalitarian state, a police state, a state completely opposed to all the ideals and principles that we have held aloft during the last few decades. A state where the rights and liberties of millions of innocent men and women will be in continuous jeopardy, a state where if there be peace, it will be the peace of the grave and the void of the desert. It will be a day of shame and sorrow when the President makes use of these powers having no parallel in any constitution of the democratic countries of the world. *S16. K.D. Shaw described them as a chapter of reaction and retrogression. I find one cannot but notice two distinct currents of theft underlying and influencing throughout the provisions of this chapter. A. To arm Tire Center with special powers against the units, and b. To arm the government against the people. T.D. Krishnamachari feared that by means of these provisions the President and the executive would be exercising a form of constitutional dictatorship. 1718. H.N. Kunzru opined that the emergency financial provisions pose a serious threat to the financial autonomy of the states. However, there were also protagonists of the emergency provisions in the Constituent Assembly. Thus, Sir Alati Krishnaswamy Iyer labeled them as the very life breath of the Constitution. Mahabharti Vajai opined that they would work as a safety valve and thereby help in the maintenance of the Constitution. 13. While defending the emergency provisions in the Constituent Assembly, Dr. B. R. Ambedkar also accepted the possibility of their misuse. He observed, I do not altogether deny that there is a possibility of the articles being abused or employed for political purposes. 19. Aggression and internal disturbance. Article No. Subject Matter. Emergency Provisions. Table 17.2 Articles related to emergency provisions at a glance. 355. Duty of the Union to protect states against external. 356-foot provisions in case of failure of constitutional machinery in states. 357. Exercise of legislative powers under proclamation issued under Article 356. L58 suspension of provisions of Article 19 during emergencies. 3S9. Suspension of th. Enforcement of the rights conferred by pardon during emergencies. 359A APPL outline of this part to the state of Punjab repealed. 0. Provisions as to financial emergent 53. Effect of proclamation of emergency. 354. Application of provisions relating to distribution of revenues while a proclamatin P operation new a proclamation of emergency is in. 352. Proclamation of emergency. FMREWAEQR, see degree did to access 016 conceptual video on national urgency and its impact on political system and other important topics on Edge Part 3 Central Government. In this part, 18. President 19. Vice President 20. Prime Minister 21. Central Council of Ministers 22. Cabinet Committees 23. Parliament 24. Parliamentary Committees 25. Indian Parliamentary Group 26. Supreme Court 27. Judicial Review 28. Judicial Activism 29. Public Interest Litigation Chapter 18 President. Articles 52 to 78 in Part 5 of the Constitution deal with the Union Executive. The Union Executive consists of the President, the Vice President, the Prime Minister, the Council of Ministers, and the Attorney General of India. The President is the head of the Indian state. Pisha is the first citizen of India and acts as the symbol of unity, integrity, and solidarity of the nation. Election of the President. The President is elected not directly by the people but by members of Electoral College consisting of 1. The elected members of both the Houses of Parliament. 2. The elected members of the Legislative Assemblies of the states. And 3. The elected members of the Legislative Assemblies of the Union Territories of Delhi and Puducherry 1. Thus, the nominated members of both the Houses of Parliament, the nominated members of the state legislative assemblies. This provision was added by the 70th Constitutional Amendment Act of 1992 with effect from June 1, 1995. The members, both elected and nominated, of the state legislative councils, in case of the bicameral legislature, and the nominated members of the legislative assemblies of Delhi and Puducherry do not participate in the election of the President. The 104th Constitutional Amendment Act of 2019 has not extended further the nomination of Anglo-Indian members to the Lok Sabha and state legislative assemblies. In other words, the amendment discontinued the provision of special representation of the Anglo-Indian community in the Lok Sabha and state legislative assemblies by nomination. Consequently, this provision ceased to have effect on the January 25, 2020. Further, where an assembly is dissolved, the members cease to be qualified to vote in the presidential election, even if fresh elections to the dissolved assembly are not held before the presidential election. The Constitution provides that there shall be uniformity in the scale of representation of different states as well as parity between the states as a whole and the Union at the election of the President. To achieve this, the number of votes which each elected member of the Legislative Assembly of each state, and the President 187. Parliament is entitled to cast at such election shall be determined in the following manner. 1. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1,000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the Assembly. 2. This can be expressed as 2. According to the 84th Constitutional Amendment Act of 2001, the expression population means the population is ascertained at the 1971 census, until the relevant figures for the first census taken after 2026 have been published. Value of the vote of an MLA equals total population of state *J total number of elected 1,000 members in the state legislative assembly. 2. Every elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to members of the legislative assemblies of the states by the total number of the elected members of both the Houses of Parliament. This can be expressed as value of the vote of an MP. Total value of votes of all MLAs of all states, total number of elected members of Parliament. An illustration of the value of votes of each member of the legislative assemblies of the states, total value of votes of each of the states, the value of votes of each member of Parliament. The total value of votes of the members of Parliament and the grand total of value of all the members in the Electoral College for the presidential election, 2022 is given in FBLI 18.4. The President's election is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. This system ensures that the successful candidate is returned by the absolute majority of votes. A candidate, in order to be declared elected to the office of President, must secure a fixed quota of votes. The quota of votes is determined by dividing the total number of valid votes polled by the number of candidates to be elected. Here only one candidate is to be elected as President, plus 1 and adding 1 to the quotient. The formula can be expressed as electoral quota. Total number of valid votes polled 1 plus 1 equals 2 plus. Each member of the Electoral College is given only one ballot paper. The voter, while casting his vote, is required to indicate his preferences by marking 1, 2, 3, 4, etc. against the names of candidates. This means that the voter can indicate as many preferences as there are candidates in the fray. In the first phase, the first preference votes are counted. In case a candidate secures the required quota in this phase, Pusha is declared elected. Otherwise, the process of transfer of votes is set in motion. The ballots of the candidate securing the least number of first preference votes are cancelled and his or her second preference votes are transferred to the first preference votes of other candidates. This process continues till a candidate secures the required quota. All doubts and disputes in connection with election of the President are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as President cannot be challenged on the ground that the Electoral College was incomplete, i.e., existence of any vacancy among the members of Electoral College. If the election of a person as President is declared void by the Supreme Court, acts done by her before the date of such declaration of the Supreme Court are not invalidated and continue to remain in force. Some members of the Constituent Assembly criticized the system of indirect election for the president as undemocratic and proposed the idea of direct election. However, 188 Indian Polity. The Constitution makers chose the indirect election due to the following reasons. 1. The indirect election of the president is in harmony with the parliamentary system of government envisaged in the Constitution. Under this system, the president is only a nominal executive, and the real powers are vested in the Council of Ministers headed by the Prime Minister. It would have been anomalous to have the president elected directly by the people and not give him or any real power. 2. The direct election of the president would have been very costly and time and energy consuming due to the vast size of the electorate. This is unwarranted, keeping in view that Husha is only a symbolic head. Some members of the Constituent Assembly suggested that the president should be elected. Constituent Assembly Debates, Volume 4, pp. 733 to 736. By the members of the two houses of Parliament alone. The makers of the Constitution did not prefer this, as the Parliament, dominated by one political party, would have invariably chosen a candidate from that party, and such a president could not represent the states of the Indian Union. The present system makes the president a representative of the Union and the states equally. Further, it was pointed out in the Constituent Assembly that the expression proportional representation in the case of presidential election is a misnomer. Proportional representation takes place where two or more seats are to be filled. In case of the president, the vacancy is only one. It could better be called a preferential or alternative vote system. Similarly, the expression single transferable vote was also objected on the ground that no voter has a single vote. Every voter has plural votes. The various presidential elections held so far are summarized in Table 18.1. Table 18.1 Elections of the Presidents, 1952 till now. SI. No. Election. Year. Victorious candidate no. Of votes. Secured, %. Main rival candidate no. Of votes. Secured, %. 1. 1952 Dr. Rajendra Prasad 507400, 83.81. KT Shah 9, 2827, 15.3. 2. 1957 Dr. Rajendra Prasad 459698, 99.35, and NDOS 2000 0.4. 3. 1962 Drive S. Radhakrishnan 553067, 98.24, ch. Hari Ram 6341, 1.1. 4. 1967 Dr. Zakir Hussain 471244, 56.23, k. Subha Rao 363971, 43.4. 5. 1969 VV Giri 420077, 50.22, in. Sanjeeva Reddy 405427, 48.5. 6. 1974 Fakhruddin Ali Ahmed 756587, 80.18, Tridev Chowdhury 189186, 19.8. 7. 1977 N. Sanjeeva Reddy, unopposed. 8. 1982 Gianni Zail Singh 754113, 72.73, HR Khanna 282685, 27.6. 9. 1987 R. Venkataraman 740148, 72.29, v. Krishna Iyer 281550, 27.1. 10. 1992 Dr. Shankar Dayal Sharma 6, 75564, 65.86, George Swell 346485, 33.21. 11. 1997 KR Narayanan 956290, 94.97, Tian Shishan 50431, 5.07. 12. 2002 Dr. APJ Abdul Kalam 9, 22844, 89.58, Lakshmi Sehgal 107366, 10.42. 13. 2007 Ms. Pratibha Patil 638116, 65.82, BS Shekhawat 331306, 34.17. 14. 2012 Pranab Mukherjee 713763, 68.12, PA Sangama 315987, 30.15. 15. 2017 Ramnath Kovind 702044, 65.65, Mirakumar 367314, 34.35. 16. 2022 Draupadi Murmu 676803, 64.03, Yashwant Sinha 380177, 35.97, President 189. Qualifications, Oath and Conditions. Qualifications for election as President. A person to be eligible for election as President should fulfill the following qualifications. 1. Hisha should be a citizen of India. 2. Hisha should have completed 35 years of age. 3. Hisha should be qualified for election as a member of the Lok Sabha. 4. Hisha should not hold any office of profit under the union government, or any state government, or any local authority, or any other public authority. A sitting president or vice president of the Union, the governor of any state, and a minister of the Union or any state is not deemed to hold any office of profit and hence qualified as a presidential candidate. Further, the nomination of a candidate for election to the office of president must be subscribed by at least 50 electors as proposers and 50 electors as seconders. Every candidate has to make a security deposit of 15,000 in the Reserve Bank of India. The security deposit is liable to be forfeited in case the candidate fails to secure 1/6 of the votes polled. Before 1997, number of proposers and seconders was 10 each, and the amount of security deposit was to 500. In 1997, they were increased to discourage the non-serious candidates for the Presidential and Vice Presidential Elections Act of 1952, as amended in 1997. For the Finance Act, 2018, with effect from January 1, 2016. This act amended the President's Emoluments and Pension Act, 1951. 5. The President's Emoluments and Pension Amendment Act of 2008. Oath or affirmation by the President before entering upon his office. The President has to make and subscribe to an oath or affirmation. In his oath, the President swears, 1. To faithfully execute the office. 2. To preserve, protect, and defend the Constitution and the law. And 3. To devote himself to the service and well-being of the people of India. The oath of office to the President is administered by the Chief Justice of India and in his absence, the senior-most judge of the Supreme Court available. Any other person acting as President or discharging the functions of the President also undertakes the similar oath or affirmation. Conditions of President's office. The Constitution lays down the following conditions of the President's office. 1. He should not be a member of either House of Parliament or a House of the state legislature. If any such person is elected as President, he is deemed to have vacated his seat in that House on the date on which he enters upon his office as President. 2. He should not hold any other office of profit. 3. He is entitled, without payment of rent, to the use of his official residence, the Rashtrapati Bhavan. 4. He is entitled to such emoluments, allowances, and privileges as may be determined by Parliament. 5. His emoluments and allowances cannot be diminished during his term of office. In 2018, the Parliament increased the salary of the President from 1.50 lakh to 5 lakh per month for a. Earlier in 2008, the pension of the retired President was increased from 3 lakh per annum to 50% of his salary per month 3. In addition, the former presidents are entitled to furnished residence, phone facilities, car, medical treatment, travel facility, secretarial staff, and office expenses up to L00000 per annum. The spouse of a deceased president is also entitled to a family pension at the rate of 50% of pension of a retired president, furnished residence, phone facility, car, 190 Indian Polity. Medical treatment, travel facility, secretarial staff, and office expenses up to T20,000 per annum. The President is entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official acts. During his term of office, he is immune from any criminal proceedings, even in respect of his personal acts. He cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him during his term of office in respect of his personal acts. Term, impeachment, and vacancy. Term of President's office. The President holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the Vice President. Further, he can also be removed from the office before completion of his term by the process of impeachment. The President can hold office beyond his term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of terms. 1. However, in USA, a person cannot be elected to the office of the President more than twice. Impeachment of President. The President can be removed from office by a process of impeachment for violation of the Constitution. However, the Constitution does not define the meaning of the phrase violation of the Constitution. The impeachment charges can be initiated by either House of the Parliament. These charges should be signed by 1/4 members of. No person except Dr. Rajendra Prasad has occupied the office for 2 terms. The House that framed the charges, and a 14 days notice should be given to the President. After the impeachment resolution is passed by a majority of 2/3 of the total membership of that one House, it is sent to the other House, which should investigate the charges. The President has the right to appear and to be represented at such investigation. If the other House also sustains the charges and passes the impeachment resolution by a majority of 2/3 of the total membership, then the President stands removed from his office from the date on which the resolution is so passed. Thus, an impeachment is a quasi-judicial procedure in the Parliament. In this context, 2 things should be noted. A. The nominated members of either House of Parliament can participate in the impeachment of the President though they do not participate in his election, and B. The elected members of the legislative assemblies of states in the Union territories of Delhi and Puducherry do not participate in the impeachment of the President though they participate in his election. It must be noted here that no president has so far been impeached. Vacancy in the president's office. A vacancy in the president's office can occur in any of the following ways. 1. On the expiry of his tenure of 5 years. 2. By his resignation. Z. On his removal by the process of impeachment. 4. By his death. 7. 5. Otherwise, for example, when his becomes disqualified to hold office or when his election is declared void. When the vacancy is going to be caused by the expiration of the term of the sitting president, an election to fill the vacancy must be held before the expiration of the term. So far, 2 presidents, Dr. Zakir Hussain and Fakhruddin Ali Ahmed, have died during their term of office. 194 Indian Polity. Military powers. Husha is the supreme commander of the defense forces of India. In that capacity, she appoints the chiefs of the army, the navy, and the air force. Husha can declare war or conclude peace, subject to the approval of the parliament. Emergency powers. In addition to the normal powers mentioned above, the Constitution confers extraordinary powers on the president to deal with the following 3 types of emergencies. A. National emergency, Article 352. B. President's Rule, Article 356 and 365. And C. Financial emergency, Article 360. A. National emergency. The president can proclaim emergency in the entire country or in any part of it on the following grounds. I. War, or 2. External aggression, or 3. Armed rebellion. The president acquires the following extraordinary powers during a national emergency. I. Husha can modify the pattern of the distribution of financial resources between the union and the states. 2. Husha can suspend the fundamental rights of citizens except the right to life and personal liberty, Article 21, and the right to protection in respect of conviction for offenses, Article 20. B. President's Rule. It is also known as a state emergency or a constitutional emergency. It can be proclaimed by the president on the following grounds. I. Failure of constitutional machinery in the states, Article 356, or 2. Failure to comply with or to give effect to directions given by the union. Article 365. The president acquires the following extraordinary powers when the president's rule is imposed in a state. I. Husha can assign to himself all or any of the functions of the state government and all or any of the powers vested in the governor or anybody or authority in the state. 2. Husha can declare that the powers of the state legislature shall be exercisable by or under the authority of the parliament. 3. Husha can authorize, when the Lok Sabha is not in session, expenditure from the consolidated fund of the state, pending the sanction of such expenditure by the parliament. C. Financial emergency. The president can proclaim financial emergency if Husha is satisfied that the financial stability or credit of India or any part thereof is threatened. During a financial emergency, the president can issue directions for the reduction of salaries and allowances of all or any class of persons serving in connection with the affairs of the union, including the judges of the Supreme Court and High Courts. T. Veto power of the president. A bill passed by the parliament can become an act only if it receives the assent of the president. When such a bill is presented to the president for his assent, Husha has 3 alternatives under Article 111 of the Constitution. 1. Husha may give his assent to the bill, or 2. Husha may withhold his assent to the bill, or 3. Husha may return the bill, if it is not a money bill, for reconsideration of the parliament. However, if the bill is passed again by the parliament with or without amendments and again presented to the president must give his assent to the bill. President 191. Case of any delay in conducting the election of new president by any reason, the outgoing president continues to hold office beyond his term of 5 years until his successor assumes charge. This is provided by the Constitution in order to prevent an interregnum. In this situation, the vice president does not get the opportunity to act as president or to discharge the functions of the president. If the office falls vacant by resignation, removal, death, or otherwise, then election to fill the vacancy should be held within 6 months from the date of the occurrence of such a vacancy. The newly elected president remains in office for a full term of 5 years from the date Husha assumes charge of his office. When a vacancy occurs in the office of the president due to Husha resignation, removal, death, or otherwise, the vice president acts as the president until a new president is elected. Further, when the sitting president is unable to discharge his functions due to absence, illness, or any other cause, the vice president discharges his functions until the president resumes his office. In case the office of vice president is vacant, the Chief Justice of India, or if his or office is also vacant, the senior-most judge of the Supreme Court available, acts as the president or discharges the functions of the president. 8. For example, when President Dr. Zakir Hussain died in May 1969, the then vice president, V.V. Giri, was acting as the president. Soon after, V.V. Giri resigned to contest the election of the president. Then the Chief Justice of India, M. Hidayatullah, worked as the officiating president from July 20, 1969 to August 24, 1969. When any person, i.e., Vice President, Chief Justice of India, or the senior-most judge of the Supreme Court is acting as the president or discharging the functions of the president, Husha enjoys all the powers and immunities of the president and is entitled to such emoluments, allowances, and privileges as are determined by the parliament. Powers and functions of the president. The powers enjoyed and the functions performed by the president can be studied under the following heads. 1. Executive powers 2. Legislative powers 3. Financial powers 4. Judicial powers 5. Diplomatic powers 6. Military powers 7. Emergency powers. Executive powers. The executive powers and functions of the President are: A. All executive actions of the Government of India are formally taken in his name. B. Husha can make rules specifying the manner in which the orders and other instruments made and executed in his name shall be authenticated. C. Husha can make rules for more convenient transaction of business of the Union Government and for allocation of the said business among the ministers. D. Husha appoints the Prime Minister and the other ministers. They hold office during his pleasure. E. Husha appoints the Attorney General of India and determines his remuneration. The Attorney General holds office during the pleasure of the President. F. Husha appoints the Comptroller and Auditor General of India, the Chief Election Commissioner and other election commissioners, the Chairman and members of the Union Public Service Commission, the Governors of States, the Chairman and members of Finance Commission, and so on. G. Husha can seek any information relating to the administration of affairs of the Union and proposals for legislation from the Prime Minister. H. Husha can require the Prime Minister to submit for consideration of the Council 92 Indian Polity _____________________ of ministers, any matter on which a decision has been taken by a minister but which has not been considered by the Council. I. Husha can appoint a commission to investigate into the conditions of backward classes. Fi. Husha can appoint an interstate council to promote interstate and interstate cooperation. Fk. Husha directly administers the Union territories through administrators appointed by him. 1. Husha can declare any area as scheduled area and has powers with respect to the administration of scheduled areas and tribal areas. Legislative powers. The President is an integral part of the Parliament of India and enjoys the following legislative powers. A. Husha can summon or prorogue the Parliament and dissolve the Lok Sabha. Husha can also summon a joint sitting of both the Houses of Parliament, which is presided over by the Speaker of the Lok Sabha. Fb. Husha can address the Parliament at the commencement of the first session after each general election in the first session of each year. Fcj. Husha can send messages to the Houses of Parliament, whether with respect to a bill pending in the Parliament or otherwise. D. Husha can appoint any member of the Lok Sabha to preside over its proceedings when the offices of both the Speaker and the Deputy Speaker fall vacant. Similarly, Husha can also appoint any member of the Rajya Sabha to preside over its proceedings when the offices of both the Chairman and the Deputy Chairman fall vacant. E. Husha nominates 12 members of the Rajya Sabha from amongst persons having special knowledge or practical experience in literature, science, art, and social service. F. Husha nominated, before 2020, 2 members to the Lok Sabha from the Anglo-Indian community. However, the 104th Constitutional Amendment Act of 2019 has discontinued this provision. Fg. Husha decides on questions as to disqualifications of members of the Parliament in consultation with the Election Commission. H. Husha prior recommendation or permission is needed to introduce certain types of bills in the Parliament. They are: I. A bill involving expenditure from the Consolidated Fund of India. 2. A bill for the alteration of boundaries of states or creation of a new state. 3. A money bill. 4. A bill that imposes or varies any tax or duty in which states are interested. V. A bill which varies the meaning of the expression agricultural income as defined for the purposes of the enactments relating to Indian income tax. 6. A bill which affects the principles on which sums of money are or may be distributable to states. And 7. A bill that imposes any surcharge on any specified tax or duty for the purpose of the sinner. Further, a state bill imposing restrictions on the freedom of trade, commerce, and intercourse with that state or within that state can be introduced in the legislature of the state only with the previous sanction of the President. I. When a bill is sent to the President after it has been passed by the Parliament, Husha can: I. Give Husha assent to the bill, or 2. Withhold Husha assent to the bill, or 3. Return the bill, if it is not a money bill, for reconsideration of the Parliament. However, if the bill is passed again by the Parliament, with or without amendments, the President has to give Husha assent to the bill. J. When a bill passed by a state legislature is reserved by the Governor for consideration of the President can: I. Give Husha assent to the bill, or 2. Withhold Husha assent to the bill, or 3. Direct the Governor to return the bill, if it is not a money bill, for reconsideration of the state legislature. It should be noted here that it is not obligatory for the President to give Husha assent even if the bill is again passed by the state legislature and sent again to him/her for Husha consideration. K. Husha can promulgate ordinances when the Parliament is not in session. These ordinances must be approved by the Parliament within 6 weeks from its reassembly. Husha can also withdraw an ordinance at any time. L. H. lays the reports of the Comptroller and Auditor General, Union Public Service Commission, Finance Commission, and others before the Parliament. M. Husha can make regulations for the peace, progress, and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu, and Ladakh. In the case of Puducherry also, the President can legislate by making regulations but only when the Assembly is suspended or dissolved. Financial powers. The financial powers and functions of the President are: A. Money bills can be introduced in the Parliament only with his prior recommendation. President 193. B. Hisha causes to be laid before the Parliament the annual financial statement, i.e., the Union budget. C. No demand for a grant can be made except on his recommendation. D. Hisha can make advances out of the Contingency Fund of India to meet any unforeseen expenditure. E. Hisha constitutes a finance commission after every 5 years to recommend the distribution of revenues between the center and the states. Judicial powers. The judicial powers and functions of the President are: A. Hisha appoints the Chief Justice and the judges of Supreme Court and High Courts. B. Hisha can seek advice from the Supreme Court on any question of law or fact. However, the advice tendered by the Supreme Court is not binding on the President. C. Hisha can grant pardon, reprieve, respite and remission of punishment, or suspend, remit or commute the sentence of any person convicted of any offense, I. In all cases where the punishment or sentence is by a court-martial. 2. In all cases where the punishment or sentence is for an offense against a union law. And 3. In all cases where the sentence is a sentence of death. Diplomatic powers. The international treaties and agreements are negotiated and concluded on behalf of the President. However, they are subject to the approval of the Parliament. Hisha represents India in international forums and affairs and sins and receives diplomats like ambassadors, high commissioners, and so on. Thus, the President has the veto power over the bills passed by the Parliament. 9. That is, Hisha can withhold Hisha assent to the bills. The object of conferring this power on the President is twofold: A. To prevent hasty and ill-considered legislation by the Parliament, and B. To prevent a legislation which may be unconstitutional. The veto power enjoyed by the executive in modern states can be classified into the following 4 types. 1. Absolute veto, that is, withholding of assent to the bill passed by the legislature. 2. Qualified veto, which can be overridden by the legislature with a higher majority. 3. Suspensive veto, which can be overridden by the legislature with an ordinary majority. 4. Pocket veto, that is, taking no action on the bill passed by the legislature. Of the above 4, the President of India is vested with 3: absolute veto, suspensive veto, and pocket veto. There is no qualified veto in the case of Indian President. It is possessed by the American President. The 3 vetoes of the President of India are explained below. Absolute veto. It refers to the power of the President to withhold his assent to a bill passed by the Parliament. The bill then ends and does not become an act. Usually, this veto is exercised in the following 2 cases. A. With respect to private members' bills, i.e., bills introduced by any member of Parliament who is not a minister. And B. With respect to the government bills when the Cabinet resigns, after the passage of the bills but before the assent by the President, and the new Cabinet advises the President not to give his assent to such bills. In 1954, President Dr. Rajendra Prasad withheld his assent to the PEPSU appropriation. Veto is a Latin word that connotes forbid. President 195. Bill. The bill was passed by the Parliament when the President's rule was in operation in the state of PEPSA 10. But, when the bill was presented to the President for his assent, the President's rule was revoked. Again in 1991, President R. Venkataraman withheld his assent to the salary, allowances and pension of members of Parliament Amendment Bill. The bill was passed by the Parliament on the last day before dissolution of Lok Sabha, without obtaining the previous recommendation of the President. Suspensive veto. The President exercises this veto when Hisha returns a bill for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President, it is obligatory for the President to give his assent to the bill. This means that the presidential veto is overridden by a repassage of the bill by the same ordinary majority and not a higher majority as required in USA. As mentioned earlier, the President does not possess this veto in the case of money bills. The President can either give Hisha assent to a money bill or withhold Hisha assent to a money bill, but cannot return it for the reconsideration of the Parliament. Normally, the President gives Hisha assent to a money bill as it is introduced in the Parliament with Hisha previous permission. Pocket veto. In this case, the President neither ratifies nor rejects nor returns the bill, but simply keeps the bill pending for an indefinite period. This power of the President not to take any action, either positive or negative, on the bill is known as the pocket veto. The President can. LFT the Patiala and East Punjab States Union PEPSU was merged into the Punjab state in 1956. 196 Indian Polity. Exercise this veto power as the Constitution does not prescribe any time limit within which Hisha has to take the decision with respect to a bill presented to him or for his or assent. In USA, on the other hand, the President has to return the bill for reconsideration within 10 days. Hence, it is remarked that the pocket of the Indian President is bigger than that of the American President. In 1986, President Zail Singh exercised the pocket veto with respect to the Indian Post Office Amendment Bill. The bill, passed by the Rajiv Gandhi government, imposed restrictions on the freedom of press and hence was widely criticized. After 3 years, in 1989, the next President R. Venkataraman sent the bill back for reconsideration, but the new National Front government decided to drop the bill. It should be noted here that the President has no veto power in respect of a constitutional amendment bill. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to a constitutional amendment bill. Presidential veto over state legislation. The President has veto power with respect to state legislation also. A bill passed by a state legislature can become an act only if it receives the assent of the governor or the President, in case the bill is reserved for the consideration of the President. When a bill, passed by a state legislature, is presented to the governor for his assent, HUSHA has four alternatives under Article 200 of the Constitution. 1. HUSHA may give his assent to the bill, or 2. HUSHA may withhold his assent to the bill, or 3. HUSHA may return the bill, if it is not a money bill, for reconsideration of the state legislature, or 4. HUSHA may reserve the bill for the consideration of the President. When a bill is reserved by the governor for the consideration of the President has three alternatives under Article 201 of the Constitution. 1. HUSHA may give his assent to the bill, or 2. HUSHA may withhold his assent to the bill, or 3. HUSHA may direct the governor to return the bill, if it is not a money bill, for the reconsideration of the state legislature. If the bill is passed again by the state legislature with or without amendments and presented again to the President for his assent, the President is not bound to give his assent to the bill. This means that the state legislature cannot override the veto power of the President. Further, the Constitution has not prescribed any time limit within which the President has to take decision with regard to a bill reserved by the governor for his/her consideration. Hence, the President can exercise pocket veto in respect of state legislation also. Table 18.2 summarizes the discussion on the veto power of the President with regard to central as well as state legislation. Table 18.2 Veto power of the President at a glance. Central legislation, state legislation. With regard to ordinary bills. 1. Can be ratified. 1. Can be ratified. 2. Can be rejected. 2. Can be rejected. 3. Can be returned. 3. Can be returned. President. Central legislation, state legislation. With regard to money bills. 1. Can be ratified. 1. Can be ratified. 2. Can be rejected, but cannot be returned. 2. Can be rejected, but cannot be returned. With regard to constitutional amendment bills. Can only be ratified, that is, cannot be rejected or returned. Constitutional amendment bills cannot be introduced in the state legislature. Ordinance-making power of the President. Article 123 of the Constitution empowers the President to promulgate ordinances during the recess of Parliament. These ordinances have the same force and effect as an act of Parliament, but are in the nature of temporary laws. The ordinance-making power is the most important legislative power of the President. It has been vested in him/her to deal with unforeseen or urgent matters. But the exercise of this power is subject to the following four limitations. 1. HUSHA can promulgate an ordinance only when both the Houses of Parliament are not in session or when either of the two Houses of Parliament is not in session. An ordinance can also be issued when only one House is in session because a law can be passed by both the Houses and not by one House alone. An ordinance made when both the Houses are in session is void. Thus, the power of the President to legislate by ordinance is not a parallel power of legislation. 2. HUSHA can make an ordinance only when HUSHA is satisfied that the circumstances exist that render it necessary for him/her to take immediate action. In the Cooper case, 1970, the Supreme Court held that the President's satisfaction can be questioned in a court on the ground of malafide. This means that the decision of the President to issue an 11. 12. The definition of law contained in Article 13. Cooper v. Union of India, 1970. Expressly includes ordinances. Ordinance can be questioned in a court on the ground that the President has prorogued one House or both Houses of Parliament deliberately with a view to promulgate an ordinance on a controversial subject, so as to bypass the parliamentary decision and thereby circumventing the authority of the Parliament. The 38th Constitutional Amendment Act of 1975 made the President's satisfaction final and conclusive and beyond judicial review. But this provision was deleted by the 44th Constitutional Amendment Act of 1978. Thus, the President's satisfaction is justiciable on the ground of malafide. 3. His ordinance-making power is coextensive as regards all matters except duration with the law-making powers of the Parliament. This has two implications. A. An ordinance can be issued only on those subjects on which the Parliament can make laws. B. An ordinance is subject to the same constitutional limitation as an act of Parliament. Hence, an ordinance cannot abridge or take away any of the fundamental rights. 12. 4. Every ordinance issued by the President during the recess of Parliament must be laid before both the Houses of Parliament when it reassembles. If the ordinance is approved by both the Houses, it becomes an act. If Parliament takes no action at 198 ex Indian Polity, the ordinance ceases to operate on the expiry of 6 weeks from the reassembly of Parliament. The ordinance may also cease to operate even earlier than the prescribed 6 weeks if both the Houses of Parliament pass resolutions disapproving it. If the Houses of Parliament are summoned to reassemble on different dates, the period of 6 weeks is calculated from the later of those dates. This means that the maximum life of an ordinance can be 6 months and 6 weeks, in case of non-approval by the Parliament, 6 months being the maximum gap between the 2 sessions of Parliament. If an ordinance is allowed to lapse without being placed before Parliament, then the acts done and completed under it, before it ceases to operate, remain fully valid and effective. The President can also withdraw an ordinance at any time. However, his power of ordinance making is not a discretionary power, and Husha can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Prime Minister. An ordinance, like any other legislation, can be retrospective, that is, it may come into force from a backdate. It may modify or repeal any act of Parliament or another ordinance. It can alter or amend a tax law also. However, it cannot be issued to amend the Constitution. The ordinance-making power of the President in India is rather unusual and not found in most of the democratic constitutions of the world, including that of USA and UK. In justification of the ordinance-making power of the President, Dr. B.R. Ambedkar said in the Constituent Assembly that the mechanism of issuing an ordinance has been devised in order to enable the executive to deal with a situation that may suddenly and immediately arise when the Parliament is not in Session 13. It must be clarified here that the ordinance-making power of the President has no necessary connection with the national emergency envisaged in Article 352. The President can issue an ordinance. Constituent Assembly Debates, Volume 8, p. 213. 14d.c. Wadhwa vs. State of Bihar, 1986. Even when there is no war or external aggression or armed rebellion. The rules of Lok Sabha require that whenever a bill seeking to replace an ordinance is introduced in the House, a statement explaining the circumstances that had necessitated immediate legislation by ordinance should also be placed before the House. The Supreme Court's judgment relating to the ordinance-making power of the governor in the D.C. Wadhwa Case 14, 1986, is worth mentioning here. In that case, the court pointed out that between 1967 to 1981, the governor of Bihar promulgated 256 ordinances, and all these were kept in force for periods ranging from 1 to 14 years by repromulgation from time to time. The court ruled that successive repromulgation of ordinances with the same text without any attempt to get the bills passed by the Assembly would amount to violation of the Constitution, and the ordinance so repromulgated is liable to be struck down. It held that the exceptional power of lawmaking through ordinance cannot be used as a substitute for the legislative power of the state legislature. Pardoning power of the President. Article 72 of the Constitution empowers the President to grant pardons to persons who have been tried and convicted of any offense in all cases where the 1. Punishment or sentence is for an offense against a union law. 2. Punishment or sentence is by a court-martial, military court. And 3. Sentence is a sentence of death. The pardoning power of the President is independent of the judiciary. The President, while exercising this power, does not sit as a court of appeal. The object of conferring this judicial power on the President is twofold. A. To keep the door open for correcting any judicial errors in the operation of law. And President 199. B. To afford relief from a sentence which the President regards as unduly harsh. The pardoning power of the President includes the following. 1. Pardon. It removes both the sentence and the conviction and completely absolves the convict from all sentences, punishments, and disqualifications. 2. Commutation. It denotes the substitution of one form of punishment for a lighter form. For example, a death sentence may be commuted to rigorous imprisonment, which in turn may be commuted to a simple imprisonment. 3. Remission. It implies reducing the period of sentence without changing its character. For example, a sentence of rigorous imprisonment for 2 years may be remitted to rigorous imprisonment for 1 year. 4. Respite. It denotes awarding a lesser sentence in place of one originally awarded due to some special fact, such as the physical disability of a convict or the pregnancy of a woman offender. 5. Reprieve. It implies a stay of the execution of a sentence, especially that of death, for a temporary period. Its purpose is to enable the convict to have time to seek pardon or commutation from the President. Under Article 161 of the Constitution, the governor of a state also possesses the pardoning power. Hence, the governor can also grant pardons, reprieves, respites, and remissions of punishment or suspend, remit, and commute the sentence of any person convicted of any offense against a state law. But the pardoning power of the governor differs from that of the President in following 2 respects. 1. The President can pardon sentences inflicted by court-martial, military courts, while the governor cannot. 2. The President can pardon death sentence while governor cannot. Even if a state law prescribes death sentence, the power to grant pardon lies with the President and not the governor. However, the governor can suspend, remit, or commute a death sentence. In other words, both the governor and the President have concurrent power in respect of suspension, remission, and commutation of death sentence. In Kihar Singh case, 1988, the Supreme Court examined the pardoning power of the President and laid down the following principles. 1. The petitioner for mercy has no right to an oral hearing by the President. 2. The President can examine the evidence afresh and take a view different from the view taken by the court. 3. The power is to be exercised by the President on the advice of the Union Cabinet. 4. There is no need for the Supreme Court to lay down specific guidelines for the exercise of power by the President. 5. The exercise of power by the president is not subject to judicial review except where the presidential decision is arbitrary, irrational, mal-fide, or discriminatory. Constitutional position of the president. The Constitution of India has provided for a parliamentary form of government. Consequently, the president has been made only a nominal executive, the real executive being the Council of Ministers headed by the Prime Minister. In other words, the president has to exercise his powers and functions with the aid and advise of the Council of Ministers headed by the Prime Minister. Dr. B.R. Ambedkar summed up the true position of the president in the following way: 14 A. Kehar Singh vs. Union of India, 1988. Constituent Assembly Debates, Volume 7, pp. 32-34. In the Indian Constitution, there is placed at the head of the Indian Union a functionary who is called the President of the Union. The title of the functionary reminds of the President of the United States. But beyond the identity of names, there is nothing in 200p Indian Polity common between the form of government prevalent in America and the form of government adopted under the Indian Constitution. The American form of government is called the presidential system of government, and what the Indian Constitution adopted is the parliamentary system. Under the presidential system of America, the president is the chief head of the executive and administration is vested in him. Under the Indian Constitution, the president occupies the same position as the king under the English Constitution. He is the head of the state but not of the executive. He represents the nation but does not rule the nation. He is the symbol of the nation. His place in administration is that of a ceremonial device or a seal by which the nation's decisions are made known. He is generally bound by the advice of his ministers. He can do nothing contrary to their advice, nor can he do anything without their advice. The President of the United States can dismiss any secretary at any time. The President of the Indian Union has no power to do so, so long as his ministers command a majority in Parliament. In estimating the constitutional position of the President, particular reference has to be made to the provisions of Articles 53, 74, and 75. These are: 1. The executive power of the Union shall be vested in President and shall be exercised by him or either directly or through officers subordinate to him or in accordance with this Constitution, Article 53. 2. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice, Article 74. 3. The Council of Ministers shall be collectively responsible to the Lok Sabha, Article 75. This provision is the foundation of the parliamentary system of government. The 42nd Constitutional Amendment Act of 1976, enacted by the Indira Gandhi government, made the President bound by the advice of the Council of Ministers headed by the Prime Minister. 16. The 44th Constitutional Amendment Act of 1978, enacted by the Janata Party government headed by Morarji Desai, authorized the President to require the Council of Ministers to reconsider such advice either generally or otherwise. However, he/she shall act in accordance with the advice tendered after such reconsideration. In other words, the President may return a matter once for reconsideration of his ministers, but the reconsidered advice shall be binding. L6 in the original Constitution, there was no such specific provision in Article 74. In October 1997, the Cabinet recommended President K.R. Narayanan to impose President's rule under Article 356 in Uttar Pradesh. The President returned the matter for the reconsideration of the Cabinet, which then decided not to move ahead in the matter. Hence, the BJP-led government under Kalyan Singh was saved. Again in September 1998, the President K.R. Narayanan returned a recommendation of the Cabinet that sought the imposition of the President's rule in Bihar. After a couple of months, the Cabinet re-advised the same. It was only then that the President's rule was imposed in Bihar, in February 1999. Though the President has no constitutional discretion, Pusha has some situational discretion. In other words, the President can act on his discretion, that is, without the advice of the ministers, under the following situations: I. Appointment of Prime Minister when no party has a clear majority in the Lok Sabha or when the Prime Minister in office dies suddenly and there is no obvious successor. 2. Dismissal of the Council of Ministers when it cannot prove the confidence of the Lok Sabha. 3. Dissolution of the Lok Sabha if Council of Ministers has lost its majority. President 201. Table 18.3 Articles related to President at a glance. Article No. Subject Matter. 52. The President of India. 53. Executive Power of the Union. 54. Election of President. 55. Manner of election of President. 56. Term of office of President. 57. Eligibility for re-election. 58. Qualifications for election as President. 59. Conditions of President's office. 60. Oath or affirmation by the President. 61. Procedure for impeachment of the President. 62. Time of holding election to fill vacancy in the office of President. 65. Vice President to act as President or to discharge his functions. 71. Matters relating to the election of President. 72. Power of President to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. 74. Council of Ministers to aid and advise the President. 75. Other provisions as to ministers like appointment, term, salaries, etc. 76. Attorney General of India. 77. Conduct of business of the Government of India. 78. Duties of Prime Minister in respect to furnishing of information to the President, etc. 85. Sessions of Parliament, prorogation and dissolution. 111. Assent to bills passed by the Parliament. 112. Union Budget, Annual Financial Statement. 123. Power of President to promulgate ordinances. 143. Power of President to consult Supreme Court. Continued. Table 18.4 Presidential Election, 2022, Value of Votes of Elected MLAs and MPs, 17. SI. No. Name of State Union Territory. Number of Assembly seats, elective. Population, 1971 Census. Value of vote of each MLA. Total value of votes for the state. 1K. This information is obtained from the official website of the Election Commission of India. $1,202 Indian Polity. SI. No. Name of State Union Territory. Number of Assembly seats, elective. Population, 1971 Census. Value of vote of each MLA. Total value of votes for the state. 44,394.29 NCT of Delhi 7406, 569,858,058 by 070. 406030 UT of Puducherry 347170716016 by 030. 480 total 40335430020005 minus 543,231. A. Value of each vote of members of Parliament. Total members, Lok Sabha 543 plus Rajya Sabha 233 equals 776. Value of each vote equals 5 foot 43.31 equals 700. 77b. B. Total value of votes of 776 members of Parliament is equal to 700 times 776 equals 543, 200. C. Total electors for the President election equals MLAs 4033 plus M. PS 776 equals 4,809. D. Total value of votes of 4809 electors for the presidential election 2022 equals 543, 231 plus 543. 200 equals 1086 for 31. Chapter 19 Vice President. Tihi Vice President occupies the second highest office in the country. Husha is accorded a rank next to the President in the official warrant of precedence. This office is modeled on the lines of the American Vice President. T election underscore 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 the Vice President, like the President, is elected not directly by the people but by the method of indirect election. Husha is elected by the members of an electoral college consisting of the members of both houses of Parliament. 1. Thus, this electoral college is different from the electoral college for the election of the President in the following two respects. 1. The original Constitution provided that the Vice President would be elected by the two houses of Parliament assembled at a joint meeting. This cumbersome procedure was done away by the 11th Constitutional Amendment Act of 1961. Constituent Assembly Debates, Volume 7, p. 1001. 1. It consists of both elected and nominated members of the Parliament, in the case of President, only elected members. 2. It does not include the members of the state legislative assemblies. In the case of President, the elected members of the state legislative assemblies are included. Explaining the reason for this difference, Dr. B.R. Ambedkar observed, 2. The President is the head of the state and his power extends both to the administration by the center as well as to the states. Consequently, it is necessary that in his election, not only members of Parliament should play their part, but the members of the state legislatures should have a voice. But, when we come to the Vice President, his normal functions are to preside over the Council of States. It is only on a rare occasion, and that too for a temporary period, that Hisham may be called upon to assume the duties of the President. That being so, it does not seem necessary that the members of the state legislatures should also be invited to take part in the election of the Vice President. But the manner of election is same in both the cases. Thus, the Vice President's election, like that of the President's election, is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. All doubts and disputes in connection with election of the Vice President are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as Vice President cannot be challenged on the ground that the Electoral College was incomplete, i.e., existence of any vacancy among the members of Electoral College. If the election of a person as Vice President is declared void by the Supreme Court, acts done by him or her before the date of such declaration of the Supreme Court are not invalidated, i.e., they continue to remain in force. The various vice presidential elections held so far are summarized in Tabli 19.1. 204p Indian Polity underscore 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 underscore. Table 19.1 Elections of the Vice Presidents, 1952 till now. SI. No. Election. Year. Victorious. Candidate. No. Of votes. Secured. Runner-up candidate. No. Of votes. Secured. 1. 1952 Drive S. Radhakrishnan, unopposed 2. 1957 Drive S. Radhakrishnan, unopposed 3. 1962 Dr. Zakir Hussain 568 N. Samant Singh 14-4. 1967 VV Giri 486 Prof. Habib 192 5. 1969 GS Puttock 400 HV Kamath 156-6. 1974 BE Jutti 521 Ini Horo 141 7. 1979 M. Hidayatullah, unopposed 8. 1984 R. Venkataraman 508 BC Kambali 2079. 1987 Dr. Shankar Dayal Sharma, unopposed 10. 1992 KR Narayanan 700 Kaka Jogindar Singh 0111. 1997 Krishna Kant 441 Surjit Singh Barnala 273-12. 2002 BS Shekhawat 454 Shushil Kumar Shinde 305-13. 2007 Mohammed Hamid Ansari 455 Najma Heptullah 222-14. 2012 Mohammed Hamid Ansari 490 Jaswant Singh 238-15. 2017 Venkayad Naidu 516 Kopal Krishna Gandhi 244-16. 2022 Jagdeep Dhankar 528 Margaret Alva 182. Qualifications, Oath and Conditions. Qualifications TBB eligible for election as Vice President, a person should fulfill the following qualifications. 1. Hisha should be a citizen of India. 2. Hisha should have completed 35 years of age. 3. Hisha should be qualified for election as a member of the Rajya Sabha. 4. Hisha should not hold any office of profit under the union government, or any state government, or any local authority, or any other public authority. But a sitting president or vice president of the union, the governor of any state, and a minister for the union or any state is not deemed to hold any office of profit and hence qualified for being a candidate for vice president. Further, the nomination of a candidate for election to the office of vice president must be subscribed by at least 20 electors as proposers and 20 electors as seconders. Every candidate has to make a security deposit of 15,000 in the Reserve Bank of India. 3. Presidential and Vice Presidential Elections Act, 1952 as amended in 1997. Oath or affirmation. Before entering upon Hisha office, the Vice President has to make and subscribe to an oath or affirmation. In Hisha oath, the Vice President swears, 1. To bear true faith and allegiance to the Constitution of India. And 2. To faithfully discharge the duties of his or office. The oath of office to the Vice President is administered by the President or some person appointed in that behalf by him or her. Conditions of office. The Constitution lays down the following 2 conditions of the Vice President's office. 1. Hisha should not be a member of either House of Parliament or a House of the State Legislature. If any such person is elected as the Vice President, Hisha is deemed to have vacated the seat in that House on the date on which Hisha enters upon the office as Vice President. 2. Hisha should not hold any other office of profit. Term and vacancy. Term of office. The Vice President holds office for a term of 5 years from the date on which Hisha enters upon Hisha office. However, Hisha can resign from Hisha office at any time by addressing the resignation letter to the President. Hisha can also be removed from the office before completion of Hisha term. A formal impeachment is not required for Hisha removal. She can be removed by a resolution passed by a majority of all the then members of the Rajya Sabha and agreed to by the Lok Sabha. This means that this resolution should be passed in the Rajya Sabha by an effective majority and in the Lok Sabha by a simple majority. Further, this resolution can be introduced only in the Rajya Sabha and not in the Lok Sabha. But no such resolution can be moved unless at least 14 days advance notice has been given. Notably, no ground has been mentioned in the Constitution for Hisha removal. The Vice President can hold office beyond Hisha term of 5 years until Hisha's successor assumes charge. Hisha is also eligible for re-election to that office. Hisha may be elected for any number of terms. 4. 5. Krishna Kant was the first Vice President to die in office. When 2 presidents, Dr. Zakir Hussain and Fakhruddin Ali Ahmed, died in office, the then respective Vice Presidents, V.V. Giri and R.D. Jutti acted as President. Dr. 8. Radhakrishnan was elected for a second term. Vice President X 205. Vacancy in office. A vacancy in the Vice President's office can occur in any of the following ways. 1. On the expiry of Hisho tenure of 5 years. 2. By Hisho resignation. 3. On Hisho removal. 4. By Hisho death. 5. Otherwise, for example, when Hisho becomes disqualified to hold office or when Hisho election is declared void. When the vacancy is going to be caused by the expiration of the term of the sitting Vice President, an election to fill the vacancy must be held before the expiration of the term. If the office falls vacant by resignation, removal, death, or otherwise, then election to fill the vacancy should be held as soon as possible after the occurrence of the vacancy. The newly elected Vice President remains in office for a full term of 5 years from the date Hisho assumes charge of Hisho office. T powers and functions ____________. The functions of the Vice President are twofold. 1. Hisho acts as the ex officio chairman of Rajya Sabha. In this capacity, Hisho powers and functions are similar to those of the Speaker of Lok Sabha. In this respect, Hisho resembles the American Vice President, who also acts as the chairman of the Senate, the upper house of the American legislature. 2. Hisho acts as president when a vacancy occurs in the office of the president due to Hisho resignation, impeachment, death, or otherwise. Hisho can act as president only for a maximum period of 6 months within which a new president has to be elected. Further, when the sitting president is unable to discharge. 6206 Indian Polity. Hisho functions due to absence, illness, or any other cause, the Vice President discharges Hisho functions until the President resumes Hisho office. 7. The Vice President, Drive S. Radhakrishnan discharged the functions of the President in June 1960, when the then-President Dr. Rajendra Prasad was on a 15-day tour to the USSR, and again in July 1961, when Hisho, Dr. Rajendra Prasad, was very ill. 8v the Finance Act, 2018, with effect from January 1, 2016. This act amended the Salaries and Allowances of Officers of Parliament Act, 1953. The Vice President's Pension Amendment Act, 2008. This act amended the Vice President's Pension Act, 1997. While acting as President or discharging the functions of President, the Vice President does not perform the duties of the office of the Chairman of Rajya Sabha. During this period, those duties are performed by the Deputy Chairman of Rajya Sabha. The Constitution has not fixed any emoluments for the Vice President in that capacity. Hisho draws Hisho regular salary in his/her capacity as the ex officio chairman of the Rajya Sabha. In 2018, the Parliament increased the salary of the chairman of the Rajya Sabha from 1.25 lakh to lakh per month. 8. Earlier in 2008, the pension of the retired Vice President was increased from 20,000 per month to 50% of Hisho's salary per month. 9. In addition, Hisho is entitled to daily allowance, free furnished residence, medical, travel, and other facilities. During any period when the Vice President acts as President or discharges the functions of the President, Hisho is not entitled to the salary or allowance payable to the Chairman of Rajya Sabha, but the salary and allowance of the President. Indian and American Vice Presidents compared. Though the office of the Indian Vice President is modeled on the lines of the American Vice President, there is a difference. The American Vice President succeeds to the presidency when it falls vacant and remains President for the unexpired term of Hisho predecessor. The Indian Vice President, on the other hand, does not assume the office of the President when it falls vacant for the unexpired term. Hisho merely serves as an acting President until the new President assumes charge. It is evident that the Constitution has not assigned any significant function to the Vice President in that capacity. Hence, some scholars call him His Superfluous Highness. This office was created with a view to maintain the political continuity of the Indian state. Table 19.2 Articles related to Vice President at a glance. Article No. Subject Matter 63. The Vice President of India. 64. The Vice President to be ex officio Chairman of the Council of States. 65. The Vice President to act as President or to discharge Hisho functions during casual vacancies in the office or during the absence of President. 66. Election of Vice President. 67. Term of office of Vice President. 68. Time of holding election to fill vacancy in the office of Vice President and the term of office of person elected to fill casual vacancy. 69. Oath or affirmation by the Vice President. 70. Discharge of President's functions and other contingencies. 71. Matters relating to or connected with the election of Vice President. Chapter 20 Prime Minister. In the scheme of parliamentary system of government provided by the Constitution, the President is the nominal executive authority, de jure executive, and Prime Minister is the real executive authority, de facto executive. In other words, President is the head of the state while Prime Minister is the head of the government. Appointment of the Prime Minister __________________________________________________________________________________________________________________ The Constitution does not contain any specific procedure for the selection and appointment of the Prime Minister. Article 75 says only that the Prime Minister shall be appointed by the President. However, this does not imply that the President is free to appoint anyone as the Prime Minister. In accordance with the conventions of the parliamentary system of government, the president has to appoint the leader of the majority party in the Lok Sabha as the prime minister. But when no party has a clear majority in the Lok Sabha, then the president may exercise her personal discretion in the selection and appointment of the prime minister. In such a situation, the president usually appoints the leader of the largest party or coalition in the Lok Sabha as the prime minister and asks him to seek a vote of confidence in the House within a month. This discretion was exercised by the president for the first time in 1979 when Neelam Sanjeeva Reddy, the then president, appointed Charan Singh, the coalition leader, as the prime minister. After the fall of the Janata Party government headed by Morarji Desai. There is also one more situation when the president may have to exercise his individual judgment in the selection and appointment of the prime minister, that is, when the prime minister in office dies suddenly and there is no obvious successor. This is what happened when Indira Gandhi was assassinated in 1984. The then President Zail Singh appointed Rajiv Gandhi as the prime minister by ignoring the precedent of appointing a caretaker prime minister. Later on, the Congress Parliamentary Party unanimously elected him as its leader. However, if, on the death of an incumbent prime minister, the ruling party elects a new leader, the president has no choice but to appoint him as prime minister. On the death of Jawaharlal Nehru and Lal Bahadur Shastri when the leadership was contested, the president made temporary arrangements by appointing the senior-most minister as the prime minister until the formal election of the leader by the party. Both the times, it was Gulzari Lal Nanda who acted as the prime minister. In 1980, the Delhi High Court held that the Constitution does not require that a person must prove his majority in the Lok Sabha before Husha is appointed as the prime minister. The president may first appoint him as the prime minister and then ask him to prove his majority in the Lok Sabha within a reasonable period. For example, Charan Singh, 1979, VP Singh, 1989, Chandrasekhar, 1990, 208Y, Indian Polity. R.V. Narasimha Rao, 1991, A.B. Vajiyappi, 1996, Deve Gowda, 1996, L.K. Gujral, 1997, and again A.B. Vajpayee, 1998, were appointed as prime ministers in this way. In 1997, the Supreme Court held that a person who is not a member of either House of Parliament can be appointed as prime minister for 6 months, within which she should become a member of either House of Parliament. Otherwise, Husha ceases to be the prime minister. Constitutionally, the prime minister may be a member of any of the 2 houses of parliament. For example, 3 prime ministers, Indira Gandhi, 1966, Deve Gowda, 1996, and Manmohan Singh, 2004, were members of the Rajya Sabha. In Britain, on the other hand, the prime minister should definitely be a member of the lower house, House of Commons. TOTH, term and salary before the prime minister enters upon his office, the president administers to him the oaths of office and secrecy. To an his oath of office, the prime minister swears. 2. The form of oath of office and secrecy for the prime minister is similar to that for any union minister. 3. For example, VP Singh in 1990 and Deve Gowda in 1997 resigned after defeat in the Lok Sabha. 3. The Salaries and Allowances of Ministers Act, 1952, has been passed for this purpose. 3b. The Salaries and Allowances of Ministers Amendment Act, 2001. 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. 3. To faithfully and conscientiously discharge the duties of his office. And 4. To do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. In his oath of secrecy, the Prime Minister swears that his will not directly or indirectly communicate or reveal to any persons any matter that is brought under his consideration or becomes known to him or as a Union Minister except as may be required for the due discharge of his duties as such minister. The term of the Prime Minister is not fixed and Husha holds office during the pleasure of the President. However, this does not mean that the President can dismiss the Prime Minister at any time. So long as the Prime Minister enjoys the majority support in the Lok Sabha, Husha cannot be dismissed by the President. However, if Husha loses the confidence of the Lok Sabha, Husha must resign or the President can dismiss him or. 3. The salary and allowances of the Prime Minister are determined by the Parliament from time to time. 3d. Husha gets the salary and allowances that are payable to a Member of Parliament. Additionally, Husha gets a sumptuary allowance, free accommodation, traveling allowance, medical facilities, etc. In 2001, the Parliament increased the sumptuary allowance from ₹1,500 to ₹3,000 per month. Powers and functions of the Prime Minister. The powers and functions of Prime Minister can be studied under the following heads. In relation to Council of Ministers, the Prime Minister enjoys the following powers as head of the Union Council of Ministers. 1. Husha recommends persons who can be appointed as ministers by the President. The President can appoint only those persons as ministers who are recommended by the Prime Minister. 2. Husha allocates and reshuffles various portfolios among the ministers. 3. Husha can ask a minister to resign or advise the President to dismiss him or in case of difference of opinion. 4. Husha presides over the meeting of Council of Ministers and influences its decisions. 5. Hisha guides, directs, controls, and coordinates the activities of all the ministers. Prime Minister 209. 6. Hisha can bring about the collapse of the Council of Ministers by resigning from office. Since the Prime Minister stands at the head of the Council of Ministers, the other ministers cannot function when the Prime Minister resigns or dies. In other words, the resignation or death of an incumbent Prime Minister automatically dissolves the Council of Ministers and thereby generates a vacuum. The resignation or death of any other minister, on the other hand, merely creates a vacancy which the Prime Minister may or may not like to fill. In relation to the President, the Prime Minister enjoys the following powers in relation to the President. 1. Hisha is the principal channel of communication between the President and the Council of Ministers. It is the duty of the Prime Minister. 4. A. To communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. B. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for. And C. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister, but which has not been considered by the Council. 2. Hisha advises the President with regard to the appointment of important officials like Attorney General of India, Comptroller and Auditor General of India, Chairman and members of the UPSC, Election Commissioners, Chairman and members of the Finance Commission, and so on. For Article 78 specifically deals with this function of the Prime Minister. In relation to Parliament, the Prime Minister is the leader of the lower house. In this capacity, Hisha enjoys the following powers. 1. Hisha advises the President with regard to summoning and proroguing of the sessions of the Parliament. 2. Hisha can recommend dissolution of the Lok Sabha to President at any time. 3. Hisha announces government policies on the floor of the House. Other powers and functions. In addition to the above-mentioned three major roles, the Prime Minister has various other roles. These are: 1. Hisha is the chairman of the Niti Aayog, which succeeded the Planning Commission, National Integration Council, Interstate Council, National Water Resources Council, and some other bodies. 2. Hisha plays a significant role in shaping the foreign policy of the country. 3. Hisha is the chief spokesman of the Union government. 4. Hisha is the crisis manager-in-chief at the political level during emergencies. 5. As a leader of the nation, Hisha meets various sections of people in different states and receives memoranda from them regarding their problems, and so on. 6. Hisha is leader of the party in power. 7. Hisha is political head of the services. Thus, the Prime Minister plays a very significant and highly crucial role in the politico-administrative system of the country. Dr. B.R. Ambedkar stated, "If any functionary under our Constitution is to be compared with the U.S. President, he is the Prime Minister and not the President of the Union." Role descriptions. The various comments made by the eminent political scientists and constitutional experts on the role of Prime Minister in Britain holds 210 Indian polity. Good in the Indian context also. These are mentioned below. Lord Morley, he described Prime Minister as primus inter pares, first among equals, and keystone of the cabinet arch. He said, "The head of the cabinet is primus inter pares, and occupied a position which, so long as it lasts, is one of exceptional and peculiar authority." Herbert Marrison, as the head of the government, he, Prime Minister, is primus inter pares. But it is today for too modest an appreciation of the Prime Minister's position. Sir William Verner Harcourt, he described Prime Minister as inter stellis luna minoris, a moon among lesser stars. Jennings, he is, rather, a sun around which planets revolve. He is the keystone of the Constitution. All roads in the Constitution lead to the Prime Minister. H.J. Lasky on the relationship between the Prime Minister and the Cabinet, he said that the Prime Minister is central to its formation, central to its life, and central to its death. He described him as the pivot around which the entire governmental machinery revolves. H.R.G. Greaves, the government is the master of the country and he, Prime Minister, is the master of the government. Monroe, he called Prime Minister as the captain of the ship of the state. Ramsay Muir, he described Prime Minister as the steersman of steering wheel of the ship of the state. The role of the Prime Minister in the British parliamentary government is so significant and crucial that observers like to call it a prime ministerial government. Thus, R.H. Crossman says, the post-war epoch has been the final transformation of cabinet government into prime ministerial government. Similarly, Humphrey Berkeley points out, Parliament is not, in practice, sovereign. The parliamentary democracy has now collapsed at Westminster. The basic defect in the British system of governing is the superministerial powers of the Prime Minister. The same description holds good to the Indian context too. Relationship with the President the following provisions of the Constitution deal with the relationship between the President and the Prime Minister. 1. Article 74. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. However, the President may require the Council of Ministers to reconsider such advice, and the President shall act in accordance with the advice tendered after such reconsideration. 2. Article 75. A. The Prime Minister shall be appointed by the President, and the other ministers shall be appointed by the President on the advice of the Prime Minister. B. The ministers shall hold office during the pleasure of the President. And C. The Council of Ministers shall be collectively responsible to the House of the People. 3. Article 78. It shall be the duty of the Prime Minister. A. To communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. B. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for. And C. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chief Ministers who became Prime Ministers. 6. People Morarji Desai, Charan Singh, V.P. Singh, P.V. Narasimha Rao, H.D. Deve Gowda, and Narendra Modi became Prime Ministers after being Chief Ministers of their respective states. Morarji Desai, Chief Minister of the erstwhile Bombay State during 1952-56, became the first non-Congress Prime Minister in March 1977. Charan Singh, who succeeded him, was the Chief Minister of the undivided Uttar Pradesh in 1967-1968 and again in 1970. V.P. Singh, also from UP, became Prime Minister in the short-lived National Front government, December 1989 to November 1990. P.V. Narasimha Rao, the first Prime Minister from South India, who held the post from 1991 to 1996, was Chief Minister of Andhra Pradesh between 1971 to 1973. H.D. Deve Gowda was Chief Minister of Karnataka when he was chosen to lead the United Front government in June 1965. 6. J.C. Johari, Indian Government and Policies, Vishal Publications, Volume 2, 13th edition 2001, p. 729. Subhash C. Kashyap, Our Constitution, National Book Triest, 5th edition, 2011, p. 203. 8. This Committee on Electoral Reforms was appointed in 1974 by Jayaprakash Narayan, J.P., during his Tital Revolution movement. It was headed by Justice Vithal Mahadio Thurkand. This unofficial committee submitted its report in 1975. It was also known as J.P. Committee. Narendra Modi, BJP, was the Chief Minister of Gujarat when he became the Prime Minister in May 2014. He served as the Chief Minister of Gujarat for 4 times during 2001 to 2014. Caretaker Government. The Constitution of India does not contain any provision for a caretaker government. It is only a situational arrangement and a functional necessity. Meaning the following points clearly doing out the meaning of a caretaker government. 1. The creation of a caretaker government after the dissolution of the popular chamber of the Parliament and its termination with the induction of a new ministry after the general election is an essential feature of the parliamentary system of government in operation. The Hindu, April 6, 2009. Prime Minister 34211. Such a government is enjoined upon to hold free and fair polls so that a new popular government comes into being. 6. 2. The term, caretaker government, has come to be used in common parlance to describe the status of a council of ministers that has resigned on having lost the confidence of the Lok Sabha or otherwise, but is asked by the President to continue till alternative arrangements are made. If an alternative government cannot be formed immediately and general elections have to be held, the outgoing council of ministers may have to hold charge till the conclusion of elections and formation of new government. 7. Limited role. Unlike a regular government, a caretaker government is meant for only managing the routine activities of the government. Hence, it is not expected to make any significant policy decisions or initiate new measures and schemes except those relating to national security or national interest. The following comments and observations highlight the limited role of a caretaker government in the governance of the country. 1. The Thurkand Committee, 1974-75, recommended that a caretaker government should not I. Initiate and announce new policies. 2. Promise or start new projects. 3. Grant allowances or loans, salary increases. And 4. Hold official functions attended by ministers. 8. 212 Indian Polity. 2. In August 1979, the then President N. Sanjeeva Reddy, while dissolving the Lok Sabha, issued a communique stating that the President had consultations with the Prime Minister and some of his cabinet colleagues who assured that elections will be peaceful, free and fair. The revision of the electoral rolls will begin immediately and the election timetable will commence in November 1979 and will be completed by December 1979. 2. The government will not take decisions during this period which set new policies or involve new spending of a significant order or constitute measures of administrative or executive decisions. However, Work of an urgent nature involving the national interest will not be held up. 3. The Calcutta High Court in a judgment delivered in December 1979 observed that there is no mention of a caretaker government as such in our Constitution, but such an extraordinary situation calls for a caretaker government and, therefore, the Prime Minister and the Council of Ministers can, in such a situation, only carry on day-to-day administration in office, which are necessary for carrying on for the sake of making an alternative arrangement. 4. The caretaker Prime Ministers are constrained for 2 reasons. First, the normal channel of accountability through Parliament does not exist. Second, the government does not abuse its position to gain electoral advantage. 1. 9. Rajiv Devan, caretaker despotism, is the president meddling? The Sunday Times of India, New Delhi, August 15, 1999, p. 16. Table 20.1 Articles related to Prime Minister at a glance. Article No. Subject Matter. 74. Council of Ministers to aid and advise President. 75. Other provisions as to ministers. 77. Conduct of business of the Government of India. 78. Duties of Prime Minister as respects the furnishing of information to the President, etc. 88. Rights of Ministers as respects the House's Central Council of Ministers. Chapter A.S. The Constitution of India provides for a parliamentary system of government modelled on the British pattern. The Council of Ministers headed by the Prime Minister is the real executive authority is our politico-administrative system. The principles of parliamentary system of government are not detailed in the Constitution, but 2 articles, 74 and 75, deal with them in a broad, sketchy, and general manner. Article 74 deals with the status of the Council of Ministers, while Article 75 deals with the appointment, tenure, responsibility, qualification, oath, and salaries and allowances of the ministers. Constitutional provisions. Article 74, Council of Ministers to aid and advise President. 1. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise officer functions, act in accordance with such advice. However, the President may require the Council of Ministers to reconsider such advice, and the President shall act in accordance with the advice tendered after such reconsideration. 2. The advice tendered by ministers to the President shall not be inquired into in any court. Article 75, Other provisions as to ministers. 1. The Prime Minister shall be appointed by the President, and the other ministers shall be appointed by the President on the advice of the Prime Minister. 2. The total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. This provision was added by the 91st Amendment Act of 2003. 3. A member of either House of Parliament belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. This provision was also added by the 91st Amendment Act of 2003. 4. The ministers shall hold office during the pleasure of the President. 5. The Council of Ministers shall be collectively responsible to the Lok Sabha. 6. The President shall administer the oaths of office and secrecy to a minister. 7. A minister who is not a member of the Parliament, either House, for any period of 6 consecutive months shall cease to be a minister. 8. The salaries and allowances of ministers shall be determined by the Parliament. Article 77, Conduct of Business of the Government of India. 1. All executive action of the Government of India shall be expressed to be taken in the name of the President. 2. Orders and other instruments made and executed in the name of the President shall be authenticated in such manner 214 JRL Indian Polity, as may be specified in rules to be made bv the President. Further, the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. 3. The President shall make rules for the more convenient transaction of the business of the Government of India, and for the allocation among ministers of the said business. Article 78, Duties of Prime Minister. It shall be the duty of the Prime Minister 1. 10. Communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. 2. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for. 3. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Article 88. Rights of Ministers as respects the Houses. Every minister shall have the right to speak and take part in the proceedings of either House, any joint sitting of the Houses, and any committee of Parliament of which he may be named a member. But he shall not be entitled to vote. Nature of advice by ministers underscore 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 underscore. Article 74 provides for a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. The 42nd and 44th Constitutional Amendment Acts have made the advice binding on the President. 1. Further, the nature of advice tendered by ministers to the President cannot be inquired by any court. This provision emphasizes the intimate and the confidential relationship between the president and the ministers. This article was amended by the 42nd Constitutional Amendment Act of 1976 to the effect that the president shall, in the exercise office functions, act in accordance with the advice rendered by the Council of Ministers. The 44th Constitutional Amendment Act of 1978 further added a proviso to this article to the effect that the president may require the Council of Ministers to reconsider such advice, and the president shall act in accordance with the advice tendered after such reconsideration. Lal. Inner Rao vs. Indira Gandhi, 1971. L.B. Shamsher Singh vs. State of Punjab, 1974. In Unna Rao Case 1-1, 1971, the Supreme Court held that, even after the dissolution of the Lok Sabha, the Council of Ministers does not cease to hold office. Article 74 is mandatory and, therefore, the President cannot exercise the executive power without the aid and advice of the Council of Ministers. Any exercise of executive power without the aid and advice will be unconstitutional as being violative of Article 74-H. Again in Shamsher Singh Kaselb, 1974, the court held that, wherever the Constitution requires the satisfaction of the President, the satisfaction is not the personal satisfaction of the President, but it is the satisfaction of the Council of Ministers with whose aid and on whose advice the President exercises his powers and functions. T. Appointment of Ministers. The Prime Minister is appointed by the President, while the other ministers are appointed by the President on the advice of the Prime Minister. This means that the President can appoint only those persons as ministers who are recommended by the Prime Minister. Usually, the members of Parliament, either Lok Sabha or Rajya Sabha, are appointed as ministers. A person who is not a member of either House of Parliament can also be appointed Central Council of Ministers 215 as a minister. But, within 6 months, Husha must become a member, either by election or by nomination, of either House of Parliament, otherwise, Husha ceases to be a minister. A minister who is a member of one House of Parliament has the right to speak and to take part in the proceedings of the other House also, but Husha can vote only in the House of which Husha is a member. T. Oath and Salary T. of Ministers. Before a minister enters upon his office, the President administers to him/her the oaths of office and secrecy. In his oath of office, the minister swears, 1. To bear true faith and allegiance to the Constitution of India, 2. To uphold the sovereignty and integrity of India, 3. To faithfully and conscientiously discharge the duties of his office, and 4. To do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. In his oath of secrecy, the minister swears that Hisha will not directly or indirectly communicate or reveal to any persons any matter that is brought under Hisha consideration or becomes known to him/her as a union minister except as may be required for the due discharge of Hisha duties as such minister. In 1990, the oath by Devi Lal as Deputy Prime Minister was challenged as being unconstitutional as the Constitution provides only for the Prime Minister and ministers. The Supreme Court upheld the oath as valid and stated that describing a person as Deputy Prime Minister is descriptive only and such description does not confer on him/her any powers of Prime Minister. It ruled that the description of a minister as Deputy Prime Minister or any other type of minister such as Minister of State or Deputy Minister of which there is no mention in the Constitution does not vitiate the oath taken by him/her so long as the substantive part of the oath is correct. The salaries and allowances of ministers are determined by Parliament from time to time. 23A minister gets the salary and allowances that are payable to a member of Parliament. Additionally, Husha gets a sumptuary allowance, according to Hisha rank, free accommodation, traveling allowance, medical facilities, etc. In 2001, the sumptuary allowance for the Prime Minister was raised from L. 500 to 3,000 per month, for a cabinet minister from L. 000 to 2,000 per month, for a minister of state from 500 to 1,000 per month, and for a deputy minister from 300 to 600 per month. 2. The Salaries and Allowances of Ministers Act, 1952, has been passed for this purpose. The Salaries and Allowances of Ministers, Amendment, Act, 2001. 3. Each minister need not resign separately. The resignation of the Prime Minister amounts to the resignation of the entire Council of Ministers. T. Responsibility of ministers. Collective responsibility. The fundamental principle underlying the working of parliamentary system of government is the principle of collective responsibility. Article 75 clearly states that the Council of Ministers is collectively responsible to the Lok Sabha. This means that all the ministers own joint responsibility to the Lok Sabha for all their acts of omission and commission. They work as a team and swim or sink together. When the Lok Sabha passes a no-confidence motion against the Council of Ministers, all the ministers have to resign, including those ministers who are from the Rajya Sabha. Alternatively, the Council of Ministers can advise the President to dissolve the Lok Sabha on the ground that the House does not represent the views of the electorate faithfully and call for fresh elections. The President may not oblige the Council of Ministers that has lost the confidence of the Lok Sabha. 216 Indian Polity. The principle of collective responsibility also means that the cabinet decisions bind all cabinet ministers and other ministers, even if they differed in the cabinet meeting. It is the duty of every minister to stand by cabinet decisions and support them both within and outside the parliament. If any minister disagrees with a cabinet decision and is not prepared to defend it, Husha must resign. Several ministers have resigned in the past owing to their differences with the cabinet. For example, Dr. B.R. Ambedkar resigned because of his differences with his colleagues on the Hindu Code Bill in 1953. C.D. Deshmukh resigned due to his differences on the policy of reorganization of states. Arif Muhammad resigned due to his opposition to the Muslim Women Protection of Rights on Divorce Act, 1986. Individual Responsibility Article 75 also contains the principle of individual responsibility. It states that the ministers hold office during the pleasure of the president, which means that the president can remove a minister even at a time when the Council of Ministers enjoys the confidence of the Lok Sabha. However, the president removes a minister only on the advice of the prime minister. In case of a difference of opinion or dissatisfaction with the performance of a minister, the prime minister can ask him or her to resign or advise the president to dismiss him or her. By exercising this power, the prime minister can ensure the realization of the rule of collective responsibility. In this context, Dr. B.R. Ambedkar observed, collective responsibility can be achieved only through the instrumentality of the prime minister. Therefore, unless and until we create that office and endow that office with statutory authority to nominate and dismiss ministers, there can be no collective responsibility. 4. Constituent Assembly Debates, Volume 8, p. 1160. No legal responsibility in Britain. Every order of the king for any public act is countersigned by a minister. If the order is in violation of any law, the minister would be held responsible and would be liable in the court. The legally accepted phrase in Britain is, the king can do no wrong. Hence, Husha cannot be sued in any court. In India, on the other hand, there is no provision in the constitution for the system of legal responsibility of a minister. It is not required that an order of the president for a public act should be countersigned by a minister. Moreover, the courts are barred from inquiring into the nature of advice rendered by the ministers to the president. Composition of the Council of Ministers. The Council of Ministers consists of 3 categories of ministers, namely, cabinet ministers, ministers of state, and deputy ministers. The difference between them lies in their respective ranks, emoluments, and political importance. At the top of all these ministers stands the prime minister, the supreme governing authority of the country. At times, the Council of Ministers may also include a deputy prime minister. The deputy prime ministers are appointed mostly for political reasons. The cabinet ministers head the important ministries of the central government like home, defense, finance, external affairs, and so forth. They are members of the cabinet, attend its meetings, and play an important role in deciding policies. Thus, their responsibilities extend over the entire gamut of central government. The ministers of state can either be given independent charge of ministries' departments or can be attached to cabinet ministers. In case of attachment, they may either be given the charge of departments of the ministries headed by the cabinet ministers or allotted specific items of work related to the ministries headed by cabinet ministers. In both the cases, they work under the supervision and guidance as well as under the overall charge and responsibility of the cabinet ministers. In case of independent charge, they perform the same functions and exercise the same powers in relation to their ministries' departments as cabinet ministers do. However, they are not members of the cabinet and do not attend the cabinet meetings unless specially invited when something related to their ministries' departments are considered by the cabinet. Next in rank are the deputy ministers. They are not given independent charge of ministries' departments. They are attached. Central Council of Ministers 217. To the cabinet ministers or ministers of state and assist them in their administrative, political, and parliamentary duties. They are not members of the cabinet and do not attend cabinet meetings. It must also be mentioned here that there is one more category of ministers, called parliamentary secretaries. But they are not the members of the Council of Ministers. They are appointed by the Prime Minister and not by the President. 5. They have no department. 5. Study Report on Parliamentary Secretary, Ministry of Parliamentary Affairs, 1997, p. 3 and p. 9. R. Table 21.1 Distinction between Council of Ministers and Cabinet. Council of Ministers Cabinet 1. It is a wider body. 1. It is a smaller body. 2. It includes all the 3 categories of ministers, that is, cabinet ministers, ministers of state, and deputy ministers. 2. FT includes the cabinet ministers only. Thus, it is a part of the Council of Ministers. 3. It does not meet as a body to transact government business. It has no collective functions. 3. It meets as a body frequently and usually once in a week to deliberate and take decisions regarding the transaction of government business. Thus, it has collective functions. 4. It is vested with all powers but in theory. 4. It exercises, in practice, the powers of the Council of Ministers and thus acts for the latter. 5. Its functions are determined by the cabinet. 5. It directs the Council of Ministers by taking policy decisions which are binding on all ministers. 6. It implements the decisions taken by the cabinet. 6. It supervises the implementation of its decisions by the Council of Ministers. 7. It is a constitutional body, dealt in detail by the Articles 74 and 75 of the Constitution. Its size and classification are, however, not mentioned in the Constitution. Its size is determined by the Prime Minister according to the exigencies of the time and requirements of the situation. But, as provided by the 91st Constitutional Amendment Act of 2003, its maximum size should not exceed 15% of the total strength of the Lok Sabha. Its classification into a three-tier body is based on the conventions of parliamentary government as developed in Britain. It has, however, got a legislative sanction. Thus, the Salaries and Allowances of Ministers Act of 1952 defines a minister as a member of the Council of Ministers, by whatever name called, and includes a deputy minister. 7. It was inserted in Article 352 of the Constitution in 1978 by the 44th Constitutional Amendment Act. Thus, it did not find a place in the original text of the Constitution. Now also, Article 352 only defines the cabinet, saying that it is the council consisting of the Prime Minister and other ministers of cabinet rank appointed under Article 75, and does not describe its powers and functions. In other words, its role in our politico-administrative system is based on the conventions of parliamentary government as developed in Britain. 8. It is collectively responsible to the lower house of the Parliament. 8. It enforces the collective responsibility of the Council of Ministers to the lower house of Parliament. 2.18.0 Indian Polity. Under their control. They are attached to the senior ministers and assist them in the discharge of their parliamentary duties. T. Council of Ministers versus Cabinet. The words Council of Ministers and Cabinet are often used interchangeably, though there is a definite distinction between them. They differ from each other in respects of composition, functions, and role. These differences are shown in BLE 21.1. T. Role of Cabinet underscore 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 1. It is the highest decision-making authority in our politico-administrative system. 2. It is the chief policy formulating body of the central government. 3. It is the supreme executive authority of the central government. 4. It is chief coordinator of central administration. 5. It is an advisory body to the president, and its advice is binding on him. 6. It is the chief crisis manager and thus deals with all emergency situations. 7. It deals with all major legislative and financial matters. 8. It exercises control over higher appointments like constitutional authorities and senior secretariat administrators. 9. It deals with all foreign policies and foreign affairs. T. Role descriptions underscore 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 the various comments made by the eminent political scientists and constitutional experts on the role of cabinet in Britain holds good in the Indian context also. These are mentioned below. Ramsay Muir, the cabinet is the steering wheel of the ship of the state. Lowell, the cabinet is the keystone of the political arch. Sir John Marriott, the cabinet is the pivot around which the whole political machinery revolves. Gladstone, the cabinet is the solar orb around which the other bodies revolve. Barker, the cabinet is the magnet of policy. Bagehot, the cabinet is a hyphen that joins, the buckle that binds the executive and legislative departments together. Sir Ivor Jennings, the cabinet is the core of the British constitutional system. It provides unity to the British system of government. L.S. Amory, the cabinet is the central directing instrument of government. The position of the cabinet in the British government has become so strong that Ramsay Muir referred to it as the dictatorship of the cabinet. In his book, How Britain is Governed, he writes, a body which wields such powers as these may fairly be described as omnipotent. In theory, however, incapable it may be of using its omnipotence. Its position, whenever it commands a majority, is a dictatorship only qualified by publicity. This dictatorship is far more absolute than it was 2 generations ago. The same description holds good in the Indian context too. F. Kitchen Cabinet underscore 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 the cabinet. A small body consisting of the Prime Minister as its head and the cabinet ministers is the highest decision-making body in the formal sense. However, a still smaller body called the Inner Cabinet, or Kitchen Cabinet, has become the real center of power. This informal body consists of the Prime Minister and a few influential colleagues in whom Husha has faith and with whom Husha can discuss every problem. It advises the Prime Minister on important political and administrative issues and assists him in making crucial decisions. It is composed of not only cabinet ministers but also outsiders like friends and family members of the Prime Minister. Every Prime Minister in India has had his/her inner cabinet, a circle within a circle. During the era of Indira Gandhi, the inner cabinet, which came to be called the Kitchen Cabinet, was particularly powerful. The Prime Ministers have resorted to the device of inner cabinet, extra-constitutional body, due to its merits, namely, 1. It being a small unit is much more efficient decision-making body than a large cabinet. 2. It can meet more often and deal with business much more expeditiously than the large cabinet. 3. It helps the Prime Minister in maintaining secrecy and making decisions on important political issues. Central Council of Ministers 219. However, it has many demerits also. Thus, 6. 6 Avasthi and Avasthi, Indian Administration, Laxminarayan Agarwal, 1st edition, 1993, p. 79. 1. It reduces the authority and status of the cabinet as the highest decision-making body. 2. It circumvents the legal process by allowing outside persons to play an influential role in the government functioning. The phenomenon of kitchen cabinet, where decisions are cooked and placed before the cabinet for formal approval, is not unique to India. It also exists in USA and Britain and is quite powerful in influencing government decisions there. Table 21.2 Articles related to Central Council of Ministers at a glance. Article No. Subject Matter. 74. Council of Ministers to aid and advise President. 75. Other provisions as to ministers. 77. Conduct of business of the Government of India. 78. Duties of Prime Minister as respects the furnishing of information to the President, etc. 88. Rights of Ministers as respects the Houses Chapter 22 Cabinet Committees. TE Cabinet works through various committees. These committees are called as Cabinet Committees. The features, list, and functions of these committees are explained below. Features of Cabinet Committees. The following are the features of Cabinet Committees. 1. They are extra-constitutional in emergence. In other words, they are not mentioned in the Constitution. However, the rules of business provide for their establishment. 2. They are of two types, standing and ad hoc. The former are of a permanent nature, while the latter are of a temporary nature. The ad hoc committees are constituted from time to time to deal with special problems. They are disbanded after their task is completed. 1.3. They are set up by the Prime Minister according to the exigencies of the time and requirements of the situation. Hence, their number, nomenclature, and composition varies from time to time. 4. Their membership varies from one committee to another committee. They usually include only cabinet ministers. Sometimes, the non-cabinet ministers can also be appointed as their members. Further, the non-cabinet ministers can also attend the meetings of the cabinet committees as special invitees. At present, the following 8 cabinet committees are functional. 1. Cabinet Committee on Political Affairs 2. Cabinet Committee on Economic Affairs 3. Appointments Committee of the Cabinet 4. Cabinet Committee on Parliamentary Affairs 5. Cabinet Committee on Security 6. Cabinet Committee on Accommodation 7. Cabinet Committee on Investment and Growth 8. Cabinet Committee on Employment and Skill Development. For example, the Emergency Committee was set up in 1962 after the Chinese invasion. 5. They not only include the ministers in charge of subjects covered by them, but also include other senior ministers. 6. They are mostly headed by the Prime Minister. Sometimes other senior cabinet ministers also act as their chairman. But, in case the Prime Minister is a member of a committee, Husha invariably presides over it. 7. They not only sort out issues and formulate proposals for the consideration of the cabinet, but also take decisions. However, the cabinet can review their decisions. 8. They are an organizational device to reduce the enormous workload of the cabinet. They also facilitate in-depth examination of policy issues and effective coordination. They are based on the principles of division of labor and effective delegation. F. List of Cabinet Committees. Cabinet Committees 221. Functions of Cabinet Committees. The following are the functions of the Cabinet Committees. 1. The Cabinet Committee on Political Affairs deals with all policy matters pertaining to domestic and foreign affairs. 2. The Cabinet Committee on Economic Affairs directs and coordinates the governmental activities in the economic sphere. 3. The Appointments Committee of the Cabinet decides all higher-level appointments in the Central Secretariat, public enterprises, banks, and financial institutions. 4. The Cabinet Committee on Parliamentary Affairs looks after the progress of government business in the Parliament. 5. The Cabinet Committee on Security deals with all issues relating to defense, law and order, internal security, and atomic energy. 6. The Cabinet Committee on Accommodation deals with all issues regarding the allotment of government accommodation to the members of Parliament, central government employees, other persons, and various organizations. 7. The Cabinet Committee on Investment and Growth deals with all policy matters aimed at accelerating capital inflows, export promotion, import substitution, and improving ease of doing business. 8. The Cabinet Committee on Employment and Skill Development deals with all issues related to developing skills, enhancing employability of workforce, and increasing women workforce participation. Of all the cabinet committees, the most powerful is the Political Affairs Committee, often described as a super cabinet. R. T groups of ministers in addition to cabinet committees, several groups of ministers, GOMs, are constituted to look into different issue subjects. Some of These GOMs are empowered to take decisions on behalf of the cabinet, whereas the others make recommendations to the cabinet. 2. Second Administrative Reforms Commission, Government of India, Report on Organizational Structure of Government of India, 2009, p. 136. This commission was headed by Veerappa Moily, a senior Congress leader and former Karnataka Chief Minister. 3. Ramesh K. Arora and Rajni Goyal, Indian Public Administration, New Age International Publishers, 3rd edition, 2013, pp. 238 to 239. For Second Administrative Reforms Commission, Government of India, Report on Organizational Structure of Government of India, 2009, pp. 136 to 137 and 140. The institution of GOMs has become a viable and effective instrument of coordination among the ministries. These are ad hoc bodies formed to give recommendations to the cabinet on certain emergent issues and critical problem areas. Ministers heading the concerned ministries are inducted into the relevant GOMs, and when the advice is crystallized, they are disbanded. 3. The Second Administrative Reforms Commission of India, 2005 to 2009, made the following observations and recommendations with respect to the working of the GOMs. 4. 1. The Commission observed that the constitution of a large number of GOMs has resulted in many GOMs not being able to meet regularly to complete their work, thus leading to significant delays on many major issues. 2. The Commission felt that more selective use of the institution of GOMs would perhaps lead to more effective coordination, particularly if they are empowered to arrive at a decision on behalf of the cabinet with time limits that are prescribed for completing the work entrusted to them. 3. The Commission recommended that there is need to ensure that the existing coordination mechanism of GOMs function effectively and helps in early resolution of issues. Selective, but effective use of GOMs with clear mandate and prescribed time limits would be helpful. Chapter Parliament. Parliament is the legislative organ of the Union government. It occupies a preeminent and central position in the Indian democratic political system due to adoption of the parliamentary form of government, also known as Westminster Model of Government 1. Westminster is a place in London where the British Parliament is located. It is often used as a symbol of the British Parliament. Articles 79 to 122 in Part 5 of the Constitution deal with the organization, composition, duration, officers, procedures, privileges, powers, and so on of the Parliament. Organization of Parliament under the Constitution. The Parliament of India consists of 3 parts, viz., the President, the Council of States, and the House of the People. In 1954, the Hindi names Rajya Sabha and Lok Sabha were adopted by the Council of States and the House of People respectively. The Rajya Sabha is the upper house, second chamber, or House of Elders, and the Lok Sabha is the lower house, first chamber, or popular house. The former represents the states and union territories of the Indian Union, while the latter represents the people of India as a whole. Though the President of India is not a member of either House of Parliament and does not sit in the Parliament to attend its meetings, she is an integral part of the Parliament. A bill passed by both the Houses of Parliament cannot become law without the President's assent. She also performs certain functions relating to the proceedings of the Parliament, for example, issues summons and prorogues both the Houses, dissolves the Lok Sabha, addresses both the Houses, issues ordinances when they are not in session, and so on. In this respect, the framers of the Indian Constitution relied on the British pattern rather than the American pattern. In Britain, the Parliament consists of the Crown King or Queen, the House of Lords, upper house, and the House of Commons, lower house. By contrast, the American President is not an integral part of the legislature. In USA, the legislature, which is known as Congress, consists of the Senate, upper house, and the House of Representatives, lower house. The parliamentary form of government emphasizes on the interdependence between the legislative and executive organs. Hence, we have the President in Parliament, like the Crown in Parliament in Britain. The presidential form of government, on the other hand, lays stress on the separation of legislative and executive organs. Hence, the American president is not regarded as a constituent part of the Congress. Composition of the 2 houses. Composition of Rajya Sabha. The maximum strength of the Rajya Sabha is fixed at 250, out of which 238 are to be the representatives of the states and union territories, elected indirectly, and 12 are nominated by the president. At present, the Rajya Sabha has 245 members. Of these, 225 members represent the states, 8 members represent the union territories, and 12 members are nominated by the president. The 4th schedule of the Constitution deals with the allocation of seats in the Rajya Sabha to the states and union territories. 1. Representation of states. The representatives of states in the Rajya Sabha are elected by the elected members of state legislative assemblies. The election is held in accordance with the system of proportional representation by means of the single transferable vote. The seats are allotted to the states in the Rajya Sabha on the basis of population. Hence, the number of representatives varies from state to state. For example, Uttar Pradesh has 31 members while Tripura has 1 member only. However, in USA, all states are given equal representation in the Senate irrespective of their population. USA has 50 states and the Senate has 100 members, 2 from each state. 2. Representation of Union Territories. The representatives of each Union Territory in the Rajya Sabha are indirectly elected by members of an electoral college specially constituted for the purpose. This election is also held in accordance with the system of proportional representation by means of the single transferable vote. Out of the 8 Union Territories, only 3, Delhi, Puducherry, and Jammu Kashmir, have representation in Rajya Sabha. The populations of other 5 Union Territories are too small to have any representative in the Rajya Sabha. Parliament 223. Composition of Lok Sabha. The maximum strength of the Lok Sabha is fixed at 550. Out of this, 530 members are to be the representatives of the states and 20 members are to be the representatives of the Union Territories. At present, the Lok Sabha has 543 members. Of these, 524 members represent the states and 19 members represent the Union Territories. 1. Representation of states. The representatives of states in the Lok Sabha are directly elected by the people from the territorial constituencies in the states. The election is based on the principle of universal adult franchise. Every Indian citizen who is above 18 years of age and who is not disqualified under the provisions of the Constitution or any law is eligible to vote at such election. The voting age was reduced from 21 to 18 years by the 61st Constitutional Amendment Act, 1988. 2. Representation of Union Territories. The Constitution has empowered the Parliament to prescribe the manner of choosing the representatives of the Union Territories in the Lok Sabha. Accordingly, the Parliament has enacted the Union Territories Direct Election to the House of the People Act, 1965, by which the members of Lok Sabha from the Union Territories are also chosen by direct election. 3. Nominated members. Before 2020, the President nominated 2 members from the Anglo-Indian community to the Lok Sabha if the community was not adequately represented. Originally, this provision was to operate for 10 years, i.e., up to 1960, only. Later, this duration has been extended continuously since then by 10 years each time. 32. 3. Nominated members. The President nominates 12 members to the Rajya Sabha from people who have special knowledge or practical experience in art, literature, science, and social service. The rationale behind this principle of nomination is to provide eminent persons a place in the Rajya Sabha without going through the process of election. It should be noted here that the American Senate has no nominated members. 2. An Anglo-Indian is a person whose father or any of whose other male progenitors in the male line is or was of European descent, but who was domiciled within the territory of India and is or was born within such territory of parents, habitually resident therein and not merely established there for temporary purposes. 224 YJ Indian Polity. Last extension up to 2020 was made by the 95th Amendment Act, 2009. But the 104th Amendment Act, 2019, has not extended further the operation of this provision. In other words, the amendment discontinued this provision of special representation of the Anglo-Indian community in the Lok Sabha by nomination. Consequently, this provision ceased to have effect on the 25th January, 2020. The allocation of seats in Parliament, both the Rajya Sabha and the Lok Sabha for states and Union Territories is given in BLE 23.5. System of elections to Lok Sabha ________________________ The various aspects related to the system of elections to the Lok Sabha are as follows. Territorial constituencies. For the purpose of holding direct elections to the Lok Sabha, each state is divided into territorial constituencies. In this respect, the Constitution makes the following 2 provisions. 1. Each state is allotted a number of seats in the Lok Sabha in such a manner that the ratio between that number and its population is the same for all states. This provision does not apply to a state having a population of less than 6 million. 2. Each state is divided into territorial constituencies in such a manner that the ratio between the population of each constituency and the number of seats allotted to it is the same throughout the state. In brief, the Constitution ensures that there is uniformity of representation in 2 respects, A, between the different states, and B, between the different constituencies in the same state. The expression population means the population is ascertained at the preceding census of which the relevant figures have been published. Readjustment after each census. After every census, a readjustment is to be made in A, allocation of seats in the Lok Sabha to the states, and B, division of each state into territorial constituencies. Parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, the Parliament has enacted the Delimitation Commission Acts in 1952, 1962, 1972, and 2002 for this purpose. The 42nd Amendment Act of 1976 froze the allocation of seats in the Lok Sabha to the states and the division of each state into territorial constituencies till the year 2000 at the 1971 level. This ban on readjustment was extended for another 25 years, i.e., up to year 2026, by the 84th Amendment Act of 2001, with the same objective of encouraging population limiting measures. The 84th Amendment Act of 2001 also empowered the government to undertake readjustment and rationalization of territorial constituencies in the states on the basis of the population figures of 1991 census. Later, the 87th Amendment Act of 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, this can be done without altering the number of seats allotted to each state in the Lok Sabha. Reservation of seats for SCs and STs. Though the Constitution has abandoned the system of communal representation, it provides for the reservation of seats for scheduled castes and scheduled tribes in the Lok Sabha on the basis of population ratios 3. This means that the number of Lok Sabha seats reserved in a state or union territory for such castes and tribes is to bear the same proportion to the total number of seats allotted to that state or union territory in the Lok Sabha as the population of such castes and tribes in the concerned state or union territory bears to the total population of state or union territory. Originally, this reservation was to operate for 10 years, i.e., up to 1960, but it has Parliament M. 225. Been extended continuously since then by 10 years each time. Now, under the 104th Amendment Act of 2019, this reservation is to last until 2030. Though seats are reserved for scheduled castes and scheduled tribes, they are elected by all the voters in a constituency, without any separate electorate. A member of scheduled castes and scheduled tribes is also not debarred from contesting a general, non-reserved seat. The 84th Amendment Act of 2001 provided for refixing of the reserved seats on the basis of the population figures of 1991 census as applied to rationalization of the general seats. Later, the 87th Amendment Act of 2003 provided for the refixing of the reserved seats on the basis of 2001 census and not 1991 census. The statewide reservation of seats for SCs and STs in the Lok Sabha is given in Ibl 23.5. First past the post system. Though the Constitution has adopted the system of proportional representation in the case of Rajya Sabha, it has not preferred the same system in the case of Lok Sabha. Instead, it has adopted the system of territorial representation, first past the post system, for the election of members to the Lok Sabha. Under territorial representation, every member of the legislature represents a geographical area known as a constituency. From each constituency, only one representative is elected. Hence, such a constituency is known as single-member constituency. In this system, a candidate who secures majority of votes is declared elected. This simple majority system of representation does not represent the whole electorate. In other words, it does not secure due representation to minorities, small groups. The system of proportional representation aims at removing the defects of territorial representation. Under this system, all sections of the people get representation in proportion to their number. Even the smallest section of the population gets its due share of representation in the legislature. There are two kinds of proportional representation, namely, single transferable vote system and list system. In India, the first kind is adopted for the election of members to the Rajya Sabha and State Legislative Council and for electing the President and the Vice President. Though some members of the Constituent Assembly had advocated the system of proportional representation for the election of members to the Lok Sabha, the Constitution has not adopted the system due to two reasons. 1. Difficulty for the voters to understand the system, which is complicated, due to low literacy scale in the country. 2. Unsuitability to the parliamentary government due to the tendency of the system to multiply political parties leading to instability in government. Additionally, the system of proportional representation has the following demerits. 1. It is highly expensive. 2. It does not give any scope for organizing by elections. 3. It eliminates intimate contacts between voters and representatives. 4. It promotes minority thinking and group interests. 5. It increases the significance of party system and decreases that of voter. Duration of two houses. Duration of Rajya Sabha. The Rajya Sabha, first constituted in 1952, is a continuing chamber, that is, it is a permanent body and not subject to dissolution. However, 1/3 of its members retire every second year. Their seats are filled up by fresh elections and presidential nominations at the beginning of every third year. The retiring members are eligible for re-election and renomination any number of times. The Constitution has not fixed the term of office of members of the Rajya Sabha and left it to the Parliament. Accordingly, the Parliament in the Representation of the People Act, 1951, provided that the term of office of a member of the Rajya Sabha shall be 6 years. The Act 226 Indian Polity W. also empowered the President of India to curtail the term of members chosen in the first Rajya Sabha. In the first batch, it was decided by lottery as to who should retire. Further, the Act also authorized the President to make provisions to govern the order of retirement of the members of the Rajya Sabha. 4. 6. A minister in the union or state government is not considered as holding the office of profit. Also, the Parliament can declare that a particular office of profit will not disqualify its holder from parliamentary membership. Duration of Lok Sabha. Unlike the Rajya Sabha, the Lok Sabha is not a continuing chamber. Its normal term is 5 years from the date of its first meeting after the general elections, after which it automatically dissolves. However, the President is authorized to dissolve the Lok Sabha at any time even before the completion of 5 years, and this cannot be challenged in a court of law. Further, the term of the Lok Sabha can be extended during the period of national emergency by a law of Parliament for 1 year at a time 5 for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. The durations of the Lok Sabha from first to present are mentioned in THB 23.6. T. Membership of Parliament. Qualifications. The Constitution lays down the following qualifications for a person to be chosen a member of the Parliament. 1. Pisha must be a citizen of India. 2. Pisha must make and subscribe to an oath or affirmation before the person. Under this, the President has made the Rajya Sabha term of office of members, Order, 1952. The term of the 5th Lok Sabha that was to expire on March 18, 1976, was extended by 1 year up to March 18, 1977 by the House of the People, Extension of Duration, Act, 1976. It was extended for a further period of 1 year up to March 18, 1978 by the House of the People, Extension of Duration, Amendment Act, 1976. However, the House was dissolved on January 18, 1977, after having been in existence for a period of 5 years, 10 months and 6 days. Authorized by the Election Commission for this purpose. In Hishu oath or affirmation, Hisha swears, a. TB bear true faith and allegiance to the Constitution of India, b. 7b uphold the sovereignty and integrity of India, 3. Hisha must be not less than 30 years of age in the case of the Rajya Sabha and not less than 25 years of age in the case of the Lok Sabha. 4. Hisha must possess other qualifications prescribed by Parliament. The Parliament has laid down the following additional qualifications in the Representation of People Act, 1951. 1. Hisha must be registered as an elector for a parliamentary constituency. This is same in the case of both the Rajya Sabha and the Lok Sabha. The requirement that a candidate contesting an election to the Rajya Sabha from a particular state should be an elector in that particular state was dispensed with in 2003. In 2006, the Supreme Court upheld the constitutional validity of this change. 2. Hisha must be a member of a scheduled caste or scheduled tribe in any state or union territory if Hisha wants to contest a seat reserved for them. However, a member of scheduled castes or scheduled tribes can also contest a seat not reserved for them. Disqualifications under the Constitution. A person shall be disqualified for being elected as a member of Parliament. 1. If Hisha holds any office of profit under the union or state government, except that of a minister or any other office exempted by Parliament. 6 Parliament 227. 2. If Hisha is of unsound mind and stands so declared by a court. 3. If Hisha is an undischarged insolvent. 4. If Hisha is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to a foreign state. And 5. If Hisha is so disqualified under any law made by Parliament. The Parliament has laid down the following additional disqualifications in the Representation of People Act, 1951. 1. Hisha must not have been found guilty of certain electoral offenses or corrupt practices in the elections. 2. Hisha must not have been convicted for any offense resulting in imprisonment for 2 or more years. But the detention of a person under a preventive detention law is not a disqualification. 3. Hisha must not have failed to lodge an account of Hisha election expenses within the time. 4. Hisha must not have any interest in government contracts, works, or services. 5. Hisha must not be a director or managing agent nor hold an office of profit in a corporation in which the government has at least 25% share. 6. Hisha must not have been dismissed from government service for corruption or disloyalty to the state. 7. Hisha must not have been convicted for promoting enmity between different groups or for the offense of bribery. 8. Hisha must not have been punished for preaching and practicing social crimes such as untouchability, dowry, and sati. On the question whether a member is subject to any of the above disqualifications, the President's decision is final. However, she should obtain the opinion of the Election Commission and act accordingly. Disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified from being a member of Parliament if Hisha is so disqualified on the ground of defection under the provisions of the IFN Schedule. A member incurs disqualification under the defection law. 1. If Hisha voluntarily gives up the membership of the political party on whose ticket Hisha is elected to the House. 2. If Hisha votes or abstains from voting in the House contrary to any direction given by Hisha political party. 3. If any independently elected member joins any political party. And 4. If any nominated member joins any political party after the expiry of 6 months. The question of disqualification under the IFN Schedule is decided by the chairman in the case of Rajya Sabha and speaker in the case of Lok Sabha, and not by the President of India. In Kahoto Halahan Case 7, 1992, the Supreme Court ruled that the decision of the chairman-speaker in this regard is subject to judicial review. 7 Kahoto Halahan vs. Zakilhu, 1992. Vacating of seats in the following cases, a member of Parliament vacates Hisha's seat. 1. Double membership. A person cannot be a member of both houses of Parliament at the same time. Thus, the Representation of People Act, 1951, provides for the following. A. If a person is elected to both the houses of Parliament, Hisha must intimate within 10 days in which house Hisha desires to serve. In default of such intimation, Hisha's seat in the Rajya Sabha becomes vacant. B. If a sitting member of one house is also elected to the other house, his/her seat in the first house becomes vacant. C. If a person is elected to 2 seats in a house, his/her should exercise his/her option for one. Otherwise, both seats become vacant. Similarly, a person cannot be a member of both the parliament and the state legislature at the same time. If a person is so elected, 228 Indian Polity. His/her seat in parliament becomes vacant if his/her does not resign his/her seat in the state legislature within 14 days. 8. 9v. The Finance Act, 2018. This act amended the Salary, Allowances and Pension of Members of Parliament Act, 1954. 2. Disqualification. If a member of parliament becomes subject to any of the disqualifications specified in the Constitution, his/her seat becomes vacant. Here, the list of disqualifications also include the disqualification on the grounds of defection under the provisions of the TFC and H schedule of the Constitution. Z. Resignation. A member may resign his/her seat by writing to the chairman of Rajya Sabha or Speaker of Lok Sabha, as the case may be. The seat falls vacant when the resignation is accepted. However, the chairman-speaker may not accept the resignation if his/her is satisfied that it is not voluntary or genuine. 4. Absence. A house can declare the seat of a member vacant if his/her is absent from all its meetings for a period of 60 days without its permission. In computing the period of 60 days, no account shall be taken of any period during which the House is prorogued or adjourned for more than 4 consecutive days. 5. Other cases. A member has to vacate his/her seat in the Parliament. A. If his/her election is declared void by the court. B. If his/her is expelled by the House. C. If his/her is elected to the office of President or Vice President. And D. If his/her is appointed to the office of Governor of a state. If a disqualified person is elected to the Parliament, the Constitution lays down no procedure to declare the election void. This matter is dealt by the Representation of the People Act, 1951, which enables the High Court to declare an election void if a disqualified candidate is elected. The aggrieved party can appeal to the Supreme Court against the order of the High Court in this regard. According to the Prohibition of Simultaneous Membership Rules, 1950, made by the President. Oath or affirmation. Every member of either House of Parliament, before taking his/her seat in the House, has to make and subscribe to an oath or affirmation before the President or some person appointed by him or for this purpose. In his/her oath or affirmation, a member of Parliament swears, 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. And 3. To faithfully discharge the duty upon which his/her is about to enter. Unless a member takes the oath, his/her cannot vote and participate in the proceedings of the House and does not become eligible to parliamentary privileges and immunities. A person is liable to a penalty of 500 for each day his/her sits or votes as a member in a House in the following conditions. 1. Before taking and subscribing to the prescribed oath or affirmation. Or 2. When his/her knows that his/her is not qualified or that his/her is disqualified for its membership. Or 3. When his/her knows that his/her is prohibited from sitting or voting in the House by virtue of any parliamentary law. Salaries and allowances. The members of either House of Parliament are entitled to receive such salaries and allowances as may be determined by Parliament, and there is no provision of pension in the Constitution. However, in 1976, the Parliament has provided pension to the members. In 1954, the Parliament enacted the Salary, Allowances and Pension of Members of Parliament Act. In 2018, the salary of members was increased from 50,000 to 1,000,000 foot asterisk per month, the constituency allowance from 45,000 to 70,000 per month, and the office expenses allowance from 45,009 Parliament 229 to 60,000 per month. Earlier in 2010, the daily allowance was increased from 1,000 to 2,000 for each day of residence on duty. Besides, the members are also provided with traveling facilities, free accommodation, telephone, vehicle advance, medical facilities, and so on. In 2018, the pension of every person who has served for any period as a member of Parliament was increased from 20,000 to 25,009 per month. Further, if a person has served as a member of Parliament for more than 5 years, his/her is paid an additional pension of 2,000 per month, 500 per month before 2018, for every year served in excess of 5 years. 9A Section 3 of the Salaries and Allowances of Officers of Parliament Act, 1953, as amended. The salaries and allowances of the Speaker and Deputy Speaker of Lok Sabha and the Chairman and Deputy Chairman of Rajya Sabha are also determined by Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of Parliament. In 1953, the Parliament enacted the Salaries and Allowances of Officers of Parliament Act. Under this Act, Officer of Parliament means any of the following officers, namely, the Chairman and Deputy Chairman of the Rajya Sabha and the Speaker and the Deputy Speaker of the Lok Sabha. In 2018, the Parliament increased the salary of the Chairman of the Rajya Sabha from 1.25 lakh to 14 lakh per month 9 star. Similarly, other officers of Parliament, i.e., the Speaker and the Deputy Speaker of the Lok Sabha and the Deputy Chairman of the Rajya Sabha, are entitled to receive a salary per month at the same rates as are payable to the members of Parliament. Further, each officer of Parliament, other than the Chairman of the Rajya Sabha, is entitled to receive a daily allowance for each day during the whole of his term, at the same rate as is payable to the members of Parliament. Also, each officer of Parliament, other than the Chairman of the Rajya Sabha, is entitled to receive a constituency allowance at the same rate as is payable to the members of Parliament. According to the same Act, the sumptuary allowance is paid to the Speaker of the Lok Sabha at the same rate as is payable to a Cabinet Minister 913, i.e., 2,000 per month. Likewise, the sumptuary allowance is paid to the Deputy Speaker of the Lok Sabha and the Deputy Chairman of the Rajya Sabha at the same rate as is payable to a Minister of State, i.e., 1,000 per month. Presiding Officers of Parliament. Each House of Parliament has its own presiding officer. There is a Speaker and a Deputy Speaker for the Lok Sabha and a Chairman and a Deputy Chairman for the Rajya Sabha. A panel of chairpersons for the Lok Sabha and a panel of vice-chairpersons for the Rajya Sabha is also appointed. Speaker of Lok Sabha election and tenure. The Speaker is elected by the Lok Sabha from amongst its members as soon as may be after its first sitting. Whenever the office of the Speaker falls vacant, the Lok Sabha elects another member to fill the vacancy. The date of election of the Speaker is fixed by the President. Usually, the Speaker remains in office during the life of the Lok Sabha. However, Hisha has to vacate his office earlier in any of the following three cases. 1. If Hisha ceases to be a member of the Lok Sabha. 2. If Hisha resigns by writing to the Deputy Speaker. And 3. If Hisha is removed by a resolution passed by a majority of all the then members of the Lok Sabha, i.e., an effective majority. Such a resolution can be moved only after giving 14 days advance notice. 9b Section 5 of the Salaries and Allowances of Officers of Parliament Act, 1953, as amended. 230 Indian Polity. When a resolution for the removal of the Speaker is under consideration of the House, Hisha cannot preside at the sitting of the House, though Hisha may be present. However, Hisha can speak and take part in the proceedings of the House at such a time and vote in the first instance, though not in the case of inequality of votes. It should be noted here that, whenever the Lok Sabha is dissolved, the Speaker does not vacate his office and continues till the newly elected Lok Sabha meets. The tenure of the Speakers of the Lok Sabha from first to present is mentioned in Table 23.7. Role, powers, and functions. The Speaker is the head of the Lok Sabha and its representative. Hisha is the guardian of powers and privileges of the members, the House as a whole, and its committees. Hisha is the principal spokesperson of the House, and his decision is final in all parliamentary matters. Hisha is thus much more than merely the presiding officer of the Lok Sabha. In these capacities, Hisha is vested with vast, varied, and vital responsibilities and enjoys great honor, high dignity, and supreme authority within the House. The Speaker of the Lok Sabha derives her powers and duties from three sources, that is, the Constitution of India, the rules of procedure and conduct of business of Lok Sabha, and parliamentary conventions. Residuary powers that are unwritten or unspecified in the rules. Altogether, Hisha has the following powers and duties. 1. Hisha maintains order and decorum in the House for conducting its business and regulating its proceedings. This is Hisha's primary responsibility, and she has final power in this regard. 2. Hisha is the final interpreter of the provisions of a. the Constitution of India, b. the rules of procedure and conduct of business of Lok Sabha, and c. the parliamentary precedents within the House. 3. Hisha adjourns the House or suspends the meeting in absence of a quorum. The quorum to constitute a meeting of the House is 1/10 of the total strength of the House. 4. Hisha does not vote in the first instance, but Hisha can exercise a casting vote in the case of a tie. In other words, only when the House is divided equally on any question, the Speaker is entitled to vote. Such vote is called casting vote, and its purpose is to resolve a deadlock. 5. Hisha presides over a joint sitting of the two Houses of Parliament. Such a sitting is summoned by the President to settle a deadlock between the two Houses on a bill. 6. Hisha can allow a secret sitting of the House at the request of the leader of the House. When the House sits in secret, no stranger can be present in the chamber, lobby, or galleries except with the permission of the Speaker. 7. Hisha decides whether a bill is a money bill or not, and Hisha's decision on this question is final. When a money bill is transmitted to the Rajya Sabha for recommendation and presented to the President for assent, the Speaker endorses on the bill Hisha's certificate that it is a money bill. 8. Hisha decides the questions of disqualification of a member of the Lok Sabha, arising on the ground of defection under the provisions of the 10th Schedule. In Kahoto-Holohan case, 1992, the Supreme Court ruled that the decision of the Speaker in this regard is subject to judicial review. 10. 9. Hisha acts as the ex officio chairman of the Indian Parliamentary Group, which is a link between the Parliament of India and the various parliaments of the world. Hisha also acts as the ex officio chairman of the Conference of Presiding Officers of Legislative Bodies in the country. 10. Hisha appoints the chairman of all the parliamentary committees of the Lok Sabha and supervises their functioning. 10 Kahoto-Holohan vs. Zakilhu, 1992. Husha is the chairman of the Business Advisory Committee, the Rules Committee, and the General Purposes Committee. Independence and impartiality. As the office of the Speaker is vested with great prestige, position, and authority, independence and impartiality becomes its sine qua non. 11. In this context, V.V. Giri observed, the holder of an office provided with such extensive authority and power must discharge the duties of his office impartially. So impartiality is regarded as an indispensable condition of the office of the Speaker, who is the guardian of the powers and privileges of the House and not of the political party with whose support Husha might have been elected to the office. It is not possible for him or her to maintain order in the House unless Husha enjoys the confidence of the minority parties by safeguarding their rights and privileges. Powers of the presiding officers in Indian Legislature, in Journal of Constitutional and Parliamentary Studies, New Delhi, Volume 2, No. 4, October Dec. 1968, p. 22. The following provisions ensure the independence and impartiality of the office of the Speaker. 1. Husha is provided with a security of tenure. Husha can be removed only by a resolution passed by the Lok Sabha by an effective majority, i.e., a majority of all the then members of the House, and not by a simple majority, i.e., a majority of the members present and voting in the House. This motion of removal can be considered and discussed only when it has the support of at least 50 members. 2. Husha's salaries and allowances are fixed by Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of Parliament. 3. Husha work and conduct cannot be discussed and criticized in the Lok Sabha except on a substantive motion. 4. Husha powers of regulating procedure or conducting business or maintaining order in the House are not subject to the jurisdiction of any court. Parliament M. 231. 5. Husha cannot vote in the first instance. Husha can only exercise a casting vote in the event of a tie. This makes the position of Speaker impartial. 6. Husha is given a very high position in the order of precedence. Husha is placed at 7th rank, along with the Chief Justice of India. This means Husha has a higher rank than all cabinet ministers, except the Prime Minister or Deputy Prime Minister. In Britain, the Speaker is strictly a non-party man. There is a convention that the Speaker has to resign from his party and remain politically neutral. This healthy convention is not fully established in India, where the Speaker does not resign from the membership of his party on his election to the exalted office. Deputy Speaker of Lok Sabha. Like the Speaker, the Deputy Speaker is also elected by the Lok Sabha itself from amongst its members. Husha is elected after the election of the Speaker has taken place. The date of election of the Deputy Speaker is fixed by the Speaker. Whenever the office of the Deputy Speaker falls vacant, the Lok Sabha elects another member to fill the vacancy. Like the Speaker, the Deputy Speaker remains in office usually during the life of the Lok Sabha. However, Husha may vacate his office earlier in any of the following 3 cases. 1. If Husha ceases to be a member of the Lok Sabha. 2. If Husha resigns by writing to the Speaker. And 3. If Husha is removed by a resolution passed by a majority of all the then members of the Lok Sabha, i.e., an effective majority. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. She also acts as the Speaker when the latter is absent from the sitting of the House. In both the cases, Husha assumes all the powers of the Speaker. Husha also presides over the joint 232 Indian Polity sitting of both the Houses of Parliament, in case the Speaker is absent from such a sitting. It should be noted here that the Deputy Speaker is not subordinate to the Speaker. Husha is directly responsible to the House. The Deputy Speaker has one special privilege, that is, whenever Husha is appointed as a member of a parliamentary committee, she automatically becomes its chairman. Like the Speaker, the Deputy Speaker, while presiding over the House, cannot vote in the first instance. Husha can only exercise a casting vote in the case of a tie. Further, when a resolution for the removal of the Deputy Speaker is under consideration of the House, Husha cannot preside at the sitting of the House, though Husha may be present. When the Speaker presides over the House, the Deputy Speaker is like any other ordinary member of the House. Husha can speak in the House, participate in its proceedings, and vote on any question before the House. The Deputy Speaker is entitled to a regular salary and allowance fixed by Parliament, and charged on the Consolidated Fund of India. Usually, the Speaker comes from the ruling party or ruling alliance, while the post of Deputy Speaker goes to the opposition party or opposition alliance. However, there have been certain exceptional cases in this regard. The Speaker and the Deputy Speaker, while assuming their offices, do not make and subscribe any separate oath or affirmation. The institutions of Speaker and Deputy Speaker originated in India in 1921 under the provisions of the Government of India Act of 1919, Montagu-Chelmsford Reforms. At that time, the Speaker and the Deputy Speaker were called the President and Deputy President respectively, and the same nomenclature continued till 1947. Before 1921, the Governor-General of India used to preside over the meetings of the Central Legislative Council. In 1921, the Frederick White and Sachidanand Sinha were appointed by the Governor-General of India as the first Speaker and the first Deputy Speaker, respectively, of the Central Legislative Assembly. In 1925, Vithal J. Patel became the first Indian and the first elected Speaker of the Central Legislative Assembly. The Government of India Act of 1935 changed the nomenclatures of President and Deputy President of the Central Legislative Assembly to the Speaker and Deputy Speaker respectively. However, the old nomenclature continued till 1947 as the federal part of the 1935 Act was not implemented. G.V. Mavalankar and Ananthasanam Iyengar had the distinction of being the first Speaker and the first Deputy Speaker, respectively, of the Lok Sabha. G.V. Mavalankar also held the post of Speaker in the Constituent Assembly, Legislative, as well as the Provisional Parliament. Husha held the post of Speaker of Lok Sabha continuously for 1 decade from 1946 to 1956. Panel of Chairpersons of Lok Sabha. Under the rules of Lok Sabha, the Speaker nominates from amongst the members a panel of not more than 10 chairpersons. Any of them can preside over the House in the absence of the Speaker or the Deputy Speaker. Husha has the same power as the Speaker when so presiding. Husha holds office until a new panel of chairpersons is nominated. When a member of the panel of chairpersons is also not present, any other person as determined by House acts as the Speaker. It must be emphasized here that a member of the panel of chairpersons cannot preside over the House when the office of the Speaker or the Deputy Speaker is vacant. During such time, the Speaker's duties are to be performed by such member of the House as the President may appoint for the purpose. The elections are held, as soon as possible, to fill the vacant posts. Speaker pro tem is provided by the Constitution. The Speaker of the last Lok Sabha vacates his office immediately before the first meeting of the newly elected Lok Sabha. Therefore, the President appoints a member of the Lok Sabha as the Speaker pro tem. Usually, the seniorest member is selected for this. The President administers oath to the Speaker pro tem. The Speaker pro tem has all the powers of the Speaker. Husha presides over the first sitting of the newly elected Lok Sabha. His main duty is to administer oath to the new members. Husha also enables the House to elect the new Speaker. When the new Speaker is elected by the House, the office of the Speaker pro tem ceases to exist. Hence, this office is a temporary office, existing for a few days. 12, for example, in the 13th Lok Sabha, Mr. Indrajit Gupta was appointed as Speaker pro tem on October 20, 1999 and remained in that office till October 22, 1999 when the new Speaker, Mr. GMC Balayoji, was elected. Chairman of Rajya Sabha. The presiding officer of the Rajya Sabha is known as the Chairman. The Vice President of India is the ex officio Chairman of the Rajya Sabha. During any period when the Vice-Resident acts as President or discharges the functions of the President, Husha does not perform the duties of the office of the Chairman of Rajya Sabha. The Chairman of the Rajya Sabha can be removed from his office only if Husha is removed from the office of the Vice President. As a presiding officer, the powers and functions of the Chairman in the Rajya Sabha are similar to those of the Speaker in the Lok Sabha. However, the Speaker has two special powers which are not enjoyed by the Chairman. 1. The Speaker decides whether a bill is a money bill or not, and his decision on this question is final. 2. The Speaker presides over a joint sitting of two houses of Parliament. Unlike the Speaker, who is a member of the House, the Chairman is not a member of the House. But like the Speaker, the Chairman also cannot vote in the first instance. His too can cast a vote in the case of an equality of votes. The Vice President cannot preside over a sitting of the Rajya Sabha as its Chairman. Parliament. When a resolution for Hisha removal is under consideration. However, Hisha can be present and speak in the House and can take part in its proceedings, without voting, even at such a time, while the Speaker can vote in the first instance when a resolution for Hisha removal is under consideration of the Lok Sabha. As in case of the Speaker, the salaries and allowances of the Chairman are also fixed by the Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of Parliament. During any period when the Vice President acts as President or discharges the functions of the President, Husha is not entitled to any salary or allowance payable to the Chairman of the Rajya Sabha. But Husha is paid the salary and allowance of the President during such a time. Deputy Chairman of Rajya Sabha. The Deputy Chairman is elected by the Rajya Sabha itself from amongst its members. Whenever the office of the Deputy Chairman falls vacant, the Rajya Sabha elects another member to fill the vacancy. The Deputy Chairman vacates his office in any of the following three cases. 1. If Husha ceases to be a member of the Rajya Sabha. 2. If Husha resigns by writing to the Chairman. And 3. If Husha is removed by a resolution passed by a majority of all the then members of the Rajya Sabha, i.e., an effective majority. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Chairman performs the duties of the Chairman's office when it is vacant or when the Vice President acts as President or discharges the functions of the President. Husha also acts as the Chairman when the latter is absent from the sitting of the House. In both the cases, Husha has all the powers of the Chairman. It should be emphasized here that the Deputy Chairman is not subordinate to the Chairman. Husha is directly responsible to the Rajya Sabha. 234 Indian Polity. Like the Chairman, the Deputy Chairman, while presiding over the House, cannot vote in the first instance. Husha can only exercise a casting vote in the case of a tie. Further, when a resolution for the removal of the Deputy Chairman is under consideration of the House, Husha cannot preside over a sitting of the House, though Husha may be present. When the chairman presides over the House, the deputy chairman is like any other ordinary member of the House. Husha can speak in the House, participate in its proceedings, and vote on any question before the House. Like the chairman, the deputy chairman is also entitled to a regular salary and allowance. They are fixed by Parliament and are charged on the Consolidated Fund of India. Panel of Vice Chairpersons of Rajya Sabha. Under the rules of Rajya Sabha, the chairman nominates from amongst the members a panel of Vice Chairpersons. Any one of them can preside over the House in the absence of the chairman or the deputy chairman. She has the same powers as the chairman when so presiding. Husha holds office until a new panel of Vice Chairpersons is nominated. When a member of the panel of Vice Chairpersons is also not present, any other person as determined by the House acts as the chairman. It must be emphasized here that a member of the panel of Vice Chairpersons cannot preside over the House when the office of the chairman or the deputy chairman is vacant. During such time, the chairman's duties are to be performed by such member of the House as the president may appoint for the purpose. The elections are held, as soon as possible, to fill the vacant posts. Secretariat of Parliament. Each House of Parliament has separate secretarial staff of its own, though there can be some posts common to both the Houses. Their recruitment and service conditions are regulated by Parliament. The Secretariat of each House is headed by a Secretary General. Husha is a permanent officer and is appointed by the presiding officer of the House. Leaders in Parliament. Leader of the House. Under the rules of Lok Sabha, the Leader of the House means the Prime Minister, if he/she is a member of the Lok Sabha, or a minister who is a member of the Lok Sabha and is nominated by the Prime Minister to function as the Leader of the House. There is also a Leader of the House in the Rajya Sabha. He/she is a minister and a member of the Rajya Sabha and is nominated by the Prime Minister to function as such. The Leader of the House in either House is an important functionary and exercises direct influence on the conduct of business. Husha can also nominate a Deputy Leader of the House. The same functionary in USA is known as the Majority Leader. Leader of the Opposition in each House of Parliament. There is the Leader of the Opposition. In a parliamentary system of government, the Leader of the Opposition has a significant role to play. His main functions are to provide a constructive criticism of the policies of the government and to provide an alternative government. Therefore, the leaders of opposition in the Lok Sabha and the Rajya Sabha were accorded statutory recognition in 1977 under the Salary and Allowances of Leaders of Opposition in Parliament Act, 1977. They are also entitled to the salary, allowances, and other facilities equivalent to that of a cabinet minister. It was in 1969 that an official leader of the opposition was recognized for the first time. The same functionary in USA is known as the Minority Leader. Under the above act, the Leader of the Opposition means that member of the Rajya Sabha or the Lok Sabha who is, for the time being, the leader in that house of the party in opposition to the government, having the greatest numerical strength and recognized as such by the chairman or the speaker. Further, where there are two or more parties in opposition to the government having the same numerical strength, the chairman or the speaker shall, having regard to the status of the parties, recognize any one of the leaders of such parties as the leader of the opposition, and such recognition shall be final and conclusive. According to the directions issued by both the chairman and the speaker, the minimum numerical strength required for recognition as a political party is 1/10 of the total membership of that house. The British political system has a unique institution called the shadow cabinet. It is formed by the opposition party to balance the ruling cabinet and to prepare its members for future ministerial offices. In this shadow cabinet, almost every member in the ruling cabinet is shadowed by a corresponding member in the opposition cabinet. This shadow cabinet serves as the alternate cabinet if there is change of government. That is why Ivor Jennings described the leader of opposition as the alternative prime minister. Husha enjoys the status of a minister and is paid by the government. Though the offices of the leader of the House and the leader of the opposition are not mentioned in the Constitution of India, they are mentioned in the rules of the House and parliamentary statute respectively. Whips. The office of whip is mentioned neither in the Constitution of India nor in the rules of the House. It is based on the conventions of the parliamentary government. Every political party, whether ruling or opposition, has its own chief whip and whips in the parliament. The whip is appointed by the political party to serve as an assistant floor leader. Husha is charged with the responsibility of ensuring the attendance of Hishar party members in large numbers and securing their support in favor of or against a particular issue. Husha regulates and monitors their behavior in the parliament. The members, Parliament 235, are supposed to follow the directives given by the whip. Otherwise, disciplinary action can be taken. The chief whip of the government party in the Lok Sabha is the Minister of Parliamentary Affairs. In the Rajya Sabha, the Minister of State for Parliamentary Affairs holds this position. The chief whip is directly responsible to the leader of the House. It is part of Hishar duties to advise the government on parliamentary business and to maintain a close liaison with the ministers in regard to parliamentary business affecting their departments. 123. 12 a.m. N. Call and S.L. Schachter, Practice and Procedure of Parliament, 6th edition, 2009, Lok Sabha Secretariat, pp. 151-52. The chief whip of a recognized party and a recognized group is entitled to telephone and secretarial facilities under the leaders and chief whips of recognized parties and groups in Parliament, facilities Act, 1998. Under the above Act, a recognized party means every party which has a strength of not less than 55 members in respect of the Lok Sabha and 25 members in respect of the Rajya Sabha. Similarly, a recognized group means every party which has a strength of not less than 30 members in respect of the Lok Sabha and 15 members in respect of the Rajya Sabha. T. Sessions of Parliament. Summoning the President from time to time summons each House of Parliament to meet at such time and place as Husha thinks fit. But the maximum gap between two sessions of Parliament cannot be more than 6 months. In other words, the Parliament should meet at least twice a year. There are usually 3 sessions in a year, viz. 1. The Budget Session, February to May. 2. The Monsoon Session, July to September. NC. The Winter Session, November to December. Indian Polity. A session of Parliament is the period spanning between the first sitting of a House and its prorogation or dissolution in the case of the Lok Sabha. During a session, the House meets every day to transact business. The period spanning between the prorogation of a House and its reassembly in a new session is called recess. Adjournment. A session of Parliament consists of many meetings. Each meeting of a day consists of 2 sittings, that is, a morning sitting from 11 a.m. to 1 p.m. and post-lunch sitting from 2 p.m. to 6 p.m. A sitting of Parliament can be terminated by adjournment or adjournment sine die or prorogation or dissolution in the case of the Lok Sabha. An adjournment suspends the work in a sitting for a specified time, which may be hours, days, or weeks. Adjournment sine die means terminating a sitting of Parliament for an indefinite period. In other words, when the House is adjourned without naming a day for reassembly, it is called adjournment sine die. The power of adjournment as well as adjournment sine die lies with the presiding officer of the House. Husha can also call a sitting of the House before the date or time to which it has been adjourned or at any time after the House has been adjourned sine die. Prorogation. The presiding officer, Speaker, or Chairman declares the House adjourned sine die when the business of a session is completed. Within the next few days, the President issues a notification for prorogation of the session. However, the President can also prorogue the House while in session. The specific differences between adjournment and prorogation are summarized in Table 23.1. Dissolution. Rajya Sabha, being a permanent House, is not subject to dissolution. Only the Lok Sabha is. Table 23.1. Adjournment versus prorogation. Adjournment. Prorogation. 1. It only terminates a sitting and not a session of the House. 1. It not only terminates a sitting but also a session of the House. 2. It is done by presiding officer of the House. 2. It is done by the President of India. 3. It does not affect the bills or any other business pending before the House, and the same can be resumed when the House meets again. 3. It also does not affect the bills or any other business pending before the House. 13. However, all pending notices, other than those for introducing bills, lapse on prorogation and fresh notices have to be given for the next session. 133. In Britain, prorogation brings to an end all bills or any other business pending before the House. Under Article 107(3) of the Constitution, a bill pending in Parliament shall not lapse by reason of the prorogation of the Houses. Under Rule 336 of the Lok Sabha, a motion, resolution, or an amendment, which has been moved and is pending in the House, shall not lapse by reason only of the prorogation of the House. Under Rule 335 of the Lok Sabha, on the prorogation of the House, all pending notices, other than notices of intention to move for leave to introduce a bill, shall lapse and fresh notices shall be given for the next session. Subject to dissolution. Unlike a prorogation, a dissolution ends the very life of the existing House, and a new House is constituted after general elections are held. The dissolution of the Lok Sabha may take place in either of 2 ways. 1. Automatic dissolution, that is, on the expiry of its tenure of 5 years or the terms as extended during a national emergency. Or 2. Whenever the President decides to dissolve the House, which Husha is authorized to do. Once the Lok Sabha is dissolved before the completion of its normal tenure, the dissolution is irrevocable. When the Lok Sabha is dissolved, all business including bills, motions, resolutions, notices, petitions, and so on pending before it or its committees lapse. They to be pursued further must be reintroduced in the newly constituted Lok Sabha. However, some pending bills and all pending assurances that are to be examined by the Committee on Government Assurances do not lapse on the dissolution of the Lok Sabha. The position with respect to lapsing of bills is as follows. 1. A bill pending in the Lok Sabha lapses, whether originating in the Lok Sabha or transmitted to it by the Rajya Sabha. 2. A bill passed by the Lok Sabha but pending in the Rajya Sabha lapses. 3. A bill not passed by the 2 houses due to disagreement, and if President has notified the holding of a joint sitting before the dissolution of Lok Sabha, does not lapse. 4. A bill pending in the Rajya Sabha but not passed by the Lok Sabha does not lapse. 5. A bill passed by both houses but pending assent of the President does not lapse. 6. A bill passed by both houses but returned by the President for reconsideration of houses does not lapse. Quorum. Quorum is the minimum number of members required to be present in the House before it can transact any business. It is 1/10 of Parliament M 237. The total number of members in each House including the presiding officer. It means that there must be at least 55 members present in the Lok Sabha and 25 members present in the Rajya Sabha, if any business is to be conducted. If there is no quorum during a meeting of the House, it is the duty of the presiding officer either to adjourn the House or to suspend the meeting until there is a quorum. Voting in House all matters at any sitting of either House or joint sitting of both the Houses are decided by a majority of votes of the members present and voting, excluding the presiding officer. Only a few matters, which are specifically mentioned in the Constitution, require either effective majority or special majority, not simple majority. The presiding officer of a House does not vote in the first instance, but exercises a casting vote in the case of an equality of votes. The proceedings of a House are to be valid irrespective of any unauthorized voting or participation or any vacancy in its membership. The following points can be noted with respect to the voting procedure in the Lok Sabha. 1. On the conclusion of a debate, the Speaker shall put the question and invite those who are in favor of the motion to say aye, and those against the motion to say no. 2. The Speaker shall then say, think the ayes, or the noes, as the case may be, have it. If the opinion of the Speaker as to the decision of a question is not challenged, Husha shall say twice, the ayes, or the noes, as the case may be, have it, and the question before the House shall be determined accordingly. 3. A. If the opinion of the Speaker as to the decision of a question is challenged, Husha shall order that the lobby be cleared. B. After the lapse of 3 minutes and 30 seconds, Husha shall put the question a second time and declare whether in his opinion the ayes or the noes have it. 238 Indian Polity. C. If the opinion so declared is again challenged, Husha shall direct that the votes be recorded either by operating the automatic vote recorder or by using aye and no slips in the House or by the members going into the lobbies. 4. If in the opinion of the Speaker, the division is unnecessarily claimed, she may ask the members who are for aye and those for no, respectively, to rise in their places and, on account being taken, Husha may declare the determination of the House. In such a case, the names of the voters shall not be recorded. Methods of voting. The various methods adopted for voting in the Lok Sabha are explained below. 13b. 1. Voice vote. It is a simple method for deciding a question put by the Speaker on a motion made by a member. Under this method, the question before the House is determined by the ayes or the noes, as the case may be. 2. Division. There are 3 methods of holding a division. These are A. By operating the automatic vote recording equipment. B. By distributing ayes and noes slips in the House. And C. By members going into the lobbies. However, the method of recording of votes in the lobbies has become obsolete ever since the installation of the automatic vote recording equipment. 3. Secret ballot. During an open voting period, the individual results are shown by the 3 colors, green for ayes, red for noes, and yellow for abstain on the individual result display panel. The secret voting, if any, is held on similar lines except that the light-emitting diode LED on the 13b. This information is adopted from the official website of the Lok Sabha Digital Sansad. Individual result display panel flashes only white light to show that the vote has been recorded. 4. Recording of votes by distribution of slips. The method of recording of votes by members on ayes and noes slips is generally resorted to in the eventuality of A. Sudden failure of the working of the automatic vote recording equipment, and B. At the commencement of the new Lok Sabha, before the seats division numbers have been allotted to the members. 5. Physical count of members in their places instead of a formal division. If in the opinion of the Speaker, a division is unnecessarily claimed, Husha may ask the members who are for ayes and those for noes, respectively, to rise in their places, and on account being takes, Husha may declare the determination of the House. In such a case, the particulars of voting of the members are not recorded. 6. Casting vote. If in a division, the number of ayes and noes is equal, the question is decided by the casting vote of the Speaker. Under the provisions of the Constitution, the Speaker, or the person acting as such, cannot vote in a division. Husha has only a casting vote which Husha must exercise in the case of equality of votes. Language in Parliament. The Constitution has declared Hindi and English to be the languages for transacting business in the Parliament. However, the presiding officer can permit a member to address the House in his mother tongue. In both the Houses, facilities are available for simultaneous interpretation of speeches made in any of the languages specified in the 8th schedule of the Constitution into Hindi and English. However, if a member addresses the House in a language for which simultaneous interpretation facility is not available, Husha has to provide a translation copy of his speech in Hindi or English. Though English was to be discontinued as a floor language after the expiration of 15 years from the commencement of the Constitution, that is, in 1965, the Official Languages Act, 1963, allowed English to be continued along with Hindi. Rights of Ministers and Attorney General. In addition to the members of a House, every Minister and the Attorney General of India have the right to speak and take part in the proceedings of either House, any joint sitting of both the Houses, and any committee of Parliament of which Husha is a member, without being entitled to vote. There are 2 reasons underlying this constitutional provision. 1. A minister can participate in the proceedings of a House, of which Husha is not a member. In other words, a minister belonging to the Lok Sabha can participate in the proceedings of the Rajya Sabha and vice versa. 2. A minister, who is not a member of either house, can participate in the proceedings of both the houses. It should be noted here that a person can remain a minister for 6 months without being a member of either House of Parliament. Lame duck session. It refers to the last session of the preceding Lok Sabha after a new Lok Sabha has been elected. Those members of the preceding Lok Sabha who could not get re-elected to the new Lok Sabha are called lame ducks. During the years 1957 and 1962, when general elections to Lok Sabha were held, in addition to 3 sessions of the new Lok Sabha, 1 session each of the preceding Lok Sabha was also held after elections to new Lok Sabha had taken place and results thereof had been announced, but before the new Lok Sabha was duly constituted. These were popularly known as lame duck sessions. The purpose of these sessions was Parliament 239. To pass the vote on account to enable the government to carry on till the new Lok Sabha was constituted. However, there was no lame duck session of the 3rd Lok Sabha as the 4th Lok Sabha was constituted soon after the result of the 4th general elections had been announced. The vote on account was passed in the first session of the new Lok Sabha 13C. T types of majority _______________________________________________________________________________________________________________________ the following 4 types of majority are required to determine the various matters in the Parliament. BL simple majority. It is a majority of the members present and voting in the House. It is also known as ordinary majority or functional majority or working majority. Article 100 of the Constitution states that except as otherwise provided in this Constitution, all questions at any sitting of either House or joint sitting of the Houses shall be determined by majority of votes of the members present and voting. This means that the simple majority is the general rule prescribed by the Constitution for the determination of questions in the Parliament. This type of majority is required in the following cases. A. Passing of the ordinary bills, money bills, and financial bills. B. Passing of the adjournment motion, no confidence motion, censure motion, and motion of thanks. C. Removal of the Vice President in the Lok Sabha, Article 67. D. Approval of the imposition of the President's Rule, Article 356. E. Approval of the Proclamation of Financial Emergency, Article 360. F. Election of the Speaker and the Deputy Speaker of the Lok Sabha, Article 93. 13 cm. N. Call and S.L. Schachter, Practice and Procedure of Parliament, 6th edition, 2009, Lok Sabha Secretariat, pp. 454-55. 240 Indian Polity. G. Election of the Deputy Chairman of the Rajya Sabha, Article 89. H. Passing of a resolution by the Lok Sabha for disapproving the continuance of the national emergency, Article 352. Al effective majority. It means a majority of the total membership of the House, excluding the vacant seats. In other words, it is a majority of the effective strength of the House. For example, the effective majority in the case of Rajya Sabha is 111 if there are 25 vacant seats out of the total 245 members. Similarly, the effective majority in the case of Lok Sabha is 265 if there are 15 vacant seats out of the total 543 members. This type of majority is referred in the Constitution as a majority of all the then members of the House. It is required in the following cases. A. Removal of the Vice President in the Rajya Sabha, Article 67. B. Removal of the Deputy Chairman of the Rajya Sabha, Article 90. C. Removal of the Speaker and the Deputy Speaker of the Lok Sabha, Article 94. 31 Absolute majority. It means a majority of the total membership of the House, irrespective of the fact whether there are vacant seats or absentees. For example, the absolute majority in the case of Rajya Sabha is 123 out of the total 245 members. Similarly, the absolute majority in the case of Lok Sabha is 272 out of the total 543 members. This type of majority is not prescribed by the Constitution for any case or purpose as a standalone, single requirement. But it is required in certain cases as a component of special majority, i.e., special majority, which is explained below. QI special majority. The various cases of requirement of special majority can be further classified in the following way. Special majority. 1. A majority of the total membership of each House and a 2/3 majority of the members present and voting is required in the following cases. A. Amendment of the Constitution, Article 368. B. Removal of the judges of the Supreme Court, Article 124. C. Removal of the judges of the High Courts, Article 217. D. Removal of the Comptroller and Auditor General of India, Article 148. E. Removal of the Chief Election Commissioner, Article 324. F. Removal of the State Election Commissioner, Article 243K. G. Parliamentary approval of proclamation of national emergency, Article 352. Special majority. 2. A 2/3 majority of the total membership of each House is required for the impeachment of the President, Article 61. Special majority. IIL. A 2/3 majority of the members present and voting in the Rajya Sabha is required in the following cases. A. Recommendation for the creation of new All India Services, Article 312, B. Parliamentary legislation on matters in the state list, Article 249. Devices of parliamentary T. Proceedings. Question hour. The first hour of every parliamentary sitting is slotted for this. During this time, the members ask questions and the ministers usually give answers. The questions are of three kinds, namely, starred, unstarred, and short notice. A starred question, distinguished by an asterisk, requires an oral answer and hence supplementary questions can follow. An unstarred question, on the other hand, requires a written answer and hence, supplementary questions cannot follow. A short notice question is one that is asked by giving a notice of less than 10 days. It is answered orally. In addition to the ministers, the questions can also be asked to the private members. Thus, a question may be addressed to a private member if subject matter of the question relates to some bill, resolution, or other matter connected with the business of the House for which that member is responsible. The procedure in regard to such question is the same as that followed in the case of questions addressed to a minister. The list of starred, unstarred, short notice questions and questions to private members are printed in green, white, light pink, and yellow color, respectively, to distinguish them from one another. 0 hour. Unlike the question hour, the 0 hour is not mentioned in the rules of procedure. Thus it is an informal device available to the members to raise various matters of urgent public importance. The 0 hour starts immediately after the question hour and lasts until the agenda for the day, i.e., regular business of the House, is taken up. In other words, the time gap between the question hour and the agenda is known as 0 hour. It is an Indian innovation in the field of parliamentary procedures and has been in existence since 1962. Johns. N.I. Discussion on a matter of general public importance can take place except on a motion made RTH the consent of the presiding officer. The House expresses its decisions or opinions on various issues through the adoption or rejection of motions moved by either ministers or private members. The motions moved by the members to raise discussions on various matters fall into three principal categories. 1. Substantive motion. It is a self-contained independent proposal dealing with a very important matter like impeachment. Parliament 241. Of the President or removal of Chief Election Commissioner. 2. Substitute motion. It is a motion that is moved in substitution of an original motion and proposes an alternative to it. If adopted by the House, it supersedes the original motion. 3. Subsidiary motion. It is a motion that, by itself, has no meaning and cannot state the decision of the House without reference to the original motion or proceedings of the House. It is divided into three subcategories. A. Ancillary motion. It is used as the regular way of proceeding with various kinds of business. B. Superseding motion. It is moved in the course of debate on another issue and seeks to supersede that issue. C. Amendment. It seeks to modify or substitute only a part of the original motion. Closure motion. It is a motion moved by a member to cut short the debate on a matter before the House. If the motion is approved by the House, debate is stopped forthwith and the matter is put to vote. There are four kinds of closure motions. 14. 14J.C. Johari, Indian Government and Politics, Vishal, Volume 2, 13th edition, 2001, p. 360. A. Simple closure. It is one when a member moves that the matter having been sufficiently discussed be now put to vote. B. Closure by compartments. In this case, the clauses of a bill or a lengthy resolution are grouped into parts before the commencement of the debate. The debate covers the part as a whole and the entire part is put to vote. C. Kangaroo closure. Under this type, only important clauses are taken up for debate and voting, and the intervening clauses are skipped over and taken as passed. D. Guillotine closure. It is one when the undiscussed clauses of a bill or a resolution are also put to vote along with the 242 Indian Polity. Discussed ones due to want of time, as the time allotted for the discussion is over. Privilege motion. It is concerned with the breach of parliamentary privileges by a minister. It is moved by a member when HISHA feels that a minister has committed a breach of privilege of the House or one or more of its members by withholding facts of a case or by giving wrong or distorted facts. Its purpose is to censure the concerned minister. Calling attention motion. It is introduced in the Parliament by a member to call the attention of a minister to a matter of urgent public importance and to seek an authoritative statement from him or on that matter. Like the 0 hour, it is also an Indian innovation in the parliamentary procedure and has been in existence since 1954. However, unlike the 0 hour, it is mentioned in the rules of procedure. Adjournment motion. It is introduced in the Parliament to draw attention of the House to a definite matter of urgent public importance and needs the support of 50 members to be admitted. As it interrupts the normal business of the House, it is regarded as an extraordinary device. It involves an element of censure against the government, and hence Rajya Sabha is not permitted to make use of this device. The discussion on an adjournment motion should last for not less than 2 hours and 30 minutes. The right to move a motion for an adjournment of the business of the House is subject to the following restrictions. 1. It should raise a matter which is definite, factual, urgent, and of public importance. 2. It should not cover more than one matter. 3. It should be restricted to a specific matter of recent occurrence and should not be framed in general terms. 4. It should not raise a question of privilege. 5. It should not revive discussion on a matter that has been discussed in the same session. 6. It should not deal with any matter that is under adjudication by court. And 7. It should not raise any question that can be raised on a distinct motion. No confidence motion. Article 75 of the Constitution says that the Council of Ministers shall be collectively responsible to the Lok Sabha. It means that the ministry stays in office so long as it enjoys confidence of the majority of the members of the Lok Sabha. In other words, the Lok Sabha can remove the ministry from office by passing a no-confidence motion. The motion needs the support of 50 members to be admitted. Confidence motion. The motion of confidence has come up as a new procedural device to cope with the emerging situations of fractured mandates resulting in hung parliament, minority governments, and coalition governments. The governments formed with wafer-thin majority have been called upon by the president to prove their majority on the floor of the House. The government of the day, sometimes, on its own, seeks to prove its majority by moving a motion of confidence and winning the confidence of the House. If the confidence motion is negatived, it results in the fall of the government 1 foot. 15T.K. Vishwanathan, Editor, The Indian Parliament, Lok Sabha Secretariat, 14th edition, 2011, p. 21. Censure motion. A censure motion is different from a no-confidence motion as shown in Th. 23.2. Motion of thanks. The first session after each general election and the first session of every fiscal year is addressed by the President. In this address, the President outlines the policies and programs of the government in the preceding year and ensuing year. This address of the President, which corresponds to the speech from the throne in Britain, is discussed in both the Houses of Parliament on a motion called the motion of thanks. At the end of the discussion, the motion is put to vote. This Parliament. Table 23.2. Censure motion versus no confidence motion. Censure motion. No confidence motion. 1. It should state the reasons for its adoption in the Lok Sabha. 1. It need not state the reasons for its adoption in the Lok Sabha. 2. It can be moved against an individual minister or a group of ministers or the entire Council of Ministers. 2. It can be moved against the entire Council of Ministers only. 3. It is moved for censuring the Council of Ministers for specific policies and actions. 3. It is moved for ascertaining the confidence of Lok Sabha in the Council of Ministers. 4. If it is passed in the Lok Sabha, the Council of Ministers need not resign from the office. 4. If it is passed in the Lok Sabha, the Council of Ministers must resign from office. Motion must be passed in the House. Otherwise, it amounts to the defeat of the government. This inaugural speech of the President is an occasion available to the members of Parliament to raise discussions and debates to examine and criticize the government and administration for its lapses and failures. No day yet named motion. It is a motion that has been admitted by the Speaker, but no date has been fixed for its discussion. The Speaker, after considering the state of business in the House and in consultation with the Leader of the House or on the recommendation of the Business Advisory Committee, allots a day or days or part of a day for the discussion of such a motion. Dilatory motion. It is a motion for the adjournment of the debate on a bill, motion, resolution, etc. or a motion to retard or delay the progress of a business under consideration of the House. It can be moved by a member at any time after a motion has been made. The debate on a dilatory motion must be restricted to the matter contained in such motion. If the Speaker is of the opinion that such a motion is an abuse of the rules of the House, Husha may either forthwith put the question thereon or decline to propose the question. Point of order. A member can raise a point of order when the proceedings of the House do not follow the normal rules of procedure. A point of order should relate to the interpretation or enforcement of the rules of the House or such articles of the Constitution that regulate the business of the House and should raise a question that is within the cognizance of the Speaker. It is usually raised by an opposition member in order to control the government. It is an extraordinary device as it suspends the proceedings before the House. No debate is allowed on a point of order. Half-an-hour discussion. It is meant for discussing a matter of sufficient public importance, which has been subjected to a lot of debate and the answer to which needs elucidation on a matter of fact. The Speaker can allot 3 days in a week for such discussions. There is no formal motion or voting before the House. Short duration discussion. It is also known as 2-hour discussion, as the time allotted for such a discussion should not exceed 2 hours. The members of the Parliament can raise such discussions on a matter of urgent public importance. The Speaker can allot 2 days in a week for such discussions. There is neither a formal motion before the House nor voting. This device has been in existence since 1953. 244 Indian Polity. Special mention. A matter which is not a point of order or which cannot be raised during question hour, half-an-hour discussion, short duration discussion, or under adjournment motion. Calling attention notice or under any rule of the House can be raised under the special mention in the Rajya Sabha. Its equivalent procedural device in the Lok Sabha is known as notice, mention, under Rule 377. Resolutions. A resolution is a self-contained independent proposal submitted for the approval of the House and drafted in such a way as to be capable of expressing a decision of the House. All resolutions are substantive motions. The members can move resolutions to draw the attention of the House or the government to matters of general public interest. The discussion on a resolution is strictly relevant to and within the scope of the resolution. A member who has moved a resolution or amendment to a resolution cannot withdraw the same except by leave of the House. A resolution may have the following objectives. I. A declaration of opinion or a recommendation. 2. 1b. Record either approval or disapproval by the House of an act or policy of the government. 3. Convey a message or commend, urge, or request an action. 4. Call attention to a matter or situation for consideration by the government. Resolutions are classified into 3 categories. 11-1. Private member's resolution. It is one that is moved by a private member, other than a minister. It is discussed only on alternate Fridays and in the afternoon sitting. Dictionary of Constitutional and Parliamentary Terms, Lok Sabha Secretariat, 2nd edition, 2005, pp. 396-97. 2. Government resolution. It is one that is moved by a minister. It is of the following 3 kinds. A. Resolutions approving international treaties, conventions, or agreements of which the government is a party. B. Resolutions declaring or approving certain policies of the government. C. Resolutions approving recommendations of certain committees. 3. Statutory resolution. It can be moved either by a private member or a minister. It is so called because it is in pursuance of a provision in the Constitution or an Act of Parliament. Resolutions are different from motions in the following respects. All resolutions come in the category of substantive motions, that is to say, every resolution is a particular type of motion. All motions need not necessarily be substantive. Further, all motions are not necessarily put to vote of the House, whereas all the resolutions are required to be voted upon. 17. Youth Parliament. The scheme of Youth Parliament was started on the recommendation of the 4th All India Whips Conference. Its objectives are 1. To acquaint the younger generations with practices and procedures of Parliament. 2. To imbibe the spirit of discipline and tolerance cultivating character in the minds of youth. And 3. To inculcate in the student community the basic values of democracy and to enable them to acquire a proper perspective on the functioning of democratic institutions. The Ministry of Parliamentary Affairs provides necessary training and encouragement to the states in introducing the scheme. Subhash C. Kashyap, Our Parliament, National Book Test, 1999 edition, p. 139. F. Legislative Procedure in Parliament ____________________ The legislative procedure is identical in both the Houses of Parliament. Every bill has to pass through the same stages in each House. A bill is a proposal for legislation and it becomes an act or law when duly enacted. The bills introduced in the Parliament are of 2 kinds, public bills and private bills, also known as government bills and private members' bills respectively. Though both are governed by the same general procedure and pass through the same stages in the House, they differ in various respects as shown in Table 23.3. Depending on their content, the bills may further be classified into 18. A. Original bills, bills embodying new proposals, ideas, or policies. B. Amending bills, bills which seek to modify, amend, or revise the existing acts. C. Consolidating bills, bills which seek to consolidate existing laws on a particular subject. D. Expiring laws, continuance, bills to continue an expiring act. E. Repealing bills, bills seeking to repeal existing acts. Parliament *4 245. F. Validating bills, bills which seek to give validity to certain actions. G. Bills to replace ordinances. H. Constitution, amendment, bills. And I. Money and financial bills. On the basis of procedure required for their passage in the Parliament, the bills can also be broadly classified into the following 4 types. 1. Ordinary bills, which are concerned with any matter other than financial subjects. 2. Money bills, which are concerned with the financial matters like taxation, public expenditure, etc. 3. Financial bills, which are also concerned with financial matters, but are different from money bills. 4. Constitution amendment bills, which are concerned with the amendment of the provisions of the Constitution. The Constitution has laid down separate procedures for the enactment of all the 4 types of bills. The procedures with regard to ordinary bills, money bills, and financial bills are explained here. The procedure with regard to Constitution amendment bills is already explained in detail. Table 23.3 Public Bill versus Private Bill. 1. It is introduced in the Parliament by a minister. 2. It reflects of the policies of the government. Public Bill, Private Bill. An Introduction to Parliament of India, Rajya Sabha Secretariat, 4th edition, 2007, p. 24. 6. It is drafted by the concerned department's cont. 6. Its drafting is the responsibility of the member consultation with the law department concerned. 1. It is introduced by any member of Parliament other than a minister. 2. It does not reflect the stand of government on public matter. 3. It has lesser chance to be approved by the Parliament. 3. It has greater chance to be approved by the Parliament. 4. Its rejection by the House amounts to the expraise. 4. Its rejection by the House has no implication on the shown of one of parliamentary confidence in the government or its government and may lead to its resignation. Resignation. 5. Its introduction in the House requires 7 days. 5. Its introduction in the House requires 1 month. Notice. 246 Indian Polity. Ordinary bills. Every ordinary bill has to pass through the following 5 stages in the Parliament before it finds a place on the statute book. 1. First reading. An ordinary bill can be introduced in either House of Parliament. Such a bill can be introduced either by a minister or by any other member. The member who wants to introduce the bill has to ask for the leave of the House. When the House grants leave to introduce the bill, the mover of the bill introduces it by reading its title and objectives. No discussion on the bill takes place at this stage. Later, the bill is published in the Gazette of India. If a bill is published in the Gazette before its introduction, leave of the House to introduce the bill is not necessary. The introduction of the bill and its publication in the Gazette constitute the first reading of the bill. 19. 2. Second reading. During this stage, the bill receives not only the general but also the detailed scrutiny and assumes its final shape. Hence, it forms the most important stage in the enactment of a bill. In fact, this stage involves 3 more substages, namely, stage of general discussion, committee stage, and consideration stage. 19. Under Rule 64 of Lok Sabha, the Speaker may, on request being made to him, order the publication of any bill in the Gazette, although no motion has been made for leave to introduce the bill. In that case, it shall not be necessary to move for leave to introduce the bill, and if bill is afterwards introduced, it shall not be necessary to publish it again. A. Stage of general discussion. The printed copies of the bill are distributed to all the members. The principles of the bill and its provisions are discussed generally, but the details of the bill are not discussed. At this stage, the House can take any one of the following 4 actions. I. It may take the bill into consideration immediately or on some other fixed date. 2. It may refer the bill to a select committee of the House. 3. It may refer the bill to a joint committee of the 2 houses. And 4. It may circulate the bill to elicit public opinion. A select committee consists of members of the House where the bill has originated, and a joint committee consists of members of both the Houses of Parliament. B. Committee stage. The usual practice is to refer the bill to a select committee of the House. This committee examines the bill thoroughly and in detail, clause by clause. It can also amend its provisions, but without altering the principles underlying it. After completing the scrutiny and discussion, the committee reports the bill back to the House. C. Consideration stage. The House, after receiving the bill from the select committee, considers the provisions of the bill clause by clause. Each clause is discussed and voted upon separately. The members can also move amendments, and if accepted, they become part of the bill. 3. Third reading. At this stage, the debate is confined to the acceptance or rejection of the bill as a whole, and no amendments are allowed, as the general principles underlying the bill have already been scrutinized during the stage of second reading. If the majority of members present and voting accept the bill is regarded as passed by the House. Thereafter, the bill is authenticated by the presiding officer of the House and transmitted to the second House for consideration and approval. A bill is deemed to have been passed by the Parliament only when both the Houses have agreed to it, either with or without amendments. 4. Bill in the second House. In the second House also, the bill passes through all the 3 stages, that is, first reading, second reading, and third reading. There are 4 alternatives before this House. A. It may pass the bill as sent by the first House, i.e., without amendments. B. It may pass the bill with amendments and return it to the first House for reconsideration. C. It may reject the bill altogether. And D. It may not take any action and thus keep the bill pending. If the second House passes the bill without any amendments or the first House accepts the amendments suggested by the second House, the bill is deemed to have been passed by both houses and the same is sent to the President for issue assent. On the other hand, if the first House rejects the amendments suggested by the second House, or the second House rejects the bill altogether, or the second House does not take any action for 6 months, a deadlock is deemed to have taken place. IB resolve such a deadlock, the President can summon a joint sitting of the 2 houses. If the majority of members present and voting in the joint sitting approves the bill is deemed to have been passed by both the Houses. 5. Assent of the President. Every bill after being passed by both Houses of Parliament, singly or at a joint sitting, is presented to the President